Gail Ann Russell was a 30-year-old mother of two young boys in 1995 when she disappeared. She was living on Oakley Avenue in Hudson, which is located in Pasco County, Florida. She worked as a clerk at the local Circle K convenience store. Gail was in a long-term relationship with the father of her two children, Larry Podolsky. Larry was the same age as Gail and worked as a cook at Red Lobster, as well as doing landscaping work on the side. Larry and Gail had a volatile relationship. Gail's family reported that they had never seen signs of abuse, but knew Gail was not happy and did not want to marry Larry. Larry claimed their relationship was good, and the two planned to marry in February of the following year. Not long before she disappeared, Gail and Larry were at a Taco Bell on the corner of U.S. Highway 19 and State Road 52. A fight ensued, and Larry, angry at Gail, began smashing the window of his truck. When Gail tried to stop him, he pushed her to the ground. The Pasco County Sheriff's Office was called. When deputies arrived, they found Gail bleeding from scrapes to her knees and elbows. Gail told deputies what had happened, and Larry was arrested for domestic violence. He maintained his innocence and was adamant that Gail had made the story up. The following day, for unknown reasons, Gail recanted her story, telling the state's attorney's office she made the whole thing up. The charges against Larry were subsequently dropped. 2 weeks later, charges were brought against Gail for filing a false police report. Gail was arrested. Around this time, Gail made several comments to family members that made them concerned for her safety in the relationship. On Sunday, September 3rd, 1995, Larry and Gail worked a couple of jobs for the tree trimming business, starting around 1 p.m. Their two boys, Joey, aged 4 at the time, and Brian, aged 2, were at a babysitter's house. The times of the evening's activities have changed with Larry's recounts over the years. The following timeline is what was initially provided to the Pasco County Sheriff's deputies and the media following Gail's disappearance. Around 10 p.m. on September 3rd, Larry and Gail finished their work and went to a local dive bar called Bobcats for a few drinks. They left the bar sometime later. The bar was less than a mile from their home. It was never publicized where the babysitter's house was located. Gail and Larry picked up the boys and were home by 12:30 a.m. Once home, they went straight to bed, according to Larry. At about 1 a.m., Larry reported hearing a knock either on the front door or the window of the home. Gail got up to investigate, and Larry went back to sleep. The boys were asleep inside in their beds. When Larry awoke the next morning, Gail was gone. Larry reported that he called the Pasco County Sheriff's Office to report Gail missing around 1 p.m. on September 4th and was told that he had to wait 48 hours before filing a missing persons report. Pasco County Sheriff's Office reports having no record of this call and did not have any such policy in place at that time. Larry ultimately did not report Gail missing until 67 hours after her disappearance. The sheriff's office checked shelters, hospitals, mental health facilities, the coroner's office, and contacted friends and family, and found no sign of Gail. At first, investigators were concerned that Gail may have left on her own accord. After speaking with her friends and family and hearing what a devoted and loving mother she was, they realized that scenario was unlikely. After providing his initial report, Larry was described as uncooperative by investigators. Gail's family was not aware that she was missing for several days. Her mother called the home phone line to speak with her, and Larry would say that she was out or busy. This was a time before cell phones were widely available, and that was the only method for her family to contact her. Gail's family lived out of state. They contacted a family friend who lived near Gail. The friend went to the residence and was told by Larry that Gail was busy doing laundry. The friend was suspicious and contacted Gail's mother. She questioned Larry, who told her Gail had left him for another man and took everything, including her glasses and contact lenses, driver's license, and $245 they had in the home to pay their monthly bills. Gail's siblings quickly traveled to Florida and found the items Larry said Gail took, her glasses, identification, on top of the bedroom dresser. According to her sister, Gail would not leave home without her glasses or contact lenses. The lead investigator on the case, John Stanley, died before he could close what he described as the most frustrating case of his career. Investigators questioned more than 100 people in connection with the case and fielded new calls and leads for years. Larry found himself in local jails frequently on unrelated charges, and investigators would travel to neighboring counties to question him. They never received enough information to bring charges against him. Detective Sessa, who took over the case for John Stanley after he passed, told the local newspaper that they knew what happened to Gail, they just couldn't prove it in court. The absence of evidence was not for the lack of effort on the part of the Pasco County Sheriff's Office. After Gail's disappearance, they searched the trailer for blood evidence. Cadaver dogs were used around the trailer property and in an adjacent junkyard. The septic system was pumped and inspected. Gail's family offered a $10,000 reward for information and hired a private investigator and even a psychic. Gail's sister was able to raise an additional $50,000 through her connections in the entertainment industry to continue to search in nearby areas. Larry's behavior was considered suspicious by many, but never incriminating. 2 days after Gail's disappearance, Larry went to the local food stamp office and advised them Gail had left the state. He asked for the monthly food allotment to be changed from her name to his. Larry often refused to discuss the circumstances of Gail's disappearance in depth with investigators, often getting angry and irate when the questioning began. He twice refused to participate in polygraph testing. Rumors swirled around the small town, having an impact on Larry's family, especially his father, who owned a deli. Larry's father, Joseph, described the situation as hell on our family and noted how cruel people could be in accusing his son. He further noted to anyone who would listen that his son was not smart enough to get away with that serious of a crime. He was not smart enough to destroy every piece of evidence. Joseph Podolsky said that the case was not properly investigated, that Pasco County investigators did not follow up on a statement by Gail's oldest son, Joey, who was 4 at the time. Joey stated that 2 men came up, put tape over his mother's mouth, put her in a car with a tailgate. Joey repeated this in multiple Facebook posts on the Pasco County Sheriff's Department's Missing Persons post. Many other past friends commented about what a sweet and loving mother Gail was. Joey replied to every post, desperately seeking more information about his mother and vehemently defending his father. The impact of Gail's disappearance was far-reaching through her family. Her parents and siblings spent years trying to find out what happened to her and suffered greatly at the lack of answers. Larry Podolsky found himself in trouble with the law many times throughout the years and eventually died of a drug overdose, reportedly in 2004. Their 2 children, Joey and Brian, were frequently in trouble with the law. Joey appears to have died in 2020 of unknown causes. Brian is currently on trial in Pasco County, Florida, related to a shooting. Unfortunately, unless someone comes forward with information about what happened to Gail, it appears that answers will likely never be found for Gail's family. If you have any information regarding this case, please contact the Pasco County Sheriff's Office.
Oh, I see why, Emma, you said it's coming back with 6 felonies. When I saw, okay. Thank you, Miss Emma.
Welcome.
Counsel,
Your Honor, I've had an opportunity to review the pre-sentence investigation report. I've reviewed it with Mr. Briggs. There are no additions, deletions, or corrections as to the report itself.
I looked at this pre-sentence report, and no, you're not getting this from me.
Yeah, this looks like this plea was taken in district court, yet it's ended up here for sentencing.
Well, they got a problem. What is this? Is it no agreement? It's just no agreement. He's got a habitual fault. Is that what this is?
And I don't have a copy of the plea form. Let me see. Hold on.
And are the guidelines correctly scored?
Let me take a look at them. Okay. For an attempt felonious assault, I believe they would be.
Okay.
They're still 0 to 17. And that's using like the H grid. Yeah, the H grid.
That's correct, Your Honor.
Dan has.
Oof.
A criminal sexual conduct, an assault on a prison employee. Now he's got an assault with a dangerous weapon. That does not include his stolen property or possession with intent to deliver. And this is an assaultive offense on a senior citizen, apparently. They keep saying he was an old man. And what? You want me to sentence him within the guidelines? Is that what you're saying? And he got a 2-year max?
Your Honor, some of these old offenses are date back quite some time.
I'm sorry?
I said some of these older offenses are over 10 years old, 12 years old, dating back.
That's because he was in prison, assaulting a good guard.
I was, Your Honor. Correct.
Section 4. Yeah, I was able to find a copy of the plea form. It was reduced to an attempt felonious assault, technically a 2-year high court misdemeanor. The habitual was withdrawn. With the agreement as follows: agreement for a sentence within guidelines range calculated at sentencing, sentence to include no contact with the complainant, all other terms, conditions set by the court, with full restitution if applicable.
That is correct, Your Honor. That's what I had.
Now I'll give you to your counsel. You got him a wonderful deal. I'm gonna give it to you, okay? However, Mr. Casey,
Yes, Your Honor.
this just irritates me to the core of my bones. Okay?
Yeah.
Now, I don't necessarily want to take the man's deal from him. I mean, but by the same token, I don't want to honor this.
Yeah, and there may have been.
Do I have the ability to send it to some other judge who can just swallow hard and do this?
Yeah, hold their nose, yeah. And I'm looking through the notes, see, okay. Now the complainant has some issues as well. So that may have been part of the consideration.
Hard of hearing is what I read.
Yeah.
Look, I don't, all I'm saying is,
Mhm.
if I send this to somebody else and they just go along with it,
Yeah,
because as far as I'm concerned, this man should not be on the streets. Okay, now that's where I stand on it.
mhm.
I consider him to be dangerous.
I don't know how that would work, because there's been a plea. I don't know why they just didn't take do the sentence in district court.
Because it was a felony.
Yeah, I don't know what to tell you, Judge. Yeah, if he withdraws his plea,
I'll tell you what I'll do.
Yeah.
I'll tell you what I do. I know how to handle this. I'm gonna recuse myself. Okay? I'm gonna recuse myself from this case. I don't think that I you know how every now and then I tell y'all I need to walk it off. I just, get up and stroll for a few minutes, let my blood pressure go down. Yeah, that's where I'm at on this. So I'm gonna recuse myself from this case, counsel. And Miss Emma gonna take it and she gonna send the whole package to another judge. And all of it to go as is. As is. All right. But I'm not gonna be part of this. And Mr. Ripley, I know you got something to do, but I think I'm gonna walk it off. Mr.
Step away and walk
Mr.
it off.
Ripley, what do you have to do? Is it? Let me see.
Plea on Mr. Brown that's he's labeled as Zoom user.
Okay, just let me take 5 and walk it off. Okay, I think the whole plea situation will run much more smoothly, and I'm only gonna take 5. Okay, just give me 5.
Good morning,
morning.
Your Honor. Rachel McRippy appearing on behalf of Robert Briscoe.
I hope everything went well for you. I'd like to hear. Detective, your name. I'm referring to you, Ms. McRipley.
Okay.
Go ahead, Detective.
Brian Ramsey, detective with the Brownstown Police Department.
So what's he doing now?
He was picked up on the warrant for retail fraud.
No. I'm asking the lawyer, is he going to stand mute, wait formal reading?
Yes.
Not guilty plea is entered. So I just want to ask you a question. Mr. Briscoe, you think that the judges in this building are foolish?
No, sir.
Do we look like we want to be somebody's tool? I'm just asking you. You have not shown up on this. I'm going to set a bond on you that you're not going to believe. You've taken this retail fraud and made me think of it like it's a 25-year felony. You like to play games, huh? You know how many times you haven't shown up on this?
Sir, I don't like
You know how many times?
games.
Okay, well, good. We're going to give you a pretrial date. I'll listen to anything you have to say, Ms. McRipley, but just for the record, just so anybody knows. A warrant was issued in June of 17. He was here in July of 20, or was here, supposed to be here in July of 20, didn't show. That was after he was initially arraigned in 17. He didn't show up in June of 17. And then he was supposed to be here in 20, didn't show, warrant issued. We lifted the warrant in 21. I set it for an in-person. He didn't show up then. I then did it again in 23, set 6,010%. That was January of 23, and he didn't show up again. Anything you'd like to say on his behalf?
Your Honor, he has had a rough couple of years. He's been going through homelessness. So I know a lot of times it doesn't excuse, but that's the explanation that he had. He has been dealing with some deaths in his family, as well as his own health issues. He understands he needs to take care of this.
He was able to post this bond back in January of 23. Not too many homeless people can come up with $500. He still has warrants out for his arrest, at least 3 of them. I see one in Monroe, another in Wyandotte, another in Huron Township.
Your Honor,
Listen,
that's
listen to me.
okay.
Before I retire in 8 years, we are going to take care of this case. That's what
I
we're
want
gonna do.
to get everything taken care of. I'm just done and scared of just having to run every day. Being able to come and get arrested and go to jail. So,
Here's your bond conditions. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed, no contact with the victim or prosecution witnesses. You cannot enter 23800 West Road in Brownstown or any CVS store. 25,000, 10% will be your bond. We'll set this for an early date. Is that the 8th, Lisa, or 9th? 8th, right?
The 8th.
And we'll do this at 8:45 in the morning. Is that good? Or you want another time? 8, yeah, we'll make it 8:45. Propose $2,500. Also, you cannot leave the state, cannot violate a law. You must appear in court as directed. I wish you well. Ms. McRipley, I'd like to talk to you how that went the other day before you
Okay.
leave here. And I wish you well, sir. You're making this so much worse than it needs to
no,
be.
you're assuming I'm done. I'm done running. I just turned 30 years old, so I'm ready to get my life back on track.
I'll see you Wednesday. Good luck. People against,
That's it.
Those catalytic converters cost, it's always, God, that's expensive. And it just, people who go through it, they tell me about how much of a mess it is. How costly a mess. And then generally it's stolen and they're somewhere, they have to drive the vehicle back. And anybody who drives in a vehicle without a catalytic converter can go deaf, from what I hear. Because it is the loudest thing. 2137997 is called Wesley Moore. You're Mr. Moore?
Yes, sir.
And you were here with your attorney, Mr. Grove, and the state's attorney. There is in this cause number 2137997, a motion to revoke probation that has been filed as of February 7th of 2023. Are you familiar with it?
Yes, sir.
Raise your right hand. Do you solemnly swear or affirm any statements you make will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Lower your hand. Does the defendant waive a formal reading of this motion to revoke unadjudicated probation? Can we proceed in summary?
Yes, Your Honor.
In summary, this motion states that on September 13th, 2021, you were placed on 10 years deferred or unadjudicated probation for burglary of a habitation, which is a second-degree felony. Is that true?
Yes, sir.
Allegation 1 states you failed to report to the Jefferson County Probation Office for the months of December of 2021, January 2022, February 2022, all in violation of your probation order. Is that true or untrue?
It's true.
How many did he report at all?
Once he went to the actual intake.
Intake, and that was it?
And that's it.
And when was he arrested? Does anybody have that information, please? Of this year?
Yes, sir.
Okay, so he left in December and he was gone for about 1.5 years.
Yes, sir.
How were you arrested? I was arrested in Killeen by they ran my name and it was a warrant.
Okay. And number 2 states that you failed to provide verification performing community service hours as required. Is that true or untrue?
That's true.
Are you pleading true? Allegations 1 and 2, voluntarily, knowingly, intelligently, and because those are true as they are alleged.
Yes, sir.
You understand by pleading true, that is enough to grant this motion to revoke probation to 1 or more violations. And your probation can be revoked. You can now be found guilty and sentenced up to the full range of punishment, which is no less than 2 nor more than 20 years in prison. Knowing that, do you insist on pleading true today?
Sir.
I find you pleading true voluntarily. You understand and appreciate the consequences of pleading true. Let me just real quick. There's restitution at $500 too.
Yes,
Well,
sir.
Was anything paid?
No, sir. no
Nothing.
payment.
Well, that's not good. Seth Moore. Who is Seth Moore?
My son.
So this is true. You burglarized your son's house?
No, sir. So my son lived there.
I'm sorry. You burglarized the home where your son was living.
Yes, sir.
Was he involved in this burglary at all?
No, sir.
Can you explain how that makes any sense at all? That you would victimize your son? You can't help but victimize your son here.
Yes, sir. Your Honor, they live with my mother, it's our grandmother, and they had left that day, and I still passed the lock into the restroom. I didn't take anything from the house. And when I did that, my mother thought that I had taken stuff from the house and I guess called the police and reported all this stuff. And I didn't take anything from the house, but I did go past the lock. Yes, sir. I am guilty of that, to use the restroom.
So I guess it begs the question here. Okay, Mr. Moore, help me understand
Yes, sir.
your logic. There's the plea paper. Did you sign that? Under oath? Is that your signature? Read out loud in the plea hearing what's marked it and highlighted in pink color.
I'm guilty of the offense.
I'm sorry, what'd you just say?
I am guilty of the offense.
Which offense is that?
The burglary of a habitation.
Ah. Okay. And what does it say? Keep going.
And all lesser included offenses charged against me in the case.
What else?
I swear that all the going as well as the testimony I give is the truth, so help me God.
So help you God, you swear. And you're going to look at me and say you didn't commit a burglary?
I'm guilty of
Thank you.
Yes, sir.
Thank you. In spite of the words, I didn't commit a burglary coming out of your mouth. That's just. I'm not the person you want to try to deceive and trick. You got to be forthright with me. And you may not believe in it, but what we try to do is make decisions based upon accuracy and the truth. And you swore to God and then turned right around a few minutes ago and said, I wasn't committing a burglary. All right. Well, there's nothing you can really say about it because it defies logic. Plus, it defies your veracity. You're just not a believable person. You've just shown that. Trying to commit perjury to me. I swore you in this. You were sworn in on that. And you've given 2 different stories. So it's not going good for you. What do y'all think we should do?
I believe we had a recommendation, Judge.
I'm not sure I want to do that.
Well, I understand that. I just want to make sure that the record shows that there was a recommendation. I understand the court is not bound by that.
No, because we're not going to have a fraud being perpetrated by someone who obviously didn't lift a finger in the first place to fix this mess that he caused. I see there's an agreement that whatever sentence a confinement of 3 years in prison. Is that your understanding of the agreement?
Yes, sir.
I'm not going to take it. So we'll just set it for a hearing and he'll come before me and I'll make the decision for everybody, okay? I'll keep this. That's what we'll do.
Yeah, PSI, George.
And
Matt. Thank you, Your Honor.
He's just.
Okay, thank you, Jesus. Okay, go ahead, Dig. I'm sorry.
know.
for everything.
Is that directed at me or Ward? Anyway,
Jessica Blanche, appearing on behalf of people.
And good morning, Your Honor. Christina Costantino, appearing with and on behalf of Ms. Sierra Robinson. Ms. Robinson, can you unmute and state your name for the record?
Sierra Robinson.
what are we doing?
Your Honor, this is a date and time set for probable cause conference. At this time, we are requesting that this matter be scheduled for an in-person preliminary exam at the soonest available date, and I would like to address my client's bond.
Preliminary examination in this matter will be set for May 2nd, 2023, 9 a.m., and that is before Judge Perry.
Thank you, Judge. Might I address my client's bond?
You may.
Your Honor, my client's bond is currently set at $2 million with no 10% provision. We are asking for a reduction of that bond. My client's 25 years old. It's my understanding she does not have any criminal history of any kind. She's not presently on probation or parole or anything of that sort. She is pregnant currently. And it's my understanding that she's been having some health issues while in the Washtenaw County Jail related to her pregnancy. We have some concerns that she may not be able to get the appropriate treatment for both her health and her unborn child's health. She does have employment lined up. Should she be released, she would have employment lined up at Kroger. She would be residing in Ypsilanti with her mother. I personally spoken with her mother and confirmed that. Her mother is on dialysis, and Ms. Robinson typically helps take care of her mother tremendously. So she has some family obligations that a lower bond could help her to accommodate as well. She does have a high school diploma, and she does intend to enroll in college sometime in the near future should she be released. It's my understanding, Your Honor, that this warrant was authorized sometime in February. At the time, my client's address was not the same address that was on file with the felony complaint. My clients indicated she never received notice that there was any sort of warrant. And she did come in custody. That was the first time that she learned about the warrant. It's also my understanding there'd be no issue with any sort of no contact order. My client does not have any need to see the complainant in this case. So we would ask the court to consider a bond reduction from the $2 million bond. My client doesn't have any financial means to post even close to a $2 million bond. But we would ask the court to consider a $10,000 bond. And I know that's a significant reduction.
All right, I'll hear from the people, but my understanding is factually, Ms. Robinson's accused of stabbing an individual who was pregnant, and then that individual had to be induced into labor. That's go ahead.
Those are the allegations, Judge. This was a random stabbing at a bus stop. So I have huge concerns for the community. While I sympathize with the fact that the defendant is pregnant herself, she did stab the victim multiple times, and in fact said that when the victim said, "I'm pregnant," she said, "I don't give a fuck. That's why I stabbed your bitch ass." And she was induced and almost bled out on the street. So I would not be okay with any reduction in bond in this case, Your Honor. I believe she's a threat to the community.
And Judge, if I might respond.
Yes.
Your Honor, first and foremost, we dispute those allegations, of course. I'd also indicate the discovery reveals that the complainant did not ever see a knife or any other device which was used to allegedly stab her. And for what it's worth, my client was also injured as the result of this and suffered a miscarriage shortly after the encounter with the complainant. But we dispute that there was ever any sort of stabbing, which is supported by the complainant's own statements to police that she did not ever see any sort of weapon that my client allegedly had.
she didn't see it, or the person that stabbed her didn't have it? I mean, there are differences.
It's my understanding from the discovery that the complainant said she believed she was stabbed, but never saw any weapon, could not describe the mechanism by which she was stabbed.
Okay, that's what I thought. Okay, motion for bond reduction denied. Bond will continue as set. Thank you.
Thank you, Judge.
No, you got to speak louder than that. You used to call cases. I know you can talk louder than that.
Thank you, Judge. Madeline Jennings, P 44692, appearing on behalf of Paul Stacy Smith, who is scheduled here today for purposes of docket conference.
Mr. Smith, state your name for the record.
Mr. Smith, no, this is the investigator. I want to explain this briefly.
Oh, okay, because I remember he was supposed to meet him here today. What happened?
Mr. Keith Kirby is the investigator who both times went to pick up Mr. Smith. He went there today to 2000019.
Man, then I can't understand nothing you saying.
Okay,
Okay, lean into the mic and act like you irritated with a child.
The investigator, Keith Kirby, went today again to pick up Paul Smith at 2000019 Inkster Road in Inkster, and he never answered the door. Keith Kirby then went back, called him. I called him. He never came to the door. I spoke to him on April 25th. I went over the plea again, spoke to him on April 23rd. So he was very clear about the court date. The reason that the investigator was picking him up was because he had no vehicle. So
That's all right. I'm gonna solve all his problems. Capia shall be issued remand. He won't have to worry about transportation, anything else.
thank you.
Have a good day.
Please.
Good morning, Your Honor. John, KCP number 56162 on behalf of the people.
Good morning, Your Honor. Joe DeCruz on behalf of Mr. Austin Hoybook, who was literally just in your courtroom but had to go feed the meter. But he is appearing via Zoom, Your Honor. P84445.
Sir, state your name for the record.
Austin Matthew Hoybook.
Thank you. Counsel, as to the arraignment.
Your Honor, my client wishes to waive the formal reading, stand mute on the information. And Your Honor, just as a correction for the record, it's Austin Hoybook, B-O-O-K, not Brook, B-R-O-O-K.
Well, they got, okay, because they got it in the system with an I.
I realized that this morning, Your Honor, because Mr. Casey sent me the ROA yesterday so nicely and graciously, and we couldn't find it anywhere, and now we know why.
All righty. The court will enter a plea of not guilty for the purposes of arraignment on the information. Mr. Casey, are there any offers?
Yes, Your Honor, there is an offer for Mr. Hoybook's consideration. He was 23 years old at the time of the offense. He had no other contacts or criminal history. The offer is as follows. Plead as charged to embezzlement between $20,000 and $50,000 with the following sentence agreement, a 3-year term of probation. Will consent to HIDA with the following special conditions. Restitution in the amount of $44,162.26, payable Sam's Club, Southgate, Michigan. No contact with Sam's Club, and 120 hours of community service. In addition, any terms, conditions, fines, costs, and fees as set by the court. The restitution's a key component there.
I'm sorry, that last sentence?
Oh, the restitution's a key component there.
Are you looking for any portion of it at the time of sentencing or taking the plea?
We haven't had a chance to discuss that yet. Of course, that would be a good gesture on Mr. Hoybook's part. I'm not sure what his financial situation is, if he needs a loan, home loan, family support, or what, so I don't know.
Counsel, do you want that offer to remain available until your next court date?
Your Honor, yes, and if we can respectfully ask the court for a very long court date, because Mr. Hoybuk does feel like he is going to take this offer, but we do want to put a substantial amount down toward this. So the longer we have to save, the better it is for Mr. Hoybuk.
So what's your definition of longer?
Your Honor, my definition is longer than June. I'm hoping somewhere in I don't know, Your Honor, October. Whatever the
you
court.
know how to negotiate. You sit way out there, and I'll bring it back a little. You know.
Your Honor, we leave it to the discretion of the court, as long as the court feels comfortable.
I'm gonna give him a docket conference somewhere. I'm gonna give him till the end of August. I'm not going out any further than that.
Yes, Your Honor, that should be fine. Your Honor, if I would have said December, would you have given me October just out of curiosity?
Not at all.
Okay, thank you, Your Honor.
Now, we may be in the new courthouse in August. I don't know if Zoom capacity is going to be available or not. All right, so, you know, you may have to come in, but if Zoom is available, I'll still do Zoom.
Yes.
Word on the street is November, at least for
But
us.
we moving?
Yeah. But we're supposed to be fully over. I don't know what that they mean by fully over there, but we're supposed to be 100% in the new building by November.
They told us we were being evicted in the July 1st of August. I guess we'll be zooming for those 2 months out on the street in our cars.
Yeah, in the parking lot.
All right, then what you gonna give him for a date?
August 25th, Your Honor.
August 25.
No,
All right, bring money. Now don't come back up in here with $1,000 in August.
Oh no, it won't be $1,000, Your Honor. It'll be a nice amount, hopefully.
All right, I'll see you August 25th, docket conference, 9 o'clock.
Thank you, Your Honor.
Have a good day.
You too, Your Honor.
Calls the case, People versus Daryl Smith.
Hold on.
Yeah, Mr. Ganatra for the people.
Zachary Ward on behalf of Daryl Smith. Mr. Smith, can you state your name?
Daryl Alfonso Smith.
Thank you, Your Honor. The court is likely in receipt of two things. The first being a letter from the forensic examiner saying they met with Mr. Smith and have requested some records, and they haven't received those records yet, and need that to form the basis of the competency report. And then the bond violation report, I'm sure Mr. Ganatra would like to bring up.
Yes. Go ahead, Mr. Ganatra.
Your Honor, I do have the letter from the Forensic Center, and I understand we'll just have to wait for that. There is that bond violation report, which is troubling. There's a continuing pattern. I would let the court know, and you probably are already aware from having reviewed the file, he has 5 prior OWI convictions over a 10-year period. 3 of those are OWI thirds. The blood alcohol in this case is 0.174. He presents a risk to public safety. He has for a long time, and it's troubling, this community corrections report.
And Your Honor, I would need to get into some of Mr. Smith's health information. I don't know if that's more appropriate for a breakout room. Or I can.
Is it going to matter? I mean,
Your Honor, at the last violation report, I had indicated Mr. Smith was diagnosed with Alzheimer's.
Yes.
And I think I even, one of the violation reports, I had given the court a heads up that Mr. Smith's wife had informed me about. It was possibly coming down the road. Obviously, there's been these new violations. Mr. Smith's wife has been trying to get him into services. However, it's difficult to locate any services that can treat someone with a diagnosis of Alzheimer's. Your Honor, she relays to me that Mr. Smith doesn't even realize there's a tether on his leg, Your Honor. I don't, and she indicates that these incidences are occurring when she's out of the house and he's getting out of the house. She assures me there's no alcohol in the home and Mr. Smith isn't driving at all. I just, obviously, Mr. Smith is in no position to admit or deny him as he has no recollection of him.
Your Honor, the troubling thing here is there's no command and control at that home. I mean, if she's not there 100% of the time, she cannot account for him. And if he has Alzheimer's, I'm sorry, but that's not going to prevent him from doing something reckless and possibly killing someone. And it's not, his Alzheimer's is, it's not going to be a justification for it. I mean, he's still going to hurt someone. And I'm concerned about this lack of structure for him. There's no accountability right now.
I did discuss this, and obviously I think Mr. Ganache's concerns are reasonable. Mr. Smith's wife had bought some fake keys that she was going to possibly switch out his keys for, so he couldn't get out of the house. I don't know how that would work, but I've been talking with Ms. Smith about ways we can prevent this from occurring. She did indicate, and it looks like the levels probably corroborate. One was some NyQuil that she didn't realize was in the house. But that's all the information I could provide to the court. I'm happy to assist in terms of trying to find services, but I believe there's just,
and I don't mind at some point looking at some services, but I would agree with the people, the problem here, and I would sympathize with what may be his situation and indeed his wife's situation, because sometimes that can be hard on the family also. However, we're not sure what he's doing. So between the first time, well, the second time really, the third time actually, and this time we're picking up more violations. And so despite her best efforts, it's not controlling the situation or tamping down the situation. And one of these times, and I realize you said he's not driving, but I guess the belief would be that he's not leaving the house either. Well, he's leaving the house. The belief is may not be drinking, he's drinking. And at some point, it may be a situation where he hops into the car and we've got a whole other circumstance going on here.
Your
So
Honor, can I say something?
Okay, and who are you?
I'm his wife.
Yes, ma'am.
He hasn't been driving. I have been switching the keys from the car so he cannot drive. So he has not been driving. And he does not even remember anything. He doesn't even remember why he has to go to court. He's not realizing that he has that tether on his leg. I have to even, he wants to take a bath, and I have to even remind him that he has that tether on his leg, that he can't even get in the bathtub with that tether on his leg. He doesn't even know what days it is. He asks me the days. He doesn't recognize none of our grandkids or anything like that. And basically he has not been driving. I think what's going on is that we may have a neighbor above us and he drinks. And so sometimes he could be outside drinking and gives my husband a drink. So my husband is really not driving because I have the key to the car and I'm in Ann Arbor. So he's not driving the car. So he's not a threat to anybody right now because he's not driving. And I basically tells him everything that he has to do because he's not remembering it at all. So I'm doing the best that I can to not let him drive to harm anybody. So he's not a threat to anybody.
Ma'am, and I understand that. And I am not doubting your efforts in doing what you can do regarding the situation. But I think as the people have pointed out, I've got 5, thought I counted one more, but maybe it's 5 within the past decade. And quite frankly, been fortunate so far that somebody hasn't been hurt. And I trust you that in terms of access to keys and things along those lines. But if there's even a neighbor that can get to him.
I have spoke to my neighbor and told him not to give him any more drinks, no more alcohol. And I told him that if he do, I will call the police on him for giving it to him after I have asked him not to. So Judge, what I'm asking you is, can you please just wait until you get the reports from the psychiatrist and go from there?
Ma'am, I don't mind making a decision on that, but the last hearing, the last time we came up with this violation, that's what was being asked, to wait. I was assured, and I'm not saying it wasn't in good faith, that I was assured that circumstances were under control where there wouldn't even be drinking and we wouldn't have this concern. I then come back here and now I'm here again, and that assurance that the court was given didn't come through. He's drinking, and now you may have found out where, but now this is going to depend on another person not to have him drink. And I realize you taking the car, but there are these other people around, and this is becoming a dangerous situation that I can't let just sort of do nothing on hope.
Judge?
Yes, sir.
Mr. Smith, just so the court's aware, does have other significant health concerns. I believe he has congenital heart failure going on as well. But I don't know if, obviously it seems like this is getting out of Ms. Smith's hands. I don't know if we could get adult protective services involved at this point in order to potentially.
Well, I'm not going to do that. Certainly, your office or somebody could make the call if that's the case. But what I'm going to do at this point, based upon what I've seen here, and understand that it's not just this incident. It's the previous incident waiting because of the issues that are involved, giving an opportunity to have it sort of, I won't say resolve itself, but get things in place so that it's controlled. What I'm going to do at this time is I'm going to revoke. What I'm going to do is I'm going to revoke the defendant's bond. I will be open to hear anything that will allow, certainly for the protection of Mr. Smith, but also the protection of the community. I'm going to order that in revoking his bond, that he's to report to the Washington County Jail. He's to do that by 6 p.m. I'm going to give till Monday for him to report. Instead of reporting today, I'm going to give him to the 24th to report. If he fails to report to the Washington County Jail, then a bench warrant will issue without bond. That time period, counsel also will give you time to work with his wife and others to try to structure something that might be acceptable to the people and then ultimately acceptable to the court. But that's what I'm going to do at this particular point in time. I will adjourn this matter out 2 weeks. Court calls the case, People versus Darrell Smith, excuse me.
Ally Zenda on behalf of the people.
Zachary Ward on behalf of Mr. Smith. Mr. Smith, can you unmute and state your name?
No, he is. He's here.
You gotta unmute Mr. Smith if you hit the microphone button.
He's trying to
Hold on, I
unmute.
did.
There we go.
There you go.
Okay, we got you. Okay, I've received the forensic report.
We have as well, Your Honor. I have prepared an order and sent it to Ms. Kirby, but I believe she may be wanting time to review the report. I don't know.
1 second. I would say probably we would have to review it, so probably.
Okay, so you want an adjournment of the competency hearing?
Yes, Your Honor.
Yes, Your Honor.
All right. She was doing just fine. Just Carrie, just calm down. She was thinking the process through before she gave me an answer, and I appreciate that because some attorneys don't think. I'll adjourn the competency hearing. I'll adjourn it out a few weeks to the 15th, 2023 at 9 without objection. Let the parties look at it and figure out where to head from there. Okay, bond will continue.
Thank you, Your Honor.
Thank
Okay,
you.
Thank you.
Thank you, sir.
Yeah, thank you.
Marie Rosinsky on behalf of the people.
And good afternoon, Your Honor, Andrew Meyer on behalf of Darrell Smith. Mr. Smith, if you're present, could you please unmute and then state your name?
I was just working on it. There you go.
You say your name, Mr. Smith, please?
Yes, sir.
Say Darrell Smith.
Darrell Smith.
Thank you, sir.
Okay, what are we doing? I have the report from May 11th, but I don't know if that's what we're doing today.
Your Honor, we did submit a proposed form of order based on that report in which it was opined that Mr. Smith is currently not competent and unlikely to be restorable within the statutory timeframe.
Is there any additional evidence from either side?
No, Your Honor.
No, Your Honor, we would ask that you adopt the findings in that report.
All right. Court having reviewed the report, the court would determine that the defendant is, and that being the only evidence, is incompetent to stand trial and is not likely to gain competence within the statutory period. Therefore, the defendant is deemed incompetent. I know that they're, well, I'm not going to worry about that. And I have signed the order. What are it? Is there something else that this court can do to facilitate this matter, or you just want me to leave it this way, folks?
Your Honor, I think, given what's in that report, there wouldn't be any likely benefit from any further action taken by the court or the state at this time, but that's just my opinion.
And the state's opinion is that while we have no further evidence from the court and he is not likely to regain competency, that is something that we need to make sure that can be handled within the probate court, and he should be under a treatment order. So I would ask that the court not full out dismiss right now until we can try to get something in place.
Then what I will do then, I found him not competent, but I will give an adjourned date for further proceedings to, will 30 days be enough time for you to get things in order?
Yes, Your Honor.
All right. What is that for me? July 13th, 2023, 9 a.m. Bond continued at this time.
Thank you.
Thank you.
Thank you.
You want to keep warm when you're feeling chilled, but you don't want to raise your heating bill. Blankets are okay, but they can slip and slide. And when you need to reach for something, your hands are trapped inside. Now, there's the Snuggie, the blanket that has sleeves. The Snuggie keeps you totally warm and gives you the freedom to use your hands. So now, you can work the remote or read a book in total warmth and comfort. Use your laptop without being cold, or enjoy a snack while staying snugly warm. Do what you need to and stay totally warm with the Snuggie.
Good morning, Assistant Attorney General Emmanuel Owusu Coker, on behalf of the people.
Mr. Belbisi, you want to talk to us or not? Oh, that's good.
Well, if you can't hear him, I'm glad to step in, Judge.
Can you hear him?
I cannot.
Okay.
I'll take a break from eating my apple and I'll jump in. Torshell Feaster, Assistant Public Defender, on behalf of Mr. Goebel. Attorney General, do you have any idea of what Mr. Belbisi was planning on doing today?
No, I sent them an offer via email yesterday, but I didn't receive a response, so I don't know what he intends to do.
Okay, looks like I.
Is Mr. Goebel here? Can he state his name, please?
Yes, sir. Joshua Goebel.
Thank you, Judge. I did receive a message from my colleague saying that he did receive the offer, but he has not had a chance to discuss that with Mr. Goebel. If we could adjourn this for a couple of weeks so he can relay that message to Mr. Goebel.
Is this one of the ones?
We can get it resolved.
As a peer.
All right. How much time?
2 weeks will be fine.
Pardon?
2 weeks, please, Judge.
All right. Here's going to be the problem with this, and there's going to be another case along these lines. This bond was improperly set.
Oh, okay.
The arrearage on this matter was at the time was $18,333, and his bond in this case should have been set. I mean, even if I just take it from the 18, his bond should have been about $4,500 plus, but and he was released on a PR, which is absolutely inappropriate in violation of statute. So we're going to have. Well, I don't know what you wanted to say, Mr. Goebel.
The Ms. Fink, the judge, said that unless there's probable cause of why I didn't pay, then that's the only reason she can give me the PR.
Excuse me?
She gave me the PR bond because she said that that it says under the statute that if there's probable cause of why I didn't pay, if she feels like there's probable cause, then she can give me a PR. And that's what she did.
I don't think that's the reading of the statute, but there would have to be a finding of that. And I'm not sure that the Attorney General was there to give probable cause.
Okay.
Your bond was set in that amount. The court does find that that's an abuse of discretion in setting the bond in that amount.
How much is the 25% judge that he was supposed to have paid?
The 20, based upon what's on the complaint, and it may have gone up now. To get the exact figure, I can give it to you just a second. I think it's 18. It'd be $4,583.
Okay. Okay. Okay.
So what I'm going to do, sir, and I apologize to you, but that the statute is what the statute is. And it requires that it be set at 500 or 25% of the arrearage, whichever is greater. And obviously the arrearage is greater. So your bond will be set in the amount of the $4,583. There's 25 cents, but I'm not going to worry about that. I'm just because $4,583 that has to be paid in cash, and that needs to be then applied to case number.
Your Honor, I do not have that money to pay that.
I understand, sir. I may understand that. And that might have to be dealt with otherwise, but like I said, I don't write the statutes. I just have to enforce the statutes that's written. Unless some other agreement can come up before council that they think the court would approve. But at this juncture, I'm going to set your bond at that amount. And regrettably, sir, I'm going to have to order that you turn yourself into the Washtenaw County Jail. And that you're to report to the jail by 6 p.m. this evening, or a bench warrant will issue with the bond set in that amount.
Mr. Goebel, I just put my phone number for the office into the chat. Please give us a call so we have your updated information and we can talk about the bond and potential ways to remedy the situation for you.
All right.
Okay, so call us immediately, please.
All right, I need a
And I will, despite of that regarding the bond, I will adjourn the probable cause hearing. I'll adjourn it to June 8th, 2023, 9 a.m. And my apologies, but I have to do my job.
Your Honor,
Thank you.
Judge, can I give him the number?
Pardon?
May I give him our office number? Well,
Yes.
I was sentenced to do a year for not completing my probation, and I wanted to turn myself in.
Yes, sir.
My year is completed. I should be going home today, Your Honor.
You may very well be going home today.
Yes, sir.
Depends on what happens here in the next few minutes, okay?
Yes, sir.
All right. We again call 22-39654, the state of Texas versus Marcus Dwight Cantu, who's present with his attorney, Mr. West, and the prosecutor. Earlier, the defendant pleaded guilty in this case to this state jail felony, which is punished as though it were a third-degree felony because of paragraphs 2 and 3 prior convictions. A pre-sentence report has been prepared if the parties had an opportunity to review it. And are there any corrections or changes to it?
No, Your Honor.
Vince and State?
We've reviewed it, no changes, Judge.
All right, then it will be made a part of the record for all purposes. And here the agreement is that the defendant would be sentenced to 5 years in prison. That would be suspended. He would be placed on probation for 10 years and a fine of $500 and be released today. That's our plan.
Yes, sir.
All right. Anything else to add by anybody? That's what I plan to do.
Yes, sir.
Okay. Then if nothing further from anyone, I'm going to find Mr. Cantu has pleaded guilty to paragraph 1, which is in this indictment, which is evading arrest and detention with previous convictions of evading arrest, and also pleaded true to paragraphs 2 and 3, the prior convictions of delivery of a controlled substance in 2003 and unauthorized use of a motor vehicle, a state jail in 2011. Now that makes this case a state jail felony, but because of the prior convictions, it is punished as a third-degree punishment, which is no less than 2 nor more than 10 years confinement in prison. I find that the defendant has knowingly, voluntarily, and intelligently pleaded guilty and true to all 3 paragraphs of the indictment. And State's Exhibit 1 supports his guilty plea and pleas of true to find him guilty beyond a reasonable doubt of this state jail felony, punished with third-degree felony punishment. I now find you, Mr. Cantu, guilty of this state jail felony. I am following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice prison for 5 years, a term of 5 years. However, that is suspended and you were placed on regular probation for 10 years. There is a fine of $500.
That's correct.
And there will be terms and conditions of probation, which are normal and customary. Here are the probation orders. And this court is going to sign them. You will see the probation officer who is behind you here.
So I would have to pay a court cost for this?
Yeah, and that's, everybody pays
Yes,
court
yes,
costs,
sir.
everybody.
Can they give me like, see, years ago, I used to go by the White House, and by Gateway, by Blockbuster, can they like?
You talk to him and we're gonna make it as easy as we can.
Yes, sir.
Where do you plan to live? Are you gonna,
Back at my mother address, well.
Is that on-
1380 Roberts?
1380 Roberts?
Yes, sir.
And your mom's still there and
Yes, sir.
all this, okay. What are you gonna do, like, during the day for money and to live, to
Well,
become
I
independent?
have thoughts of going back to McDonald's. I like to be
Yes,
a maintenance worker, and I used to work in an underground
Are you
basement.
good at it?
Yes, sir. And it's
Good,
very intelligent to do, make burgers. put
Yes,
the
sir.
Apple pies together and all that, and prepare the breakfast and unload.
those
these, and,
apple
well,
pies,
Those dollar
How do
apple
you-
pies,
how do you do that on those apple
you
pies?
put them in that oven, then wait for them to come out and put them in that red box that they deliver them in. Yeah, I have thoughts of going back to the main office, like over there by Mako's or somewhere close like that is, by somewhere in Old Town, by Checkers, and see if they'll give me my job back. Yeah, I'm going to do that probably tomorrow.
Here's what's so important, though. Remember, be kind to others.
Yes, sir. I
And-
always use respect. No,
No,
respect.
that's
guides me
important.
a long way.
Yes, sir. That's what they say. There's really only 3 rules.
Well, that's
We
how I
have
made it.
all these laws, and there's really only 3 rules that apply to everyone on the planet, and that is live honestly, harm no one, and give each person their due respect.
Yes, sir. That's
And
how
if
I
we
made-
all did that,
that's how I
we
made
would
these
be a
38
happy
years.
planet.
Yes, sir.
But it all boils down to those 3 things. That's all.
Yes, sir.
Even though we have all those laws fit, every one of those laws and all these books all around fit in 1, 2, or 3
Yes,
of
sir.
those. They
Yes,
all
sir.
fit in the same thing. So I like to try to simplify things that seem complex when they're really not. But here's what's important too. You're no different than anybody else, Mr. Cantu.
Yes,
You
sir.
have good days and bad days.
Yes, sir.
Sometimes things don't work out
Yes, sir.
like you hope.
I agree.
The worst thing is to get angry and spiteful and strike out on people.
Yes, sir.
Don't do that.
That ain't something I do.
Everybody every day has problems, and you're not any different from anybody.
Yes, sir.
The trick is, though, to resolve those problems peacefully. And sometimes you don't win
Yes,
in
sir.
those issues, and you don't win every issue.
Yes, sir.
Sometimes both people win, sometimes one or the other wins, but
Yes, sir.
that's life. You pick yourself up, dust yourself off, and move on and be the best you can be. And we
Amen.
all have those kinds of days.
Yes,
But
sir.
work hard, be honest with people, and be kind to people. And also, I don't know if your drug usage here, stay away from illegal drugs.
Yes, sir.
Because you don't even know what's in them
I know,
anymore.
I know,
And they'll
realize that.
And it'll make you sick, and you thought you had something, you got something, and it really was something that could possibly kill you
No,
or
yes,
make
sir.
you goofy.
Yes, sir.
So that's what you want to do is do the best you can in life, and also make your family proud of you
Yes, sir.
by your achievements.
Agree with you.
Can you do that?
Don't groom myself and shampoo my hair and stuff and get myself.
Yes, sir.
Back to a job.
Good.
Do my SS5 form.
Well, they keep me updated on the probationers. We have 5,000 people on probation at any given time. And I've told them, I want to hear good things about you.
Yes, sir.
Because I'm sticking my neck out, and
Yes, sir.
I think you're worth it.
Yes, sir. I'm doing nothing wrong.
Good.
Yes, sir.
All right, Mr. Cantu.
Yes, sir.
Thank you
Thank
very
you.
much.
Yes,
You're
God
very
bless.
welcome. You'll see the probation officer there, and you'll sign up, and then you begin probation. Thank you.
Yes, sir. Thank you, Mr.
Yes, sir.
You're
And this is the date and time set for hearing in this matter. The matter had been heard back in February. Actually, March. And at that time, well, both. And in those hearings, parenting time was first considered, and then Mr. Berwanger was granted parenting time on a specific date in March, and then alternating weekends, Friday to Sunday and Wednesday evenings. The matter was to be reviewed prior to summer parenting time to determine what that would be. I guess let's start here. Both raise your right hands. Do you both swear or affirm any testimony you give in this cause to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Yes.
All right. And sir, why don't you go first and tell me how the parenting time's been going since March?
I feel like it's been going good. I've had her every day I'm supposed to, plus extra. This Wednesday is the first day that I didn't take her just because I'm in the process of a move right now. I go to court Monday for my sentencing, and the recommendation for that is 2 years of probation. Other than that, I mean, I go in for my weekly drops. I've been off drugs, spending time with the kid, doing what I'm supposed to, trying to find a job. It's been a little tough with the record out right now, but I'm hoping when Monday comes around and my sentencing and all those charges are dropped, then we'll be able to move forward from there.
So you're not looking at any jail time then for those criminal matters you had going on?
Well, I sat 3 months already.
Oh, okay. When was that, before March then? Had you gotten?
Yes.
Okay.
Yeah, that was back in December, January, and February.
All right, so time served then you?
No, 2 years of probation as well.
Yeah. All right. So what are you hoping to have the summer parenting time look like?
I would like to go back to our original agreement, the week on, week off.
That's what you want to do for the summer? Are you, and you don't have a job right now?
No, Your Honor.
So you're home during the weeks that you'd have the child?
Yes. I am in the process of finding a job. Like I said, it's just been tough because of the open criminal record right now.
All right. All right, that sounds good, ma'am. What are your thoughts?
That's really not a good idea right now. I this last week have had multiple people attempt to get a hold of me to find where Joseph is because they don't know where he is, that he's missing. I've got the text messages, the threads. Like he said, he didn't have her on Wednesday this week because there was nowhere to take her. Not only that, at this point, like even the home that he had for her, I've had CPS agents get a hold of me twice now. In fact, the last time that we had a court date, he insinuated that CPS was contacting me over me when that was not the case. It was the household he had her in was being investigated by CPS. And I have been contacted by Melanie from CPS multiple times, had very long conversations with her about what's going on and what is and is not. Like I said, I spent the last week with multiple people contacting me to ask where Joseph was because he was quote unquote missing.
Okay, are those?
And the
people-
only time I heard from him
Hold on,
in
hold on,
between,
ma'am. Are those people gonna testify today and tell me more about?
I
this?
didn't even
Getting
bother
all this-
asking them because last time I wanted to have people testify, I was told that it's all hearsay and it doesn't matter.
It's hearsay
May
when
I?
you say it. If the person who knows the information firsthand says it, it's not hearsay.
That's what I was told last time. I told you that I was going to have multiple people come in, testify to what they've seen, heard, experienced with Joe and with Delia, and I was told those things were all hearsay and they would not be considered.
No, it's hearsay when you tell me it. It's not hearsay when.
Well,
the
then I'd be glad to have
eyewitness
these
tells me
people come
that.
in. We can
All
set
right.
up another court date.
Well, today's the day, I set aside half of the morning to take care of this.
Well, like I would be glad to do that.
Can you get a hold of the CPS? So currently CPS is looking into Mr. Burwanger's residence?
No, I did not say Mr. Burringer, the household that he is in. The household
Can I-
that
can
he
I
has had my
interject?
daughter in has been investigated by CPS. I've had 3 phone calls now to be notified that there is an ongoing investigation into the household that my daughter is in.
All right,
That's,
so what do you know about that?
excuse me?
I asked Mr. Burwanger what he knows about that.
Okay, yeah, I would glad to be. First of all, CPS follows up on anything they ever hear. So Kyle, I'm sorry, I live with 2 other boys and a girl, my girlfriend's kids. Kyle had gotten a bruise on him and they thought it was a hickey. Well, we had an incident back in August of last year where my girlfriend's daughter's father got accused of doing some things to her, so they follow up on anything that had to do with remote, with sexual anything as a follow-up and just investigate it. He had a bruise on him, they assumed it was a hickey, so they came in and investigated it. The CPS cases result in nothing. They're doing their job. That's what they're supposed to do. As far as me missing, I would ask who thought I was missing, number one, because I don't talk to anybody except my girlfriend and Sam. So.
Well, it was your girlfriend's other partner that called me. Also, your sister-in-law.
He's always trying to stir stuff up, so I could care less about him. My sister-in-law knew her. She never tried contacting me, so.
So, ma'am, or I guess one of you or both, do you want to try to contact the CPS agent who's been investigating this? See if they can hop on the Zoom here and testify?
I don't have her money
My
right
phone
her
isn't
number
here.
right
I
on hand.
can go get my phone. I have her on my contact list, so I can go get it. I don't know about whether or not she'd be able to even get on here. I guess the main thing too, though, is that the last time we had a court date, it was insinuated that CPS was contacting me over something that had to do with me. Got it written down right here. It was flat out insinuated that I was the reason that CPS was
Who
contacted.
insinuated that?
It had nothing to do with me. I was literally just notified of it. But
I don't
yeah,
know, but if they're investigating Mr. Burwanger's residence, the place where the child would be, I'd like to hear about that from them.
okay,
I agree.
if
Can't ask questions of her if she's not permitted by her office policy to testify.
Okay, can I just state that all these
Well,
CPS.
hold on. Ma'am, you're not able to testify then about this matter today?
the judge did just ask, ma'am, you're not allowed to testify about this matter today.
Yeah, unless I have a subpoena, our office policy is that we're not to interfere with friend of the court orders, or sorry, friend of the court hearings.
Wouldn't be interfering, it would just be testifying as a witness.
I can kind of hear it in the background.
I apologize. I know this is so weird. He said it wouldn't be I'm sorry, it wouldn't be interfering. It would just be testifying. Is what he said. Yes.
Yeah, I suppose if this is the, I can't tell who I'm talking to, but if this is the judge I'm talking to, if you want to, or if you'd like to order me over the phone to testify about confidential CPS matters, that's really all I need is a judge's order to do so.
All right, at this time then I would direct you, ma'am, to testify truthfully about the investigation that involves Ascadelia Monet Leanne Burwanger and your information that you've gleaned and any recommendations you're making as a result of that recommendation. Does that work?
Sure, yep, that's perfectly fine.
All right, and what's your name?
Melena Staffen, Melayna, Staffen, Staffen.
All right, and do you swear or affirm any testimony you give in this cause to be the truth, the whole truth, and nothing but the true self you got?
I do, Your Honor.
All right, thank you. And how'd you become involved in this investigation regarding that child?
I have a current CPS investigation involving another adult household member who is not specifically Mr. Joseph Burwanger.
All right, and which county are you with?
Nacosta.
All right. And so Mr. Burwanger lives at an address that you were investigating based on a complaint or an investigation of another matter?
Correct. He is not listed as an adult perpetrator, nor is Ascadelia listed as a victim in my investigation.
Okay. Do you know if Mr. Burwanger lives at that address?
I'm uncertain. I have not been able to get a hold of the adult who is listed as the perpetrator for a couple of weeks now. I think I have the wrong phone number, or maybe the phone number has changed. And the apartment complex that they used to live in or do live in, I'm unsure, is a locked apartment complex. So I can't necessarily knock on their door just because I don't have access to their door.
Okay.
Can I
And
ask a question, Judge?
hold on. What were the allegations that you're investigating?
The allegations are involving a child by the name. And there were concerns about a scrape or a mark on his neck and the origins of that marking on his neck.
Were you able to determine if that mark was a result of abuse or neglect?
Yes, I was. I actually have just submitted my report today. It is under review by my supervisor, but at this time, there has not been any abuse or neglect found in the household.
So there's no substantiation of any abuse or neglect?
Correct.
You requesting that your investigation be concluded then or closed?
That is correct.
All right. All right. Mr. Burwanger, you had a question or two for the witness?
Yeah, I just the simplest fact, you feel Delia safe and loved at her household. She's met us before. I've talked to her. She's spoken with Delia at school, so
just let her answer the question. Ma'am, I guess his question was, do you feel that Ascadelia is safe in his household at this time?
Yes, I spoke with Ms. Ascadelia at school 2, maybe 3 weeks ago, and at that time she did not disclose any concerns at either her mother or her father's household.
All right. Is there any other questions?
No, Your Honor.
Ma'am, do you have any questions for Ms. Staffen?
No, we've already talked. I've already had all that down, so.
Okay. All right. I guess you're all set then, ma'am. Thank you so much.
Yep, thank you. You guys have a great day.
Thank you so much. Have a good day, sweetie.
Yep, bye.
Bye. I just want to point out my reasoning for bringing up the CPS thing in general. I had already been told that Delia was safe. She felt safe. She felt happy. My point was the last court date that we had on this recording, I could probably go find it. It was insinuated that CPS had contacted me due to a situation or circumstances involving my household, that I was being investigated for some reason in some way, shape, or form. That is not the case.
I don't know how you.
Been.
I don't know how you gathered that. I
don't
recall
know.
saying
You brought up and
we were here talking
literally
about Mr. Burwanger's parenting time, not yours. So I don't know why that would have been relevant, but okay.
What do you mean? How is that not relevant? My point is that I was being painted to be someone that was having a CPS investigation brought upon myself
I
when
get
that's
that,
not the
I get
case.
that, but your time with the child was not the issue. It was Mr. Burwanger's time with the
No,
child.
it wasn't. That's my point, is
I
that
know.
it was painted to be that my time was what was being investigated. And that's not the case.
Okay, I know what you're referring to, and what I said in that last hearing we had was that the last time that CPS talked to all the kids, Delia raised concerns about her uncle Adam coming to the house. That was all I said. There was
I haven't
nothing
laid
about.
eyes on Adam since the day he tried to
I-
kill Apple.
I
So
understand
don't know
that,
what you want me
but
to say.
Delia stated to Melanie that she felt unsafe, not unsafe, but was worried that Adam might come back. That's all I said. There was no insinuation that there was a CPS investigation out for you.
All right, so if we've cleared up the CPS investigation now, and there are no concerns with Mr. Burwanger's household from her perspective, I guess. Why still, ma'am, would you not want the court to enter an order for week on, week off parenting time during the summer?
Because at this point, it's unsure whether or not he even has a place to stay. He doesn't have a job.
We don't have a job.
It's not about wanting to keep her from him. Or
Samantha,
keep him
do you
from
have a
her.
job?
It's
Samantha, do
about,
you have a job?
let me keep her until you get your stuff together, and then we will go back to it. I've
Do you have
never
a job,
wanted to keep your
Samantha?
daughter from you.
Ma'am, do you have a job? He asked you a question.
Right now, no, but I still have an
Okay,
income.
so why am I supposed to hold that against him if you don't have a job either? And
I also have a home. A guaranteed, steady, there's no chance of it disappearing home. I live with my father.
I'm moving.
I'm not going to get thrown out
I'm
at any
getting my
moment.
stuff together. I'm moving. I'm doing what I'm
Okay, and
supposed
I
to be
don't doubt
doing.
that, Joseph.
sir, where are you moving to?
Right now I'm at a hotel for next week until we find an apartment that opens up. But that's not an issue of, she's had to maintain stable home. I got the
You
hotels,
literally,
the hotels
Living in a
paid for.
hotel right now?
Huh? Yeah, because I had to move out yesterday. So, and I'm waiting for the apartment to open up. All the paperwork to go through. So we got the hotel for a week. Everything should be finalized at the end of the week. Stuff takes time. I mean, this is how it is. It's not like she doesn't have anywhere to go. I can travel and take her to a hotel, but for me to stay in a hotel for a few days is frowned
that's
upon.
my point. Why wouldn't you take advantage of your daughter having a steady, stable place to stay?
I'm not
You can
refuting
literally
that.
come here anytime you want. I've always maintained that you can come to this house every day to see your daughter. And you don't.
She's been stable for the last 3 months. She's had somewhere to go every day.
Really hasn't.
She has. She gets off the bus, goes to the same place every day.
So, sir,
This Wednesday was the first day that changed.
Have you lived in the same place for the last 3 months until yesterday?
Yes.
You think you'll have a place in a week?
Yes, it's all the paperwork's already been submitted. We're just waiting for the apartment to open up and everything to go through.
Where's the apartment at?
We're not exactly sure yet. So we applied for an assistance and they put us at the top of the list and they bought us the hotel room for the week. They said they'll have us set up by the end of the week. But even so, if that doesn't work out, we have a cabin and right outside of Baldwin we can go to that my girlfriend's parents offered us. So.
All right, let's reconvene in a week, next Friday at 3 o'clock. We'll see how your apartment status is. Can you both make it at that time, next Friday at 3 o'clock?
Next Friday at 3 o'clock, yes.
Ma'am, does that work for you?
Yeah.
If you want to call any witnesses, feel free to call them for that day. If they need a subpoena, you'll have to send a subpoena. You can come up here, fill it out, bring it up here, the judge will sign it, and then you serve it on the person that you want to testify if they need a subpoena. If they'll testify without a subpoena, then just tell them, give them the Zoom information, all right?
Okay.
Same Zoom number and everything, Your Honor?
Yep.
Okay.
So it'll stay the same, just the weekends and Wednesdays, until I hear more next week about this apartment.
Okay. And you said that was Friday at 3 p.m.?
Yeah, if you get the apartment, get some kind of proof, I don't know, some kind of
Okay.
statement from the landlord or whatever, to prove that you have a permanent residence, that you've signed a lease or some kind of legal document.
What
Either
if we choose
either-
to go? What if we choose to go to the cabin and stay at the cabin?
Whose cabin?
It's my girlfriend's parents' cabin. They have a couple houses and they offered us a cabin. It was a little ways out, so we weren't trying to go to that. That's
Well,
what we're holding off on.
If you're gonna have the legal right to live there for an extended period of time, then get someone on to testify about that and some kind of written document that shows that.
Okay.
All right, I'll see you guys back here next week.
Good morning, Your Honor. John, KCP number 56162 on behalf of the people.
And good morning, Bobby Silver, appearing on behalf of Mr. Haley.
Sir, state your name for the record. Thank you. As to the arraignment, counsel.
As to the arraignment, Your Honor, we would waive its formal reading and stand mute to the charges.
Court will enter a plea of not guilty for the purposes of arraignment on the information. Mr. Casey, are there any offers?
Yes, Your Honor, there's an of sorts for Mr. Haley. Mr. Haley was 18 years old at the time of the offense and is eligible for height in the sole discretion of the court. That'd be all terms and conditions to be set by the court. The people would recommend, of course, that any sentence include restitution on the receiving, concealing, stolen motor vehicle count.
All right, counsel. What is your intention?
Sure. Judge, we would like some time to have a conversation about that. But I would ask the court at this point, Mr. Haley has a tether on. And I cannot for the life of me understand why he needs to have that tether. With that tether on, he's not able to go to his high school graduation or his prom. And I certainly would not, Mr. Haley, yes.
Why can't he go to the graduation or the prom?
Because it's not at school, is what he's telling me. He has stable community ties, his whole family.
Slow down, counsel. Slow down.
Sorry.
He's not in school?
I'm sorry, Judge. He was talking to me. I'm sorry.
That's all right. Did I understand you to say he is not in school?
Well, he's not in school at this minute because he's in court.
And how long has it been since he's been to school?
No, he's been going to school, but under the terms and conditions of his tether, he's only permitted to go to be at home, at work, or at school. He's not able to participate in any other activities. I think what you heard me say is that the graduation is not at his high school. It's at a different location.
Mr. Case?
No objection to adding wherever the prom is and graduation, you know.
What
You
is
can go
the
there
charge
too.
in this matter, Mr. Case?
It is a stolen car case, fleeing and eluding, with Mr. Haley allegedly crashing at the end into a light post. The light post was did not make it, and the car was badly damaged. But that's the nature of the offense.
What are your client's plans after graduation? Did he say college?
He did, Judge, and his mother's.
What college?
I have a scholarship to.
Speak up like you on that basketball court.
Wow.
I have an academic scholarship to Eastern Michigan.
You got a scholarship?
Yes, Your Honor.
An academic scholarship.
To what university?
Eastern Michigan University.
Miss Silver. You
You
want?
have to speak up so someone can hear you.
You ought to be proud if you got it. You ought to be shouting it. Now, what college?
Eastern Michigan University.
Eastern Michigan.
Yes, Your Honor.
I will note this is it as far as his criminal contacts. There's no sign of a juvenile contact. This is it.
And you, Miss Silver, you say he got a parent or guardian present?
He does, Judge. His mother is present in the courtroom. Would you like her to step up so you can see her?
I sure would.
Come on up. She's crying, but she's on her way up. Good morning, Your Honor.
Good morning. State your name for the record.
Julia Haley.
Well, I'm sure this has all been a shock for you.
Yes, ma'am.
I'm sure you've cried many a tear.
You're crying, Your Honor.
Now you want to wipe away some tears. How about not causing them in the first place?
Yes, Your Honor.
And what high school is he graduating from?
West Side Academy.
Miss Silver, how long has he been on the tether?
Since he was released from jail back in February. And there have been no violations that we've ever been notified of. So I'm gonna guess there haven't been any.
Mom,
Yes, ma'am.
do you feel more comfortable having him on the tether since you know where he is?
Honestly, I know where he is at all times. At this point, I have his location. A tether is not necessary. And the only reason why I say that is because he still don't get a chance to do school activities. And that's the only reason why it's not really necessary. He's not as bad as a child as things can be, he made a stupid decision.
Do you think he's learned something from being on a tether for a couple months?
Yes, ma'am.
All right, I'm gonna remove the tether. When is graduation?
Graduation is, speak up.
Whisper.
Speak up.
My apologies. Graduation, I know seniors get out May 19th. Graduation is in June. It's like June 3rd.
Okay, we're gonna do a docket conference, Miss Emma.
Yes, please.
The tether's not gonna come off till Monday. The paperwork won't be
We can't hear you now, Judge.
in. You can't hear me?
We hear you, now we can.
Okay. When are we coming back, Miss Emma?
Yes, ma'am. You will be coming back June. Let me find you with that.
June what?
You will be coming back June 28th.
Now, young man, graduation should be over by then, right?
Yes, Your Honor.
You give that high school diploma to your mother, and she gonna bring it back when you come. And I'm gonna see it. I'm gonna give it to her because she might actually keep up with it. And for the stress she's been under for the last semester, she's earned it too. I'm gonna see that high school diploma, and I better not see you back in here before then. You understand me?
Yes, Your Honor. I appreciate it. Thank you.
Thank you, Judge.
All right.
Thank you, Your Honor.
Have a seat, young man. Have a seat.
Miss Silver,
Yes, ma'am.
if the matter settles out, make sure that there is language that address his being able to go to college. And you
Yes.
need to explain to him that my order is going to say he will not pledge any fraternity his first year. He gonna study.
Oh, his mother's very happy about that.
That's gonna be part of the order.
Okay, thank you, Judge.
I'm sorry, what date are we coming back on, Mr. Haley?
She said June 28th.
28th.
You have to go have a seat back there, and they're gonna give you- She's so smart. Like, she's just so practical, you know?
Right.
She just gets it all. She's never gonna be one like her.
Right.
And a hard to go over.
Yeah, on top of that.
Have a great weekend, Judge.
You too.
Colleen Smith versus William Fantasia and Perseverance. People could just have like Joe or Susan, Mary, something. I don't know why anyway, never mind.
Colleen Smith is here.
All right, Miss Smith. And I think I have Miss.
Yes.
Okay. Are the other individuals?
This is Perseverance and this is William.
Hold on. Who's
The baby.
is who?
He's Perseverance.
That's Perseverance.
Yes.
Oh, so you did that on purpose? That poor little baby. No, I'm kidding. Okay. No, that's my bad. I shouldn't have said that.
It's fine.
Okay, so how old is the baby?
He's 4 months.
Ma'am, you can't sue the baby.
My other 2 minor children are also down as well.
I'm not suing them. The court, when I filed the paperwork, the court said I had to put everybody down that was in the home, including the children. It wasn't something I wanted to do, just something that the court told me I had.
Okay, so all right. You can't sue a 4-month-old baby.
Well, I didn't want to. I don't wanna
Unless you're
sue
gonna tell me
anybody.
that the baby can read. Which I don't think so. So here's what we're gonna do. First thing we're gonna do. So William, whom?
Me.
That's you. All right. And then you're Miss. I only have 3 names on here, but did they put more names on? Oh, dear goodness. Okay.
Yeah, she had me write everything on there.
No, I understand, ma'am. I just got to clean this up because
Sorry, this is what they told me.
no, and I'll try to correct that. They shouldn't have said it to you that way. Okay, so
Yeah,
William and Fantasia, you are adults.
Yes.
You are the ones that signed the lease.
no, they never signed a lease. They just. came
Okay,
into
but you're the
home.
one. Okay, all right. You're the ones that rented the property.
They didn't.
Right.
rent the property.
We don't
We
rent.
just
We were
showed
just
up.
staying with his mom. She rents. We don't rent. His mother does. And we
Okay,
stay with
okay,
her.
hold on a moment. Okay, so, all right. In whatever this scenario is, you guys are the 2 adults.
Yes.
Okay, that's what I was trying to get at.
Yeah.
And then Perseverance is a minor,
Yes.
and is it Azalea?
Yes.
See, that one I get. That's a flower. I get that one. All right. So, all right, that's a minor also.
Yes.
And then it just says to Sean, no last name. That's a minor, I'm presuming.
Yes.
All right. So first thing I'm going to do is defendants 3, 4, and 5 are minors. and dismiss from the action. Okay. All right. Okay, so now that I got the party straight, so there's only defendants 1 and 2 that are alive. Okay. So okay, explain to me this tenancy situation. Ms. Smith,
Yes,
who are you to these individuals?
I am William's grandmother.
Okay. And you own the house?
I do own the home, yes. My daughter is currently renting. I told her I have her renting there until the kids grew up. They grew up. William moved out of the home, moved in with Fantasia. And then in December, they came back to the home. And I tried to talk to them about, because there's not enough room, not appropriate bedrooms and stuff in the home. So I tried to talk to them about some kind of agreement, and they didn't want to talk to me about it. And
That's not true. I would just like to say.
Hold
that's
on.
not true.
Okay.
if she's going to dispute everything I say, what's the point? But anyway,
Well,
I'm paying.
that's
electric.
the reason we have courts.
Okay,
Go
I'm
ahead.
paying the electric, I'm paying the gas, I am paying the trash and the removal. My daughter supposed to pay $600 a month. Sometimes she can, sometimes she can't. The other month she only paid $300. They are also moving out of the home because I want to sell the home. I am trying to get a trailer for them. And I need the home cleaned out. They've broken windows. There's a door. We went there the other day. The storm window was broken out. The door was wide open. I've had to put money in to replace pipes and drains, and had to have it rooted out. Last time.
Hold on, ma'am, hold on a second. Who's your daughter?
My daughter.
William's mother.
Angela Ritchie, and she's not on the notice. She's paying rent. And so it's just Fantasia and William that moved in and aren't paying.
But
anything.
hold on, if she. Why, hold on, please. Why is it, what's your daughter's name?
Angela Ritchie.
Okay, so they came in, she's renting the home in some way.
Correct.
William and Fantasia come into the home basically by her invitation.
Well, that's what
Right.
they said. She said.
I have text proof.
I don't know.
Hold on, just stop. Is that correct, Miss Smith?
Not to my knowledge, but they say it is. I was never told.
Well, but ma'am, how are they they just walked into the house and just sat down? I mean,
well, they said.
There's somebody renting the premises, your daughter, Miss Ritchie.
Correct.
These individuals come into the home.
Correct.
Right? So why isn't Miss Ritchie filing an action to remove them if they're not supposed to be there? Question mark.
Yeah, I have no idea. It's my home. I didn't know she had to.
Okay. Are you kicking Angela Ritchie out?
I am trying, yes. I'm not, yes. I'm trying to find a home for them.
Okay, but here's my question. Why isn't she a party to this case?
I didn't know she had to be a party to the case, sir, Your Honor. And to be honest with you, you know, what she tells me and what actually happens seems to be two different things. So I'm like in the dark. I don't know.
Your Honor, may I speak? I would
If
just
you
like to
must.
say, Colleen, I did tell Angela that I wanted you to know I was here.
We offered my mom rent.
Folks, one at a time.
I
Go-
offered to pay rent. I do not mind helping. I am not like that. She literally just did not tell you. I do not know why. But that
Okay.
is the truth.
But how come you guys didn't show up today? I want to talk to you about.
We were
Right.
trying to avoid my mother, like I told you that day, because she has been starting stuff between my family.
Then why do you even want to stay there?
We
We
don't
don't.
want to stay here, but we can't just up and move. I just
Well,
got a job. I'm
I know,
sorry.
but we've been
Folks,
dealing with this since January. Okay, I'm sorry, Your Honor, go ahead.
I would also like to add, the day we received our quick 2 notice, she entered the residence without our permission and took pictures of our minor kids without permission inside the residence.
Who?
I
My
did not
grandmother
do
did.
that.
I have
I
it
did
on
not do
camera.
that.
I have cameras inside the house.
So the grandmother took pictures of her grandchildren. What do you want me to
No,
do?
No.
my kids.
Or my partner.
It's okay. It's
Okay,
just
all right. Look, folks, I'll be honest with you. If I want, I mean, I'll deal with the case, but if I wanted to be a family court judge, that's what I would have done. Here's what you guys need to do, because I don't know who's telling who what. Obviously, what ultimately Ms. Smith is looking to do is to ultimately vacate or have you guys vacate the house so she can sell it to do whatever.
yeah.
But I don't think, as I'm listening to Ms. Smith, that she really wants to kick you guys out into the street. She's just trying to figure out how to do it. She has a belief, as I can tell by what's being said, that you guys won't talk to her, won't show up, won't do whatever. So here's what I'm going to do. I'm going to adjourn this out 2 weeks. Well, I'm going to adjourn it out 3 weeks. I'm going to adjourn it out to the 23rd, 2023 at 9 a.m. You guys have 3 weeks. You guys, everybody but Perseverance. All of you are full-grown people who in some way and or another are connected to each other. Good, bad, or indifferent, you just are. So what I'm going to suggest that you do is all of you sit down, you three, the 3 adults, bring the baby, but 3 of you sit down and talk about what you can do to work it out, even if it's just a short-term remedy to try to deal with this. Everybody understood?
Yeah.
I understand, and so you are now saying that Angela doesn't have nothing to do with this. It's up to me.
Well, okay, well, Mr. Smith, here's the problem. The problem is that obviously you rented the tenancy to Angela, your daughter.
Correct.
You rented the house in some way, however it is. I realize you own it. She's still paying rent.
Sometimes.
Okay, whatever. I don't know that because she's not a party to any of this.
Correct.
And then her son and family move in. I have to presume they moved in under what's called color of authority from your daughter. So you as the owner, if you want to evict them, she's the one, so they're almost like subleasing from her lease. So she's the one that really ought to evict them, not you. If you wanted everybody out, then you could evict everybody. Then that would include Angela. Everybody's got to go. All right. So
Okay.
that's really what should happen. And let me just tell you, Ms. Smith, we could go through this. I could here's going to be the great difficulty in this case and why I want to see if you guys work it out. You could go through this entire case. You could win. And then when it comes time to evict them, because there's somebody else in the unit and it's not, the full unit is not being restored to you, I'm not sure how that eviction is going to occur. And even if I'd sign the order, because you're not clearing the premises, there's still at least one other person that's there.
Okay, I'm trying to find a home for them. We haven't had any luck, but I'm afraid to make them get out without William and everybody else leaving because of the damage that has been done. But okay.
Okay, I don't know
23rd.
anything about the damage, Ms. Smith.
All
The
right.
only other thing that I can suggest to you, Ms. Smith, is go talk to an attorney, see how they advise you to proceed on it. Okay?
Okay.
But I think you guys are family, and so I'm gonna give you 3 weeks. You guys sit down, try to hash it out, figure out what you can do or not do, and then come back. And if you want me to make the decision, I'll make the decision. I do it all day.
Okay.
So I don't have a problem doing that. Okay?
Yes, sir. Thank you very much. I appreciate it.
23rd, 9 a.m. Thank you, folks.
Bye.
Thank you.
Bye-bye. You're welcome. Colleen Smith versus William Kennan and Fantasia Ford. This is a termination. Ms. Smith? You'll need to unmute, ma'am.
Can you hear me now?
I can hear you.
Okay, sorry.
And then I see Miss Ford on the screen.
Yeah.
And also, is that Mr. Kennan?
Yes.
Got him. Okay. All right. Last time we were here, where are we on this case now?
Go ahead.
Colleen came over and explained to us that she can't afford the house anymore. Rent is not being paid, and she is concerned that the house would not be able to pass a rental inspection. So she would like to keep going through with the eviction process so that we can get help with Hawk. I have an appointment with Hawk on the 17th. I have applied to apartments. The only issue is that I do not have any credit at the moment because I owe a lot to my credit card company. So I'm not most likely going to be approved based off my credit, but we are trying to leave, and we do have the appointment with Hawk July 17th. And that's where
Not
we're
until
at.
July. Okay. Okay, let me ask this. How much is the monthly rent on the unit on this?
I don't know. The person who's supposed to be paying the rent is Miss Smith's daughter. I don't know. I did offer to pay rent for myself and William and the children, but she declined. So I also did offer to pay for utilities because I understand, but just don't have the money to move.
I'm sorry, but I didn't hear any offer for the utilities. She did offer to pay a little bit for rent. My daughter had been paying $600 a month rent, Your Honor. When I met with Fantasia and William, I gave them a printout of expenses and what I was bringing in. I have that here.
Okay, I can't read that, but I got you.
Okay. Well, I tried to submit it to court, but they said that, you were in a different area. But anyway, the rent paid so far this year was $2,700. My expenses going out when I presented it to Fantasia and them was $4,873. It is now $5,209 because I got the water bill, which had went up over $100. Any little bit of rent that can be paid, it's just not substantial enough that, Your Honor, I can't afford this home. I'm on Social Security now. When I bought the home,
Okay. I
working.
I got it. I get it from the last time. And the The reality is that the parties aren't far apart of what needs to be done. It's just trying to figure out how we're gonna do this. That's really the
Yeah.
reality.
And I
Okay.
feel really bad, I really do. I had offered to be a babysitter so they both could get work. I haven't heard anything about that.
Um,
But I
as far
also
as
have,
William working, he's disabled. He can't work. He can't do a
Okay,
lot of.
okay, folks, listen.
he was working
Let's
at
back up a
Amazon.
second.
Yes, he was working at Amazon, but he can't count or know the difference between a quarter and a penny.
Okay, just keep talking. That's okay. I don't need to talk. You guys done?
Yeah.
Okay, good. You've got an appointment with Hawk on the 17th. You're applying to apartments to do that, to
Yeah.
try to find someplace. As I recall, what you have, how many minors?
3.
Okay. All right. So the reality is until she can get into Hawk, which can also help with relocation assistance in this. So they can help with that. They can help potentially with rent, but they may want an inspection of the premises. You don't think it'll pass. So we may be running into some difficulties there.
I want to
But
sell the
let's-
home, Your Honor. I need to sell the home. I can't afford this home any longer. I'm on Social Security. We can't afford it. I'm in debt
But Colleen, you bought Angela a trailer and you haven't offered to help us at all, and we don't have anything. That doesn't make any sense. If I
Why
pay you
should-
rent, then you can use the rent to fix the house so you can sell it.
Okay. Angela's inheritance, that was her inheritance. I did get her a trailer. So, yeah, but why am I obligated to take care of everybody, Your Honor? I'm sorry.
I'm not telling you to
I've been
take care of me. I'm telling you to take my money so my kids aren't homeless.
Okay, how much money can you give me a month?
Okay,
How
hold
much
on.
do you want
Just
me to give you?
everybody stop.
I can pay. Why are you laughing?
Everybody stop.
I'm not laughing. I'm about ready to cry.
Just stop. What letter in stop do you not understand? Thank you. Ms. Ford, if I tell you to put an amount into court escrow, how much can you put in?
I make $17.25 and my hours are 20 hours a week, roughly to 30. So I can do 600.
Okay. Of the 600, when can you pay that into court escrow?
I would be able to do that the latest by July 19th.
Okay. Well, there's where our problem's gonna be. We're gonna need something before July 19th.
Okay, because can I do the 12th? Because I get paid on Wednesday.
Okay. We don't have Hawk Ann, do we? Is she here? Okay, let me do this. Amy, I'm sure you've been hearing this. Is there any way, and I know the emergency appointments aren't there, is there any way they can get an appointment earlier than the 17th?
At this point, I have to say no, but more importantly, is there a lease? I know.
I don't think there's a lease. The situation, I mean, I think they're gonna need to be directed to relocation or some type of relocation services because the lease, to the extent that it's an oral lease, was with the daughter who is not part of this. Daughter now has a trailer. These folks are there. She needs them out because she's gonna sell the house. They have nowhere to go.
You know, yeah, that was
So-
essentially the whole thing, and the requirements of the program require a lease, even if it's a written lease that they come up with to scramble something together. Again, her amount is above the threshold, and you're still aware of, I mean, we're still dealing with that delay of funding. Is this in any way a 4810? Yeah.
I have, no, it's a 48106.
Oh, 48106. So July 1st, the Ann Arbor Housing Commission will.
I'm sorry, no, it's a 48160. It's a Milan address. It's not in Ann Arbor.
Okay.
Yeah. Okay, let's do this, folks. They don't have appointments before the 17th, so it can't get moved up. So the only thing we're gonna do, or that we're gonna be able to do at this point is I'm gonna order that the defendant pay $600 to court escrow. Now I'm gonna have her pay it to court escrow rather than you because I want to make sure that it gets paid. And then I'll turn that around at the next hearing and ship that out to you, Ms. Smith, in order that the court pay it to you so that, but I can then keep track of what's paid. I will adjourn this. My next date after that's the 21st.
May I say something, Your Honor? They were
I
referring
haven't
to,
been able to stop you, so go ahead.
I'm sorry. She was referring to a lease, and I do actually have a rental agreement.
Okay,
that William signed.
But is
When
it with whom? You
When
have a
they-
blank rental agreement.
a rental agreement that I had made out, yes, when my daughter moved back into the home. And it did state that only listed on the agreement should be living there or could be.
But your daughter's not there.
She's there, she's still there because they're in the process of moving. She hasn't moved yet. They have to put a shower into the home because she's handicapped and can't get into a tub. But she has the home. I have the purchase agreement here too, but I just thought maybe this rental agreement that William signed when they moved back in might help whatever the other lady was talking about to help them out. I didn't know if it was.
Okay, but that rental agreement is between you and your daughter. Is that right?
William signed it also.
Okay, so
was a kid when he
William's on the
signed it.
rental agreement?
Yes. Him, his brother, my daughter.
I was
and-
13 when I signed it.
I'm sorry, what?
Okay, look, here's the way we're gonna do this. Miss Ford, I'm looking at you and probably William too. You guys don't have a copy of whatever agreement she's talking about, do you?
No.
All right, so I'm going to adjourn this to July 21st. You're to pay the 600 by the 12th. You have the Hawk appointment on the 17th,
Yep.
21st at what time?
So the copy of the agreement won't help them if I can give them a copy of.
Well, hold on a moment, please, please.
Sorry.
What time? July 21st, 2023 at 10 a.m. Okay? Ms. Smith, I need you to provide a copy of that lease agreement or rental agreement to the court, as well as a copy to the defendants, to Ms. Ford and Mr. Kennett.
Sure. No
Okay?
problem. I have it here.
Get
with
that
me.
copy of that agreement to them prior to the 17th.
I will do it today. Thank you.
We'll see everybody on the 21st. Thank you, folks.
Your Honor,
Thank you,
how do
Your
you
Honor.
submit money to the escrow?
Okay, you'll have to come to the courthouse. So you can come to the courthouse. You're probably, well, you could, 6 of one, half a dozen of another for you because you're down in the Milan area. So you can do it at the Saline Court,
Okay.
14A4, or you can do it at the Service Center Court that I sit at, which is the one by the Sheriff's Department.
Okay.
It'd need to be $600. It needs to be cash. And I've written it in the file, so there should be no problem with them taking the money from you. Okay?
Okay. Thank you.
All right. Thank you.
Can I just ask one
Yeah.
more question, please?
Yes.
The home needs quite a bit of repair, and I was wondering, can I go ahead and start repairing some of the stuff? After
As
my
long as it doesn't interfere with their tenancy.
Okay.
So hopefully you guys can work that out so that repairs can be done.
Okay, thank you, sir.
All right. Thank you. Are they ready on the camera? They are.
There's documentation.
Hey everyone. Guess who's back? Not Slim Shady. It's Grandma. Grandma's back again. And I will say that I was wrong. I should not have called her a Karen. She's not a Karen. I think I was applying that definition very loosely. I have learned a lot over the past month or two, and I thank you all for teaching it to me. Those of you who did it nicely, those of you who didn't, whatever.
Question mark.
Yeah, I have no idea. It's my home. I didn't know she had to.
So now we're back, and this will be our third hearing, and Grandma's got a lawyer.
Colleen Smith versus William Kennan. And Fantasia Ford.
Judge Dominic Hampton appearing on behalf of the plaintiff on this case. Judge, I was retained about 2 days ago, maybe 3 days ago. I did send in my appearance, but I don't believe it's probably made it into the court's file yet.
We don't have it. No. Okay.
We did send it out the first day, Judge.
Pardon?
I did mail it out the first day of the day I was retained. So.
Okay, that's fine. Kennan and Ford, are they here?
Yeah. I'm here.
Okay, there they are. Okay. Did you have your meeting with Hawk?
They never called me. I had the appointment set up. They never called me. So at this point, I don't know. I'm gonna have to call them back again.
Amy? She's here, but
I'm here, Your Honor. Good morning. Yeah, I see that she did have a 17th. On the 17th, she was supposed to have Angela call. But I have nothing else further than that. Yeah. I'm not sure what happened.
will they try to reset a call for her?
Of course. Of course.
Okay. All right. We'll try to get that part taken care of.
Thank you.
Mr. Hamden, what does your client want to do in this case? This is a termination.
This is the termination of tenancy case. It's been adjourned, Judge, several times. I did talk to my client, and I do apologize, but I don't think I've got a proper understanding on why this has been adjourned out. And I'm not faulting, Your Honor. I'm not understanding the reasons for the adjournments. It was a termination of tenancy, not a non-payment of rent. There was a notice to quit that was filed. And then there was the summons and complaint has been filed. I'm curious as to the reasonings.
I think because there was, if I'm recalling this one correctly, there's an intervening tenancy in this, which is a bit difficult for the court to even figure out because I think it was something with the daughter.
Yep. Everything comes back to the daughter or the mother, depending on which side you're looking at. So let's jump back to the very first hearing so we can get a summary of how this shit show all started.
Okay, explain to me this tenancy situation. Ms. Smith,
Yes,
who are you to these individuals?
I am William's grandmother.
Okay. And you own the house?
I do own the home, yes. My daughter is currently renting. I told her I have her renting there until the kids grew up. They grew up. William moved out of the home, moved in with Fantasia. And then in December, they came back to the home. My daughter supposed to pay $600 a month. Sometimes she can, sometimes she can't. The other month she only paid $300.
Ma'am, hold on a second. Who's your daughter?
My daughter
William's mother.
is Angela Ritchie, and she's not on the notice. She's paying rent. And so it's just Fantasia and William that moved in and aren't paying.
But
anything.
hold on.
Why?
Hold on, please. Why is it, what's your daughter's name?
Angela Ritchie.
Okay. So they came in, she's renting the home in some way.
Correct.
William and Fantasia come into the home basically by her invitation.
Well, that's what
Right.
they said. She said.
I have text proof.
I don't
So
know.
hold on, just stop.
So from that little snippet right there, it seems like mom told the kids they could stay there, but told the grandma she didn't tell the kids they could stay there. If they're both telling the truth.
Is that correct, Miss Smith?
Not to my knowledge, but they say it is. I was never told.
Well, but ma'am, how are they they just walked into the house and just sat down? I mean,
Well, they said.
there's somebody renting the premises, your daughter, Miss Ritchie.
Correct.
These individuals come into the home,
Correct.
right? So why isn't Miss Ritchie filing an action to remove them if they're not supposed to be there? Question mark.
Yeah, I have no idea. It's my home. I didn't know she had to.
So the issue I had with this previously, and the reason I use the term Karen incorrectly, is because grandma wanted the kids out, but not mom. And she kept giving reasons why she needed, basically she gave reasons why she needed the property empty, which is totally understandable. You need the property empty to sell it and everything else. But she wasn't trying to empty the property. She was just trying to empty the property of the kids, not the mom. So she wasn't really giving reasons to support her intentions. And this caused so much confusion in the court because she's trying to do something, but the situation is kind of counter to what she's trying to do. You want the property empty, but you still have someone living there, and everybody was kind of talking in circles so much. This is back to the first hearing again.
Okay. Are you kicking Angela Ritchie out?
I am trying, yes. I'm not, yes. I'm trying to find a home for them.
Okay, but here's my question. Why isn't she a party to this case?
I didn't know if she had to be a party to the case, sir, Your Honor.
So Angela Ritchie, Judge, I was slightly, I don't want to use the word suspicious because it sounds so bad in the courtroom. I was thinking that was what was the issue. my client's daughter lived on the property, and I was suspicious that maybe the other occupants were indicating that maybe they had the consent from her in order to stay in the property. But that individual judge no longer lives there. She moved out a few days ago. And so.
Okay, so a few
leaving the
days
property-
ago, because, but
Go ahead, Your Honor.
They
please.
also took the
but
doorknob.
before she
I'm not
was
gonna interrupt- I'm
here.
not gonna interrupt the judge. I apologize, Judge. Go ahead. I'm not
But
gonna-
before she was in the property. And that was part of the issue, as I'm recalling.
Yeah.
If you wanted everybody out, then you could evict everybody. Then that would include Angela. Everybody's got to go. All right. So
Okay.
that's really what should happen. And let me just tell you, Ms. Smith, we could go through this. Here's going to be the great difficulty in this case and why I want to see if you guys work it out. You could go through this entire case. You could win. And then when it comes time to evict them, because there's somebody else in the unit and it's not, the full unit is not being restored to you, I'm not sure how that eviction is going to occur. And even if I'd sign the order, because you're not clearing the premises, there's still at least one other person that's there.
So now that mom, Angela, is gone, there's a direct link between grandma and the kids. There are people in her property that she does not want there, and she can directly evict them through the eviction process because they're there without her permission, but she does have to go through that process.
And I thought maybe that was what the concern was, Judge, but she is not there any longer.
I want to
But
sell the
let's-
home, Your Honor. I need to sell the home. I can't afford this home any longer. I'm on Social Security. We can't afford it. I'm in debt.
One of the main reasons she wanted everybody out was to start making repairs. And at the end of the last hearing, she asked if it was okay, and we're talking about grandma, if she could go ahead and start making repairs while the kids were there because she was not able to afford the home. She wasn't going to take the money from the kids because it wouldn't even make a difference in the overall scheme of things. So instead, the kids were putting the money into court escrow by Judge Simpson's order because grandma declined it. And so she's supposed to have started making the repairs.
Okay, so daughter moved out 2 days ago. All right, Ms. Ford, what were you gonna say?
The house is, like I said before, unlivable. There's holes in the walls everywhere. The piping does not work. There's a lot of issues with this house. And they've also taken the doorknobs since moving out. I don't really understand that, but that's just about it. There's been no repairs on the house, no
Who
nothing.
took the doorknobs?
Miss Ritchie.
That would have been anybody, Judge. That would have been the other tenant who was staying there. But I'm not 100% sure how there being occupancy problems would create their ability to stay there in perpetuity.
No, I get it. This is just a mess. Probably belongs in family court. Ms. Ford,
Yes.
I think you and William were also trying to look for a place, correct?
Yeah.
Okay. How's that going?
It's not going very well. I have credit issues. He's trying to find employment. He has a criminal record, so that's taking a bit of time. And issues with his education.
Okay, I know you're gonna ask. You know I looked it up anyways. He's got an ongoing DV case. No idea who it's related to, but he's been in Judge Freshour's court, which usually doesn't stream, and he actually has a hearing on Monday, the 24th. I think it's 24th. Maybe it's 26th. I don't know, one day this week.
We don't have any
Okay.
help. The only
All right.
thing we're counting on is Hawk.
Okay, I know a bunch of you right now are typing "don't have babies" on your keyboard in the comments, which is totally fine. You can do that. let's look at it from, okay, it happened. Now what do we do? Like, we can't rewind time and shove the thing back up in there, you know? So where are we going to go from here? You got to do something to get them help. Otherwise, you have 2 adults and 3 children that are living on the streets, which doesn't do anything. So that is what grandma was basically trying to do, was put them on the streets, which is why I was saying this isn't right. You know, this isn't something we can rewind time and fix because we don't agree with the decisions they made. We have to find a solution going forward, which is let's get them some help. Let's, you know, let them stay for X amount of time to save up money for a down payment, for an apartment, or whatever it is that they need to do in order to get out of her house so she can sell it and move on with their lives. Because obviously that relationship is broken and doesn't look like it's going to be repaired anytime soon. So hopefully Hawk is able to help them, because, you know, you don't want a baby out on the streets in Michigan. Ew.
Amy, how soon can that appointment be rescheduled to see what might be out there for these folks?
Your Honor, I just reached out to the scheduling team, so she'll be updated. She'll be contacted actually once they've sorted out what happened. I apologize if that had happened.
Thank you.
Okay.
So,
All right.
I can make an overture, Judge, that may be able to maybe get this wrapped up. And I know that the normal time frame to remove is 10 days. My client is willing to extend that to 30 days to give them an entire month in order to find another location to reside. And that should give them an opportunity to meet with Hawk to look at relocation. What my client's largest concern is probably rescheduling this for another hearing and trying to do this on another occasion. And so she is willing to make that overture to give them an additional 20 days.
Well, that's fine, but it's hard for them to do that because, I mean, I guess they could accept that if they wanted to, but it's hard to do that when they're not sure what the options are, which was one of the things that was supposed to happen from Hawk. So
the issue I see though, Judge, is the fact that they're finding a location to go to through the Hawk doesn't impede my client's ability in order to occupy the premises. And my client is sympathetic and she's attempting to make an overture.
Whoa. Counsel, be real careful, because I think that this case was brought and not everybody that should have been included in this was included in this. And I am also not sure that, at least as of 2 days ago, when the other person moved out, that this would have been the person to initiate these eviction actions against these 2 individuals. So if we want to go the strict legal route, we can do it. But I think you better be careful what ground you think you're standing on.
I understand the court's position. I guess my concern, Your Honor, is this has been going on now for what appears to be approximately 3 months. And as I've indicated to the court a few days ago, I'm getting up to speed with regard to the legal minutia as well as the factual minutia. But this has been pending now for a while, and my client, I believe, is the owner of the property and is making an overture to hopefully appease both the occupants and allow them to find time in order to relocate beyond what I think the legal requirement is, which is 10 days. And so they're attempting to make an overture, Judge, in order to get this resolved.
Going to require an answer. I'm going to set this over to the 28th. Amy, can we get them an appointment before next Friday so they can see what their options are?
I'm not
Because
sure.
I think they've got 3 kids that they gotta.
I
Am
understand.
I right, Ms. Ford?
Yeah.
So they're a family facing eviction.
And Judge, just a quick note before the courts looks at its docket. On the 28th, I have to be in federal court in the morning, so I will not be available that day.
Then I gotta go to August 4th.
Judge, August 4th, and I apologize, Judge, but on August 4th, I will be on my anniversary with my wife. And
Do you still like you? No, I'm kidding.
I don't know.
No, you don't have to answer that.
It's been 21 years and I've not gotten any paperwork in the mail or any phone calls from any of the lawyers, so I'm presuming.
Okay, all right.
I was really worried the lawyer stepped in it big time and wasn't gonna get out, but he did. He redeemed himself very well. I like him. He's good.
Here's my problem. If you're not available the 28th and the 4th, I'm not available on the 11th because that's our jury selection. And 1 week out of the month, we don't do landlord tenant. And so that would put it on the 18th. Quite frankly, although there are scheduling issues, that might be the best option because then whatever can be explored through Hawk in terms of relocation for the family can at least happen. They can have a time frame. It may then even fit within or relatively close to your time frame of the overture that you made. So that, for whatever reason, might be our best bet. I'm going to adjourn this to August 18th. What time do we have? 2023, 9 a.m. They'll get that appointment from Hawk. I've noted in the file that the daughter's moved. And let's see what we can get done. I think the defendants are well aware they have to move. It's just trying to find options to try and do it. That's where we are on this. So,
Judge,
all right.
I believe I interrupted the liaison, and I do apologize to her if I did. Did she say that appointment had been scheduled?
Oh, I'm currently talking with the scheduling team to get her rescheduled back on. And it seems like it will be less, not so much for rental assistance, but for family shelter assistance.
Correct.
Okay.
Correct.
All right. Just want to clarify that. Thank you.
All right.
She'll be
Okay.
contacted though for that.
So, and we can certainly get something hopefully within that time frame now that we've set this out, right?
Yeah.
Okay. All right.
Thank you.
Thank you, folks.
As far as grandma goes, if she would have brought this action just now for the first time, I think we would have been on board. I would have been on board 100%. Like, yeah, you can't do that. You know, it's the fact that she was trying to do it before she kicked mom out that really bothered me. Like, let them pay the extra to make up for them staying there. And yeah. But, you know, it is what it is. And it's probably going to move on at this point to where they're out, they're getting the help they need. Grandma has her property back. She can move on with her life and everybody's happy. And I will try to never use the term Karen again because I don't like it. YouTube loves it. It also loves trash and a couple other words. So I'm trying to use that. Dumpster. It really likes dumpster too. I'm going to try and use some other words. If you don't have any words, let me know. Because I'm not real good with those words. All my words have 4 letters, so and we're trying not to use those 4-letter words. We're being good. So anyways, I'm sorry for everybody who doesn't like my voice and doesn't like my face. And oh my God, I got a glare in my glasses because I had to move my desk because I'm trying to move my house, but I got to find a house to move into. And so I'm trying to do as much live stuff as I can, but it's very hard when my schedule is all over the place and I'm having flare-ups nonstop because it's stressful as hell trying to do all this, but I will do it as much as I can. And when I can't, then you get to look at my avatar. Yippee! And you always get to look at the pups. So, hey, what can you do? Have a wonderful afternoon. And I will see you soon.
Colleen Smith versus William Kennan.
Good morning, Judge. Dominic Hamden appearing on behalf of the plaintiff. My client, Judge, is here in the Zoom room as well.
All right, and it's Kennan Ford.
Yep.
Okay, you guys are here. Okay, where are we now on this case, folks?
Judge, the last time we were in court, Your Honor wanted to set this matter over, I think, for 1 or 2 weeks, to give them an opportunity to meet with somebody in order to see if they could make moving arrangements. I wasn't available, so the court set it over for a month to today's date. And I do not know if there's been any progress made regarding the defendants finding alternative housing.
Folks, where are you?
When we spoke to Hawk, they told us that there was nothing that they could do until we were actually fully homeless. Because we stay here, we technically do not qualify as homeless. At least that's what the worker told me, and she said that she didn't even understand why I was given the appointment to begin with. So at this point, there's nothing that we can do. We have nowhere to go. So
Let me ask you this, folks. How long will it take you to get yourselves moved out of there? I realize you've been there for a while, but
well, at this point, we're gonna try to go to separate places. So a month. I'll take my 2 children, we don't share, and he's gonna take our baby and go to a different place for the time being.
Judge, if you could unmute my client, I'll just ask her whether or not she's agreeable to possession within 30 days or 30 days.
Unmuted. Yes,
Ma'am?
fine.
Okay. My client's indicated, Judge, that she's fine with that.
all right. What I will do then is I'm going to grant judgment finding after hearing, finding no tribal issue. I'm going to grant a judgment for possession to the plaintiff. Writ will issue 30 days out. All right.
Thank you, Your Honor.
Would there be something?
Thank you. Good luck, guys.
Thank you, Judge. Ms. Smith, I will call you probably early this morning because I will be on the road, or early this afternoon because I'll be on the road. Okay?
Thank you.
All right, Judge, have a good day
Thank you,
and
Judge.
have a good weekend.
Thank
Thank
you.
you.
Recalling State of Michigan versus Sean Rifke.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
Mr. Ripke, we mailed you the recommendation by email. It's for a 1-year sentence in jail. Are you prepared?
Mr. Ripke, can you unmute yourself and state your name?
Sean Ripke. But I was
We're
told
here
to
today.
ask the judge when I came in why Mr. Brown was still on my caseload for my defense counsel.
I just emailed you the recommendation, that's all.
Right. So I was wondering why he was
So,
talking about
sir,
my
you have a
case.
copy of the Sir, you have a copy of the recommendation?
I have not received a copy of the recommendation from the prosecution.
You received it from Mr. Brown, is that correct?
I have not received a copy of the recommendation from the prosecutor.
I'm not asking you if you received it from the prosecutor. I'm asking, and the prosecutor didn't make the recommendation. Probation did and gave it to Mr. Brown, who is your standby attorney. Did you receive the copy of the recommendation?
I have not received anything from probation.
Did you, sir, we have a copy of the email that was sent to you. Is your email address at ripkejsean@gmail.com?
You would have to check with whatever I have I haven't given probation my address.
So the recommendation is 365 days in jail, credit
I
for
would
6 days served.
I wouldn't talk to anybody but the issuing service. If it's probation, I would need to talk to probation directly.
Ms. Elder, did you speak with Mr. Ripke?
I don't believe I did, Your Honor.
Can you put him into a breakout room with Ms. Elder? If you can give him the recommendation, please.
Okay.
Back on the record in State of Michigan versus Sean Ripke.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
Mr. Ripke, can you state your name again?
John Ripke.
Okay. And we are here today for
we discussed how she hasn't provided me with any pre-observation report, any pre-conclusion report, and I haven't seen anything in writing. And she said that she had given those things to Mr. Brown, but he hasn't shared them with me. And I also haven't sent probation anything or contacted them at all in any way.
So, Mr. Ripke, I'm a little bit confused because the last time we were here and there was a probationary recommendation and you had counsel or you allowed counsel to help you, you indicated that you wanted to have.
No, I didn't. It's
Mr.
on the
Ripke,
record. It's on the record
speaking.
too,
Mr. Ripke, remember when I'm speaking, you're not. You indicated that you wanted to be sentenced to a year in jail. You have sent multiple emails and to multiple people in the county indicating that you want a year in jail, and that is probation's recommendation.
That's absolutely not true. That's absolutely not true. And I would love for you to put those emails on the record, because that is not what I said. Now I did say that
we can't hear you, Mr. Ripke. Can you speak up?
Services, but I did not say I'd like a year in jail. Frankly, I'd like the 9 days I've served time credit due for the full sentence with the $125 fine and maybe some.
Well, that's not going to happen, Mr. Ripke. That's not going to happen, Mr. Ripke.
Okay, and that is because we've made a sentencing agreement.
No, I'm not making an agreement with anyone.
Well,
I'm telling you, that's not going to happen.
I haven't seen a written plea agreement either, though that was my understanding.
There wasn't a written plea agreement. We did it orally in court, in person at the 14A4 District Court. You were there.
No, we didn't. No, we didn't.
Yes, we did, Mr. Ripke.
I agreed to.
It was on August 9th,
I would have made sure that the
2020.
sentencing agreement was attached to the plea agreement.
Mr. Ripke, it was on August 9th, 2022 at the 14A4 District Court.
Well,
you were then sentenced.
You're
sentenced, Mr. Ripke, let me finish. You were then ordered to report for sentencing, and a pre-sentence investigation was ordered, and you disappeared, and we had to issue a bench warrant. And then we've been adjourning this out over and over again for one issue or another.
Yeah, this is really dragging on my life. You know, for the recommendation of $125 in fines and costs, that seems very dismal to reflect 365 days. You know, servitude to the state.
Mr. Ripke, are you ready to proceed to sentencing?
I don't think it's appropriate to move to sentencing. I think that I think that there's been third-party intervention on my case file, and I sent it to my attorney. I sent the proof on a postcard to my attorney. I think that JavaScript.
I'm not sure what you're referring to, Mr. Ripke.
Mr. Brown, is he there? My standby counsel?
He is.
Yes, Mr. Brown, those emails that I sent you of the postcards of the JavaScript of the third-party intervener, the litigation informed these postcards that I sent you, could you please present those to the judge?
Mr. Brown, I'm not sure what he's referring to.
Neither am I.
Your Honor, if I may.
Yes.
I believe that was the email that was sent this morning that I forwarded on to Mrs. Strowski. It was sent to, let me see, I believe it was sent to the prosecutor as well as it was sent to the 14A3 District Court, Mr. Brown, Karen Barner, the prosecutor, Laura Yagi, Mrs. Strowski, and APA Willenbring. And it was sent today at 12:24 p.m.
That's correct.
What is it?
Well, it outlines third-party intervention on my case file on your guys' behalf.
I'm sorry, Mr. Ripke, I don't understand what that is and what that has to do with whether we're proceeding to
The
sentencing.
JavaScript sheet, there's, hold on just one moment here, my phone's operating. One moment. Yeah. All right, so this is a request for inspection. Well, that's the.
Lindsay, can I have
There it
Celine
is.
dates?
It says defending litigator self-represented Sean Ripke, born July 17, 1995, address 3016 Grant Lane, Midland, Michigan, and online at ripkj.sean@gmail.com submits this letter to request a status conference regarding the above reference case. Based on conversations with the prosecuting counsel, plaintiff understands that defendant Sean Ripke believes the status conference would be helpful as shared in raising concerns regarding the Faretta rights and ex parte communication. As well believe these cards recorded are information exchanged by the mode of WebSocket and are bidirectional, meaning the server pushed information to the client, which does not allow direct HTTP. This is evident by the anonymous invoke filters and the absent handle method adapter method assessor for internal reflection of the
So,
objects
Mr.
broken are my
Ripke,
file.
I'm not, Mr. Ripke,
Hence the
Mr.
no pointer
Ripke,
that's being made an obvious
Mr.
issue.
Ripke,
Your local administrative order.
Mr. Ripke, you're muted. Mr. Ripke, you don't need to read, I don't know what that is, or I don't understand what you were trying to read into the record, but we're not going to do that right now. You'll need to unmute yourself in order for us to hear you. Mr. Ripke, we need to proceed to sentencing.
I've provided the proof that that my case log has been intervened by a third party.
I don't know what that means, Mr. Ripke. Mr. Ripke, I don't know what that means.
That's not necessary. It's not my fault.
Mr. Ripke,
What
I'm going to do, Mr. Ripke, I'm going to adjourn your sentencing date. I'll give you two options. You're going to have to show up in person.
I just need a little bit more time to hire a lawyer. I'm almost there.
Mr. Ripke, we've been down that road. It's been 2 years now.
No. I just went out and
Mr. Ripke.
the trees are
Mr.
coming to the
Ripke,
ground.
it's my turn to talk. Mr. Ripke, it's my turn to talk. I'm going to adjourn this to June 22nd, 2023 at 8:30 a.m. That is going to be at the 14A4 District Court in Saline. That is going to be an in-person hearing.
All right, I'll bring my own defense attorney. You'll see me there represented.
I'm going to set that for sentencing. I'm sorry. What time do we start that day? Is that 9? I apologize. That's actually going to be at 9 a.m. That will be at the 14A4 District Court in Saline.
Okay, I'll prepare my motion.
You currently have a warrant out for your arrest, Mr. Ripke, for failing to appear to your drug test. No, I'd like you to actually do something you're supposed to do on bond.
Well, I'm
like report for your drug testing.
You bugged me out. You're failing to prosecute me.
And we are adjourned. Thank you, everyone.
All right, we are back on the record in 2023 CR 33, State of Kansas versus Celtic Storm Waddell. Jared Regier appearing for the state, defendant here in person, and pro se. Now, why were you late, Mr. Waddell?
Well, last time that I did show up on time, but
No, we're not talking about last time.
okay. Well,
Why were you
I
late
just had,
today? You've got a warrant out for your arrest because you failed to appear this morning. Yeah, why didn't you call, or why didn't you answer when I called your name? Why weren't you here?
I thought it would be okay to log in a little late because the last time I didn't get called until like 1:30 in the afternoon. So it was just a grave misunderstanding. I sincerely apologize. If I would have known, had a better understanding of that, I would have been here at 9. I apologize. I genuinely apologize.
Your bond set at 6,000 cash or surety?
What does that mean?
That means when you're surrendered to the sheriff, you stay in jail unless you give a bondsman whatever he needs to support a $6,000 bond.
Okay. So you're saying I have to go back to jail?
Well, that's generally what happens when you don't come to court when you're supposed to. Mr.
I thought it was a.
Okay, hang on. Mr. Regier, do you have any objection to me setting aside the warrant this once?
Your Honor, respectfully, I think I'll defer to the court on that one. It looks like this is the third hearing we've had in this matter. And it looks like the defendant did appear on those previous bonds, but I don't think I'm in a position to take a position one way or the other, and I'll defer to the court on that one.
All right, Mr. Waddell. Am I pronouncing it right? Is it Waddell?
Yes, it's Waddell.
Waddell.
Waddell, yeah.
Okay. Do you understand now that when they say 9 o'clock, they mean 9 o'clock when they tell you to appear?
I do. I do.
Okay.
I
Even
very
if it's
much
a
do.
docket, even if it's a docket. Okay. I will set aside the bond forfeiture, so your bondsman and you won't lose your money for the first bond.
Thank you.
You're welcome.
Okay.
And I will set aside the bench warrant, so you won't have to post a new bond of 6,000. Okay,
Thank you.
you're welcome. Now, what are we gonna do about this possession of marijuana and possession of drug paraphernalia? Are you gonna apply for, well, you told me, okay. You told me you were gonna apply for diversion, I think twice now. You haven't done that yet, have you?
No, the first time it was just to set the court date for this time. And then the last, I work nights, and like I said, I didn't get called till 1:30 in the afternoon. So I was very tired. I had a very big misunderstanding of how that whole process worked. Now I called on Friday. I genuinely understand how it all works. And so like, I am going to genuinely apply. She told me to call tomorrow since I do work nights. She didn't want me to call right after this. So she told me to call tomorrow. And I'm getting that all taken care of.
Okay. So what you're doing is asking me to set this over because you want to apply for diversion, which is what you told me in March and you didn't do.
I didn't know that I only had 10 days and a lot of things happened, and I just had a deep misunderstanding of everything.
I'm going to give you another chance, but let's not have any more misunderstandings.
They're on, I'll get it taken care of and you won't see it again.
All right, August 14th, 9 a.m. You have to be back here unless you and Miss Cool get that diversion worked out and she tells you otherwise. There is a
Okay.
good chance that you could
I
get
very
that
much,
worked out and not have to see me again. And I don't think you
she
really
she
enjoy
told that
seeing me.
she told me that she didn't have a problem with it.
All right.
On
Okay, so what time, when's your next court date?
August 14th at 9 a.m.
Okay. What are you gonna do when we're through here?
I will probably go to bed, but I will be going to call her tomorrow, like she asked me to.
Good answer. Okay, anything else, Mr. Regier?
Your Honor, I do have a note in the file. It would appear that the defendant did call the diversion coordinator last Friday on the 19th. Looks like a drug and alcohol evaluation will be necessary in this particular case. So I would respectfully suggest it would behoove everyone involved to get the ball rolling on that as soon as possible. I do find it somewhat troubling that the defendant apparently had suggested he didn't realize he was to contact the diversion coordinator about diversion, but but all other things being equal, I suppose if the court is prepared to set it over to the August 14th date, the state has no objections.
Yeah, I have some questions about some of these things too, but you go ahead and I'll give you this redo, but it's probably the last redo you'll ever get in court.
And Your Honor, if and in the event that the proper hurdles are not jumped through by the next hearing date, I will be looking at this matter much more closely.
And do not do drugs. Okay. You may go, sir.
Thank you.
You're welcome. Okay, now, I've had to.
I don't know how this stuff work. I'm new to this, so I'm 50.
Okay, well,
I'll be 50.
sir, hold on now. Are you okay? Okay. Just okay. All right, this is case number. Give me 1 second, I'm sorry. All right, this is case number 02-5619901. The people of the state of Michigan versus Carnell McCrary. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for pre-trial conference. Appearances, please, Ms. Ritter.
For the record, Your Honor, Christina Ritter on behalf of the people.
And Mr. McCrary, your name?
Ernell Michael McCreary, ill, all lowercase, not the all caps corporation.
Nobody writes the name in all caps. All right. So today is the date set for a pretrial conference. And Mr. McCrary, I understand that you are representing yourself. So how do you wish to proceed, sir?
First and foremost, if I may address the court and ask the court a few questions, with all due respect, may I speak?
I don't answer questions to counsel. I don't answer questions. That's not my role.
Well, I just wanted to say, you know, when I first came onto the Zoom, I felt that this court was disrespectful and restrained my First Amendment right to allocate myself here in this courtroom.
All right. Don't unmute until asked to do so by the court. All right, I'm ready on more.
And I'm not saying this as a personal attack, but that's just how I felt.
Okay, Mr. McQuarrie, all due respect, I'm not interested in your feelings, sir. I'm here to conduct court. So let's conduct court. How do you wish to proceed as it relates to your court matter?
I would like to challenge the plenary jurisdiction of this court as outlined by state Supreme Court.
Today is not the date for a motion. If you would like to file a motion with the court, I can give you a motion hearing date. But otherwise, I want to know as it relates to this pretrial conference where you've indicated that you want to represent yourself. It is your responsibility to understand the rules of court and how to represent yourself. Today is only the date set for a pretrial conference. As it relates to the pretrial conference, how do you wish to proceed?
Well, if I may speak without being restrained again by the court, with all
You're
due
going to be
respect.
restrained every time you go off course. So
Well,
understand every time you go off course, you're going to be restrained. You're going to be restrained in the same way that I would restrain any other person, any other lawyer, any other person who's not coming to court and addressing the court in the way that you're supposed to address the court for the pre-trial conference. So I'm asking you, Mr. McQuarrie, as it relates to the pre-trial conference, how do you wish to proceed?
I would like to ask that this court remove itself under MCR 2.003 for judicial bias. And once this
motion is denied, anything further?
Well, I would like to have it sent to the chief judge as required by the rule.
Mr. Flanagan, please call the chief judge and let him know that there's a request for recusal by Mr. McQuarrie and ask him how does he wish to proceed with the hearing for Mr. McQuarrie.
Yes, Your Honor.
Violation code of judicial conduct, judge. And I haven't
I've been doing this for 16 years. I know what I'm supposed to do. So, Mr. McQuarrie, Mr. McQuarrie, I'm addressing your request on the recusal. So everything else, we're going to stop talking until I hear from the chief judge as to whether he wants you to come now or if he's going to give you a date.
Okay.
Thank you.
The rule matters.
Okay, thank you, Mr. McQuarrie. Thank you, Mr. McQuarrie.
Yes, ma'am.
Your Honor,
Yes, sir.
they indicated that he would need to file a motion for recusal before you. And if you deny that, it then goes to the chief judge.
He already did. I accepted his oral motion. I denied it. So tell them it's denied. I'm not requiring him to file a written motion. The court rules don't require a written motion. He requested thank you for affirmation, but I don't need it. He requested the recusal and I denied it. So ask them how do they want to proceed. I can sign an order of denial if they want me to just do an order of denial, but I've denied the recusal request.
Yes, Your Honor, the order of denial needs to be signed.
And then they're going to give him a date. In past times, some chief judges take the matter up immediately. So I just want to know, do they want me to give them a date?
Do you want her to give a date for that or? Okay. Your Honor, no date. They said just sign the order and we'll bring it up. They'll contact them for a date.
All right. So Mr. McQuarrie, please contact my courtroom. Make sure that my clerk has your current contact information. And apparently the chief judge's office is going to contact you with respect to your request for recusal. I will sign an order denying your request and then forward that to the chief. Okay.
Who do my call? The clerk? What is
sir, if you just, I promise you, I've been on the bench for 16 years. And I promise you, if you just let me talk, everything you want to know will be revealed. I promise you. Okay. So as I was saying, you're going to contact my courtroom and my courtroom phone number is and you will speak with the clerk. Make sure the clerk has your current contact information so that the Chief Judge's office can contact you with respect to your hearing on my denial of your request for recusal. Anything further with respect to this matter? Please don't unmute. Who is saying hello?
Oh, can I speak or no?
Oh, well, what else is there, Mr. McQuarrie?
I would like to just say this, Judge. I have nothing personal with you. It's just that
Mr.
this
McQuarrie,
is a
I don't take
man.
things personally. Ms. McQuarrie, let me say something to you. So since we talking, let's talk. If you would let the matter proceed, this is an old case. So let me just say that this case is from 2002. And
Correct.
maybe if you had watched my courtroom on YouTube, maybe you would have seen how these old cases from 2002 are handled. And then we could have came on here and it would have been handled the same way. However, we're going to proceed in the manner that you wish to proceed. And so I'm not going to keep going on because you've asked me to recuse myself. I have denied the recusal. You have requested an appeal. I have granted that appeal, and that concludes the matter. Is there anything further that is needed for the record? Because you don't have to tell me it's not personal. I could care less about, I don't take things personal. Why would I take things personal?
I take it personal because as a black man, a 50-year-old man.
This has nothing to do with you being a 50-year-old black man. This has anything to do with you being a defendant in this courtroom. Is there any legal thing for the record? Is there any legal matter for the record?
The prosecutor's office has committed a felony against me.
Okay, well, you can address that with whoever. You can address that with the appropriate parties, but I'm not. All right, so I'm going to assume that this matter, as it relates to the pretrial conference for Mr. McQuarrie, is concluded, unless there's something for the record on behalf of the people.
No, Judge, thank you.
All right, then, sir, you're all set. You have a great day, and you stay safe.
Oh, yeah.
So in Thurston County Superior Court, your name? Wait.
Are you speaking to me right now?
Yeah, I am. What's your last name?
Hey, I'm technically the agent authorized to represent Peyton Ansley, John Milton, but it doesn't look like it looks like I haven't been appointed an attorney, and the attorney who called me and told me that I was appointed one told me that Michelle Rowe would be representing me, but I've never met or spoken to the gal.
Would you like Thurston County Public Defense to represent you?
To be honest, no, but I haven't had an opportunity to speak to anybody, so how could they possibly? You know what I mean?
Well, yeah, that was part of the problem. May 31st, you weren't in court or by Zoom, and so they were there. So let me hear from the state first on these warrants. Slow down there. Let me hear from the state first on the warrants, and then I'll turn back to everybody.
Your Honor, at this time, this will be asking for bail in the amount of the warrant, which is $5,000, I believe.
All right. And did everybody, we've got Mr. Stillwell here from Thurston County Public Defense, and they are appointed to represent you, and Ms. Rowe is part of his office. And I'm going to hear from Mr. Stillwell about the state's request here, and just the attorneys here. I did have a chance to review the pretrial services report. I want to be sure that the attorneys did too.
If I may, ma'am.
Nope, I'm going to hear from Mr. Stillwell. Just hold on there. Mr. Stillwell from Thurston County Public Defense. You've heard what the state has to say.
Yes, thank you, Your Honor. And I'm happy to go through the pretrial services report. I would note Ms. Rowe is a conflict panel attorney in our office. It indicates that we do have a conflict with these cases. And so I was not able to advise Mr. Milton on this, not knowing the status of his representation with Ms. Rowe and the conflict in our office.
So you can't step in today, then, is what you're telling me.
Seeing as this is a predisposition, I believe.
Yes.
Yeah. So if she's continuing her representation before disposition of this, I wasn't
sure if I was able to advise him given the conflict.
Okay, and so we're not going to see Ms. Rowe today then?
No, I'm not, with her not being a part of our office, I'm not sure.
Okay.
May I please share real quickly? I did receive the mail, and it was stated that I had 2 separate court dates for this apparent double warrant. The 23rd and the 26th is what my mail says that I have court dates for this month. I did not receive any notice of any court dates in May. I was very surprised to be picked up while I was awaiting to show up to court.
So, Mr. Milton, so you still get mail in Olympia at 5213 Boulevard Extension Road Southeast?
That is where I received my mail, yes.
Good, okay. How about a text message reminder? I think we sent you one as well. Has your number changed?
I've had all of my personal effects stolen from me. On March 16th, I had my car stolen from me, my laptop, my phone, and I just got a phone again, but I haven't gotten service on it because I've been unable to make money since.
Okay. That's a tough spot. All right. Well, what we're going to do here is we're going to set this. Court's already issued bail amounts, but I want to reset this for tomorrow as well. Give Ms. Rope an opportunity to talk with you and talk about those bail amounts.
I think I just denied counsel though. Did I not?
So you want to represent yourself?
Yeah, I mean, I wouldn't want to be represented by somebody who doesn't know anything about what I'm talking about.
Well, that's why we're going to get you together and meet each other and talk. So I'm going to give you that chance, and we'll talk some more tomorrow if you really, really, really don't want an attorney to represent you. But I think tomorrow I'll give you a chance to meet and see where you are on all that. But
I could just get a reset court date for whatever this FTA is for, and then
right. This is for not showing up.
That's what they're saying. Right?
On May 31st. And I'm just going to set the bail as what was set by the judge that issued the order, but set this for tomorrow to talk more.
Okay.
And in the meantime, then you're the same conditions you've had all along. Don't violate the law, stay clean and sober, show up in court. And we'll set this directly till 1:30 tomorrow. And we'll talk more about, you'll get a chance to meet your lawyer, and we'll talk more about these release conditions.
Okay. Yeah, sure. How can I'm sure that you can't answer this question either because it's likely just on computers, but if I have the paperwork that says the court dates, the date that's summoned, I don't understand how they can change the court dates on me without my knowledge, without sending me a piece of mail or notifying me by email. And since I haven't had a phone, I haven't been able to get it. Anyways, I don't.
Well, the court didn't change the court dates. We set May 31st and sent you notice, sent you a text message reminder, but now I think I have an idea that maybe you lost your phone or it was stolen.
That say otherwise. That's what's upsetting me, Your Honor. Forgive me.
Yeah, it's all right. But that's what we did is we mailed you a notice and tried to give you a text message reminder, but that wasn't your fault that got stolen. That's why we're going to be back tomorrow to talk more, give you a chance to meet your lawyer. So we'll see you tomorrow afternoon.
Okay, thank you, Your Honor.
Thanks.
Okay, over at the Thurston County Jail at the Arc, the gentleman who just saluted me, you are muted. There we go. What's your name, please?
It really depends right now. Thing to hear, but is my appointed attorney Michelle Rowe present?
Actually, I do see her, yes.
Oh, beautiful, beautiful, because otherwise I was gonna have to tell you that I'm the agent authorized to represent Peyton Ansley John Milton and not Peyton Ansley John Milton, and then have to go through a whole nother algorithm. So I'm super grateful that she's here. Yes, that's me.
Peyton Milton? Okay. Ms. Rowe?
Yes, Your Honor. We are here on a warrant return. Mr. Milton was not present on the 31st of May. And this is actually to no fault of his own. Apparently, he indicates that the court has his email address, which he has notified the court is the best way to notify him. He indicates that he received an email regarding the June 23rd confirmation date and the 28th and 29th jury trial date, but that he never received an email regarding the May 31st court date. We are now in contact with each other and have good contact information between the two. So we are asking the court to quash Mr. Milton's warrants, to reset this for a one more pretrial, or we could actually likely set it for a future change of plea date. But we are asking that he be released from custody today.
Okay, thank you. I'll hear from the state, please.
Yes, Your Honor. At this time, the state is not going to object to the quashing of the warrant. I would like any conditions of his release, though, to be to the standard DUI conditions.
Okay, those appear to have already been issued, so all previously imposed conditions do still remain in effect. I will be getting a next court date and filling in these orders here momentarily.
I'll reach
And
out
we'll
to you.
see you back here then, okay?
Send me an email, I'll get back to you more accurately. Awesome. Awesome. So July 7th, reach out to Mrs. Rowe within the week. Sounds
Yes.
like that's what I'm doing. Okay.
And did you sign it?
I'm kind of advising about some of these things. Kind of explain, I've read all that and understand the number of paragraphs, but I kind of don't get some of this.
Okay, that's fair. What I'm going to do is I'm just going to go over it with you.
Okay, thank you. I appreciate that.
Yeah, there's no problem. You have the right to be represented by a lawyer. If you cannot afford to pay for a lawyer, to have one provided at public expense. Just so you know, Mr. Richard Davies is in the courtroom to represent you today.
Okay.
You have the right to have a lawyer present during any questioning. You have the right to stop answering questions at any time, even if you have started to answer questions without asking for a lawyer, but any statement you make may be used at trial against you. You have the right to speak in public trial by an impartial jury, the right to remain silent before and during trial, and the right not to testify against yourself. You have the right to hear and question witnesses at trial who testify against you. You have the right to call witnesses to testify for you at trial. You are presumed innocent until any accusation is proved by evidence beyond a reasonable doubt, or you decide to enter a plea of guilty, and you have the right to appeal a finding of guilt after trial. You were charged with one count of theft in the 3rd degree. That is a gross misdemeanor. It's punishable by up to 364 days in jail and or a $5,000 fine. It alleges that an incident happened on or about June 8th, 2023 in Jefferson County. I've reviewed the probable cause statement or the police report that's associated with your allegation, Mr. Davies.
So Judge, I'll enter a not guilty plea on Mr. Arn's behalf.
Can I just say something, ma'am?
Okay, so Mr. Arns, you are being recorded today, so anything that you say in this court can be used, just a moment, please, can be used against you. I don't know, Mr. Davies, if you'd like to make any statements to your client.
Well, so Mr. Arns, Richard Davies here. My advice is that you not say anything at this point.
It was right in front of the free bottle drop. I give free stuff there all the time. All the time.
Well, you were free to ignore my advice, yes.
Okay. So I am finding probable cause and I'm entering a plea of not guilty on your behalf. We'll set conditions of release.
Can I get my bail reduced, please?
So Mr. Arns, what I need you to do is just listen to what the recommendation of Ms. Kleiman is.
No, let me out.
Mr. Arns, I need you to listen to what Ms. Kleiman is going to say and what Mr. Davies is going to say, and then I'm going to rule on conditions of release. Ms. Kleiman, your recommendations.
Thank you, Your Honor. I'm requesting to set bail in the amount of $1,000. Mr. Arndt has 3 other warrants currently active out of Olympia, Tacoma, and King County. He also had a case recently out of this court, which is a post-conviction matter. There are other matters still pending out of Seattle Municipal Court, but I can't currently see whether those are on warrant or currently active because they use a different program than I'm able to see. Bail is appropriate here based on potential issues of failure to appear.
I made my court dates the entire last time. I bailed out for $100.
Okay, so Mr. Arndt, I'm going to instruct that you not say anything right now. It's Ms. Kleiman's turn to talk. Go ahead, Ms. Kleiman.
When is it our turn to talk? Ever.
Okay, if you cannot let Ms. Kleiman talk, I'm going to ask the jail to mute you so that way we can go ahead and proceed. Right now, it's Ms. Kleiman's turn to talk, not yours. Go ahead, Ms. Kleiman.
I'm also asking for conditions that he not have any new criminal law violations and have no contact with the bottle shop at 305 Kearney Street in Port Townsend.
Okay, Mr. Davies.
All right, so Judge, Mr. Arndt, you're going to get a chance to talk here in a moment, all right? When you do, what I suggest you do is just talk to the judge about conditions of release, not what did or didn't happen. So Judge, the charge is theft in the 3rd degree. He allegedly, was loading up a bicycle out in front of the Bottle Me, which I think is the name of the shop. The owner of that, Russell West, well known to, JAC and the court. A condition that says that he's not to go within, say, 250 feet of the Bottle Me and appear as required, I think is sufficient. I represented Mr. Arns back earlier in the year on the disorderly conduct charge. As I recall, and Mr. Arns, you can correct me if I'm wrong, but my recollection is that he's been in this community since about 2019, doesn't have, any criminal history except for that disorderly conduct that he pled guilty to earlier in the year. So he's somebody that can and has complied with the rules of our little community here. And so I'd ask the court release him on his promise to appear at the next court date and that he not go within 250 feet of the Bottle Me or have any contact with the owner of that business, Mr. Russell West.
Man, I get free stuff there all the time. You're standing right in front of the honor box.
Okay,
I apologize for doing that.
Okay, I did take a look at the previous case that was filed in Jefferson County District Court. There was one failure to appear, but that was, it appears to be a mistake as to what time the court hearing was supposed to be. Mr. Russell, or Mr. Arns, I need to get through this hearing. I need you to let me talk.
Yes, ma'am.
Thank you. I also took a look at the warrant history, and while that is concerning to the court, those warrants are somewhat older in time. And so because Mr. Arns did appear relatively consistently at the other case, I am going to release Mr. Arns with some conditions. Mr. Arns is to have no criminal law violations. He's to have no contact with the bottle shop or go within 250 feet of the bottle shop, and he's to have no contact with Russell B. West. The next court date will be July 26th at 8:45 with a jury trial of August 10th at 8:30. I am going to make that court date a necessary hearing. So what that means, Mr. Arns, is you do have to be present either on Zoom or in person at that hearing, or a warrant could issue for your arrest. Those are the conditions of release that I'm placing on you.
So Judge, can I make one comment? You know, when I came up with that 250 feet, you know, I'm not sure if the penny saver is within that. Certainly if it was 100 feet, you know, basically you wouldn't be able to go to that park across the street from the bottle shop.
I'm not going to talk to this douchebag. I have no intention of talking to this douchebag. It was a simple misunderstanding. I've gotten free stuff there. I've known this is free stuff.
Okay, so Mr. Arns, I understand that you have a point of view on what happened or didn't happen in this particular case. I have found probable cause, Mr. Arns, I have found probable cause for this case to go forward. And so I'm going to appoint Jefferson Associated Counsel to represent you. I'll grant that request, Mr. Davies, and reduce that to 100 feet.
Great, thank you.
But I am putting those conditions of release on you, Mr. Arns. So you are required to comply with those. If you do not comply with the conditions of release, a warrant could issue for your arrest. Thank you.
Clean up the, any intel, Ms. Zoe, on the 9:30 calendar, Johnson or Lightcaster?
Yes, Your Honor. On Lancaster, I can let the court know that this state will be moving to dismiss without prejudice pending toxicology results.
So is Ms. Lightcaster or Regulus Lightcaster out there? Regulus Lightcaster.
You know, I can stand in too. I believe, like,
great.
Yeah, I'm here.
Okay, we've got Regulus Lightcaster, and so I'm hearing, and so Ms. Zoe, you're moving to dismiss without prejudice the driving under the influence and the operating without the ignition or lock device. Is that right, Ms. Zoe?
Yes, they're all part of the same incident. Thank you.
Okay, just so I know that. So, Regulus Lightcaster, I will be granting the state's motion to dismiss the driving under the influence and the operating without the ignition or lock device.
Just so you guys know, my
prejudice.
lawyer said she's on her way to tell you to
Well,
to
we've got
change your
Ms.
plea.
Collada here, and she can step in and we can get you on your way. You don't have to wait then.
I know, but my lawyer said she wanted me to tell you to wait for her to get there because we're doing something different than what.
Well, the state
know.
makes it, they're prosecuting or dismissing, so.
Your Honor, I can let the court, I will ask the court to recall it, and I think what I'm hearing is that the state did make an offer and.
Okay, so maybe there's something to do. All right, well, we'll hang on and wait for Ms. Simmons then and see where we head with all this. So you can just mute your microphone and we'll be right back with you when we have Ms. Simmons.
thank you, Your Honor.
Hi, Ms. Simmons.
Hi, good morning, Your Honor. Regulus Lightcaster is present on Zoom, and he is numbers 4 and 5 today on the 9:30 calendar. appear for jury trial confirmation.
Right, and what's the plan today?
Your Honor, we're asking to strike those trial dates and reset for a plea. Mr. Lightcaster is hoping.
Okay, so Ms. Zoe made a motion to dismiss, and I'm going to grant that motion to dismiss without prejudice on both matters. I don't know why we had to wait. And I'll sign an order to that effect. So, Mr. Lightcaster, for now, are you there? You were there a second ago. There you are. I'm granting the state's motion to dismiss without prejudice the driving under the influence, the operating without the ignition or lock device. Don't come in next Wednesday and Thursday. We're canceling those dates. And the state can refile within the statute of limitations. But for now, the prosecution on this ends. And I'll sign an order to that effect on both. And there you go. And any questions, it would be appropriate to talk to Ms. Simmons about that. Bail's being exonerated or sent back to whomever posted it. And all the conditions of release are no longer.
Your Honor.
Ms. Simmons?
Well, I didn't get a chance to speak. Mr. Lightcaster and I had a conversation prior to court today. He wants to enter a deferred prosecution. There are no toxicology results back yet, but it was our hope that we would be resetting this for a change of plea rather than having the case dismissed pending toxicology results, which will probably not be at least until August, if not later.
Well, that was the motion, so.
Your Honor, the state will rescind its motion.
All right, so do you have a speedy trial waiver, Ms. Simmons, or what's the plan there? Do you have a petition of deferred prosecution to file the day, which would stop the trial, the clock?
No, Your Honor, we're asking to strike the trial dates and set for a change of plea. I can get you a speedy trial waiver if that's necessary.
Yep. So we don't.
Okay, we will do that.
Because then the clerk is really waylaid and we have to waylay you and your client for the morning because we need those before everybody leaves. So try and get those to the clerk, or actually get those to the clerk before we bring a case on, but we'll do that. Mr. Lightcaster, sounds like you got a plan, which the court can certainly get behind. Deferred prosecutions are a real good opportunity for people. So you're gonna need to work with Ms. Simmons this morning. You and I don't need to see each other anymore, but you and Ms. Simmons need to talk and deal with that speedy trial waiver. But we're gonna cancel next Wednesday and Thursday and reset for a confirmation and jury trial. And have you got the evaluation done yet, Ms. Simmons? Are you ready to
No,
enter?
Your Honor, we have no evaluation done. We have to check out. Mr. Lightcaster just got a new job and he's applying for insurance with them. So he needs to have that in place first.
Reset confirmation and jury dates, and then you feel free to get earlier dates when you're ready to enter the deferred. We can certainly do that, but we'll just reset for confirmation and jury dates. So just get that. We put Ms. Garza's email in the chat for everyone. So just get that into Ms. Garza before we finish this morning. And Mr. Lightcaster then talked with Ms. Simmons, and has anything changed with your address for mailing? We've got you in Roy, 34912 84th Avenue Court South. Still good? Is that still good, a mailing address? Can't hear you. Thumbs up, thumbs down?
Yes, ma'am.
Okay, and did the text message reminder get to you?
Yes.
All right. Look in the mail and talk with Ms. Simmons. And that's it. Mr. Lightcaster, just be in touch with Ms. Simmons this morning.
Okay.
Thanks. Okay.
Sade Bagneries, sorry, Sade.
Hey, Judge, how you doing? Alex Arca for Sade Bagneries.
All right, let's see. get your clerk, your client to turn their camera on. All right, it's 23 CP 217236. Sade Bagnery's got cruelty in the first, cruelty in the third, and battery.
Correct, Judge.
Well,
Judge, I did not represent her at the first appearance. I got brought on afterwards, but I'll be quick and to the point. Judge, apparently one of the victims in the case, as listed on the bond orders, whom my client does not know, but more importantly, the second victim, Lawrence Gunn, is her son. According to the bond conditions, she's not supposed to have any contact and her son. The only problem is Mr. Gunn is her son, whom she takes care of. So again, Judge, I was not there at the first appearance, but it's kind of hard for her not to have contact with her son since she's the primary caretaker. Number two, Judge, she's 36 years old. She has no criminal history. She has 4 kids. One's a 2-month-old, which I believe she's holding there. Another one's 4. The other one's 15 years old. The other one is 16. Judge, I think it's been about 90 days since the date of arrest, give or take a day in either direction. But I was inquiring as to, one, if she can have contact with her son, because I think that might have been an error to have no contact with her own son. And then 2, if the ankle monitor can be removed. She has no prior criminal history, no prior FTAs. She lives outside of the county now, I believe in Suwannee. So she is local. Again, she's not a flight risk. I don't know why that was added on, but it just seems kind of odd considering she's a local individual with no prior criminal history, no prior FTAs.
so hold on. So she said she doesn't know Malik?
She doesn't, apparently, and her son had it out. Her son was being bullied
At the bus stop.
She went to go ahead and defend her son because her son was being jumped, is my understanding. And then at that point, she went ahead and intervened. Is not her son. She does not and is. However, is her son, and part of the bond conditions was that she was supposed to have no contact with him, with her own son, which.
So this says that allegedly hit him in the back of the head and pepper sprayed him into his eyes, nose, and mouth. But she's only had this ankle monitor on for how long? Since
About
March?
90 days, Judge.
All right, Ms. Patton?
Yeah, no FTAs, Judge. I mean, she's
I
not a
would-
flight risk.
I'm sorry, I didn't mean to cut you off.
Yeah, I know this
Oh,
isn't
no,
one
that's
that
okay.
I did, so I mean, I can't speak if it was a mistake or.
I would object to removing the ankle monitor. However, I did take a look at the warrant in terms of contact with her son. It doesn't seem like she's had any issues with her son. So just so no long as there's, no violent contact with her son, not that I'm alleging that she's done that in the past, I just would have that as a condition. But based upon what's happened with the pepper spray in the eyes and choking and striking in the back of the head, I would object to removing the ankle monitor.
All right,
Judge,
so-
I have to beg to differ. For the purpose of an ankle monitor, she usually go to track somebody's movement. And she does not live anywhere close to the alleged incident anymore. She's over in Suwannee. My understanding is that this happened somewhere in Fulton County. But if she had FTAs or something of that sort, Judge, I would completely understand. And I would always have to agree with the state. But in this situation, there's no FTA. She's got no prior criminal history. She's been doing well for the past 90 days. Furthermore, she works as a bartender and a host event consultant and does host eventing or event hosting. Sorry if I got it backwards. So the ankle monitor kind of prohibits her from doing her job because no one really wants a bartender that's got an ankle monitor just bulging out. But again, if I had heard something as to an FTA or prior criminal history, I would completely agree and understand. However, I think that's far from the issue here.
Well, I tell you what, I'm not going to make her wear it a year, but I will remove as far as no contact. I mean, like I said, I don't know. Typically, if I put they can't have contact with the child, it's like if there's a juvenile court case pending and I'll let juvenile court order, control whoever does that. So if you come back in a few months and there's absolutely no violations, I'll be glad to take it off. And, let's see, what's this?
All right.
Back in September, we'll talk about removing it then.
Your Honor, if I may, you could switch it to a teletrax monitor if she's worried about it being in place at work. I do understand that that might be an issue. However, like I said, it is to track what her movements are and to ensure that there is no contact, but a teletrax monitor might be easier if she's working to pass off is just, it looks more like a Apple Watch.
The watch, yeah. Ms. Lewis, did they work out the issues with that?
Unfortunately, Judge, same update as last week when you asked.
Yeah, see, they haven't worked out the issues with that. So unless she wants to pay for it, because there's contract issues, whether the contract's gonna cover that.
Yeah, it's beyond the pale of what we can even do or determine, Judge. We can't move the needle on any of this. This is kind of above us.
Well, I think that right there was sticking his head in. Just shoot me the order, Mr. Arco. We'll sign it and get it back to you. And like I said, just put it back on, come back 3 weeks and we'll talk about it.
Understood, Judge. Thank you so much for your time.
All right, thank you.
Judge, you said 3 weeks or 3
I
months?
meant 3 months. 3 months, sorry.
That's what I figured you meant.
Yeah, sorry. All
Yeah,
right.
I figured 3 weeks would be too soon.
Yeah, but just send that to me to remove the order. We'll get that signed off on.
Thank you, Judge. And who should I send the order to? You directly or to your chambers?
Sure, you can send it to me directly or Miss Robinson to the, what's the email? Is it Orca?
He should have the email from where he got the notice for today's hearing from me.
Oh, yeah, just send it there. Yeah, she'll get it to me, and I'm pretty good about signing them as just quick as I get them.
Thank you, Judge. I appreciate it and have a great night.
All right, thank you. You too. Thank you, ma'am. Best of luck to you.
So this is an update to a bond modification that we ran back in June. This is Sade. I have no idea how to pronounce her last name. She is the ex-girlfriend of Neo, who in the original clip I mistakenly called a rapper. I apologize sincerely. He is a musical artist. We'll just stick with that. There wasn't much information out there when we ran the original clip, so I couldn't give you a lot of background. However, that has changed. Apparently, the information's all out there. So I will let you know a little bit of background information before we talk about this too much. The whole circumstance that led to her arrest was her son, and this is not the son that she has with Neo. This is a different son with someone else. The alleged victim's mother accuses Sade of pepper spraying and kicking the child before putting him in a chokehold. It's also noted that Sade's son was attacking the child as well. That's according to the shaderoom.com, who picked up the story last week after Sade posted quite a few things on her own personal Instagram. One of the quotes was, "My son was getting bullied and jumped from the kids at his school, and I only got involved to help and protect him as any mother would." So she was charged with battery and cruelty to children in the 1st and 3rd degree and was released on a total of $31,000 bond, and that was back in March 29th. Coming to this June hearing, her attorney is asking for a bond modification that will allow her to have contact with her son again, because as part of her initial bond condition, she was not allowed to have contact with the victim or her son. And they're also asking for the ankle monitor to be removed because it interferes with her business. I'm not sure exactly what her business is. It looks like maybe modeling, but I can't find a definitive answer online.
Bagneries? Sorry, Sade.
Hey, Judge. How you doing? Alex Arca for Sade Bagneries.
All right, let's see. Get your client turn the camera on. All right, it's 23 CP 217236. Sade Bagneries got cruelty in the 1st, cruelty in the 3rd, and battery.
Correct, Judge.
Well,
Judge, I did not represent her at the first appearance. I got brought on afterwards, but I'll be quick and to the point. Judge, apparently one of the victims in the case, as listed on the bond orders, whom my client does not know, but more importantly, the second victim, Lawrence Gunn, is her son. According to the bond conditions, she's not supposed to have any contact and her son. The only problem is Mr. Gunn is her son, whom she takes care of. So again, Judge, I was not there at the first appearance, but it's kind of hard for her not to have contact with her son since she's the primary caretaker. Number two, Judge, she's 36 years old. She has no criminal history. She has 4 kids. One's a 2-month-old, which I believe she's holding there. Another one's 4. The other one's 15 years old. The other one is 16. Judge, I think it's been about 90 days since the date of arrest, give or take a day in either direction. But I was inquiring as to, one, if she can have contact with her son, because I think that might have been an error to have no contact with her own son. And then 2, if the ankle monitor can be removed. She has no prior criminal history, no prior FTAs. She lives outside of the county now, I believe in Suwannee. So she is local. Again, she's not a flight risk. I don't know why that was added on, but it just seems kind of odd considering she's a local individual with no prior criminal history, no prior FTAs.
So hold on, so
She doesn't apparently, and her son had it out. Her son was being bullied
at the bus stop.
She went to go ahead and defend her son because her son was being jumped, is my understanding. And then at that point, she went ahead and intervened. Is not her son. She does not and is. However, is her son. And part of the bond conditions was that she was supposed to have no contact with him, with her own son, which.
So this says that allegedly hit him in the back of the head and pepper sprayed him into his eyes, nose, and mouth. But she's only had this ankle monitor on for how long? Since
about
March?
90 days, Judge.
All right, Ms. Patton?
Yeah, no FTAs, Judge. I mean,
I'm sorry, I didn't mean to cut you off.
Yeah, I know, this isn't one that I did, so I mean, I can't speak if it was a mistake or.
I would object to removing the ankle monitor. However, I did take a look at the warrant in terms of contact with her son. It doesn't seem like she's had any issues with her son. So just so no long as there's, no violent contact with her son, not that I'm alleging that she's done that in the past, just would have that as a condition. But based upon what's happened with the pepper spray in the eyes and choking and striking in the back of the head, I would object to removing the ankle monitor.
Right.
Judge, I have to beg to differ. For the purpose of an ankle monitor, she usually go and track somebody's movement. And she does not live anywhere close to the alleged incident anymore. She's over in Suwannee. My understanding is that this happened somewhere in Fulton County. But if she had FTAs or something of that sort, Judge, I would completely understand. And I would always have to agree with the state. But in this situation, there's no FTA. She's got no prior criminal history. She's been doing well for the past 90 days. Furthermore, she works as a bartender and a host event consultant and does host eventing or event hosting. Sorry if I got it backwards. So the ankle monitor kind of prohibits her from doing her job because no one really wants a bartender that's got an ankle monitor just bulging out. But again, if I had heard something as to an FTA or prior criminal history, I would completely agree and understand. However, I think that's far from the issue here.
Well, I tell you what, I'm not going to make her wear it a year, but I will remove as far as no contact. I mean, like I said, I don't know. Typically, if I put they can't have contact with the child, it's like if there's a juvenile court case pending and I'll let juvenile court order, control whoever does that. So if you come back in a few months and there's absolutely no violations, I'll be glad to take it off. And, let's see, what's this?
All right.
Back in September, we'll talk about removing it then.
Your Honor, if I may, you could switch it to a teletrax monitor if she's worried about it being in place at work. I do understand that might be an issue. However, like I said, it is to track what her movements are and to ensure that there is no contact. But a teletrax monitor might be easier if she's working to pass off. Is just, it looks more like a Apple Watch.
The watch, yeah. Ms. Lewis, did they work out the issues with that?
Unfortunately, Judge, same update as last week when you asked.
Yeah, see, they haven't worked out the issues with that. So unless she wants to pay for it, because there's contract issues, whether the contract's going to cover that.
Yeah, it's beyond the pale of what we can even do or determine, Judge. We can't move the needle on any of this. This is kind of above us.
Well, I think that right there was sticking his head in. Just shoot me the order, Mr. Arco. We'll sign it and get it back to you. And like I said, just put it back on, come back 3 weeks and we'll talk about it.
Understood, Judge. Thank you so much for your time.
All right, thank you.
Judge, you said 3 weeks or 3
I
months?
meant 3 months. 3 months. Sorry.
That's what I figured you meant.
Yeah, sorry. All
Yeah, I
right.
figured 3 weeks would be too soon.
Yeah, but just send that to me to remove the order. We'll get that signed off on.
Thank you, Judge. And who should I send the order to? You directly or to your chambers?
Sure, you can send it to me directly or Miss Robinson to the, what's the email? Is it Orca?
He should have the email from where he got the notice for today's hearing from me.
Oh, yeah, just send it there. Yeah, she'll get it to me, and I'm pretty good about signing them as just quick as I get them.
Thank you, Judge. I appreciate it. And have a great night.
All right, thank you. You too. Thank you, ma'am. Best of luck to you.
It is now September, so they are back in court asking for the ankle monitor to be removed again.
All right, Sade, was it by Bernice? 23.
Yes, Judge Manning. Good to see you, Alex Arca.
Good to see you. 23 CP 217236. Cruelty in the first, cruelty in the third, and battery. Bostic, preach. Rah.
I love that.
Nothing on Mr. The defendant, Judge, been out 3/29/23.
All right, go ahead, Mr. Arca.
Judge, I'll be quick. So last time I was before you was about close to 90 days ago now. I don't know if you recall this situation. My client was trying to protect her son and daughter from being beat up. There was a ankle monitor put on, and then her to have no contact with her son, which was an error. You went ahead and corrected it. You said come back in 90 days. If she's had no issues, we'll go ahead and take off the ankle monitor. Now, in full transparency, Judge, my client is a celebrity. She, I believe she can tell you what show she was on.
I don't know. She hasn't turned her camera on like she should.
Sade, you need to turn on your camera if you can. I know we've been on here a while. There we go. The pretty young lady on the left, Judge, that's her. So, Judge, she's a celebrity. This case has gotten some attention via the media, etc. However, I do have to make a point. She has had no contact with the victim or the victim's children. So she's been compliant with that. In fact, they now go to a different school. We're just here 90 days later to go ahead and ask that the ankle monitor or Talatrix monitor be removed. As you said at the last hearing 90 days ago, you said, hey, 90 days, she's had no problem, come before you again. Here we are.
All right. Mr. Scott?
It's actually 88 Jordan.
I have no idea who she is. Sorry, ma'am. I'm no idea who you are.
It's actually 88 Jordan on behalf of the state for this case, Your Honor. Good evening.
All right.
Your Honor, the state would oppose the motion to modify the bond conditions. I will make my argument as succinct as possible. I also do have an impact statement, Your Honor, from whom is the mother of the victim child in this case. Your Honor, essentially, as Attorney Arca was saying, the defendant is a high-profile individual. There were issues that came about as of September 11th. The defendant did post a picture of her ankle monitor in regards to this case. She also posted a few pictures and videos of children involved in a fight in this particular case. She also posted a direct message which highlights the victim's social media, or at least that she purported that this was the victim's social media. Your Honor, just to be as succinct as possible, we believe that the defendant here, there is a risk that she is using her platform to circumvent her bond conditions, to have indirect contact with the victim and the victim's family in this case. Your Honor, specifically, these particular posts were picked up by a large media blog Instagram profile called Shade Room. They have over 275 million followers. The particular post in which the defendant made was reposted by this blog site and had over at least 156,000 people view that particular post, Your Honor. We are concerned. We completely understand that the defendant is a mother, but we also, as a state, have to present that the victim has a mother as well. These are all children that are involved in these videos. I don't want to specifically make an argument in regards to the case, but If the defendant has an issue with the children, she should go to the police and not post these videos on social media. Your Honor, as I will say in the impact statement that's provided by the victim's mother, this particular post on September 11th has affected her child. The child has been sent screenshots of the September 11th post that made the shade room. So, Your Honor, we would say that the defendant, and albeit extremely recently, this was only a week ago, we are concerned that she is not abiding by her bond conditions. And we would ask that Your Honor deny the motion to modify her bond in removing the ankle monitor. And I can provide that impact statement now, Your Honor, if you would like.
Sure, go ahead.
Thank you. To whom it may concern, per OCGA 17-7-1, as the mother of the assaulted victim, I understand that I have the right to address the court in relation to the defendant's request for conditional changes of her bond release. I'm pleading with all parties involved to heavily consider my sentiments regarding the defendant's request prior to making a ruling today. I'm requesting that the defendant's bond be revoked and she be arrested due to the violation of the original bond agreement. I'm also asking that she be granted another bond or be allowed to remain free on her current bond, but that the ankle monitor remain in place and a gag order be added as conditions to her bond. The defendant is utilizing her celebrity and social media platform to incite violence against my son and other minors, which could potentially escalate what started as mutual combat initiated by her son into another assault or worse. Lethal consequences as a result of retaliation by her followers. On September 11th, 2023, at approximately 2 p.m., the defendant posted a video and other content with my son's image and alleged social media profile, as well as other minors, regarding the open legal matter of her and her minor son attacking my son at the bus stop. The intent, I'm assuming, was to control the narrative and minimize embarrassment of the pending child cruelty charges because a gossip site posted details of her arrest. They reached out to me for comment and I declined with the intent to protect all minors involved. The content has now leaked to several very popular social media gossip sites, whereas of 2:30 p.m. on September 11th, one site had a minimum of 60,000 followers engaged with the post and at least 1,300 people encouraging her heinous act against my son, making direct statements that he should have been murdered and put on a t-shirt. Less than 12 hours later on the same site, 160,000 interactions were recorded with other 15,000 individuals posting comments. As of 10 a.m. today, there's over 200,000 interactions and 25,000 comments supporting, encouraging, and inciting violence against the minor and anyone associated with egregious comments such as, please post the kids and parents' info so we can help with the bullying situation. What's the bully's at name? We're trying to do something. Tell them to pop back out. Richie One Rich does beautiful t-shirts. Their family would have been ordering a few. I hope when she pops one of them, y'all don't get in the comments crying and defending them. Swiss cheese all them folks. Girl, do you need us to pull up or something? That's just a few. I've known of the defendant's social status and celebrity affiliations since the first of 3 altercations between both minors on February 24th. I've never once used that information to attack or tarnish her character because I don't want to compromise the safety of either minor. I've maintained the position of protecting both minors and attempting to resolve the conflict in a civil and mature manner before, during, and after involving authorities and pressing charges against her. In addition to her involvement, the threat of shooting up my home, individuals driving around my neighborhood in ski masks asking where I live, and her son recording and posting via social media threatening to kill my son is the exact reason I exercise the right of a temporary protective order. I am in fear of my son's safety as well as my own, even more so now that our names have been leaked via social media and individuals are requesting my profile be tagged for others to intimidate and attack me and my son and other minors based on her false, exaggerated perception of events. Her social media engagement is allowing her to further perpetuate a hostile situation, by twisting the narrative to garner support on a private matter. While I am aware that the court of public opinion will not be prevalent in the court of law, I'm appalled and disappointed that she is using her platform to encourage fans and advocate violence against minors and others. Her actions put both of our children at risk of being hurt or even worse, murdered over what started as a school fight between peers. And I'll sum the rest of it up, Your Honor. I do thank you for your time. My son has received several screenshots of the September 11th social media post from his peers, forcing him to relive this horrific event. We are both experiencing anxiety and stress because of it. He also fears for his safety. It's affecting his ability to focus at school. There's still fear to ride the bus to or from school, even though the co-defendant has been expelled from all Fulton County school properties and events. We both have trouble sleeping. He's afraid to hang out with friends. I even had to hire additional security for his birthday party this past Saturday because of her September 11th post, for fear of someone attempting to attack him while he celebrated. I would like to ensure that she's held accountable for her bond order violation. Her whereabouts are monitored continuously, and that our freedom of speech regarding this matter is revoked until the conviction has been issued and the case has been finalized. Thank you for your time, Your Honor. That does conclude the state's presentation.
Judge, can I go ahead and make a quick statement?
Sure, you can go ahead and respond.
Yeah, Judge. So number one, the client had not, the defendant had, not the defendant, sorry, the victim had an opportunity to be present, did not be present. Number two, I think it's unfair for Sade, because of her status, because of being a celebrity, to not be able to go ahead and post or comment when she's sent me screenshots of news anchors, social media, websites, and things of the such, to go ahead and ask her to comment. In fact, she's sent me screenshots of that, and they're all asking her to go ahead and present a comment. As far as the posts and the blogs, all she's done is protect her character, say that she protects her kids. She did not show the face of the kids at all or say their name. All she did was tell her story. This is a criminal court. This is not talking about, we're not here to talk about the First Amendment or freedom of speech. I know the victim went on, but you directed Miss Sade Baggernice to go ahead and stay away from this individual. They've had no contact. She's taken her children out of the school so that they don't have any more problems. Now, if social media sites are reaching out to a celebrity asking for comment and commentary, I don't think that this is the appropriate court to go ahead and put a gag order in place. And Judge, you might have your own opinion, but I think I'm accurate when I say that the criminal court can't go ahead and sanction her for being a celebrity, and more importantly, for social media sites to reach out to her to ask her for her story. In fact, that's her right to go ahead and talk about it. However, she's not saying, hey, the victim lives at X address, they go to X school, this is where you can find them. She's done nothing of that sort. She came back 90 days later. She hasn't reached out to this woman. She hasn't touched her. She hasn't touched her kids. She hasn't said where they go to school. In fact, you've got everybody reaching out to Sade asking her, hey, can we go ahead and talk? Can you do a news story? She can't control whether or not 60,000 or 1 million viewers reach out to the website, and if the public's talking, Judge, the public will talk. You've been in many news stories before. You know, you're one of my favorite you're one of my favorite judges, but you know how that goes, Judge. But at the end of the day, I think the question is, did Ms. Baggernice go ahead and violate anything? She hasn't. She hasn't reached out to her. She hasn't reached out to her kids. She, in fact, hasn't said, hey, you can find them at X school, at X buck stop. She stayed away. She's done everything you've asked. And for that, I ask that you just go ahead and remove the ankle monitor. I mean, there's no issue with her. She's appeared in court when you've asked. The whole purpose of bond is, will they go ahead and appear in court when their time is called? She has. She's on at 7:15. This is obviously important to her. She's just merely protecting her character. We can't fault her for being a celebrity. She hasn't gone ahead and bashed the woman or the kids. You know what it's like to be on the media. Judge, I just asked that you go ahead and remove the monitor. I mean, at the end of the day, she's appearing every time she's supposed to. She's hired counsel. You know, I come to your court, and every time I've appeared with my clients. But I asked that you go ahead and remove it because at the end of the day, what has she done wrong? She's being asked by social media platforms to go ahead and comment. That's her business. She's a celebrity. I mean, you're a celebrity in a different ring of people, but at the end of the day, you don't see her violating by going near this person. You haven't heard anything in 90 days from this lady.
Like I said, I don't know who she is. No idea. Doesn't really matter, honestly, if she is to me. But if some of these things are getting, sorry, I went a little blurry there. If some of these things are making the parent of these other children get threats, that's nothing. That's beyond not cool.
Yeah, but Judge, at the end of the day, she has no control over that. I mean, she's got zero control.
If I may, Your Honor, respectfully, because I do respect Attorney Archer, it's exceeded by making a comment on the case and further posting pictures or screenshots or videos or whatever may have been posted. That exceeds it. That goes to a deep concern there for the state. I know that as adults, we may not view social media to be quite as important as children do, but these are all children that are involved in this particular case, where one of us may not be able to identify a child. I'm sure that a lot of these children who go to this particular school, they know the Shade Room. It's an extremely popular blog post. They can easily pick out which child is which in those videos. That is where it's exceeded. I'm not saying that the defendant does not have the right to say that I did not do these charges and I'm going to fight them in a court of law, but it is concerning for the state to look on a blog post and see potential videos of children being involved. And as I've said before, and I don't mean to repeat myself, if these were violent acts that the defendant has recordings of, the place for them is not an Instagram story or a blog site. It is, she should take that information to the police, because that's not doing anything but bringing more harm to children in this case.
Judge, again, she's done nothing wrong. She hasn't gone near the defendant, near the victim, near the victim's children. She has not provided an address to those people. She's a public figure. She's a celebrity in her circle, in her circuit. But the purpose of the ankle monitor is to go ahead and track her whereabouts.
Right. And here you go. I just Googled this and I'm saying some of this was posted 6, 7, 8 days ago. Why are you doing it right before you come to court?
You're on mute. You're on mute, Sade.
I don't want to hear you say a word, ma'am. I do not want to hear you say a word. But and I know you, Mr. Arca, one thing you always say to your clients is stop talking about what happened. Stop talking about it, because it's not helping you. Because when you post something and you use one word the wrong way, Mr. Jordan's going to say, no, here you said shall and should and did not, and all that stuff can get twisted. The only thing this is going to do, ma'am, is hurt your case. Who cares that the media wants to know what happens? If you're not guilty, then you're not guilty. Who cares? In my position, when I'm on there, I can't say anything. And trust me, that's horrible when things are being said about me, but I'm still here. Stop posting stuff. These are kids that are involved. And if you haven't been watching, there are kids on here that are hurting other kids and committing serious crimes, allegedly. Let me do that, allegedly, because they have that presumption of innocence. But if you watch my bond hearings, or if you watch the news, children are killing children. You are pouring gasoline on a fire. And if one of those children gets hurt, that is on you. because of something you did because you think you're a celebrity or whatever you do. I have no clue, but I don't care who you are. You have no right to pour gasoline on a fire that could maybe get some child hurt. Put it on the other foot. What if the non-celebrity mother did it to your child? You'd be up in arms. You would be beside yourself because somebody was posting something in the shade room or whatever it is and talking to the media. You would be beside yourself. You would have your high power lawyer write them a cease and desist letter and all kinds of other things. Put the shoe on the other foot. Act like you're a mother. Even if one kid picked on your kid, that's what happens. Let the system handle it, not you. If people are posting stuff that they want to pull up and do we need to go handle this? God, all you're doing is inciting people that think they know you and think they want to help you when you don't need help. The only person you need help from is your lawyer. I mean, the ankle monitor is not keeping her, it's keeping her away from them. But if it's obviously not posting her side of whatever, I mean.
Judge, if I may, I think,
Go ahead.
given the words you just stated, I think she's gotten the message clear. I would still kindly ask Judge that you go ahead and just allow her to remove it. I think Ms. Baggernice has now a clear understanding of your position and where you stand.
Well, but I do want to add that she stops posting stuff about these kids. I'm not interfering with her First Amendment right. You can say whatever, but stop posting stuff about these kids anywhere.
Understood, Judge, and I think she gets that loud and clear. Would you be inclined to at least allow her to remove the towel trick, since it's really, I think it served its purpose. I think from what you see here today, just based off her facial expressions, I think she's heard you loud and clear, Judge, and I'll have a frank conversation with her as soon as I get off.
What is she doing?
She's crying.
All right. So, but just add that she's not to post anything else on social media about this. I'm not interfering with her First Amendment right. One post I want her to make, and I want Mr. Jordan to let us know if she makes it, is it to tell people to stay out of it. This will work itself out. Leave it alone. She's not wanting anybody to do anything. She's got you and she's got a good lawyer and you're going to handle this. And let the mother, if the other kid's a bully, let that mother handle it.
Understood, Judge.
Don't need to get harmed over this. You could add that, she could take it off. And like I said, but I want to see something posted on wherever. Leave it alone. Leave these children alone.
Yes, Your Honor.
Am I clear, ma'am? Just give me a thumbs up. All right. Is that good with you, Mr. Jordan?
Yes, Your Honor. Understood.
When you make that, let me make sure that you can say whatever you want to about me, but I'm going to protect these kids. So make sure that hopefully Mr. Jordan will see it or show Mr. Arca the screenshot. Don't put it up there and then take it down. But you encourage people to leave anybody involved in this alone and let the court system handle it. Please, for the safety of everybody involved, because you're going to get some people hurt. And I don't care who you are.
Judge Manning, your assistant, what was her name again? So I can go ahead and send her the order after sending it to Mr. Jordan.
Travoria Robinson, you can send it to her.
Miss Gloria Robinson?
Travoria.
Where you got the
same one that sent you the link.
where you got the link.
Oh, okay. Got it, Judge. Thank you so much. I appreciate that. Thank you, Ms. Robinson.
Just so you know, I'm impressed with people like Pat Benatar, one of my favorites, but.
You gonna say preach out for me one more time before we go?
No.
I'm
sure half the people on here have no idea who Pat Benatar is.
I do.
I'm not that old.
I do.
We do, Bostic.
All right, Judge. I'll get that over to Mr. Jordan before I send it over to you, Judge.
All right. Y'all have a good one. Thank you. Good to see you.
Likewise, Judge.
My condolences, Your Honor.
All right, thank you. Thank you, Mr. Jordan. I think we have.
We met Miss Ollie back in June in Judge Manning's courtroom when she decided to completely ignore the court order that told her to stay away from her daughter and her home and to sit there and have a Zoom meeting in the same house, not realizing that two people on Zoom will cause a very, very annoying noise, like a screeching, nails on the chalkboard, make your noise. So she got called out, got in trouble, and was told to leave the residence and has supposedly been staying at a friend's house since then. There was 2 hearings since our last. If you missed it, I'm going to play the first hearing. If you remember the first hearing, go ahead and fast forward to 8 minutes. And that's the new content. Enjoy.
Mika Ali, start your camera. We got 22 CP 214957. Cruelty in the first and simple battery. Go ahead, Ms. Rondon.
Yes, Your Honor. We're here for a bond modification as part of her bond order in December of 2022. She was ordered to stay away from the family home and to have no contact with the alleged victim. We're asking for both of those conditions to be modified. Recently, Miss Ollie has been diagnosed with cervical cancer and has started treatment for that. And part of that treatment has included major surgery. It's being unable to live in her own home has caused her major issues with recovering from this major surgery and taking care of her health. She's had to live out of her car due to this bond condition. And, obviously her health is very important. And so we are asking for, 1, the stay away order to be amended and also for the no contact order to be taken away. It is my understanding after talking to Miss Ollie, and I believe some other folks are on the Zoom that can speak to this, that there was a defects case that was opened up in addition or related to this incident, and it's my understanding that that defects case has been closed, and that it has been closed because the allegations from the child, she admitted she made them up. I was told DFAX was going to be on here to speak to that, and that the child herself is also on the Zoom call. So I can turn it over to the DFAX representative, whoever they are, I'm not sure which screen it is, to speak to that.
Is anyone from DFAX here? No one from DFAX. What do you know, Bostic? Anything I need to know?
Okay.
No new information, no new arrests. I think this is her only, actually.
All right, Miss Patton, let me pull it up and look at it. Anything you want to say yet, Miss Patton? Are you
Your Honor, honestly, I haven't heard anything from DFAX. If Your Honor is inclined, I would like to hear from the minor child. My position right now is objecting it based upon what's alleged. These are serious allegations. I am sympathetic to Miss Ollie's diagnosis, but these are very serious allegations, and my position is to object. If Your Honor is inclined, I think she is on here, Sanaya.
All right, Sanaya. How old are you, Sanaya?
16.
All right, can you turn your camera on for me? All right, if you could raise your right hand, Sanaya, do you swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth? Yeah. All right, you got to speak louder and be still. Sit down somewhere and be still, okay? Got to see your face. Okay. Go ahead, Miss Rondon.
Hi, Miss Ollie. I'm just gonna ask you a couple questions. regarding the incident that happened in December of 2022, well, will you tell the court whether or not you have stated to defects that this incident did not actually occur?
It's you, Sanaya. She's asking you a question.
Yeah, Miss Sanaya Ali, did you hear my question?
No, can you repeat it?
Of course.
Okay, Miss Sanaya, if you're close to somebody, you need to get away because there's feedback.
Is the defendant currently in the same?
Whoa. Are y'all at the same house?
That's what it looks like.
Sure does.
Yeah.
So right now, what you're telling me is you're violating your own bond conditions before I say you can amend them.
I had no choice. I've been reading.
Stop talking. Stop talking.
Miss
Stop talking.
Ali.
Stop talking.
A child.
Miss
Stop
Ali,
talking. Stop
please stop
talking. Miss Ali, stop talking. Absolutely nothing you say is going to help you right now. Ms. Patton?
Your Honor, based upon that, my original, I would object. I think it still stands. She hadn't even stayed with the conditions as are right now. She's in the home with her. And how can the child and the victim in question be safe enough to tell me what's really going on if she's in the house with her?
And Ms. Rhonda, this is not me doubting you. I can feel my blood pressure going up. Wait a minute.
I agree, Your Honor.
Miss Ali, I am sorry for your condition. However, I am not sorry that you couldn't follow instructions. I mean, and the nerve to show, it's like, what in the world? You didn't even try to hide it.
You and lied to you.
Miss Ali.
Absolutely nothing you can say. Ms.
Try to
Rhonda does not want you to
Miss
say
Ali.
a word. It is not going to help you. So, Ms. Rhonda, I tell you what, you can place this back on another time. I'll give you a chance to have a conversation with Miss Ali. And then put it back on for another motions hearing. But
Thank you, Your Honor, I do appreciate that chance. In addition, I know it's not changing anything today, but I was told there are documents supporting the dismissal of the defects case and other things that were also allegedly turned over to the DA's office.
Sure.
Since this case was not originally mine, I did not have a chance to get my hands on those documents before tonight's hearing. I will get those documents before we come back, and I will share them with the state in advance.
So, Ms. Travoria, what do you think the reset date will be for her?
It'll be sometime the end of July.
Is that okay, Ms. Rhonda? Or of course, if you send stuff to Ms. Patton and y'all come up with a consent, that's fine too. I mean, just let me know.
Ms. Rhonda, and excuse me, Your Honor, for interrupting you. I know you said a defects case was closed, but I'm concerned that a defects case was closed with the thought that she wasn't living there, and clearly she is. So I'm concerned that a defects case was even closed out based upon the information that we've learned here today, because it doesn't seem like it was closed out based upon all the information being given, being truthful.
I have
I'm sure Ms. Rhonda will get to the bottom of it.
I will get to the bottom of it. I do have a name and number of the defects caseworker. So they will be my first call. And I will.
Thank you, Ms. Rhonda.
Yes.
Yeah, and if you want to send that to us, you can.
Absolutely.
All right. Best of luck to you, Ms. Ollie. Have a good evening. But you need to leave where you're at. Yeah, well, let's see. We got a couple more bond modifications real quick. So we got Tamika Ollie. Who's representing Tamika Ollie?
Good evening, Your Honor. Miss Ollie is my client.
All right, Ms. Ollie, if you turn your camera on. All right, this is number one on the modification. It's 22 CP 214957. Tamika Ollie, it's cruelty of the first and simple battery. Anything I need to know, Bostic? Preach. Rah.
Nothing to report. I think she was released 6/2/22.
All right, go ahead, Ms. Rodney.
Your Honor, I'm going to ask for a continuance in this case for maybe about a week. This case was continued from June to allow me some time to speak to my client and to gather further information relevant to the modification motion. Some of those documents include records from DFACS, records from East Point Police Department, etc. My investigator has sent subpoenas and has, followed up to get these documents, and I don't have them for tonight's purposes. And I do think they'll be very important to the modification motion and to ultimately the case itself. And so I would ask for a continuance to I would only need about a week's time.
All right, what's the next date we have, Miss Robinson?
I'm sorry, Judge, what was the question?
The next time we could get her on here.
It will be for the August calendar. Hold on 1 second, I'm sorry. It will be, do August 14th.
All right,
I think the 14th is fine, and I believe once I get these documents that the state may consent to what I'm asking for. So if I get the documents sooner than that, I will of course share them with the state, and if we can consent, then we'll go down that avenue.
okay, I was asking if that, since I've read the motion, if you think it's something else, let us send us send us a consent, okay? If you got that. Okay.
And definitely, just send me whatever you got, Miss Rhonda. We'll definitely look it over.
All right, so we'll get you back on in another couple of weeks, ma'am. Thank you.
Miss Ollie is on the Zoom. There she is.
All right. Raise your right hand, Miss Ollie. Do you swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth?
Yes, ma'am.
All right. All right, this is the one add-on is 22 CP 214957, cruelty in the first and simple battery family violence. And last time we were here, as I recall, she was at the house with the daughter in violation of the bond conditions. I'd said anything, Bostic, preach, trial.
Nothing new to add, Judge.
All right, go ahead, Ms. Rhonda.
Yes, Your Honor. The motion filed is a bond modification motion, and we are asking for 2 conditions of Miss Ollie's bonds to be modified. The first condition that we're asking to be modified is the stay away condition. We are asking that Miss Ollie be allowed to reside at the address stated in the bond condition, the Atlanta Street, Atlanta GA address, which is the family home. Miss Ollie is undergoing treatment for cancer and does need a stable and good home to be able to participate in her cancer treatments and to recover fully. The second condition that I'm asking the court to modify is the no contact order with her daughter. We are asking for that to be modified from no contact to a no violent contact order. This case was continued from the last time it was on the calendar at the defense's request so that we could make contact with the DFACS because there at one point supposedly was a case in connection with this criminal case. Unfortunately, I have not been able to make contact or receive any response from DFACS concerning my multiple requests to speak about this case. I think what that indicates to me is that if there was an open pending case with the Ollies, that DFACS would have an opinion on this, and that DFACS would like to make their opinion on whether contact or no contact, they would want that to be known to the court. And I think that them not answering any requests and not being present in court today to give an opinion signifies they don't have one. And so, Your Honor, I would ask for the condition of no contact to be amended to a no violent contact order, and for Miss Ollie to be allowed to return to the family home on Atlanta Street.
So, Ms. Rondon, since last time she was already living there in violation of the bond conditions, I'm assuming that you had a nice little chat with her. So where has she been staying since then? Because now she's outside. So I mean, I have to tell you this, this makes me feel weird, like maybe she's outside of her own house, maybe she's there, but I would trust what you say.
Yes, we did have a conversation after the last hearing, and she's been staying at a friend's home.
All right, what says the state?
Your Honor, so, and I apologize, Your Honor, so, obviously I wasn't here for the last hearing, so if I could just ask a few clarifying questions, would that be all right?
Oh, sure, absolutely.
All right, and, Ms. Rondon or Ms. Ali, either one of y'all can answer this if you know the answer. Who is living at the home, other than the daughter, who else is living at the home right now?
Miss Ollie, just, I would say that you can answer that question and just repeat the only people that are living permanently in that home.
You're on mute, Miss Ollie.
Mom, dad, and 5 children.
Okay. So Your Honor, based on that information, I don't have any problem with, well, my one issue, Your Honor, obviously there's a threat to intimidation. The main victim is the daughter. So that would be the one outstanding threat. Miss Ali does not have any criminal history. So I don't think she's a threat to commit more felonies. So with that in mind, I don't have any issue with either one of these conditions being modified. I'm not going to object to it, but I am concerned that this may put Miss Ali, even with her medical circumstance, in a position to violate her bond condition because there's obviously some issues going on there much deeper than just the altercation.
Well, she's already violated it one time and I was not happy.
Yes, Your Honor.
I think I was a little more than not happy. So that's fine, Miss Rondon. Just send me the order.
Thank you, Your Honor.
Ms. Molly, I will tell you this, the main reason that I'm modifying this is because of your lawyer.
Yes, ma'am.
But when a judge, and not just me, tells you to do something, you gotta do it, whether you like it or not. I'm glad that you went the right route by getting it modified, but you didn't need to anticipate what was gonna happen, okay? Because
understand.
I'd almost made up my mind that you weren't going back there until the case was over. All right. So we'll go ahead and modify it. No further violent contact. Now, I say if you have any violent contact with it, I'll go ahead and let you know it won't be good because they can violate your bond. Then you'll be back in jail, Miss Ollie. I wish you the best. Hope everything turns out well for you as far as your if your cancer treatment goes. So just think about that before you, if you ever want to get an argument with, don't do it. Just take care of your health, okay? Best of luck to you, ma'am. Miss Rhonda will shoot me that, and once I sign the order, you can go ahead and make it.
All right. While we're waiting for the other gentleman to come back, we have Mr. Lyndon McCombs. Mr. McCombs, you look familiar to me. Did we? I talked to you not so long ago, didn't I? You have to unmute, sir. You have to unmute.
All right, I talked to you in the court, sir, with Miss Bonnie, and then I remember you now, Mom, today, back some months ago.
I'm trying to remember what we talked about when you were here before. We did not complete your case on that day, or that was another case that you had. What was it, Madam Clerk?
This one.
No, the case was completed. What it was that we came before you on Zoom back in I can't remember the exact date, but it's on our way. And then he came in the courtroom because he kept asking for the plea to be set aside.
Oh, that's why you look familiar. Okay.
And I expressed to him that the only way to do that was to file the motion. You granted him a hearing date, which is today, and he was supposed to have his own counsel because he said that he would get an attorney. But nevertheless, we had the incomparable attorney, Phyllis Gaten Robinson, who loves me so very much, deal with him, and here we are.
Okay, all right, so you were gonna come back with an attorney, you did not do so. And so I took a guilty plea from you on the date of January 23rd, 2023. And then you came back to the courtroom and you wanted to have that set aside. I wouldn't just do it automatically because I told you come back with me or my clerk told you to come back with an attorney. And you said you were gonna do so, is that correct?
Your Honor, when I was in your courtroom, you set this for a date. If I knew I had to come in with an attorney today.
Okay, no, all right, sir. We're here. We're here. But I never set aside the guilty plea before. I let you come back and make an argument for it. Yeah, I let you come back to make an argument to set it aside, but I've never set it aside. So what, Madam Counsel, Attorney Phyllis Gaten Robinson, you had an opportunity to talk with Mr. McCombs?
Yes, Your Honor. So this is a complicated combination of the issue started in another court jurisdiction, police department kind of spilled over to Detroit because of issues that happened in Southgate. Mr. McComb's license appears to have been suspended, to my understanding, for an incident in Southgate. After that, he received a ticket for driving without a license.
Okay.
He was given an offer to plead to the reduced charge of failure to display / no operator's license on person, so he didn't get points or pay a fine. Now I'm unclear as to if he paid.
No, there will still be a fine. He may not get any points, but there will still be a fine.
And to pay a fine, so he wouldn't get any points and he would pay a fine. It was how it should have been worded, Your Honor.
Right.
So I'm not unclear as to if he paid that fine or not.
Has not.
Okay, so his request is to set aside his guilty plea based upon the fact that he did not understand the ramifications of the plea. Is that correct, Mr. McComb?
Correct. Yes, ma'am. Yes. And
no, sir. No, sir. Sir, every plea I take, I swear you in and I go over all your rights and I ask you, do you understand? I take every plea the same way. So I know I explained your rights to you. I do that on every single case.
You did explain to me that when what I was getting, but Your Honor, what I'm trying to express to the court, Your Honor, is for one, I would like to go back to the date of incident, Your Honor. For one, I was charged with driving while no license not proper, Your Honor. Your Honor, I'm a vendor. I sell food for a living. I run El Sol.
Okay, so Mr. McComb, one second. I'm sorry, Your Honor, if I may. Mr. McComb, I need you to be conscious of the fact that you are making a recorded record, right? And so I don't want you to talk too much and get yourself and create other issues for yourself. We are here for the question of whether or not on the date and time you encountered Officer Shabazz, you had a valid license. That is the question.
Yes, and I had a green light.
You're breaking up, sir.
And at the time, the officer, I didn't even know.
So I think what you said was at the time you encountered the officer, you didn't know?
At the time I encountered the officer on 6/26 here, I did not green license. The police department did not alert.
You're breaking up. Your Honor, is he fading out for you too?
It's breaking up, but
the police department never told me that the license, but I had green license. I didn't know that when I got encountered that day by the police officer, or else I would express to him I had a green license. I didn't.
All right, you had, sir, if the officer writes you a ticket for no driver's license, he told you you had no license. How else is he gonna write you a ticket for no license without you saying, he didn't tell me I didn't have a license? How could he write you a license for a ticket for no license if that's not informing you right then? If you didn't know before, that's not the officer's responsibility. The Secretary of State sends you something. And if you didn't know, you got tickets before, you didn't resolve them, which you should know that you had no license.
Kind of here on the Secretary of State, this is when they sent it to me, kind of, and this was the about the green note.
So let me tell
Mr.
you, let me tell you something,
McComb.
sir. This ticket was on 6/26/2022. I have your driver's license in front of you. I showed that you had a violation on 3/5/2018. You had a violation of 7/11/2018. You had a violation of 7/19/2019. You had a judgment against you in Southgate on January 2nd, 2021. You had a suspension. Hold on, sir. You had a suspension from that ticket in Southgate that said it was effective from 3/16/2021 to 3/23/2021. Okay. Then you had a violation on January 2nd, 2021 in Southgate. Let's see, that's got an older date on it. All right. You had a violation of 5/7/2022, where you pled guilty in Southgate for operating while impaired. So, and you pled guilty on 5/7/2000, no, on 8/6/2022, but you had your citation was 5/7/2022. And let's see, restricted license, 2002.
It's all the same case, Your Honor.
Hold up. It doesn't matter, sir. I'm showing that you had a complied consent refusal suspension, and your license was suspended on 5/28/2022 because you had a drunk driving case and you failed to comply, and they suspended your license on 5/28/2022, and it was suspended until 5/27/2023. This ticket was 6/26/2022. Your license was suspended on 5/28/2022, a month before it. So you didn't have a license, sir.
And just an FYI, I reached out to the court reporter on that day, and he was advised of his rights. He
All
was
right.
advised of the plea. He decided to take a plea.
Sir,
And he
I got something from the court reporter on that date that said on that day you were told you had a right to a trial and you decided to plea instead. I know I told you that, sir, because I do it on every single case, every single one. None go by and I do it. I don't do it. So your license was suspended, sir. And your license was suspended because you had you were stopped for alcohol related, or what they believed is alcohol related. And if you refuse to comply or take a breathalyzer or take blood or anything like that, they will suspend your license immediately. And they did in that case. So you did not have a license, sir. On the date of this event.
From Southgate, I did not refuse. You clearly see right here.
Sir, I wasn't there. I'm telling you what the Secretary of State records say. So I don't know what you're trying to show me. I can't read it like that, though. You know what? I'm going to let you put that up. I'm going to zoom in on it. So hold up whatever you're trying to show me, sir. I can't read that like that. All I'm getting is a glare. I can't read it, and it's off to the side. You don't need to be in the picture, sir. I just need to see the paperwork. You muted yourself.
Sorry, let me take the cover. Hey, can you hear me, Your Honor?
I can hear you fine, but I can't see. You're not holding up. You're not putting something where I can read it to see what you're trying to show me.
I'm sorry, Your Honor. I'm putting it up to you now. Your Honor, it says right here where it says suspect. Let me get a little closer. Suspect was asked to perform field sobriety test.
What does that have to do with this, sir? What? So
I've been
Okay,
set
all
up.
right. Well, let me
I've been
ask you
set
this,
up
sir.
by-
Let me ask you this.
Yes,
You
sir.
said you took a field sobriety test, okay? All right.
Yes, sir.
Was it positive for alcohol?
Yes, sir.
All right, then they would have suspended your license, sir.
They issued me a green license, Your Honor. I have that paper right here. I had a green license on that day, Your Honor. And I
Sir,
didn't even know that Southgate issued it to me. Your Honor, they did not tell me that they even took my license from me, and that's not fair, Your Honor.
sir, if you're drinking and driving, they could do, that's not fair that you put people's lives at risk. That's what's not fair.
Your Honor, they alleged that I was drinking and driving. I have a medical marijuana card, and I had got conflicting.
Let me tell you something. Let me tell you something else, Mr. McCombs.
Yes,
if
sir.
you have a medical marijuana card, that doesn't mean you can smoke marijuana and drive.
No,
just
it
means
doesn't,
you
Your
can-
Honor.
What you say? It does not mean you can drive. So if
No,
you're
it
smoking
doesn't.
marijuana, it doesn't what?
No, it doesn't. I'm saying that I think that it gave a wrong test result, Your Honor.
But so, Mr. McCollum, this is what I tried to discuss with you in the breakout room. Detroit 36th District Court cannot fix your issues with Southgate District Court. The issues you have in Southgate, you have to take up in Southgate. If you think Southgate did something wrong, that's an issue you have to address with Southgate.
When I go to Southgate, they tell me that they can't do nothing for me now because their hands are tied because of this suspension that I got from Detroit. They said I have to first go down.
They can't do anything about Detroit, sir. They can do something about their ticket. And if they did something about their ticket, then I might take that into consideration. So,
But Your Honor, they're
they
telling
can't.
me I had to go to the district court. That's what the court.
Sir, you took a plea. You took a plea. I went over all your rights with you. I asked you, were you pleading guilty because you are guilty? I asked every single person that question. You said yes. And that's where it ends, sir, because I'm not going backwards on it. I asked you, were you pleading guilty because you were guilty? And you said yes.
Sir, I pled because you gave me a deal to pay $240, no points. No, that's why.
Yeah, so, no, you know what, sir? I will give you a deal, but I still ask you, are you pleading guilty because you're guilty? I don't give you a deal so you can lie.
Well, I mean, Your Honor, you know, listen, I'm
not going through this anymore. This ticket stands. I'm not going back. I'm not reversing myself. I asked you, you took the plea. That's where we are, sir.
It appears that he logged off, Your Honor.
Yeah, well, guess we're going nowhere anyway on it, so. All right, what do we have left?
Okay. So what we got, Mr. Contreras, is I got probable cause for negligent driving in the first degree. That's a misdemeanor. Maximum punishment, 90 days in jail and $1,000 fine, and then the driving while license suspended third. So I got probable cause for both. Mr. Kressel already represents you on the other, because we don't really know what your income situation is right today, do we? Are you working yet? No.
Got laid off.
Right.
As of this week,
Right.
so I've been
Well, I
calling
know
around.
You and I just had that conversation. I didn't figure you'd have a job by now. So I know. Try not to feel bad. But you know I gotta put some bail on you, don't you? So we're gonna put $2,000 cash on you. You're gonna have to post $2,000.
Today?
Well, I'll give you till today. I'll give you till 3 o'clock tomorrow afternoon.
So
if you can't come up with $2,000 cash, you got to report into jail by 3 o'clock tomorrow.
Okay.
And then, do you know why I'm doing that?
No.
Well, because we already got a pending case.
Yes.
You're back
absolutely.
here, and the allegations here are serious enough in terms of when I read allegations like this, we got a public safety situation.
Absolutely.
So I don't want you driving.
Absolutely.
So anyway, and we appoint clown public defenders. So I'm gonna put down $2,000 cash. You got to post on this cause number.
Would you?
What's that?
Could you do 1,500? I
Nope.
could come up with 1,500.
I know, but I can't do it. So here's where we are on this. You got $1,500 cash. I'm not trying to insult you, and I'm the judge here in town, and I got to be worried about you driving around loaded when you might run somebody down. And I don't want the cops to have to drive around worrying about you. Okay? So we got two different interests. My interest is to keep you off the road. So you got till 3 p.m. tomorrow, I think is 6/16, isn't it? Is tomorrow the 16th?
It is.
By 3 p.m., you got to post that. You can't drive unless you're properly licensed and whatever else DOL wants you to do. You got to report back to court as directed. Now, here's the unfortunate thing. 19th is a holiday. So our next court date for you is going to be June 26th at 1:30. So I need you here in person, because this is pretty serious stuff. If you post that $2,000, you got to be back here in person on the 26th.
Thank you.
Well, I don't want to hear or see from you for a long time, except your court dates.
Absolutely.
That's the deal you and I are, that's the agreement we're making. Okay. Now that's the DUI, that's the neg 1. Now, I got other bad news for you. Apparently you have an ignition interlock requirement. And again, you don't have to answer anything. I'm just looking here at your driving record. What DOL is showing is that you have an interlock ignition requirement. So we just added $1,000 more to your bail. It's now $3,000. So I'm using one order for two cause numbers, I think. I'm gonna write in $3,000. You got till 3 p.m. tomorrow to post it. You may not drive.
3,000?
What's that?
3,000?
3,000 cash. And like I say, I'm sorry I gotta do that to you, but we already have DUI action going, and we got you driving around town without an interlock. So you, sir, are a threat to community safety. And that's why we're putting it at 3,000. And I see that you signed your advice of rights. You know about your advice of rights. You got an attorney. Now, Chief Rowley doesn't have to go looking for you tomorrow, does he, at 3? You either be here with the money and get it posted, or you come over to jail. And then we'll see you Monday, 26th at 1:30. Do you have anything for him, Melissa?
I do like to sign this, please.
Yeah, this is your next court date, et cetera. And you know how to get in touch with Cressel, don't you? Okay.
Thank you.
No, thank you. Got 2 tickets, Mr. Gonzalez. I got CR 30537 and CR 30538. And we got business to conduct first before we talk about anything else. Did you see me come out and try to get you to turn your music down this morning? I'm kind of a big guy. I know you must have seen me.
I wasn't paying attention.
I know
I'm
you
sorry.
weren't paying attention. So let me explain something to you, Mr. Gonzalez. It's called basic courtesy. You got people working in this building that don't want to hear your music when you pull up to the window and turn it
I
up.
didn't.
And when the judge comes out and knocks on your window,
I
here's a good-
apologize.
no, I don't want to hear an apology. I'm giving you a little social advice. Act like you
I
care.
understand.
Act like you
I
care.
understand.
I don't think you do, because you keep
I-
talking. Act like you care. Otherwise, you and I won't be getting along so well, okay?
Okay.
Just giving you a heads up.
You need to take your hat off.
And you need to take your hat off. Get it off. Act like you care, and we might start getting along, you and me.
Yes, sir.
Okay? I read this police report on 30537. I'm finding probable cause for misdemeanor harassment. Maximum punishment is 364 days in jail, $5,000 fine. Disorderly conduct kind of grows out of that same set of facts. This is a situation going on with your neighbors. Maximum punishment, 390 days in jail and a $1,000 fine. I've seen you signed your advice of rights. We'll get back to that in a second. On 30538, I found probable cause for criminal trespass, 2nd degree. I'm pretty sure that is, because it involves the yard and not the house. So that's maximum punishment, 90 days in jail and a $1,000 fine. And the obstruction resisting, that's the alleged conduct toward police officers. That's maximum punishment, 364 days in jail, $5,000 fine. Do you understand what you're charged with?
No, sir.
What don't you understand?
The charges,
Okay. Okay, so you may not agree with the charges. I'm asking you if you understand
Okay,
you've been
yes,
charged
sir.
with 4
Yes,
things.
sir. I'm sorry.
Okay, and you keep interrupting me, so I don't know if you actually hear me. It's kind of like your music. I can't tell if you actually listen.
No,
Are you
I
listening?
am. I'm sorry.
I don't want to hear you're sorry. I want you to know, I want to know that you're listening. I
Yes,
want you
sir.
to look at me
I'm
and
looking
not
at you.
talk and act like you hear what I'm saying to you. Can you do that, please? Can
Yes.
you? Good. Now, you've been charged with 4 different offenses. I see you've posted bail. Did you post $2,500 bail?
Yes, sir.
Okay, what's a good address for you?
Sir.
And what's a good telephone number for you? On the ticket, we got an address for Graham, Washington, but you're living
That's
around
my
here,
other
aren't you?
house.
Okay, so, can you afford to hire a lawyer?
Yes, sir.
Okay, so we're gonna keep bail where it is, whatever you posted, the $2,500, that stays the same,
Okay.
okay? And you need to hire a lawyer. And you probably heard me tell 2 or 3 other people that it's a holiday Monday. So the soonest we can come back to court is the 26th at 1:30.
Yes, sir.
And I want you back here for that because I want to know if you have a lawyer or not.
Yes, sir.
And if you have trouble hiring a lawyer, I need to know that too, in case I have to appoint you one.
Yes, sir.
Right. So actually what the date that's being set, the 26th, is actually, it's an arraignment. We would enter a plea of not guilty for you on that date, the formal not guilty plea, right? Right now, we just assume you're not guilty, but we're going to have you back here on Monday, we think the 26th, with a lawyer.
Yes, sir.
Okay. So you go get yourself a lawyer and we'll see you Monday, the 26th at 1:30. No further criminal conduct. You're prohibited from talking to your neighbors for the time being. And we'll see you on that Monday.
Okay.
Okay, I just have to, I guess all these other people will just, oh yeah, we need your signature, Mr. Gonzalez. Hang on a second.
Very well.
Do we have McGuire in here? Do I have McGuire? Come on up. McGuire, I got you down for an address in Vancouver. You from Vancouver?
Yes, I live with my son. I have an address, well, I have a post office box in Bellevue. I'm a union carpenter and
We just want to know where to mail you a letter that you're going to open and read.
I get better mail than my post office box.
That's a lot of digits. We got a lot of. What's the zip in Bellevue?
98015.
Are you hard of hearing? No, because you're standing up and you keep looking at me like you can't understand me. Can you hear me okay?
Yeah.
Okay. You can have a seat if you want. I just wanted to make sure that you could hear me.
I'm just really sore.
Well, hang on a second here. McGuire, let me look at something. Yeah, we had a jury trial yesterday and we had a couple of old guys like me that it's harder to hear because the tones, you don't always hear the tones.
Some things are.
Yeah. And then everybody makes fun of you when you're looking at them funny. You were looking at me like that and I thought, oh, again, he can't hear me. All right. So, you actually, you just said something about working. You actually have an income, don't you?
Yeah, I just finished a job. I was in Chelan, and so I'm on unemployment right now, but I work in the union. I get called out.
Right. So what I'm thinking is we cannot appoint you a lawyer. You're not probably the kind of guy we'd appoint a lawyer to.
No, probably not.
Right. So
I was wondering if okay.
You wondering what now?
Well, I was wondering if I could just explain what I did. And
yes and no. How about you let me do this first?
Okay.
So it sounds like you took $6.49. The allegation is you took $6.49 worth of food without paying for it.
Yeah, I ate it.
I know. Okay. So, but here's the deal. So one of the things about theft here in town, especially at outfitters, is they have what's called a compromise and misdemeanor. If you pay for it, you can take care of it,
I asked them.
I know, but charges got filed and there's probable cause to go forward with theft on this, which is 364 days in jail and a $5,000 fine. No, I'm not trying to scare you. You don't need to be scared.
I've never been in.
Well, I know, I already looked, I saw that, okay? But I have to tell you the truth that there's probable cause to go forward with a theft. I don't enjoy telling you that. I'm just telling you the truth. Anyway, so we want you back here, but you can appear by Zoom if you're out of town. If you know how to do Zoom, we want you back here on the 26th at 1:30.
I'll be here.
But what you really got to have is a lawyer.
I don't know if I can quite afford one.
Well, but here's the deal.
That's why I was wondering if I can make a deal with you.
I can't see, the reason why I can't do that is because this involves the city prosecutor. This is a City of Forks case. And so I'm not actually a party to the case. I'm just a judge. But actually, one of the things that you can do, I want you, first of all, between you and me, I want you back here on the 26th at 1:30. And you can appear by Zoom, call around, shop around for a lawyer. If you really can't afford one, we can have you fill out a financial affidavit at that time. I mean, we'll work with you on that. But I want you back here to answer this charge officially on the 26th at 1:30. And you can do it by Zoom. You don't have to drive. But you said you're going to drive up here, so that's great too. So here's the deal: is before you leave today, you can ask, because you're not represented by a lawyer yet. You can ask to talk to the prosecutor and see if he has any suggestions for you.
Okay.
Oh, no, I'm not willing to sign a waiver yet. What she was asking about, my clerk wanted to know, is if you wanted to waive a lawyer, and I'm not willing to do that with you yet, because you strike me as somebody that doesn't really know how the court system works.
No.
So I don't want to ask you to do that yet. You always have the chance later on to waive your right to counsel. But right now you don't actually have a lawyer, so the prosecutor across the hallway may talk to you about this, okay?
Is that the one that I have to deal with?
Yes, because it's actually a City of Forks case, and it's the attorney who's in charge of that. If he doesn't want to talk to you, I can't make him talk to you. You know, I just need you back here on the 26th at 1:30. All righty?
Your signature real quick, let me give you a copy.
Oh, yeah. Signatures. Didn't we do all this yesterday?
Maybe.
Like we do the same thing every day. And you can't go back to outfitters till you get cleared.
No, I know. I was the stupidest thing.
I know, I understand stupid. We all get stupid.
It's just minor.
That's all right. You don't need to keep talking about it, but you do need to go see if the prosecutor is willing to talk to you.
Okay.
He's busy, so he might not be willing to talk to you right now, but you can, as long as you don't have a lawyer yet, he's capable of talking to you. Once you get represented, he can't talk to you directly.
Okay, thank you, sir.
Thank you. Where are we on time? Baby. Uncle Stone, it better be a good argument. Can you hear me? I'm not in the mood for those defense tricks today. Between you and Shadowski, I get tired of it, beating me up. Hang on a second here. We got let's take a look. Whatever number that is. Anyway, there it is. 3A0301241. An axle measuring deal. Let me take a look at this here. 4-ax log tractor, 2-ax pole trailer, stopped the entire vehicle. While weighing the entire vehicle, it was observed, noted the axle spacing between 2 and 6 seemed short. Trailer still on the scale. I measured the axle spacing between A2 and A6 at 40 and 6. Contacted the defendant, instructed him to park, and informed the defendant he's operating over legal weight for axle spacing between 2 and 6. The region measured the axle spacing and defendant observed the measurement. Log truck and trailer 77.4 with a 2.6 axle spacing and 6 something. Measured the distance 73,000 pounds. So in theory, he was about 4,500 pounds overweight is what it, does that sound what you're, I guess 3,900. Is that what it sounds like to you, young Mucklestone, is about 3,900 over?
The report might, looks like it's there referencing as such, Your Honor. Just Gus Mucklestone, Rule 9 here for the record. And I did have a motion whenever Your Honor is ready.
Yeah, go ahead with your motion. I'm just reviewing the certificates. Go ahead with your motion.
All right, well, this is a motion to exclude the scale certificate documents. This is a foundational issue, Your Honor. The ID and reference number for the scale that was included in the certification reports following the officer's report, the officer does not make any mention of any model number or identifying the scale that was used in any sort of way in his report. So there's really no logical connection that we can make here. And you know, for all intents and purposes, it could be a completely different scale. We don't know. So I'm asking the court to exclude the scale report, Your Honor.
Okay, so what I'm hearing you say and what I think I'm seeing here, I'm looking at the narrative on the ticket, which does not actually reference the citations, the certificates.
That's correct. It does not identify the scale that's being used.
All right, so I'm satisfied that foundational requirement, I told you to not beat up on the judge. I'm a nice judge and here you are abusing me. So yeah, I know, I accept your apology. I feel better now. Anyway, the narrative does not reference the certificates. So as far as I know, the certificates don't necessarily relate to this case. So you have prevailed on your foundation argument. You tell that kid, BB, from me, from Judge Hannafy, I know all his relatives. I don't know the kid, but I know all his relatives, to not drive trucks unless he's sure what they weigh. Because, you know, employers put people in trucks and they don't always, sometimes people start driving trucks before they know what they've got.
Yes, Your Honor. Yeah, we definitely. Well, we appreciate it. It's always great to see you.
I don't want to see BB anymore. I don't want to see his name for a long time. Another 2 or 3 years. I don't want to... Right. All righty. We'll see.
Right,
I dismissed it. I dismissed it. Instead of not found infracted, I just dismissed because we don't have foundation. Okay, we'll send you that, Mr. Mucklestone. Good job.
Thank you very much, Your Honor. Have a great day. It's my only matter.
You too. Shadowski, I'm tired of it already. Abuse. Lawyer.
Well, don't worry, Judge. I'm not going to beat you up on this one.
You're not? What do you got?
No. I got State of Washington versus Robert Strand, cause number 380293907. Well, Judge, I reviewed the discovery, which I did receive from the prosecutor's office, and honestly, I didn't see any issues. Well, certainly no dispositive issues related to the speed measurement. So I took the liberty of reviewing Mr. Strand's record prior to coming to court today. It appears that he's eligible for a deferral, and I'd ask that the court allow him to take advantage of that. See, I'm not beating.
We absolutely will allow him to take a deferral, and it's always a pleasure, Mr. Shadowski, that you and your wife are very competent and ethical attorneys.
Well, you know, Judge, I can't win them all. So, and plus, Mr. Mucklestone beat up on you already this morning, so I felt bad.
Well, it's always a pleasure to see you, Joe. Yeah, we'll send you that deferred stuff.
All right. Hey, I appreciate it, Judge. I got to go see Judge Newport here before he holds me in contempt.
All right. Thank you, sir.
All right. We'll see you.
Bye. You know, I still can't get 23 through my head. I'm putting 22 on everything.
Oh, if we could call this case Sean, but I don't see him in the courtroom.
Merkel. I don't have a Merkel anywhere. Andrew Merkel is not here. I guess we'll just find it committed, but what do you want to bet I get a letter in 3 days?
Or they come bake at the window in the afternoon, ask for report.
I know. Anyway, we'll find it committed for right now, but you know, where does that leave us? Does that leave us with?
Last case of the morning, and this would be CD 23-602.
A Jimenez and a Sutherland. Is that the one we're talking about? Are you Zoe? Yeah. Okay. Did I say your first name okay?
Zoe's my first name.
I know, but people spell Zoe differently.
Oh, yeah. Yeah.
So I almost called you a Zoe, but that would sound weird, wouldn't it?
People that have known me forever, that's what they call me.
Well, okay. So what about Sutherland? Is she around?
I believe she's on Zoom.
Oh, are you there?
Yeah.
That's right. Yes, right. We already went through this. We saw the coming thing, and then I figured out you were Sutherland. Okay.
Yeah,
hang on. Let me. Oh, I know. We're just. It's just the world of Zoom. We look at these little squares and we try to figure out who's there, and sometimes people don't answer. Okay, let me look at this again. It's been a while. 2026, 2023. Stepson, next one. Stealing. So this is kind of your relative. Candace is kind of a relative.
She married my brother.
Okay, so, but you don't live with them, do you?
No.
Right, so you came to visit,
Yes.
right? You went over to their place to visit.
Yes.
Okay. So there's no actual reason for you to have contact with them necessarily, is there? I mean, is there hard feelings going on right now?
I do not see them often, but
Right.
my brother has children.
Okay,
And so there are events.
right. Well, the thing is, so one of the things that goes on with a no contact order, an anti-harassment order, is there either has to be a pattern of harassment or an assault or threatening behavior, you know, like I'm gonna kill you kind of stuff. And so what I'm trying to get a feel for here is, since you don't live with them, if I issue this order, I mean, are you concerned that she's gonna try to text you or have contact with you, or what's your concern exactly?
Yeah, there's no telling what
No telling.
she will do. I mean, she
Right.
pulled the gun on me, my 3-year-old, my 9-year-old.
Right, so you have safety concerns?
Yes.
Okay, so Ms. Sutherland, Ms. Jimenez, I can never say that, am I close?
You're close.
Okay,
I don't think I say it right.
well, I had a Mexican girlfriend in Yakima for 3 years, you'd think I could say some of these names right, but I can't. All right, so anyway, Ms. Sutherland,
Your Honor, my last name is actually Cumming.
oh, right, okay, I'm sorry, so let's go with Cumming. So, so Ms. Jimenez is worried about a pattern of behavior. In other words, she doesn't want to have any contact with you. And that's kind of it seems to be kind of a difficult situation, because if you all try to get together for family things, that might be difficult to enforce a no contact order. So do you have any thoughts about her request and how we might get this resolved without hurt feelings?
One, yes, and I just wanted to say before I start, I don't know how to start the video, so I'm sorry if you guys can't see me. I'm not trying to do that on purpose.
No, we're with you. We got you. I believe you.
Okay.
Go ahead. So what are your thoughts on how to resolve this thing?
Well, one, I would like to start when it got sent to me was a couple of days before my daughter's graduation, which was in Nia Bay. And I was extremely scared to go there and had to contact people, like the police there, to make sure it would be okay that I get to go to my daughter's graduation. She's absolutely correct when it comes to like events. I usually don't go on vacation because there's vacations where Zoe and my husband take both of their kids down to California to see someone called Papa, who's Zoe and grandpa or great grandpa, who to whoever you're referring to. And I don't go to those because their mother calls me and says, hey, Zoe don't want you here, and she's threatening not to take the kids. And I would never want to hold a grandma away from their grandchildren. So I just stay home or usually go on another vacation. So
what I'm trying to get at is if Ms. Jimenez is concerned about safety and or harassment, there's a legal basis to issue the order for, like, say, a year. But I don't want to do that if you think it's unjustified. If you think what she's saying is untrue, then we probably need to have a hearing on this. So I'm just trying to get a feel for this.
I absolutely think it's untrue. The Lacey police even came to our house. And it's not an official police report. It's just a detailed history for a police event, and it has a number. I could send it to the court like in a PDF file, but the police even showed up.
I'm not sure that's necessary. So what I've got here is I've got what appears to be, from what I'm reading, it appears to be an ongoing dispute between you and Ms. Jimenez. Is that about right? There's kind of an ongoing dispute. Is that correct?
No.
So it's limited in time to, like, what? When
This
did the
one
dispute
event. This one event.
Okay.
Before that, the last time I seen her was probably over 2 years.
Right. Yeah, so here's part of the problem I'm having is, and I assume you saw this. There's this argument over money. Candace became upset that I wouldn't engage with her She said they would call the police. I told her to go ahead and do that, and that I would wait right there. She wasn't happy with that response and continuing to yell at me. Shortly after that, she said, "Oh, I'm going to get my money." Then Candace went inside the door and grabbed a large gun. I instantly grabbed my 3-year-old daughter and buckled her into a car seat. My 11-year-old, 17 kids were already in the car seeing all of this. Once my 3-year-old was in the car, I drove away and called 911. But what that is, Ms. Cumming, is that's behavior that amounts to probably a harassment, a misdemeanor harassment, possibly more.
I
don't see.
I-
Right. So
I'm-
the problem, well, what I'm thinking is, and I'm not trying to insult either of you, because we've got a family situation, but I think I would prefer to issue the order for 1 year that you can't have contact with her. And I'm not doing that to insult you. You know what? Anti-harassment order is not a criminal charge. It's just kind of a civil order that would prohibit you from contacting her. Does that make sense?
I understand. Can I say my side of the story and then show you?
Absolutely. Yes, ma'am. I would love
I
to hear it.
actually have that police thing that I was talking about. The police actually
Right.
they went and spoke with our neighbors and
Right.
they believed my side of the story, and that's what they put and they looked at their Zoom cameras. They said that
Right.
they didn't see a gun, and at the end of the report it says first RP, which if you read the report refers to Zoe as the first one.
Right.
That showed a
Right.
video of her leaving the scene and no guns were observed.
Okay, yeah, but hang on, that brings up something else. Are you both living in Clallam County? Where are you living?
I live in Clallam County.
So, and where do you live, Ms. Cumming?
I live in Lacey, Washington, or Thurston.
Okay, right. So I understand what you're saying, and I get that. And so let me explain to you how a civil matter works a little bit. Whether or not criminal charges were filed external to this doesn't really matter. If I believe, and I tend to believe that there's some behavior that arises to the level of disorderly conduct and or harassment type stuff, then I've got a situation that calls for the imposition of an order. And all that order does is it prohibits you from making contact with Ms. Jimenez for the next year. That's the way I want to get this resolved. I understand that you believe the allegations are untrue, but my particular concern is that it meets the legal threshold for the imposition of an order. And all that really means, the consequence to you is you just can't make contact with Ms. Jimenez. You can't text her, you can't call her, you can't go to her house. Now, this is addressed to both of you. I don't know what to do about family events. I've never been in this situation where I couldn't have contact with a sister-in-law or somebody, so I don't know how that works. But I would strongly recommend both ladies to keep doing what you're doing, which is apparently you're trying to avoid each other. Right? I mean, both of you are trying to avoid each other.
Correct.
So yes, Ms. Cumming, go ahead.
I was gonna say, I try to avoid her. I didn't know that she was actually coming over to our house. I was at work when
Right.
she.
Well, so here's I'm just gonna give you a little perspective from
There was no gun involved and I never got to say.
And the reason why I know that's true, what you're saying is true, is because there's no arrest report for a gun. So I got that part. But I'm going to tell you a little prosecutor's perspective, because I spent 15 years of my life being a prosecutor. When there's a dispute over money and somebody says, and I'm not accusing you of anything, I'm trying to give you an example. If somebody says, "Oh, I'm going to get my money," in some jurisdictions, a prosecutor would interpret that as a threat. And that possibly sometimes becomes a robbery if you threaten somebody about money. So what my advice to you is, if you get into a dispute like this with somebody, the smartest thing you can do is just back right out. Just turn around.
I tried to call the police. I walked back into the house. I was on my front porch. I walked back into my house and calling the police. She grabbed her phone out, started videoing me and said, "Gun, gun, 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 gun." And that's
I know. So, but here's the thing.
And the police actually said they were going to file charges of false 911 reporting on her. I'm sorry.
And so it goes back to what I said earlier. I don't have any evidence of any crime being filed, and I'm not actually concerned with criminal filings, because that's not in front of me, and it might, if it's down in Lacey or something, it wouldn't be in front of me anyway. But anyway, so I'm finding that there's a basis for a no contact order of 1 year. And that just means that you can't go out of your way to contact her. And I don't know how either one of you is going to handle family things. I mean, so it kind of works both ways, Ms. Cummings. Like if she was trying to contact you to bait you into doing something, the order is against you, so you cannot make contact with her. So you're both in a better position if you really leave each other alone. Is that your dad with you?
Yeah.
It's really a good thing to just not do any or say anything that provokes an argument. But I'm going to issue the order for 1 year, Ms. Cumming, and that's not a personal insult to you. I just think it's best for this situation.
Would it
It's for
affect,
one-
well, is it
What?
gonna affect my criminal, my criminal record? Because I don't.
No, it shows up on your record as the imposition of you are a respondent in a 1 year anti-harassment order. And so it's not a criminal violation of any kind. It's what's called a civil order. And they're specifically designed by the legislature to prohibit contact in exactly a situation like this that could get out of control. In other words, go ahead, I'm sorry.
I had another question.
Yes.
Her oldest daughter and my youngest son, or my youngest child, are
Yes.
really good friends on this app called Snapchat. Is that gonna make it look like I'm trying to contact her family members? Or
No. I can't, and you understand this, Ms. Jimenez, I don't have any control over the kids. If they're talking on Snapchat, that doesn't concern us.
I like them talking.
No,
They're
and she
cousins.
likes your child talking to her child anyway, so no. If somebody brought that to me, Ms. Cumming, and said, hey, her kid is contacting the other kid via Snapchat, I would not assume that you were behind that, okay? That would not be a conclusion I would reach, okay? So I think you're safe. But both of you, if you could just please leave each other alone for next year so I don't have to hear about this anymore. Can I get that? I'm old.
I don't want any contact with her.
It's
at
okay.
all.
I don't think she really wants contact with you either. We're just trying to make sure nothing more happens. We don't want any yelling at the car. We don't want any nasty texts. We don't want any arguments on the porch. We don't want, Judge Hannafy and Forks doesn't want to hear a thing, but quiet, peace and quiet. How about that? Ms. Cumming, your connection is very good on Zoom. Are you a Zoom pro?
No.
Well, you did a good job. I'm going to sign an order for 1 year that you can't initiate contact.
I had one more question. I understand your order, but
Yes.
as you've seen in her thing, when she says that I accused her son of stealing, have you ever, in your 15 years of prosecution, have you ever seen someone that didn't steal something off and pay it back?
Well, you see, now this is where we get into that gray zone, is that the judge here and most police officers don't get into arbitrating arguments on theft. Either a crime was committed or not. I'm assuming no allegation of theft is just turned into a criminal charge. So as far as I'm concerned, no crime was committed. Whether or not the alleged theft gets worked out, does somebody get paid back? I have no idea. But I can tell you that I'm concerned about people, the hard feelings in this one, people having temper flares and whatever kinds of feelings people have in families that tend to be more intense than normal. I want you two ladies to leave you alone. And also, if you feel harassed in any way, you can always ask for an anti-harassment order of your own. If somebody is mouthing off to you or harassing you, you should feel comfortable to go to court and go get your own order. So what I'm trying to do is trying to keep you both away from each other for a year if I can get it done.
Yeah.
Okay. Well, thank you, ladies. Thank you, father, or whatever, mother, whoever all you people are. See everybody, hopefully not for a year. Court would be adjourned.
If you want to come back after
Oh.
lunch, you have to order something.
Yes, if you want to come back, sorry.
There wasn't one in the car.
Spell your last name?
Yes, Matthew Scott, last name spelling SCOTT.
All right, thank you. Mr. Ziegler, whenever you're ready, please proceed.
Thank you, Your Honor. Trooper Scott, what is your occupation?
I'm a trooper with the Michigan State Police
How long have you worked in law enforcement?
since 2012.
Were you on duty on January 15th, 2023?
Yes,
Do you recall assisting Officer McCormick in a traffic stop early that morning?
yes.
How did you become involved in that stop?
During that time, myself and my partner, we were patrolling within that area, and we had noticed and heard radio transmission over the radio saying Officer McCormick had conducted a traffic stop on Hyde Street near Essex Street. So at that point in time, we decided to go over and assist with the investigation.
Okay. And what happened when you arrived on scene?
At that time, they had already been established within their investigation. And as I was walking, I was seeing a male subject was in handcuffs, being detained, being brought back to the patrol vehicles, and there was a female subject in the driver's seat at that time.
Did you make contact with the female in the driver's seat?
Yes,
And when you approached the vehicle, did you ask her any questions?
I did.
What did you ask her?
Initially, I asked if had anyone given or asked to consent to search of the vehicle, and she said no.
Did she say anything after that?
I did request for verbal consent to search of her
Your
vehicle.
Honor, I'd object to the extent that whatever it was that Ms. Borziak had said is hearsay.
Repeat the question, Mr. Ziegler?
Your Honor, I was asking what the trooper had asked her and what her response was.
And my response, Your Honor, is that he had indicated that she had not given him consent, and then there was a follow-up question to that for which I have an objection, in as much as it's hearsay, whatever she said thereafter.
All right, Mr. Ziegler, maybe you can just pick up from where we left off and ask your next question, and let's see if that's objectionable.
Well, at some point, does the driver of the vehicle make some motion regarding the center console?
Yes, she voluntarily opened the center console, stating that I could search in that center console.
Again, Your Honor, I object to the extent that whatever it was that she allegedly said, Your Honor, is hearsay. She's not a witness that's testifying.
Your
I mean,
Honor,
at least,
if I could respond, Your Honor.
yes, Mr. Ziegler.
Your Honor, my response would be that it's not offered to prove the truth of the matter asserted. The question in this case is whether or not there was consent. That's a question of whether or not the officer had a reasonable belief that he had apparent authority to search that area. So the statements aren't offered to be whether they're true in and of themselves. They're offered to show whether or not the officer at the time had apparent authority to search that area. So it's offered for the effect on the listener, not for the inherent truth of whether or not he could actually search that area or not.
All right, I'll allow the statements for that purpose as stated by Mr. Ziegler.
Thank you, Your Honor. When she opened the center console, did she make any statement to you?
She did. She pretty much at that point in time, it said, you can go ahead and search in here. There is a knife.
Okay. And what did you do upon being notified that there was a knife in the center console?
I obtained the knife from the center console and examined the knife in itself, which was I guess if you want to describe the knife as a out of the front blade, where it was push activated with a trigger, and it shot the blade through the top of the handle, and it revealed the blade to be double-edged.
Okay. Would you describe that as a switchblade?
Yes.
It was a mechanically activated knife.
Correct.
Okay. Did you communicate that information to Officer McCormick?
I did.
What happened after you and Officer McCormick were aware of the nature of the knife?
At that point, we agreed to have the female driver exit the vehicle so we can conduct a further search of the vehicle's contents.
And did you then subsequently search the vehicle?
Yes.
What did that search reveal?
My findings at that time, underneath the front right passenger seat, we located a black lockbox. And within plain view, with the side of the slit of the lockbox, revealed to be what appeared to be illegal narcotics inside of it.
How are you able to determine that by examining the box?
Again, within plain sight, there was a small crack of that lockbox, and within the eyesight, you can actually see it inside of that lockbox, and it had a glass smoke pipe, which appeared to had like a white crystalline substance coating the inside of it. And based on my training and experience, I would identify that to be illegal narcotics.
Was that box locked or unlocked?
It was locked.
Okay. And you were able to determine that prior to opening the box?
Correct.
At some point, was a decision made to actually open that box?
Yes.
How was that done?
At that point, with that probable cause, we had accessed a small pry bar from our patrol vehicle, and we opened it up and revealed quite a bit of an unknown amount at that time of suspected illegal narcotics and paraphernalia.
Okay. When you say paraphernalia, was there actually a pipe inside the box?
Yes.
During this incident, were you equipped with a functioning body camera?
Yes.
And would any video recorded by that body camera be date and time stamped?
Yes.
And if there is video of an interaction similar to the one you've described today, date and time stamped from January 15th, starting around 1:45 a.m., would that be your body camera footage?
Yes.
Your Honor, I would move to mark People's Exhibit 1 from our motion as Exhibit 1 to this hearing.
Mr. Seeger.
My only objection.
Hold on, Mr. Ziegler, are you asking to have that admitted?
I am, Your Honor.
Okay, Mr. Seeger.
Yeah, excuse me, Your Honor. And Your Honor, the only objection that I would have to the admission of the body camera statements that are made by other parties, and as much as it depicts the investigation that Trooper Scott conducted, I don't have any particular objections to that, Your Honor, but any statements made by someone who is not the defendant, if it's used for the truth of the matter asserted, or the court is somehow considering those statements, then I would object to the admission of those portions. But in terms of just reviewing the body cam in as much as it reflects what Trooper Scott did during the course of his investigation, I don't have an objection to that, Your Honor.
Do you have any response to Mr. Seeger's objection as to statements on that video?
Your Honor, I'm not sure that there would be any, maybe there's some discussion between the officers at some point on the video that might be hearsay. I don't think the court needs to consider any of those statements. The relevance of the body cam is simply what occurred, what the Ms. Borisiak said, which has already been admitted, the nature of the box. So I have no objection to the admission of the body camera with those stipulations as laid out by Mr. Seeger.
Okay, so the court will admit the video as People's Exhibit 1 then.
Thank you, Your Honor. I have no further questions for this witness.
Thank you, Mr. Seeger.
Sure. So Trooper Scott, when so at one point in time, prior to the stop, Mr. Harshman was operating the motor vehicle. Is that correct?
I cannot recall if Mr. Harshman was in control of the vehicle. So prior to our arrival, Miss Jennifer Borziak was in the driver's seat at that time.
All right. And Miss Borziak was not arrested, correct?
To my knowledge, no.
Okay. And when you arrived on scene, Mr. Harshman had already been secured?
Yes.
All right.
It's
And
in
do
the
you know,
process.
okay. Do you know how long it was before you got there that was there any officer that was standing next to the vehicle at the time that you arrived?
When I arrived on scene, it was Officer McCormick with the Kalkaska Village Police, and then Deputy Ray Ferrier with the Kalkaska Sheriff's Office that were on scene.
Okay, but do you know where they were situated? Because the body cam that was provided or is admitted as Exhibit 1 does not show the lead up to your search of the vehicle.
Right. So when I'll note for the court, when my body cam was activated is when I had just approached the vehicle and made contact with the driver. So at that time, to my recollection, it was Officer McCormick was dealing with the defendant here, and Deputy Ray Ferrier was standing on the driver's side of the vehicle.
Okay. Do you know how much, like, so you said that you heard, I guess, maybe through dispatch or something that there was a traffic stop. Is that correct, officer?
Yes.
All right. And then do you know how much time had elapsed between you hearing that over dispatch and you arriving on scene?
I cannot say for certain exactly how much time. I mean, obviously that is noted through dispatch. But if I would had to put a number, it would just be within a few minutes.
Okay. And then you said that you observed a substance in the safety box, is that right?
Correct.
All right, and that box itself, were there any holes in it other than the crack that you noted?
No, there was no actual holes in or around the box itself.
All right, and so when you say that the box was cracked, what do you mean?
So it appeared if you were looking at the lock container, as I guess at face value there, it appeared like the one side had been smashed down enough where the top container of the lip was overlapping the edge, revealing that side. So if the lockbox, if you were opening it up from the sides, that seal was cracked open just enough where you can actually look inside.
Okay, and the pipe that you found, it was a smoking pipe, is that right?
Allegedly it could be used as a smoking pipe, but yes, that'd be my guess at the time.
Okay, all right, and so possessing a smoking pipe in and of itself is not illegal, correct?
If it's paraphernalia, just depending on the type of smoking pipe in itself. I mean, that's something
Okay,
that
but I
with
mean,
training, through training and experience with the white crystalline substance with the smoking pipe, I could say that would be illegal. But just possessing a clear non-use smoking pipe, no, that is not illegal.
all right, I mean, you can buy a smoking pipe at any marijuana store in Kilkasket County, correct?
Correct.
All right, and also the pipe itself, like people can smoke all kinds of substances in a pipe, right?
They can, yes.
All right, like, and just in terms of marijuana, people use keef, correct?
They
Are
can,
you
yes.
familiar? All right, and keef is a crystallized type looking substance, right?
Well, I personally have not much had experience with the substance that you're identifying as.
So you don't have any training or experience with people using marijuana?
With marijuana, yes.
All right, so but you're not familiar with keef?
No, I'm not.
All right, or any other crystallized substances that are related to marijuana?
No.
So, but your training and experience includes all kinds of different drugs?
Yes.
All right, and how long have you been a trooper, Trooper Scott?
I've been with the Michigan State Police for probably a little over 3 years.
All right, and so when you say that you have training and experience, how many stops previous to marijuana becoming recreationally legal or medically marijuana did you, how many times were marijuana, did you make have you ever made an arrest related to marijuana?
I have.
All right, and did any of those people have pipes?
Yes.
All right, and were any of those pipes used?
Yes.
All right, and did any of those pipes have residue?
Yes.
All right. And so it's possible that when you were looking at the pipe that you allegedly saw through the crack, that it could have been residue from another substance?
At that point in time, when I had peered into the locked container, like I mentioned before, there was that glass smoke pipe that was lined with the white crystalline substance, along with other suspected narcotics and paraphernalia inside the container.
Okay, but that's not the question though. Like you weren't able to determine just by looking at it what the residue was in the pipe, right?
Well, I appeared, it looked like a white crystalline substance. That's what I identified it as.
Okay, well, I understand that, but you didn't test that prior to opening it, right?
No, I was unable. There's no way I could test at that time.
All right, and you have the ability to do like roadside, like a true narc test, right?
Theoretically, yes.
All right, and you didn't find any, residue on the outside of the box itself, correct?
Correct.
All right, and the driver of the vehicle didn't give you permission to look in the lockbox itself, correct?
Correct.
All right, Mr. Harshman did not give you permission to look in the lockbox itself, correct?
Correct.
All right. And the box itself was locked, correct?
Yes.
All right, and you didn't seek a warrant of any kind to manipulate that box, correct?
Correct.
All right, and you could have sought a warrant if you had probable cause to believe that there was some kind of illegal item in the box, correct?
At that point, we established probable cause with exigency.
Okay, it was exigent for you to open the box at that time?
Yes.
All right, and why was it exigent for you to open the box?
It was from the moving vehicle in itself.
Okay, but I don't understand why it was exigent. So you're saying it was an emergency. Exigent means to me that it's an emergency. Why was the situation exigent?
Well, again, at that point in time, we established that probable cause, and with the vehicle exigency, we determined with my training and experience that we opened up the container.
All right, but you opened up the container with a pry bar, right?
Yes.
All right, and so when you say that it was exigent, it wasn't as if that box was going to disappear, was it?
The vehicle could have, yes.
All right, but the person was detained, right? The driver was detained, right?
The driver at that point in time physically was not, even though it was a traffic stop investigation.
Okay. So you could have sought a warrant then, right?
Theoretically, yes.
All right, well, theoretically, but you didn't, right?
Correct.
All right, so your probable cause is based solely on what you allegedly saw in the box itself, right?
Yes.
And you could have, I'm sorry, you could have detained Ms. Borziak, right?
At that point in time, yes.
Okay, all right, and so the vehicle wasn't, the vehicle could have been towed, right? I think that there wasn't a proper plate on the vehicle.
I cannot recall.
Okay. And so, Trooper, it wasn't really clear to me. So when I was looking at the body cam, it appeared as though you were manipulating articles in the vehicle prior to asking for consent to search the vehicle. Is that correct?
Ms. Borziak requested for her coat.
Okay, but you were manipulating that coat in advance of asking for consent to even enter the vehicle, right?
I did not search the coat.
Okay, but you were handling the coat, right?
She requested for her coat.
All right, were you handling the coat?
At that point in time, I may have put a hand on it without manipulating or looking with the intent of searching the coat itself.
Okay, so was she free to touch the coat?
Your
Yes.
Honor, I'm going to object to this line of questioning. I don't see what the relevance is of the officer handling or even searching the coat because no item that would be suppressed was found in the coat. It doesn't have any bearing on the questions before the court.
Well, Your Honor, I guess the only relevance there, at least, and I'm just trying to create a record, is that the officer appears to have been manipulating articles within the vehicle in advance of obtaining consent. If consent was ever given.
Well, I mean, if the driver asks for the coat and he's providing it to her, he's got to touch the coat. So to me, that's consent to touch the coat when she asked to have it. So I think we can move on from the coat.
Okay, thank you, Your Honor. Ms. Borziak was the one that provided you with the knife, right?
She was the one that opened up voluntarily the center console, yes,
All right, and did she say that there was a knife in there?
correct.
I don't have any further questions, John.
Thank you. Mr. Ziegler, did you have any follow-up questions?
Very briefly, Your Honor. Trooper Scott, you're familiar with what's called a true narc or some kind of field test for controlled substances?
Yes,
Have you performed those kinds of tests in the past?
I have.
To your training and experience, would it have been possible for you to true narc or field test that substance while it was still in the box?
We could have, yes.
Okay. Did you have one of those tests on you?
I did not.
No further questions, Your Honor.
Mr. Seeger?
No further questions, John.
Trooper Scott, I have a couple questions for you. Do you know whether, and I'm referring to the box that you ultimately pried open and is the subject of this motion. Did you ever inquire as to whether or not that box belonged to either Mr. Harshman or Ms. Borziak?
During the vehicle search, no. It was after the contents. Well, without my recollection, I don't know if that conversation took place when we had found that locked container, but at the same time, when I was looking through, revealing the contents, when we pried it open, it was brought to Officer McCormick's attention, who then continued on with his investigation.
Okay, did you ask for consent from either of them prior to opening the box?
To my recollection, I did not.
Do you know if anyone at the scene did?
I do not recall.
Okay, and then again, you don't recall whether or not either of them was asked if they had, whose box it was, I guess.
I do not recall that conversation at that specific time without reviewing further body cam footage or body cam footage from others.
All right, thank you. Mr. Ziegler, any follow-up questions to those that I just asked?
No, Your Honor.
Mr. Seeger?
No, sir.
Okay. Is Trooper Scott free to disconnect at this time?
Yes, Your Honor.
Mr. Seeger, any objection to that?
No, sir.
All right, thank you, Trooper Scott. You're free to disconnect, but you're free to remain on the line if you'd like to as well.
Thank you, Your Honor.
Mr. Ziegler, any further witnesses today?
No further witnesses, Your Honor.
All right, Mr. Ziegler, anything you'd like to present today by way of oral argument?
Your Honor, largely I would rely on my brief. I think the evidence, including the video, which was admitted, establishes that there was a consent to look into the center console. The driver of that vehicle, Ms. Borisiak, voluntarily opened the console without any prompting, without any direction, without any questions about weapons. She voluntarily opens that console, indicates there's a knife in there. The officer takes the knife, establishes that it is a double-edged, non-folding stabbing instrument, which would be illegal to transport in a vehicle in that manner under MCL 750227. At that point, there's probable cause to believe that there is evidence of a crime in the vehicle. At that time, the motor vehicle exception would apply. Officers are then justified in searching the entire vehicle under the motor vehicle exception. Mr. Seeger was asking questions on direct about exigency and about emergency. Case law clearly establishes that a motor vehicle creates an exigency. This has been case law for quite some time. It's been U.S. Supreme Court case law. There are Michigan cases establishing that. I've cited them in my brief. A motor vehicle that is readily mobile creates an exigency. Officers are thereby justified in searching the entire vehicle for evidence of that crime or any contraband that might be related to that. So their subsequent search of the vehicle, even though it was done without consent, was properly done pursuant to that warrant exception. Additionally, I would note, although I did not cite this in my brief, in response to the court's questioning about the owner of the box, there is a U.S. Supreme Court case, Wyoming versus Houghton, Houghton, which states that when officers are doing a probable cause search of a motor vehicle under the motor vehicle exception, they are justified in searching into any container regardless of ownership of that container, so long as that container could conceivably contain the evidence that they are looking for. It's a 1999 US Supreme Court case. So that establishes that regardless of whether the box belonged to Mr. Harshman or to Ms. Borisiak or to some third party, officers are justified in searching in that container, so long as that container could contain the evidence they are searching for. Since the container contained narcotics and a pipe, it could also have conceivably contained a knife, a small knife or some other concealed weapon that may have fit into that box. Also, I would say that once the officers look into there and see a glass smoking pipe, crystalline substances, there's residue on the pipe, they also have independent probable cause to get into that box, which is still in the vehicle. So either way the court wants to look at it, the motor vehicle exception applies to the search of that box, whether it's just because they had probable cause to get into the vehicle generally, or whether they had probable cause to get into that container in particular. The motor vehicle exception applies. The search is justified. Even if it's not, I would argue that the good faith exception applies, and I've detailed that in my brief as well. Thank you, Your Honor.
Thank you, Mr. Seeger.
Your Honor, the only reply that I would have, and this is just in response to the brief that was filed by Mr. Ziegler, is at least the brief that was filed by Mr. Ziegler appears to be prefaced on the idea that law enforcement found a what's alleged to be an illegal knife in the vehicle, and such that the motor vehicle exception somehow applies. First, I would note, Your Honor, if the court looks at the court file and looks at the felony information, you will see that the court or the district court made a determination that the CC or the weapons charge was not bound over. So there was no probable cause to believe that the alleged item that was perhaps advanced by the prosecuting attorney's office as a vehicle to allow them to have access to the vehicle and subsequently do a search, that matter was not bound over. So I think that that's their first problem. So when the court makes its own findings, he's not bound over on that, Your Honor. So I mean, like, I guess to a certain extent, what a police officer, quote unquote, believes to be probable cause and what a court later determines to be probable cause, I would probably have to defer to the court's findings, not the alleged good faith belief of the officer. Additionally, Your Honor, when I looked at the body cam, Your Honor, which the court has had an opportunity to review, it does not really appear to me, and maybe it appears to the court, that there does not appear to be a hole in the box such that you can see it. The body cam footage, or at least as I reviewed it, did not look to be very telling one way or another. The officer, based on his quote unquote training and experience, is able to identify certain substances, I guess, but it's strange to me that he's also likewise unable to identify marijuana, which seems to be a much more common substance, which was illegal at one point in time. And you can buy a smoking pipe pretty much anywhere in Kilkaskia County at the local grocery store, at one of the, I don't know, 10 dispensaries that are in Kilkaskia County. And there are numerous different forms of marijuana that are going to leave residue. To what end that is, Your Honor, I guess based on his training and experience, he's not able to identify those things, which I find to be odd, which really goes to my belief that his testimony is not entirely credible. My larger problem, Your Honor, is that the officer pretty much admitted that he could have sought a warrant. And in as much as like the prosecuting attorney is advancing this theory of the motor vehicle exception, I don't see an exigent circumstance because both parties were exited from the vehicle. So if they wanted to seek a warrant, I'm familiar with the process based on my training and experience, Your Honor, and it is not entirely difficult to request a warrant. And obtaining a warrant is probably not entirely difficult. It's just strange that it goes through a detached and neutral magistrate, which in this case, they decided we'll just use a crowbar and break into somebody's item. He also admitted that he could have field tested the substance, for which he did not. no consent was requested or given by any of the occupants in the vehicle. And so I find those to be large problems in whether or not the actual seizure of the box and manipulation of the box was legitimate. I guess I would largely rely on my brief itself, but I do not find the theory of the prosecuting attorney to be compelling in any way. And I guess my larger problem is, you know, we have all these exceptions that the higher courts have carved out, I guess, but like good faith to me means that like you are actually acting in good faith. In this case, it appears to me that they just unilaterally decided that we were going to break into somebody's personal belongings without the benefit of obtaining a warrant, which is not a difficult process for them to execute. The parties were detained. If they thought that there was they had reason to believe that there was probable cause that there was some kind of foreign substance within the contents of that box, presumably, Your Honor, it wouldn't have been difficult to obtain a warrant because that happens all the time. I don't know how many files I have, Your Honor, but there are warrants for pretty much every case that I have, and I have almost never seen a warrant be declined when requested. So I find it somewhat legally disingenuous that the officer is maintaining, or at least that the prosecuting attorney's office is maintaining, that it was somehow an exigent circumstance because no one was going anywhere, Your Honor, and they were in possession of the box. And if the court looks at it factually, if you review the video, Your Honor, I did not see, and the court can correct me if I'm wrong, but I did not see when I was looking at the body cam itself, I did not see this alleged hole or crack in the box such that I could see inside of it. The only thing that I saw later was after he manipulated the box with a pry bar, the contents of that box. And so I would just ask the court to grant the relief that's requested. And I don't generally have any further argument, Your Honor.
Thank you. Mr. Ziegler, any response?
Just very briefly, Your Honor, the defense mentions that the count regarding the knife was not bound over. First and foremost, that has no bearing on whether or not the officers had probable cause at the time they initiated the stop and did the search. Obviously, the officers can't be expected to know what a court is going to rule or not rule in the future. Second of all, there's no evidence or testimony about why that count was not bound over. The court can't just assume that the evidence was not sufficient. There may have been other reasons why that count was not bound over. There's no transcript available to the court. Third, we had testimony today about what that knife was. It was a push open mechanical knife. I would describe it as a switchblade, but a mechanical knife. Officer testified that it was double-edged, meaning it had a blade on both sides. Statute is quite clear that any sort of double-edged, non-folding stabbing instrument cannot be transported in a motor vehicle in the manner it was being transported. So the facts as presented to this court today establish at a minimum probable cause to believe that there was an offense being committed. Whether or not that offense actually results in a bind over or in a conviction or whatever later, that has no bearing on whether the officers have probable cause at the time to do a search. Defense brings up marijuana keef. Even if it's possible that that residue was marijuana keef, and I don't know what that looks like on a pipe. I've never seen that. I'm not a medical expert or a drug recognition expert. The standard is probable cause. It's not proof beyond a reasonable doubt. So the fact that there is a pipe and some crystalline substance in a box, I think that is at a minimum probable cause to believe that there may be narcotics in that box. Finally, Mr. Seeger argues that they could have sought a warrant. The standard is not whether they could have sought a warrant or not. The standard is whether or not a search warrant exception applies. In this case, as I've established, the motor vehicle exception applies. I cited several cases in my brief discussing the motor vehicle exception, the legal underpinnings of the motor vehicle exception. There are numerous cases about the motor vehicle exceptions. Long and short, there doesn't need to be an emergency. There's no requirement that if a warrant could be sought, that a warrant must be sought. As long as there is a motor vehicle plus probable cause, officers are allowed to do a search. It doesn't matter whether they could or could not have sought a warrant in any particular case. So for those reasons, Your Honor, I think the search is justified.
All right, thank you. Again, I did have a chance to review the briefs of the parties and the law that was cited by both. Had an opportunity, of course, to listen to Trooper Scott's testimony here today and an opportunity to review the entire, again, 33-minute video of the stop. The first question here I think the court needs to consider is whether or not there was probable cause to search the vehicle. It's clear to me based on the video that the driver of the vehicle did provide consent for the officer to look in that center console area. She lived in an unbound area. And in my view, she clearly gave consent to search that part of the vehicle and informed the officer that there was a knife there. The court finds that the discovery of the knife would provide probable cause to search the vehicle. That knife was clearly contraband under the case law and the motor vehicle exception. If you've got a vehicle that's mobile and an officer has probable cause to believe that that vehicle may contain contraband, then the officer can conduct a roadside search without a warrant. And that's what happened in this case. We found a double-edged knife that was mechanically operated. That's contraband, where the officer had reason to believe that that was contraband. And so the court finds that that would allow for the search of the vehicle itself. During that search, the officers located this black lockbox. One of the things that stood out to me, and neither counsel really addressed this, but does the defendant even have standing upon discovery of that black box to assert a Fourth Amendment privilege? That's a threshold matter. The defendant has to have a privacy interest in that box to be able to assert that it was wrongfully searched. And that means that the defendant had to have a reasonable and personal expectation of privacy in that box. The factors that the court looks at to make that determination is whether or not the defendant owned the box, whether he had possession and control over that box, whether there was historical use by him of that item or property. Did the defendant have the ability to regulate access to that? And then, of course, generally the totality of the circumstances. And one of the arguments that Mr. Seeger makes in his brief at paragraph 19 is that the defendant denied knowledge of the box and informed the officer that it must have belonged to the previous owner of the vehicle. And part of this traffic stop was the driver and I believe Mr. Harshman both claiming to police at the time that they had just purchased that vehicle. So the defendant can't claim that he doesn't own or possess that box, but at the same time assert a Fourth Amendment privilege to prevent the search of that box. It's got to be one way or the other. Either the box is his and he can assert the Fourth Amendment privilege and make these arguments that he's making today, or it's not his and he doesn't have standing to assert a Fourth Amendment violation. And based on the arguments in the brief, and the officer wasn't clear here today in his testimony about whether or not they had knowledge that Mr. Harshman was denying possession of it at the time. But either way, clearly he's denying possession of it now, or at least for the purposes of this motion. And so if that's his argument, the court finds that he doesn't have standing to assert a Fourth Amendment privilege. If it's not his, he doesn't have ownership of it, he never had possession or control over it, he never used it in the past, and then the totality of the circumstances based on an argument that it's not his and it belonged to the previous owner of the vehicle, then there is no basis for him to assert Fourth Amendment privilege. He didn't have a reasonable expectation of privacy in the contents of that box. And so he can't now make an argument that the police shouldn't have searched it. And case law is very clear that he can't assert a Fourth Amendment right on behalf of whoever the owner of that box is. So to the extent that Mr. Harshman would argue at trial that it's not his, there would be no reason to suppress the evidence here based on standing. So the court would deny the motion based on standing. To the extent that it was his, and he is able to assert a Fourth Amendment right with regard to the contents of the search of that box, the court finds that there is sufficient evidence to support a plain view exception here. Looking at the video, I mean, I agree with Mr. Seeger. It's hard from the video to see what the officer could see, but I wouldn't expect that a body cam video would be able to depict exactly what an officer would have not seen in that box through the opening. But what we have is the officer's testimony, and his testimony was that he was clearly able to observe both pipe and a white crystalline substance. The officer is not required to make a positive identification of the substance that's in there. Again, we're just talking about probable cause. There's no need for an officer to try and stick some kind of testing device inside that box to make a positive determination of what the substance is before he can search it. He just has to have probable cause that there's contraband inside. Based on the video and the officer's testimony, they could hear a pipe, they could see a pipe, they could see a white crystalline substance. There was actually white crystalline substance falling out of the box as indicated on the video. And so looking at those circumstances as a whole, based on that officer's training and experience, certainly it could have been other things, but he had probable cause to believe that that was contraband. And so the officer had the ability to open that box at that time. Again, whether or not, and I agree with Mr. Ziegler, whether or not, and this goes back to the initial search of the vehicle, whether or not that weapon was eventually determined to be contraband by a court, or whether it was dismissed as part of a preliminary examination. Again, that's not information that an officer would ever have at the scene, and isn't required to have, and doesn't later invalidate police officers' probable cause. So for all those reasons, the court finds the evidence should not be suppressed, and the court will deny motion to suppress. And Mr. Seager just asked that you provide an order to the court that reflects the court's ruling here today, either with the stipulation as to form from Mr. Ziegler or under the 7-day rule. And then we also have to set, I'm sorry, go ahead.
In your honor, and Mr. Ziegler, do you have an objection to me just signing your name with permission, generally just saying for the reasons stated on the record?
Please do.
All right. Thank you, Your Honor.
Okay, and then in terms of the status conference today, Mr. Seager, did you want an opportunity to talk to your client in light of the court's ruling, or did you want to proceed with any scheduling on either of these today?
Well, Your Honor, I think that when I had last spoken with Mr. Ziegler, there are two files which the court has, but that it's my understanding that we would both prefer to handle the drug case first, to the extent that we're going to go forward with either of the trials. I have talked to my client and he wishes to proceed to trial. That does not necessarily mean that some kind of potential resolution can't be met at some point in time in advance of trial, Your Honor. But to my understanding, currently Mr. Hirschman wishes to proceed. And so if the court dockets a trial date, whenever that would be appreciated. And then the second item would be if the court would give us one final settlement conference in advance of the trial date, that may be helpful as well.
Okay, so that would be as to file 234778, which is the drug charge. So the court will set that for a jury trial at its next available date. Mr. Ziegler, can we do that trial in one day, or are we going to need more than that?
I think we could do it in one day, Your Honor.
Mr. Seager?
Likewise, Your Honor, I believe it's a one-day trial.
Okay, so we'll set it for a one-day jury trial at the court's next available date. Because Mr. Harshman is lodged, this will be given priority. And then the court will set it for one final status conference at the motion day immediately preceding the trial date. And that will act as a plea cutoff. Mr. Ziegler, anything else I can address for the people today in terms of scheduling?
No, Your Honor.
Mr. Seager?
No, sir.
Okay, so, and I'll set the other file for a status conference at the same time as the final status conference in 234778. The court will notify the parties of the trial date as well as the final status conference. That's all I have for today. All parties are free to disconnect on this file.
Thank you, Your Honor.
Thank you.
Mr. Sweeney, your client, Miss Cabrian, is here, and I saw you earlier. Thank you for coming back.
You're welcome, Your Honor. It was not of my own volition. The whims of technology have been throwing me back and forth a little bit this morning. I apologize if I cut out. I'll be making every effort to return if it happens again. We are prepared to proceed on Ms. Cabrian's matter. I believe she's present via Zoom. And Your Honor, this matter is before the court for confirmation. I expect that the state will be raising a motion to continue. I did receive notice of that motion to continue. I do have an extensive response and would request an opportunity to address the court prior to the court making a ruling.
All right. And Ms. Green, anything to add to your motion to continue?
No, Your Honor, thank you.
All right, Mr. Sweeney.
Thank you, Your Honor. I understand the state's position in this. I also understand that Mr. Brettler's unavailability is unavoidable and that Ms. Green will be forced to kind of step into that role suddenly and abruptly. However, there are sort of two competing reasons why the defense, or I should say complementary reasons why the defense is objecting to this motion to continue. One is, Your Honor, this is alleged to be a no contact order violation case. This is a no contact order violation case in which the alleged victims are also the protected parties and are also the sole eyewitnesses as to the violation occurring. I will note for the court's information, defense has not been provided with a witness list, and it is defense's understanding that the alleged victims have reached out multiple times to the prosecution, indicating that they do not have information that is helpful to the prosecution, and they are uninterested in the case proceeding. I raise this, Your Honor. I understand this is somewhat putting the facts before the court in the inappropriate venue, but I do think it is important for the court's consideration of the prejudice that Ms. Cabrian is going to suffer as the result of a continuance in this matter. Ms. Cabrian is 39 years old. I understand somewhat gauche to raise her age. It is relevant because she is attempting to enroll in the Air Force. The Air Force has an age limit that restricts enrollment after the age of 39. She is going to be turning 40 on September 12th. She's been attempting to enroll in the Air Force for several months. As the court can see, this case has a significant pendency, and she has been attempting to enroll in the Air Force, I believe, for the last 6 months. Ms. Cabrian can correct me if I'm incorrect in that estimate. Is that correct, Ms. Cabrian?
Yes, I've been working with a recruiter since January, and he is waiting.
Yep. And Your Honor, the reason this is significant is because the recruiter requires all conditions to be cleared before Ms. Cabrian is eligible to submit the basic testing that's required for enrollment. Ms. Cabrian has provided multiple practice tests with passing scores. It's anticipated that she should pass. However, she's required to enroll in that test, provide a passing grade prior to her ability to actually enroll in basic training. Basic training would be likely to occur in either July or August. If this case is delayed significantly, if there's more continuances granted, it will not only affect the likelihood that Ms. Cabrian will reach that September deadline and be ineligible to proceed forward with her attempts to enroll in the military, which she's been attempting to do for some time now. It will also limit her ability, her recourse, should she fail the test that she is required to complete. The interval of retakes on these tests is 1 month. As a result, she's already facing a disadvantage relative to other applicants and entrants because she has fewer potential retakes available already. And a continued delay really puts all her eggs in one basket for being able to pass this test. While I understand that the state might have an interest in making sure that they can put forward the strongest case possible, frankly, I just do not see that in this case where a witness list hasn't been filed, the alleged victims have been reaching out and making affirmative attempts to try to communicate with the prosecution, and it is a simple no contact order violation case, that the difficulties that Ms. Green will face in trying to be brought up to speed quickly at all outweigh the significant and extreme prejudice that Ms. Cabrian will face should she be unable to proceed forward with the career that she's been attempting to enter for the last several months. This is literally a last chance in Ms. Cabrian's lifetime opportunity that she'll be foregoing should this case continue to face unnecessary delays. So for those reasons, Your Honor, defense will be objecting to the motion to continue.
Thank you, Mr. Sweeney. That was very detailed. Ms. Green, one question for you. Is it just the absence of Mr. Bretler, the deputy prosecuting attorney assigned? That's the sole basis of the motion to continue, correct?
Yes, Your Honor.
All right, I'm going to deny the motion to continue based on the fact that I think the state can proceed on a violation of a protection order case without the assigned deputy. I think any deputy in your office should be able to prepare that case for trial. It's not an assault 4. It's not a difficult case. It's a violation of a protection order case. So I do think that it is unnecessary to continue this, and that any kind of delay in this would create a substantial hardship and would prejudice the defendant, given the situation that has been outlined by Mr. Sweeney. So I would ask that your office get someone assigned to this case in lieu of Mr. Bretler and have this case prepared for trial, as I am going to allow it to proceed on the current docketed dates, which are June 12th and June 13th. Ms. Cabrian, your case will go to trial on June 12th unless you hear otherwise from your attorney or the state on this matter. That is in person, so that is not a virtual appearance. So please make arrangements to appear in court in person for trial on July 12th at 9 a.m. unless you hear from your attorney before that there's been some other resolution.
And
Yes, Your Honor.
just to confirm, Your Honor, that's June 12th, correct?
Did I say July?
Yes.
I am really getting the dates mixed up today. June 12th. Thank you, Mr. Sweeney.
No problem. I just wanted to make sure there wasn't any confusion. Thank you.
However, Ms. Simmons, it appears, is her attorney of record, and I don't see Ms. Simmons.
All right. Good morning, Ms. Geiger. Have you talked to
Good
Ms.
morning.
Simmons?
I have not yet. I've gotten all the stuff that she was asking me to get. Or
Do you have
but
any?
I haven't had a chance to talk to her yet.
Okay, Ms. Green, do you have any notes on whether or not who's assigned to this case?
It is Miss Williamson. It is a non-DV case. It was just set to today's calendar. I have no information about how today is supposed to proceed.
Okay, and it looks like, would this have been set in error on today's docket? Should this have been set on a different?
Well, I know what it's supposed to. Hold on.
Have you talked to Ms. Simmons today, Ms. Geiger? Or
No,
recently?
I have not. I have not. I was supposed to talk to her investigator, but he never called me or got a hold of me, and I didn't call her before the court date today. She hasn't even talked to me to hear my side of the story yet.
For speed trial.
But I think she's supposed to be my lawyer for all of my cases there now at Thurston County.
All right, hold on a second.
I will.
All right. We only have speedy trial through June 19th, and we don't have another public defender on. Oh, Miss Simmons is here physically or on Zoom?
She's in courtroom number 3. Yeah.
Can we send her a message? Can we email the clerk there to have her come over here? She's on Zoom in courtroom 3. We're going to email the court clerk in courtroom 3 to let her know that when she is available to Zoom into our,
Oh, I'm sorry. My mom was talking. I couldn't hear you. I'm sorry. Go ahead.
Your attorney is in courtroom 3 on Zoom. So we're going to send her a message to come over to this Zoom platform. So you can go on mute and just hang out and wait a little bit. That would be great. And we'll see if we can get her over here to figure out what's going on.
Sounds good.
If you and her need to have a conversation, I can take a recess and you and her can connect on a Zoom call in a breakout room and have a confidential conversation before I take your case on the record. Okay.
Okay. Thank you. Is this court date today is just for the DV or is it for any of my other cases? Mom. Sorry.
Yeah, this looks like it's for a non-DV case. It looks like it's for a hit and run attended vehicle, but let me look up and see if you have, give me 1 second. I'll try to answer that question for you. Trying to pull up her criminal history. Does she have other cases set in Thurston County District Court? My thing is just circling.
She was originally my lawyer for the domestic violence, and then
Oh,
the last time I
so-
spoke to her, she had taken over my hit and run case.
All right, so which one was this?
Assault for the 22 PD 0909.
Ew.
That was dismissed on March 27th.
Okay. All right, so there is a assault 4th degree from July 3rd of 2022 that was dismissed.
Oh,
And then
huh?
there is a civil protection order that you're the respondent in.
I'm confused.
Are you talking about, I'm trying to figure out what case you might be talking about.
For
That
which-
might be. You keep saying you have a domestic violence case.
Yeah, so the paper I'm looking at right now is for, it says, oh no, actually this one says hit and run for this one. But yeah, I
Okay.
had a domestic violence case that was an
So-
assault and malicious mischief.
Okay, so that case was dismissed. There was a July 3rd case of an assault 4th degree and a malicious mischief charge. And let me just go and look when that happened.
With the Mr.
But
Beagles?
huh?
I had a restraining order with the Mr. Beagles. Is that dropped as well?
Let me take a look.
Thank you.
My computer's just circling.
I have that effect.
The protection order that was connected to that case
Uh-huh.
was dismissed, but I don't, she's got other. Sure.
You want me to move this up so you can
And
see
she's
it?
the respondent in a protection order violation or a protection order. All right, we're checking a couple of things here. So Gary Lee Beagles is, there was a no contact order issued in September of 2022. That has been rescinded, meaning that's not in effect. And that looks like it was connected with the domestic violence assault 4, but you may have some other no contact orders out there. We're checking.
I have an anti-harassment that was filed recently and a it's not a domestic violent, but it's a not, I don't know the difference, but it's not like a restraining order. It's a protection
No
order or
contact,
something.
a protection order, a civil protection order.
Yeah, it was my boyfriend at the time, my boyfriend's ex or whatever. And so he's back with her. I don't ever go around there or see her. And it was granted because my Zoom cut out. And I just didn't even bother to fight it.
Okay, so you do have 2 civil protection orders, it looks like, one out of Pierce County District Court and one out of Thurston.
I have one out of Pierce? For what?
It looks, what is that, PD
There's
one?
2 Michelle Geigers too.
Oh,
2 Michelle
hold
L.
on a sec.
Geigers.
Hold on. Maybe it's not Pierce.
I said there's 2 Michelle L. Geigers, one's out of Kittitas County or whatever. I don't know.
What'd you say?
Yes, it's one from Pierce.
Oh, it is from,
Oh, that's the one with that I'm talking about. The protection order. That's Pierce County is Eatonville.
okay. All right, so you're aware of the 2 civil protection orders you have.
Yes, one with Tony
Okay.
and one with Carol.
So those are out there. Those
Okay.
are in effect. There's 2 civil protection orders, but the no contact order that was associated with the assault and the malicious mischief is dropped. That's the Gary Beagles. Okay.
Okay.
All right. So I can't give you any other information. So we'll wait for your attorney to come over on Zoom. Okay.
Okay. Okay. Thank you.
How long is that going to take?
All right. Thank you.
It is, Judge.
Okay. And that's 23 CR 003862B. Got DUI, driving under the influence of alcohol, less safe, offense date, June 16, 2023, pretrial.
Second arrest, 2004, sale of cocaine.
Okay.
Yes, Your
Date?
Honor. In this case, the defendant was charged with DUI, alcohol less safe. He was pulled over by Roswell PD. Upon making contact with the defendant, it was determined that the driver was a less safe driver. He was booked on this charge. State is asking for a $2,500 surety bond, no weapons, drugs, or alcohol, or driving while out on bond.
All right. PD Kim. Yes, Your Honor. Mr. Holloway is 42 years old. He was born in Florida and he moved here about 2007. He's been here for about 16 years in Georgia. Your Honor, he was the one who called 911 because there was another driver who was erratic in driving and he wanted to avoid that car and got into a accident, I guess. And then he was the one who called the police to get help. However, he was misunderstood as a DUI less safe. We would like to request for signature on bond. He is a driver, Pizza Hut driver. He does cashiers and all that kind of stuff. He does a lot of driving, Your Honor, and that's main source of income for him. And he graduated from high school. After that, he went to Job Corps. Your Honor, we would like to request for a signature on bond. Thank you. State, were there was field sobriety done or?
We only have the warrant right now, so I'm not sure if he refused or not. But that's all the information I have currently.
There was no test was done whatsoever, Your Honor. He was not even offered to do it. He didn't even have a chance to deny or anything like that. All right. I'm going to order a $3,000 signature bond. I'm going to order that signature bond through the jail. I'm going to order no drugs, no alcohol, no weapons or guns while on bond. And I'm a little torn, state, as it comes to no driving. I usually say no driving unless you have a valid license, and I don't know if his license were taken to go through the administrative process or just what the status is. I understand he drives for a living, but we just want to make sure there are no issues. They have muted him. And I don't know, PD Kim, if you want Mr. Holloway to respond to that. Mr. Holloway, would you like to respond to the fact that, will you be okay? Did the police take away your driver's license? Yes or no, please?
I'm sorry, say again.
Did the police take away your driver's license?
Not to my knowledge, I can double check the law.
Yeah. Yes, so Your Honor, we would like to continue the driving, and even the police probably think that he was not fully drunk, Your Honor.
Well, Your Honor, I'll just take the obvious. It looks like the defendant is still in his work uniform, which leads me to believe that this happened while he was on the job. So if he is a Pizza Hut delivery driver, and he was arrested for DUI, that's a serious concern of the state.
True. I don't think Pizza Hut would have him still driving if they learn of this charge. I generally say there's no driving except for court and coming to see your attorney, usually medical situations. And sometimes I include work, but I'm concerned I don't want anyone to be hurt out there on the road with it. And it's just that I don't have a lot of information to consider at this point.
My apologies, Judge. They did not take his license. He currently still has his license on him.
Okay. All right. I'm giving you the signature bond to let you out. I'm going to go ahead and allow, because I don't have any priors to consider with driving violations. You had nothing else on a driving history, correct, pretrial?
Right, yeah, no.
I didn't pull the driving history. I
checked it, Your Honor. I didn't see anything.
Didn't see anything. All right, I'm going to, Mr. Holloway, very cautiously allow you to drive while on bond only, and I'm gonna limit you a little bit for work, court, and to see your attorney, and any medical visits that you need to make. And any other time, you need to be at home. If you were younger, I'd put you on a curfew, but I'm not going to do that. But I just wanted to be limited driving, and hopefully you will sort through this, and that I'm not putting someone back on the road, you know, who may hurt others or hurt yourself. Okay.
Yeah, I appreciate that, car is needed.
Please do not say anything else, Mr. Holloway. All right. Thank you. That concludes this case. Thank you.
Position 4.
Linda Njima charged with 1 count of battery family violence. Pretrial.
First.
Oh, you said that. I'm sorry. I just saw that in the chat. All right. First arrest, state.
Yes, good afternoon, Judge Missy. How are you?
I'm good. How are you?
I'm good, thank you. So this incident occurred June 15th, 2023 in South Fulton. And this is where the defendant punched Mr. Orock Elias in the face, leaving him with a bloody nose. Your Honor, this incident started because the defendant's husband, Mr. Elias, told her that he was having a child with someone else. And so she asked the other woman to come and discuss what was going on. And after the woman left, Mr. Elias was upstairs in the bedroom, and the defendant broke into the bedroom and she punched him in the face. The defendant told the officers that she didn't hit him and that he instead, or an alternative, had allergies, which was causing his nose to bleed. But our office did speak to Mr. Elias, and he let us know that they have been together for 10 years and they have a 3-year-old daughter together, and they live together at the incident location. He let us know that they do not have a domestic violence history and that he's not afraid of the defendant. And he also told us that he did not want her arrested, nor does he want to press charges, Your Honor. However, the state, given that this happened 2 days ago, the state just wants to make sure that there is an adequate cooling off period between the two. So because of this, the state's recommendation is a $3,000 surety bond. We're asking for a 1-day anger awareness course, no further contact with Mr. Elias, and to stay away from, as well as no alcohol, drugs, or weapons while out on bond. And we're asking for a one-time police escort so the defendant can get her belongings, Your Honor. And it looks like Mr. Elias is on the Zoom call, so I'd like to sound for him.
All right, Mr. Elias. Do you wish to address the court today?
Yes, Your Honor.
All right, raise your right hand for me first. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, first question is, and I think I know the answer. Are you in fear of Miss Njima?
Excuse me, can you say it again?
Are you in fear of Miss Njima?
No.
Is she your wife?
Yes, Your Honor.
And what else would you like to say?
I would like to say she didn't hit me. When she woke me up when I was sleeping, I realized I had a nose bleeding, so I thought she hit me, but she didn't hit me. I know when I called the officers, when they came over, I was about to, because when I called 911, they said, if anything changed, let me call back. So I was trying to call back. They were so quick to come to the scene. So I tried to stop them. They said, no, right now they have to take her to jail. So yeah, I don't want to press no charges. She's never been to a situation like that, except when the lady came over.
All right, any cross-exam in ASG Bickerstaff?
No cross, Your Honor.
Anything, Mr. Coleman?
Got to unmute. Good afternoon, Your Honor.
Good afternoon.
Yes, I'll be requesting cinch bond for Ms. Njima. She does not have any criminal history based on her husband's representation. There is no history of violence between the two of them. My client is 34 years of age. She does reside in Fulton County. Ms. Ajima does have her master's degree. She's currently employed as a home health care worker. Again, first arrest, representations of the alleged victim that he is not in fear of his wife, and actually denies that she ever even hit him. I'd be requesting a signature bond.
All right. I'm going to order a $3,000 signature bond. I'm going to do that signature bond through pretrial per judge. I'm going to order the one-day anger awareness course through pretrial. No drugs, alcohol, weapons, or guns while on bond. But my concern here is the cooling off period. At the very least, there seems to have possibly been an argument over a situation going on during their marriage. So, and I understand there's a 3-year-old child involved. And I'm assuming both parties reside.
Yes, Your Honor, that's correct.
And Mr. Coleman, have you talked to your client at all? Does she have anywhere else she could stay?
I'd not asked her that question. I don't believe that she does. And again, considering that the alleged victim in this case stated that he does not have any fear of his wife and that there's no history of violence between the two of them, I'd be requested there be no further violent contact.
All right, I have the victim here. I'm going to order no further violent contact. I'm going to order, well, I guess that's it. No further violent contact, the one-day anger awareness course. And hopefully that will be all that's needed. Anything else, counsel?
No, thank you, Your Honor.
All right.
To the young man without a shirt, you need to put on a shirt. You're actually technically in court.
In custody first. But we're gonna start with the case of Joe Benjamin Gehring. He bonded out on the 10th day of June for $1,500 with AAA bonding. He was arrested. I'm not sure if it was the sheriff's office or wildlife and parks or who it was, but anyway, he was arrested for suspicion of voting under the influence. I'm going to presume the county attorney's office got something with regard to this case, but at this point, they've not elected to file.
Your Honor, my office has received this office, as I understand it, and information has not yet been filed regarding Mr. Gehring.
That's what I said. They've not filed charges.
That is my understanding, Your Honor, yes.
Yeah, that's what it looks like. So what that means, Mr. Gehring, is sometimes, I don't know your particular facts. They do have to provide an affidavit of probable cause to the county attorney's office, but sometimes there's further testing that needs to be done. They need additional evidence. They need to look at videos. It can be a number of things. So they have up to I think it's 5 years to file a case. Generally, they don't wait that long unless it's a blood work and they're waiting for KBI and it slips through the cracks for a year or two, but that's pretty rare. But just because you're being released today and released on this bond does not mean that you cannot subsequently be charged. Ms. Cummings, different attorneys prefer different things. I could continue him on his bond and set this out a couple weeks for another first appearance and see if they're going to file charges or not. or I can release him today. He'll have no bond. And we always direct that they make an effort to summons to someone's address on their driver's license or last known address. And they do generally always do that when someone's already been arrested first. But then, of course, if they don't get service, then they issue a warrant again, which is what we try to avoid. And sometimes when attorneys enter and give notice to the county attorney's office, there's not a real good mechanism for that I'm aware of. Sometimes attorneys get notified, sometimes they don't. So I don't know how you would rather proceed, whether you'd like me to set this out so you could see what the county attorney's office is really going to do and get a chance to talk to them. Or if you want me to just release him today, no further court hearing, and see what happens.
We would prefer to release him today, Your Honor.
Okay. Mr. Regier appears on behalf of the state. Is there anything you'd like to add? Ms. Cummings is appearing for her husband, Bill Cummings, who's representing Mr. Gehring on this case that's not been filed. Anything you want to add, Mr. Regier?
Nothing from the state at this time, Your Honor.
All right, thank you. You're free to go.
Okay, thank you. So I guess I just wait and hear. If I hear something, then I will react then.
Yeah, the best thing is to notify the county attorney's office if you move. And always keep your driver's license current and make sure that Mr. Cummings knows how to get a hold of you. And I'm sure he'll send a letter to the county attorney's office on your behalf saying they are to contact him, that he represents you. But just confer with Nika or Mr. Cummings, and they'll give you further advice and direction, okay?
Sounds good. I mean, I'd just like to add one thing. It was the warden. It was the warden. I don't know if that makes a difference, but it was the warden who had talked to me out on the water.
Okay.
And brought me in. So, okay.
All right, thank you.
Thank you very much. Have a nice day.
You too.
Thank you.
All right, who's in custody there first? Is it Mr. Morrison?
Yes, Your Honor.
All right. We are going to go on the record in state of Kansas versus Robert Morrison. It is 2023 CR 299. The state appears by and through Mr. Regier. Mr. Morrison's in custody. Mr. Morrison, you've been charged in Butler County District Court 23 CR 299 with one count of criminal trespass. It's alleged that on or about the 13th day of June 2023, that you went on to and that is apparently a location in which you'd been told not to enter or be at, or there were signs, or it was fenced, but in some way it was made clear to you not to be on the property and you went on the property. That's what's called a criminal trespass. It is a B non-person misdemeanor. If you were convicted, it would carry a maximum of 6 months and $1,000 fine. There are no mandatory minimums. I'm going to enter a not guilty plea for you. I assume that you would like to have a chance to talk to an attorney about this case.
Yeah. Yes.
All right. And you're going to be able to hire your own attorney?
No, I cannot.
Okay, why is that?
I'm only on Social Security.
How old are you?
60.
How long have you been on Social Security?
The last 35 years.
All right. Are you a resident of Butler County?
Yes, I am.
Do you live in Augusta?
Yes, I do.
How long have you lived there?
Last 4 years.
Do you own your own home there that's paid for?
No, I do not.
Do you own a car that's paid for?
No, I do not.
All right, I'm going to appoint Darren Patterson to represent you. You're to not be on the premises that I outlined or have any contact with any state witnesses that are endorsed on the, either the second sheet or the back of your charging document, which is your information. And your court date with Judge Webster is September the 11th at 8 o'clock. Recommendation on bond.
Your Honor, if the state will order all special conditions, the state is prepared to proceed with a 1,000 cash or surety bond. I think the court has already addressed no contact with the property. Additionally, besides no contact with endorsed witnesses, I'm assuming that would also be no contact with the victim as well as any co-defendants.
Yes. So my question to you, Mr. Morrison, is can you make $1,000 bond? It'll be about $100 or thereabouts.
No,
You have somebody that can get some money to a bondsman?
no,
Well, when do you get your next Social Security check?
On the 3rd,
Do what?
on the 3rd, next month.
You don't have any family members or friends or anything that would front you $100?
My daughter's on vacation right now, Pensacola.
Who is?
My daughter.
Well, she could probably wire some money. Do you have some money in your checking account?
Not enough.
How much do you have in your checking account?
Probably $30.
Are you gonna be able to stay away from this location and not
Oh,
get
yeah.
into trouble with the law?
Yes, no problem. Yes,
When is the last time he's been arrested or convicted or been in any kind of trouble at all, Mr. Regier?
Your Honor, it looks like this defendant does have a conviction from 2018. So within the last 5 years or so, it appears to be a felony drug conviction.
Okay. Mr. Morrison, are you using drugs while you're on Social Security?
no,
Are you would you test positive for anything today if I ordered them to have you produce a UA?
no,
What about a hair follicle? That goes
That's
back
fine.
6 months.
no.
So you're ready to do that today for me?
Yeah.
Okay. I'm gonna do a 2,000 OR bond. You better not violate your bond conditions. Augusta Police Department's pretty aggressive. If you violate, you'll be in jail and you'll go in front of Judge Webster and you probably won't make a bond. Or if you fail to appear, we're gonna take a $2,000 judgment against you. They're gonna add it onto your case if you're convicted. If not, they're gonna do some kind of garnishment. Then your bond that you'll have to post, because you'll get arrested too if you fail to appear, will be double or triple. And sometimes Judge Webster does out no bond holds. And you can see how far out she's scheduling things, because this is September 11th. So you can pretty well guarantee you'll sit in custody for a minimum of 90 days. So you need to appear at every appearance. Now, she, through the chief judge, has continued her dockets by Zoom like we're doing right now. So if you don't have a smartphone and high-speed internet, or a computer with high-speed internet, and you're not savvy enough to download Zoom and use the app and make sure your audio and your video works and all of that, then you need to show up at the courthouse and you see where Mr. Spickler is with the Sheriff's Department. I don't know if you're lieutenant, sergeant, captain. Are you still captain?
Sergeant.
Sergeant.
Sergeant Spickler, they're at the courthouse.
Yeah, I don't know if you can
back.
see him at the Sallyport, but they will provide a place for you to be set up like you are right now with all the equipment you need to conduct your hearing. So don't wait too long to figure that all out, because again, Judge Webster will issue a warrant for you if you can't turn on your audio or video. Okay? No drugs, no alcohol, don't violate the law, but I am going to let you sign your own bond.
Thank you.
All right, you're excused. Mr. Regier, on these lower level offenses, I just cannot find that because someone is without funds, that they should sit in jail for 90 days. I mean, if this docket were 30 days, I would have accepted your recommendations. And I know it's not your fault that they're so backed up, but I just can't in good conscience tell people you don't have a hearing until almost 90 days and sorry you can't make a $100 bond or whatever. So that's why I denied your request.
And I do, while I am certainly not in favor of an OR bond in this particular case, I do understand the court's position, and I will, of course, submit to whatever orders the court may order.
Okay, thank you.
Yeah.
All right, can you turn on your video? There you go. Can you get your face in front of it? There we go. Very good. All right, Mr. Stark. The state, by and through the prosecutor's office, which is the Butler County Attorney's Office, has charged you as follows in 2023 CR 298. In count one, on or about the 9th day of June 2023 in Butler County, Kansas, it's alleged that you unlawfully and without authority entered or remained within a dwelling or residence to which with the intent to commit a felony theft or sexually motivated crime. A felony, a theft, or sexually motivated crime. So you entered or remained with the intent to commit another crime in a residence. It's what's known as a residential burglary. It is a level 7 person felony. And the sentencing range is anywhere from 11 months up to 34 months with the Department of Corrections. If you have 2-person felonies or more, you would be presumptive prison. If you are on bond or parole or probation for a felony at the time of this offense, you would be presumptive prison. And if you have 2 prior burglary charges, you would be presumptive prison. Otherwise, it is possible, if you were convicted, that you could receive probation. The fine amount is up to, I believe, $300,000. Then you're charged with stealing tools from an Antonio Canita. Doesn't mean you have to know the person, but it's alleged that on or about that day, he had tools stolen from his possession that were his, that you weren't authorized to take. It also is alleged you have 2 prior misdemeanor thefts, which makes this a level 9 non-person felony. The sentencing range for that is 5 months up to 17 months with the Department of Corrections. I'm going to enter a not guilty plea for you. It looks like Hot Rod has bonded you out. I will approve that bond with the understanding that you are not to go on or near this house on Cherokee. You're not to have any contact with the Mr. Candina or any of the endorsed potential witnesses in this case. Your bond that you've posted is $5,000. I entered not guilty plea. Are you currently working?
No.
Why not?
I don't know. I got laid off. Actually,
Did you get laid off?
yeah, I got laid off. Like last.
What?
Yeah, I got laid off. I'm not working. I can't afford a lawyer.
Well, I suggest you get a job. I just went to Jimmy John's for lunch. They can't even fulfill people's orders because they don't have enough employees. There are places all around El Dorado, Wichita, I don't care where you go, the service industry, and there are not enough workers. I don't care where you go. I don't care where you have to work, but I'm ordering as part of your bond that you obtain employment. I'm going to appoint Jim Watts to represent you. Is there a co-defendant in this case, Mr. Regier?
Your Honor, I do not have that information at this point. However, I do have a note from Ms. Norris, and it would be the state's request that there be no contact with any co-defendants, as well as all the other special conditions previously iterated by the court.
Well, I'm trying to figure out who the co-defendant is because I don't want to assign the same attorney, but I'll let Mr. Watts figure that out. Mr. Starr, your assigned judge is Judge Crum. Your court date in front of him is August the 14th at 2:30.
Okay.
Get in touch with him as soon as you can. Stay in contact with him. Do not violate any conditions of your bond and appear as directed. I would suggest you practice with somebody on Zoom because the judge needs to see your face. And you can't seem to stay in the.
I can't hear you, so I gotta hold my phone to my ear first.
Well, you know what? A car is the very worst place to do this.
I get that.
All right. So find a better spot, have a better connection, make sure you're ready to go for your court hearing. Okay.
Okay.
All right. Thank you. You're free to go. Is Mr. Luna Jr. Edward, Louis, or Luna Jr. on here? There we go. All right, you're outside that, and it looks like you got the ocean or lake in the background, which is probably the only thing that's worse than, but it looks like you're working, so that's good.
Yeah, I'm working, ma'am. Sorry.
All right, very good. We are going to go on the record in Edward Luna. It is 2023 TR 2050. Mr. Luna, the state has charged you with fleeing or attempting to elude a police officer, driving while being a habitual violator, failing to stop at a stop sign, and no proof of insurance. It's alleged that on or about the 8th day of June 2023 in Butler County, Kansas, you did then and there unlawfully and willfully fail or refuse to bring a motor vehicle to a stop, or otherwise did flee or attempt to flee a pursuing police vehicle when given a visual or audible signal, to wit, a hand, voice, siren, or emergency light. And it was clear that it was an official vehicle marked and that you were required to pull over. It's also alleged while you failed to pull over for the police, you also engaged in reckless driving. That's what makes it a felony. It is as charged a level 9. The person felony. These are person crimes because of the risk posed to the public when you try to evade a police officer. Again, these are just charges. I'm going to enter not guilty plea for you, but I have to tell you what a maximum sentence is you could receive if you were convicted. That is 5 months up to 17 months with the Department of Corrections and up to $100,000 fine. The habitual violators, up to 1 year in the county jail and up to a $2,500 fine. And then the count 3 and 4 are fines generally. And the no proof of insurance, although it's a B misdemeanor with up to 6 months and $1,000 fine, there is a mandatory minimum fine of $300. Sir, are you going to be able to hire an attorney by the time of your next court date, which will be September the 11th at 9 a.m.?
Yes, Your Honor, I should be
Okay.
able to.
Your Honor? Your Honor,
Yes.
being it's a felony, that's the misdemeanor control docket. It needs to be.
Oh,
applied.
thank you. Thank you. Thank you. Thank you. My bad. Before I forget, I'm gonna approve your bond for $3,500 surety that you posted in the case, as long as you reappear and don't violate the law.
Yes, Your Honor.
The reason I don't know is because I don't have an assigned judge, and the judge I do have assigned is Judge Webster. So that's why, that's my excuse for making that mistake. So I have no idea who the district judge is that's assigned to this
Okay.
case.
Okay, Your Honor.
Well,
But
hang
I-
on, don't go anywhere.
All right,
We gotta find what judge you're in front of so I can give you a court date. So that you can tell your attorney when you have to be in court.
okay.
It is yours, Judge.
Do what?
It's yours.
Okay. I'm Judge Satterfield, District 1 or Division 1. Your court date will be in front of me the day
Okay.
after Labor Day, September 5th. That's a Tuesday at 2:30 in the afternoon. That's your
Okay.
next court appearance, September 5th at 2:30. But you need to start working on an attorney right away.
Yes, Your Honor, I will do that.
You've got them secured. They know the court date. They've entered appearance. They've gotten your reports from the case, and they're ready to go in front of me on September 5th. Okay?
Okay, okay,
All right. Thank you.
thank
Honor?
you.
Yes.
Given that an OR bond has already been executed in this case, as well as the fact that there is at least one level 9 felony currently before the court, the state would respectfully request as a special condition that the defendant not leave Butler County.
I'm not
Okay,
going
well,
anywhere.
I don't know anything about that. I'm going to order that you not leave the state of Kansas because it looks like you work construction. You might be
Yeah.
at the lake, but I have no idea. But if you
Yeah.
work construction, you probably have to travel. What I'm telling you is not violate the law. Why don't you stay in the state of Kansas? I was mistaken again. I figured you posted a surety bond, but you didn't. You posted an OR bond.
Correct.
Did you sign OR bond or did you put up 3,500 cash?
No, I signed an OR bond.
Okay. So, all right, very good. Thank you.
Thank you.
Thank you.
Okay. Dakota Griffey. Now, this looks like a surety bond. $2,500. Anytime bail bonds out of Manhattan, Kansas.
Yeah.
All right. Sir, you were on probation in Butler County to Sarah Wheeler. Apparently you violated your probation. And a warrant was filed for your arrest. It's alleged that on or about September 19, 2022, you were placed on 12 months probation. You were in jail at the time. You were released from jail. The officer indicated she would make efforts to transfer your probation to Pottawatomie County, but that you needed to check in and report until then to her. We always tell people to do that. You failed to call her. She communicated with Pottawatomie County's Court Service Office to see if you showed up there inquiring about your probation. The answer was no. It was a courtesy supervision because of a Riley County case. And basically you just failed to complete your conditions of probation in this case. So you're going to need to go back in front of Judge Webster on September the 11th. Are you working right now?
I'm almost there. I basically am trying to hear back from the manager at Sonic, but I just literally had an interview. Yeah. My bad.
All right, well, since you're not employed, I'm gonna go ahead and appoint Darren Patterson to represent you. I would recommend that if you are revoked, that they add $150 to your case for attorney's fees for him, but I will appoint you an attorney. And that means you need to appear by Zoom like you are right now at 8 a.m. on September the 11th.
Okay.
All right.
Uh,
Let me, why don't you write down your attorney's telephone number?
okay. It's right here.
Okay.
All right, I'm ready.
316-322-7700. Darren, D-A-R-R-E-N, Patterson, P-A-T-T-E-R-S-O-N. He's in El Dorado. I wouldn't start calling him till Monday because it'll take a few days to get his appointment papers and to receive any information about your case. All right. So next week, start calling him and stay in contact with him.
Is it going to be in the same Zoom link and like password and all?
No, you'll get a new one from him.
Okay. All right. Thank
That's
you.
a good question. Hang on just a minute, Mr. Regier. Is there anything from the state?
Your Honor, more of a point of clarification. Looking at the continuing bond, it looks like 2,500 professional surety, which I'm assuming the court is going to approve if the court will allow me to say so. However, the bond itself does not appear to address any standard conditions. I'm assuming all those would apply in this case.
Yes.
Thank you. Your Honor.
Primarily don't violate the law. I don't know there are any witnesses or anything. So don't violate the law.
Sure.
And yeah, I did say there was a 2,500 cash or surety, but you're right. It's a different bond form they used and there isn't anything about any particular conditions. All right. Thank you. You're free to go.
Thank you.
Cinderella Heiss has 2 cases.
Your video on?
It is Butler County District Court.
He is here. I'm just asking.
Yeah.
Yeah.
Great, thanks.
Go.
Okay, he's right here. I'm just helping him get his stuff situated.
All right, great. Mr. Burkholder?
Yeah.
All right. If you ever have any difficulty, you can always come to the courthouse on the south side. We have a Sally Port, and you go in that back area and they have equipment set up for you.
Okay.
We are on the record in 23 CR 245. You're charged with a simple battery of one Cheyenne Roberts. It's alleged that on or about the 24th day of January 2019, so this is an old case,
Yeah.
that you caused physical contact with her. So you made physical contact while you were angry, or insulting her, or in a rude manner. In other words, it wasn't in a kind sort of invited touching. So it was an uninvited touching. All right, I'm going to enter not guilty plea for you. This is not charged as domestic in nature like domestic violence, but it is still a B-person misdemeanor if convicted with the maximum 6 months in the county jail and a maximum $1,000 fine. You're going to have to go in front of Judge Webster, but that won't be until September the 11th, 2023 at, I'm not sure the time yet. Hang on just a minute. I do want to set a $1,500 OR bond for you. So
Okay.
you're going to sign your own bond, and you'll have to go to the courthouse to make arrangements for that. You probably are going to have to go run to the detention center on Stone Road. Do you know where the county jail is?
Yeah.
And you're probably going to have to be printed and mugged on this, because every new case that gets filed has to have a new ORI number, an agency number that's assigned to you and or that charge. And so there's a booking and processing procedure that has to go along with it.
Okay.
Now, have you had continued contact with Cheyenne Roberts?
Not lately.
Okay. I'm going to ask that you, during the pendency of this, until you talk to an attorney or further order of the court, that you not have any contact with her.
Okay.
You don't share a child with her or anything, do you?
No.
Okay. Don't violate the law. When you get processed at the jail, you'll be immediately released.
Okay.
Because you're not going to have to post a bond. And you've got the court date. Now my question is, are you in a position that you can find your own attorney and pay for your own attorney to appear with you on September 11th?
I have one.
All right. Who do you think that might be?
Ma'am, my name is Mark Lewis. I'm his staff, for lack of a better term. He has he's on court services right now, probation, for another case. I do believe he had what was his name? Bigger gentleman, I can't remember his name. He was court appointed.
Probably Mr. Fabre.
Yes.
Yeah, well, that doesn't.
So he's going to probably need a court appointed, because he does not actually probably have representation at the moment, and he doesn't have the means for one at the moment.
Okay, so if you're a caseworker, is he on Social Security?
Yes, ma'am.
All right, so I'm going to appoint Darren Patterson to represent him. And that means he has to report for court on September the 11th by Zoom, like you're doing right now. at 8 a.m.
Okay, at 8 a.m.
And yes, and if you're having any problems with your Zoom, like right now,
All right, let's go on the record. All right, we've had a busy afternoon. We did a criminal sexual conduct preliminary examination with a child witness, which took us a couple of hours. We didn't live stream that for apparent reasons. We did deal with another matter, and we're about to deal with the last scheduled matter of the day. And I'm going to start over again. The title of the case is People versus Rosalind Ray Keenan. The allegation is that on or about May 16th in the village of White Pigeon, she did resist and obstruct a police officer and drive with a suspended driver's license. Resisting and obstructing is a felony now. It's punishable by up to 2 years imprisonment. And driving suspended as a traffic matter, punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record and requires that your license be suspended. Someone who is identified as Rosalind Keenan is present, and she wanted to explain more about that. We'll give her a chance to do that, but Prosecuting Attorney David Marvin is here, and he's representing the state. So let me ask you again, are you Rosalind Ray Keenan?
I'm here on as a sui juris impropria persona, Rosalind Ray family of Keenan, beneficiary. Is this on record?
Yes, everything has to be on the record, so it's all being recorded.
Okay, I'm here on the special appearance, and I'm a free woman on the land. I'm here under fraud, menace, and duress. I am the private woman, Rosalind Ray All
right.
Keenan. The all capital mentioned name is the only appellation given to me. Anytime I autograph is to be done in a certain manner that I have here, or it's forgery. Could you do this for the judge, please? That's mine. Thank you.
All right, I'll accept this.
Thank you.
All right, so I think we have the right person here. When she signed her bond, she signed it as Rosalind Ray Keenan beneficiary with quick bail bonds. All right, now we've got another issue. This is a felony charge. The first one is. The second one is under the Motor Vehicle Code. And it requires that we have a preliminary examination, or it requires that you're entitled to a preliminary examination. We had a pre-exam conference last week, and you expressed at that time that you did not wish to have an attorney. You're here with you this morning without an attorney, and we'll address that in a moment. You've been talking with Mr. Marvin. You have an absolute right to represent yourself. I normally don't recommend it. Mr. Marvin will sit down and talk with anybody, whether they're an attorney or whether they're a layperson. So you and he have been meeting to discuss this. Mr. Marvin, is there a plea offer here?
There is, and I'll tell you about that. But I wanted to mention that this is, I believe, the third time we've sat down, and so this is dragged out a bit, but only because she's not represented, and in these 3 separate meetings and adjournments, the court has allowed those, and I appreciate it. I have spent a lot of time with her and her son, who's here. He's always been here, and they're very honest and they're good intended.
Thank you.
And I think that we've come to a resolution that I believe is fair. I've offered, I'm gonna state it for the record, and only time will tell if she's gonna accept it, in hopefully 2 seconds, but what I would do is offer an attempt resisting and obstructing and dismiss count 2. And I would ask that the court set this for sentencing at a later date, and I'd ask for 6 months. And if by that time, there's no other incidents with law enforcement or any other reason to continue, I would dismiss this, or at any time before that, if I felt that it was necessary. And again, after working with her, I don't think this is the kind of thing that should be, I would hate to see this upstairs as her first felony. I think that she's interested in a way of life that she's honestly trying to understand, but I think that partly to assist her, I've kind of hatched this plan, and I've offered that. I have the feeling she's going to take it today, but if not, I've got my officer and we're ready for a prelim.
He's offering to reduce the driving suspended charge. And he is offering to dismiss the felony charge and reduce it to a charge called attempted resisting obstructing a police officer. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Do you understand that charge?
No, I don't understand the nature and the cause of the
All right,
charges.
Mr. Marvin, let's just do a prelim. I'm not gonna tap dance with her. You may be more sympathetic about this flat earth nonsense than I am. But if I'm gonna have to argue about everything from who she is to what the charge is, it'd be easier to just put on the prelim. From the affidavit of probable cause, her conduct was outrageous with a capital O. And so I'll give you one more opportunity, Ms. Keenan. Mr. Marvin is agreeing to dismiss the driving suspended charge. The record shows your license is suspended from Indiana and you don't have a valid Michigan license. That's a benefit. It won't affect your driving privileges.
Excuse me? What did you say about the?
It's a benefit. And
No, before that, about the license.
he's dismissing it. And it won't affect your driving privileges here or Michigan or Indiana if he dismisses that. So he's offering to dismiss it. And that's a benefit. He is offering to reduce the felony charge to a misdemeanor. And that's attempted resisting and obstructing a police officer. If you wish to do that, we can pursue it now. If you don't, we can take testimony. The officer's been waiting here for 3 hours. What would you like to do?
Are you asking me to take a plea?
I'm asking you if you're willing to accept the prosecutor's plea offer.
Well, I don't understand that.
Mr. Marvin, let's
Explain
just
it.
put
I'm
on
not
a
playing
prelim.
games. I'm serious.
You are playing games. And first of all, you
I'm
don't.
trying to advance to
All right,
what I'm
stop.
here
You don't
for.
interrupt the judge, whether you're a flat earther or not.
I'm not flat earth.
All right, well, this crazy stuff you're saying, I've got very little patience for it. You don't have an attorney, which concerns me, because these charges could result in your incarceration. I will appoint an attorney for you. All you got to do is tell me. But you also have the absolute right to represent yourself. So do you wish to represent yourself, or would you like me to get an attorney to assist you with
It's
this?
my right to appear for myself.
It is.
I don't think it would be a violation of your oath of office
To do what?
to if you did your duty under the Constitution, because I'm seeking legal intent, not advice.
Well,
And
do you
I-
want me to appoint an attorney for you? Would you like to represent yourself?
So may I ask, what jurisdiction is this, civil or criminal?
This is a criminal case, which points out the fact that you could use a lawyer if you can't tell the difference between a civil and a criminal case. Criminal case means you could go to jail, in this case, for up to 2 years. In a civil case, there's no possibility of jail. It's usually over money damages or other types of non-jail relief, like other types of non-jail relief. So yes, this is a criminal case.
Well, thank you. So, you said the record is on.
Yes.
Could the record of the court show that this is a criminal action? And my next question is, I know that the Constitution grants the court 2 types of criminal jurisdictions. One is criminal jurisdiction under common law, and the other is criminal jurisdiction under admiralty or military tribunal venue under Article 1, Section 8, Clause 17 of the Constitution. Under which of these 2 jurisdictions is the court intending to try me?
This is statutory jurisdiction of the law of the state of Michigan. It's not any of those things, including the wacky admiralty clause people try to invoke. This is criminal jurisdiction authorized by the state legislature here in the state of Michigan.
Thank you. Well, please let the record of the court show that the court intends to conduct a criminal action against me under a statutory jurisdiction. But that makes me wonder, I have never heard of criminal action under statutory jurisdiction, and there is no such jurisdiction established in the Constitution. And I will be able to proceed if you can show me where I can find the published rules of civil procedures under a statutory jurisdiction and where this nature, cause, and jurisdiction exists. It is crucial that I have the published rules of procedure so that I can conduct a fair defense and fair trial. Otherwise, this needs to be dismissed. And I would like it in writing, please.
Thank you. It's not civil procedure, it's criminal procedure. And the defendant doesn't come up and show, court, tell me why I get to do this. You've been charged under the criminal statutes of the state of Michigan, and I've just advised you of that on the record. I'm just trying to establish at this point whether you want to represent yourself or not. As I mentioned, the conduct in here and the affidavit or the bond information report is outrageous with a capital O. And you could very well go to jail for a substantial period of time. Mr. Marvin was trying to extend to you an opportunity to avoid that option, but you're wasting all of our time with this stuff that doesn't have any legal merit. I'm offering to give you an attorney who can actually argue any legal merit or advise you or assist you in this regard. But we've had some White Pigeon police officers here on overtime for several hours. They're still waiting for you to decide what you wish to do. I haven't even gone over the first. Well, first of all, we had to establish who you were. That took much more time than it deserved. Secondly, I'm trying to determine whether you wish to have an attorney or not. Again, you do have the right to represent yourself. You wish to, but you've exhibited to me that you don't understand the law, and you're at risk of being incarcerated for this conduct. So to further comment on Mr. Marvin's offer, if you pled to the charge of attempted resisting and obstructing a police officer, he offered to defer the sentence for 6 months, and if there were no further problems, to dismiss it, which is very generous based on the police report bond information that came with the file. So what would you like to do here today? Do you wish to represent yourself?
Thank you. I know I can peer for myself. I'm competent and I am confident. Okay,
All right.
so
The next question is, are you
Please.
willing to accept Mr. Marvin's plea offer to plead to the misdemeanor charge?
I wasn't completed with what I wanted to say to you, please.
Okay.
May I? Thank you. So I wanted to say that I don't believe it's a violation of your oath of office if you did your duty under the Constitution, because I'm seeking legal intent. Okay, so I have the right to peer for myself. In order to intelligently defend myself, I have to know the jurisdiction this court is operating under, because the rules of civil procedure under common law jurisdiction are very different from the rules of civil procedure
All
on
right, stop.
admiralty or military
Stop.
tribunal venue.
Stop. We went through this before.
I
This
know,
is not civil
It's the
procedure.
Sixth Amendment grants me the right to know the jurisdiction being applied,
And I told you what it was.
and it gives you the duty.
All right, stop. If you interrupt me one more time, I'm gonna find you in contempt and you're gonna go to jail. and we're-
Objection, please.
All right, please.
Please.
We're gonna
sir,
talk
may
about
I-
this
the
tomorrow
contempt.
at 3 o'clock. I find that you're in contempt.
I
You're
do
going
not
to
wish to
jail
be
right
held in
now
contempt,
and we will,
sir.
well, you have been.
I'm
This
simply
matter
trying
is
to
adjourned until
exercise
tomorrow
my
at
Sixth
3
Amendment
o'clock.
rights, please.
So you can think about it
And we can go
overnight in
forward with
jail.
this right now, please.
No, you're going to
I do
jail
not
for
wish to be in
24 hours.
contempt.
I know you don't wish to go to jail, but you certainly
I
have
will
earned it.
continue with this if you'll please let me finish.
We'll talk about it tomorrow at 3 o'clock. And you will be more respectful to the court.
I
You
can
will speak.
provide the
You will not interrupt
citations.
the court. Your citations are meaningless.
I'm sorry I
So you
interrupted
can
you.
go
If you want to
with the
continue,
officer. I don't want to argue about it. Take
I'm
her
not
out of here. We will address this tomorrow at 3 o'clock.
Stand up and put your hand.
No.
I can't get her aspects because they're.
They'll get them for you. You can give all the paperwork to him.
Thank you.
Mr. Marvin, I don't know what you've got tomorrow at 3 o'clock, and I don't know what I have, but we'll take another shot at this tomorrow.
Justice takes time.
Just misunderstood.
Yeah, I don't know what's going on, and I don't think this was a fair trial,
We haven't had a trial yet.
a fair preliminary.
We didn't even get there yet.
Please be careful with this one.
Yep, absolutely. Here we go. Yeah, it's okay. We're gonna go over here, Ms. Keenan. Yep, I'll get all the property for you. I'll go right over here.
Here, fill my pockets. I have a key.
Listen to the officer.
Yep, I will get all the property from you, ma'am, and whatever property you want to release to your son, I'll be more than happy to. She's going into custody for contempt.
Okay, let's go this way.
And then let's watch out for this chair here. There we go. Go ahead and watch your foot. There we go.
That's it, then it's court over.
Yeah, we're done.
Can I say something?
Yes?
I don't think that she was trying to be in contempt of court. She was trying to exercise a right. And I think it was just a misunderstanding of how for her to be able to pronounce that. But,
Well, I told her to stop and she didn't stop, and she doesn't know what she's doing. She needs a lawyer. And she's gonna contempt herself into 90 days if she doesn't be careful. So we'll address this tomorrow at 3 o'clock. And to whatever extent you're advising her on this stuff, you're not doing her any favors. Mr. Marvin gave her the sweetest deal where she could not have a charge on her record. And all she wants to do is argue about admiralty law.
please have that record still, or that chart, that option still, if I talk to Mr. Marvin.
Yeah, I guess so. Well, you can't represent her as a lawyer.
I know.
But he could, Mr. Marvin wants this to be over with.
I do too.
All right.
Thank you.
Thank you. Bye-bye.
Bye-bye. Bernice Dyer versus Tina, is it Wagazi?
Legacy.
Yes, Wagazi, however you like.
Wagacy.
Vegas. Okay. All right, I have Tina and George Wagacy. All right,
Yes.
where are we on this?
100% moved out.
You're, say again?
100%.
Oh my God.
You're moved out?
Correct.
Ms. Dyer? Is that your understanding?
Yes, they moved out. Yesterday, they were supposed to be out Tuesday. And
No,
they,
we were to Friday.
I'm talking, please.
I love these
Wrong.
family cases. No,
And,
you don't stop them from talking. This is my courtroom, not your house.
Stop.
My house.
Right.
Are we clear?
Yes, sir. Yes, sir.
Yes, sir.
All right. They moved out.
Yes.
Oh. What do you want me to do?
They still have stuff in the house. And they took the dog. They come in yesterday and they stole my dog.
That dog was given to me. I have a bill of sale.
No.
Yes.
Speak quiet.
From the owner.
Just wait till he says something.
Okay, so let me get this right. You guys moved out. There's still stuff there, and now there's a dog missing.
No, there's
Not
nothing.
missing.
The dog is my wife's. We have a bill of the animal. It was never my mother's.
Okay.
The dog is chipped in my hand.
What kind of dog is it?
It's a Labrador.
Okay, so it's a real dog. All right. So let me just start with the property first.
Okay.
In terms of property, Ms. Dyer is saying that there are certain things that are there. But you guys are saying moved out. You don't want any of the stuff that may be yours or she thinks is yours, right?
No. Right.
Correct.
Okay. I don't know that there's a whole lot I can do about the dog. Somebody's gonna have to sue somebody else about the dog because that's not part of this case.
I didn't think so.
Boy, this is not right.
Oh, it's 100% right.
No, it's not.
Yeah.
Folks,
Okay.
if I wanted to be a family law judge, that's what I would have done. I really don't want to. This is my second one of the day.
Yeah.
So here's what I'm gonna do. If they moved out, it's all been satisfied. Is there any reason I shouldn't dismiss the case, Ms. Dyer?
Judge, the dog is registered in my name and I've taken care of him for 5 years. This is my dog. And through their claim, they're lying.
Excuse me. She took care of him while I lived there for 5 years. No, she took it to the vet one time. So the dog is not hers. It's not even this case issue. I know. We are 100% moved out. And I know that's all you care about, Judge.
Well, no, I care about the dog.
Oh, well, the dog is mine. The dog was given to me.
You guys are fighting over the dog. I don't think the dog ought to be with either one of you. So here's what I'm gonna do. If they moved out, you filed a termination. That means this case is dismissed. It's gonna be dismissed without prejudice. If Ms. Dyer, and I'm not suggesting it, but if you want to sue for the dog, you're gonna have to sue for the dog.
I will.
That's not part of this case.
Right.
So I can't deal with that.
Okay.
All right?
You go
Thank
for
you,
it, 'cause
folks.
You will not win.
Sir, enjoy the rest of your day.
Yeah, too late. Court calls the is it Shalilia versus Justin Holbrook?
Yes, Your Honor. I am plaintiff Muthukumar Chellaya.
I am here.
Mr. Holbrook?
Yes.
You're here? All right. Pardon? Oh, I'm sorry. And there's also last name Kumar, I guess, Natija Kumar and Brijas Kumar. This is a termination case.
I'm here.
What's going on?
I'm Nityaja.
Your Honor, I have given them enough time to vacate the house. I'm looking for the possession, trying to sell the house. They started moving like 6 months ago. Then they didn't do it. I even paid them for moving supplies, truck and storage. And they asked for a week last week with the other judge, but they haven't done anything for the whole week.
I've been busy with work. I'm the only one that's been able to move anything. I was supposed to go down there today, move some things. I just haven't had the chance all week. And we don't have much left. We've been moving stuff out for a while, but that was due to a mold report that we have gotten back. We weren't able to live in the home. So we started to move our things out, but then our items in the basement got damaged. And we were told through him that we'll be receiving compensation for our items through the insurance company, even though we didn't have renter's insurance, but we are his family. So we were told that we were going to be getting compensated for our items. So that's what took so long for us to move all of our items out. But at this point, we just really have things in like the garage and the pool barn. It's a 10 acre.
So when are you gonna have all of that out?
I'm trying to take one more trip because we currently live an hour away. So I have to figure out the best ways to get down there and when I can and to make a trip. So I'm trying to do like one more trip. I'm either
Can
going
you
to try
be
to.
out by the end of can you be out by the end of the month?
Yes.
Then here's what I'm gonna do. I'm going to adjourn this matter out June 30th. I'm going to indicate defendants to move out by then.
Your Honor, may I ask if we can have?
I'm sorry. I didn't mean to ignore you. Go ahead, ma'am.
No, it's okay. I also agree. We will be moving our stuff out. All we have is small items in the basement in the pool barn. I have not had a chance to be able to go get it as well. Is there a way I can get a 1 week extension? Because I do have work that whole week. So if we can maybe do sometime in July, just so I have an opportunity to get my items.
Plaintiff, you have a problem with me giving a date in July?
Your Honor, I've been trying to sell the house for a whole year, and I had 2-3 potential buyers walk away because of their behaviors, irresponsibility. And I have a buyer to close the house today. I had
Okay,
one
so
last.
hold on, folks. Sir, whose father are you?
Nityaja. Kumar.
That's your dad?
Yeah.
You don't want to give your daughter another week into the July?
No, sir. I have a potential
Really?
buyer. Walked away a couple times already. I lost $35,000 more deal. I put so much money for this house. They paid nothing. And I put her through college. And like I had a closing date last week. I have closing. The buyer is ready to close today. I don't know if they will still stick around or not. I lost so much money. Like I am also living an hour away, coming here, taking care of the house. I am not able to maintain. All the left in the garage and barn is the trash from last year. Animals getting in there, tearing apart.
Your Honor, we've been told that we've had to leave the property and stop packing up our items because he's been showing the house, and this has been happening for months. I've been on like we've not been been notified, and he's just been bringing people there. We've had birthday parties, and he's used that as excuses, and people have came there and still tried to kick everybody out. And so that is the main problem. Every time I'm there trying to move my items out, there's somebody there. He comes there and he calls the police on me. He called the police on me for trying to take my pool because he was trying to sell the house with the pool. So every time I go there, there's been the issue on we have to leave early. We can't get as many things as we would like.
Okay. Here's what I'm going to do.
Your Honor, like he took the kitchen sink countertop from the basement that does not belong to him. It belonged to the house. He changed the locks on me. He took the lock box. he took the sale sign of the realtor. He broke into the house. They broke the drywalls in the house, took off, damaged the house so bad, the value has gone down so much. They like smoking, kick the house, bang and damage so much, lost so much. Like it's the worst house. Like it's a very bad situation. I'm afraid they do more damage, sir.
Jeez, Pete. You all done now? So I'm gonna tell you what I'm gonna do. Is it 7/7?
Sorry?
July 7th?
On July 7th, 9 a.m.
I'm gonna indicate that the defendants say they're gonna move, they'll be out. And what time? 9. So what I'm gonna do, since you won't give your daughter another week to try to get it done, she's just asked for that to get the little things out. In honor of my daughter, I guess I'll give her another week. So we're gonna go to July 7th, 2023, 9 a.m. You guys are to be out by that time, sir. You are not to do anything to interfere with their moving out. You understand that?
Yes, sir. And like they have been saying this, and my daughter said she will kill me before him. They are so bad like that, and he spoiled the whole.
Did I tell you to keep talking?
No, sir.
I didn't think so. All right, we'll see you guys on the 7th. Everybody have a great 4th.
Thank you,
Thank
Your
you, Your Honor. I appreciate it.
Clerk, take him for the plaintiff.
Good morning, Your Honor. For the record, Peter Beck appearing on behalf of Page and Ashton Dubisky.
We're also here, Your Honor, Paige and Ashton Dubisky.
All right. Last time we were here, you're gonna pay $700, $800 on the 16th. I ordered the landlord to take a partial payment. Where are we now in this case?
I paid the $700 on the docket. Sorry, and then the
All right,
$800 on the 14th.
Hold on.
I think
You have an attorney representing you, right, folks?
Yes.
Okay, why don't you let them talk? This is what they do for a living. Otherwise, the attorneys feel useless, so we don't want that to happen. All right, Mr. Beck, go ahead, sir.
Your Honor, there was a promise to make $800 payment by Friday, June the 16th. The payment was made yesterday by Ms. Dubisky. And what she's asking is for an opportunity to pay $1,000 every 2 weeks. So there'll be $1,000 paying on June the 30th of 2023. And 2 weeks after that, an additional $1,000. There's currently, I believe, an amount owing of $5,173 minus the $800 brings the total down to $4,373. So basically what we're asking for, Your Honor, is some additional time to get her to be able to satisfy the outstanding balance.
It sounds like a conditional dismissal would be appropriate here, Your Honor. So if we want to just kick this out a little bit, me and Attorney Beck can hopefully hash it out before the next hearing and get it filed.
Why don't I do that? Let's do June 30th, 2023 at 12 noon. Let you guys try to work out a conditional dismissal. And then Mr. and Mrs. Dubisky, you'll be able to see what the magic that attorneys can do, okay? So,
yes.
Are you gonna pay you're gonna pay $800 today. Are you gonna pay anything before the 30th?
Your Honor, I paid the $800 that was due today. I paid it on Wednesday, the 14th, because I got paid a couple days early through my bank.
Okay. Are you gonna be able to pay anything before the 30th?
I get paid on the 30th. So that's when I was gonna do the $1,000.
So here's what we'll do. They're gonna try to wrap this up in a conditional dismissal, so I'll let the attorneys deal with that and with any additional payment so that it'd be credited, okay?
Okay, thank you, Your Honor.
We'll see everybody on the 30th. Thank you.
Thank you, Your Honor.
Calling case 222642, people of the state of Michigan versus Caven Carter, scheduled for arraignment on violation of probation. Parties' appearances, please.
He's a walk-in.
Yes,
Yeah, not,
He wasn't on the docket.
no, he was not. Okay.
Well, it says here
I-
he was sentenced on May of 22. No phone
I have some
number.
information on Mr. Carter.
Okay.
This was the person from last week where he was, hold on one second, let me get it.
Thanks, partner.
Says he wasn't a scounder.
No, he never.
Never
reported-
showed up at all.
Right, he never reported to probation. It looks like he had reached back out to the agent to try to clear the warrant. I was trying to see, I had prepped for him last week.
And what happened last week?
It was a miscommunication with the date.
Oh, I remember.
Yeah.
So I need to set aside a warrant here.
Yes,
Yeah.
please. And for the record, Nicole Casca, P55470 on behalf of Mr. Carter.
Carter set aside the warrant. Okay, so Carter, what have you been doing since you got sentenced back in 22?
I've been working on cars. I did a temp service for a minute. It was just too much. They kept stopping the job, so I just went towards fixing them cars.
You don't have a job at the moment.
No, man.
So you know what you need to do.
And he only owes 128, which my client has told me that he can pay.
Whatever. He went over to flip the script. The boy, he needs a job. He needs some job skills.
I have job skills, Judge. I know how to demolition. I fix on cars.
No. You fixing on cars without any type of certification, which means you can't get hired in anywhere.
Yeah, I'm trying to go back to school with that right now. I'm trying to finish my license, fix my license, so I can go back to school for that now. Currently taking care of all my tickets in 36 districts now.
How old are you?
26.
26. And the last time you had a full-time job was when?
I worked at, I want to say right before COVID started, I worked at a plant on 17 Mile.
Okay, COVID been over for at least 6 months, 9 months to a year. But you don't have a job at the moment.
No, ma'am.
Okay. And I say to you, if you go over to flip the script, they're gonna help you out. They're gonna give you some job skills for free with certification. They're gonna help you find a job. They're gonna get you a job. You got problems with rent, they're gonna help you with the rent. I tell you all that and you tell me no thank you. Did I get that right?
No, ma'am.
Oh, I didn't get that. I misunderstood you.
I wasn't saying like no thank you, but
Okay, and then I think I said to somebody else earlier today, you got some issues over at 36 with your driver's license to help straighten that out too.
I just went to court last 2 weeks ago and they threw out all my tickets, so my license is really taken care of. I'm just waiting on all of this to process. So I can go to Secretary of State and pay my reinstatement fee.
Oh, well, good.
Yes, ma'am.
But you ain't got no job.
No, I actually just, no. Another thing about the job stuff is I'm like a loner. I like being by myself, so I don't have to deal with other people's problems. I apologize. I'll just flip the script thing.
Yeah.
Ooh.
Stop talking.
Yes, ma'am.
You tell him to just sit down while I cool down. I'll be back.
Have a seat. She'll be back. It's best that you let her cool off.
Here she is.
Okay, thanks. Back up. Back up.
I want to put the parties back in front of the court, please. He got sentenced in May of 22. It's now June of 23. Nobody's seen him. Don't nobody know nothing that he says he's done has been done or hasn't been done. I offered some man and some assistance. He told me, yeah, I got an excuse for everything. Miss Costa, you want to give it your best shot?
I do, Judge. Please. Okay, so Judge, I think there may have been, if the court remembers, and I know it's going back ways, but I know the court has a really fantastic memory. This was his first time through on any adult criminal case. I think there was some confusion after he was in court because the sentencing was by Zoom. On Mr. Carter's part, I did advise him that he always could have contacted the court or his attorney. He did not know that he had either of those two options. I know that he's been crime-free. He has not picked up any new cases. He's been doing everything he's supposed to be doing as far as except not reporting to a probation.
How would I know that? He's never reported.
Well, if he had picked up a new case, Judge, we would have known a lot sooner than today's date.
Has he got a GED? Where is it from?
He does not have a GED yet.
Okay. He hasn't had a steady job.
Well, he has a high school diploma, Judge.
How would I know that? He's never reported.
If I may, Your Honor.
You go right ahead. Help me out here.
He doesn't have any new criminal activity. He hasn't had any since being sentenced. So the attorney was correct in that fact. And let me see about he said a high school diploma.
Yes.
It's a misdemeanor. I don't even know if y'all got any information on him.
We may. I'm gonna look just 1 second, Judge. Search. Education. Yep, so nope, we don't have a pre-sentence report here.
Oh, you know?
Nope.
You know, in the back of my mind, I'm saying to myself, well, if he don't care, why should I care? If I'm trying to offer him opportunities for a better life, but he's not interested, I should probably just save that slot for somebody else.
Judge, I think he would like to avail himself of that opportunity.
That's what you think. He haven't said a word other than he don't need no more job skills. He don't need no certification with no job skills. He don't need no help with no rent or nothing like that. He don't need no job. He don't need.
I apologize, that's not what I was saying.
Madam Clerk, have you got a piece of paper for flip the script? They got all kind of vocational training for free. Truck driving. You got your license straight. Maybe you want to get a license so you can drive a truck, line haul. I don't know. All I know is they're trying to make life better for young folks just like you. For free. Madam Clerk.
Ma'am.
Take his probation out 6 months from today or until he finished flip the script, whichever happens first, and then close him out. You should go over there today. They're right up on the boulevard. You whoop with bus. You can walk from here. Go over there and find out what they got at least. Who knows? When you finish program, you might be in a position, make enough money, go buy a house. Who knows? Maybe you don't want a house. Please have the young man leave in front of the camera. I'm tired. It's taxing. It's real taxing. I'm not trying to just give him a better life.
It's all set.
Yes, go ahead and go, man. You're all set, man. Just go to flip today. All right.
Thank you, Judge.
Yeah.
Right. Go out in the hallway and do it. Yep.
Let me finish
Your Honor. Just want to clarify, you said 6 months probation, extend probation for 6 months from today?
Or until he finished, flip the script, whichever happens first. I'm not gonna keep trying. You know, I can provide opportunity. I can't make you take it.
Okay.
Yes.
All right, let's go ahead and get started.
Thank you, Judge.
I'm sorry, I see a Douglas Coughlin. Mr. Coughlin, what's your matter? Because I don't remember calling any case related to that case to you.
Judge, he's one of the, he's not a named victim in the indictment for this case, but he was one of the individuals who was affected by the case, Mr. McGowan's case. And so he's just viewing.
Okay, just viewing. Can you hear me, Mr. Coughlin? Can he hear? Because I addressed him and
He doesn't look like it.
Responding.
Hello, Your Honor. Thank you for seeing me.
Mr. Coughlin?
That was my client, Judge. I apologize.
Okay. I don't know if Miss Caldwell, if he's able to participate because he's not responding, but was he going to speak later?
I don't believe so, Judge. Like I said, he's not one of the victims that's actually named in the indictment. I think he just wanted to attend because he was affected by it.
All right. You may proceed, Mr. Maloof.
Judge, Mike Maloof here on Mr. McGowan's case. This case originated out of the city of Atlanta in September of 2015. In September of 2015, there was an accident that resulted in injuries to multiple parties. Mr. McGowan was arrested and cited with 3 different charges at that time by the city of Atlanta. The first was reckless driving. The second was failure to exercise due care. And the third was serious injury by vehicle. He was arrested, posted bond, was released. And then the case was sent by the city of Atlanta to Fulton County originally. They sent it to the Fulton County Solicitor's Office. Mr. McGowan went to the solicitor's office on multiple occasions, or the clerk of state court in Fulton County was told there was nothing proceeding against him. Eventually, the case was transferred to the DeKalb County District Attorney's Office. My notes indicate that on July 20th, 2017, that's when the case was actually given to the DeKalb County District Attorney's Office. They indicted the case on, it was, I believe, June of 2019, 3 years and approximately 9 months after the incident. Mr. McGowan had filed a notice of change of address with the court in October of 2017. The notes that I saw in the system indicated that notice was sent to his old address. I could be mistaken on that, but that's what the system indicates. Anyways, Judge, he never received notice. He moved out of state in April of 2018 to Austin, Texas, more than about 3 years from the date of the incident. He has lived there the entire time. He was picked up on May 1st of this year at an airport in Miami, where he was arrested on these warrants that were issued when the case was indicted and he failed to appear at his arraignment.
Mr. McGowan, so we originally filed a motion to recall the bench warrant, then we filed a motion for bond. Judge, I'd ask the court to recall the bench warrant. If the court's not inclined to do so, I would ask for a bond. I would ask the bond be set in the amount of $25,000. Mr. McGowan has no prior felony convictions. This is a serious injury by vehicle case. There are three named victims in the indictment. Mr. McGowan has not been in any trouble since this incident. Again, he has no prior felony convictions. The reason that he missed his court date was he did not receive notice. He attempted to file a change of address with the court. It's not reflected in the system. I don't think he's a danger to run. His fiance is actually on this call. Miss Laverick is here. We provided the court with 4 character letters showing that he has ties to the community, also that he has good character. This is a case where there's not the serious injury is not a DUI, it's reckless driving. The allegations were at a particular event. This was a ride, a charity ride, a distinguished gentleman's ride. That's a motorcycle charitable event. Multiple people are driving motorcycles. He was doing what was called surfing, which is you put your feet up on the bike. He was driving a 1943 BSA WM20, so a very old bike. In our bond motion, we indicated that you can't actually turn the bike off. The way that there was a malfunction on the bike is our allegations. Based on all that, Judge, we would ask that he be granted a bond or the warrant recalled, or in the alternative, granted a bond of $25,000. I think that's reasonable under the circumstances. I need to be able to speak with him. I've had trouble going to see him at the jail. We're probably going to have to secure an expert on this case. And again, I don't think this was a deliberate skipping court, and he did try and keep a valid address with the court. So that's our position today, Your Honor.
All right, Ms. Caldwell.
Judge, Mr. McGowan is charged with 4 counts of serious injury by vehicle and 1 count of reckless driving. The facts of the case are that on or about September 27th, 2015, Atlanta Police Department officers responded to the area of Glenwood Road and Hass Avenue in reference to a traffic accident. Upon arrival, witnesses stated that they saw a male, the defendant, driving recklessly on his motorcycle, attempting to do a stunt, and subsequently losing control of the motorcycle. As a result, the motorcycle struck a curb and flew into a crowd of pedestrians that were out of the roadway. The motorcycle rider was identified as the defendant, and there were a total of 5 pedestrians that were injured due to Mr. McGowan's motorcycle colliding with the crowd, as well as a few cars being damaged as a result. Those victims include Mr. Roy Thomas, who is on here as Steve Thomas. He sustained injuries to his right knee. Mr. Kevin Owens, who sustained serious injuries to his arm, his left knee, his pelvis, and a possible concussion. Paul Bertignall, who sustained injuries to his head and knees. Douglas Coughlin, who sustained minor injuries to his extremities. Anthony Terrebonne, who sustained a bruised left leg. And the allegations in the indictment are based on the first 3 of those victims who had the most serious injuries. All injured parties needed to be transported to the Atlanta Medical Center where they received treatment. There were several vehicles that were damaged as a result of this, and victim Owens later did need to have corrective surgery as a result of these injuries. Officers determined the defendant was at fault and arrested him as a result. And Mr. Maloof is correct that this case did start in Atlanta. It went from the city solicitor to Fulton State Court, and then to DeKalb County when they realized that venue lied here and that the injuries were serious enough to sustain that felony charges were warranted. The case was transferred to our office and indicted on June 18th, 2019. And it should be noted that the defendant actually sent a letter to the Superior Court of DeKalb County, and that letter has been provided to Mr. Maloof. But he sent a letter on October 24th, 2017, in which he informed the DeKalb Superior Court of his new address at the time.
Say that, give me that date one more time.
October 24th, 2017. And on that date, he informed the DeKalb Superior Court of his updated address at that time. And so Mr. McGowan was aware that the case was pending here in DeKalb County Superior Court. There was no confusion as to that. He knew how to update his address. Notice was sent to that address that he provided. So notice was proper. The defendant failed to appear at arraignment on July 10th, 2019, and a bench warrant was issued for his arrest. It is the state's understanding that since that date that Mr. McGowan did move. However, Mr. McGowan, there's no record of Mr. McGowan ever updating his address. And based on that prior letter, it does appear that Mr. McGowan knew how to update his address and knew where the case was pending. He was arrested on May 2nd, 2023.
The bench warrant was for arraignment, you said?
Yes, Judge. And so from that time, 2019 to 2023, until the time that he was arrested, there was never any filing that the state's aware of to update that address. The defendant's criminal history consists of a 1990 conviction out of Knoxville, Tennessee for reckless endangerment and a driver's license suspension or no driver's license. The defendant was sentenced to 6 months with suspended sentence. In 1999, the defendant was fined as a result of a driving with a suspended license charge. 2003, the defendant was charged with DUI, and there were additional charges added for striking a fixed object, reckless driving, and homicide by vehicle in the first degree.
What was that?
There were additional charges added, including striking a fixed object, reckless driving, and homicide by vehicle in the first degree. However, it is the state's understanding that that case was never actually indicted in Fulton Superior Court. In 2007, the defendant was arrested for aggravated assault out of Fulton. That was dismissed. In 2015, he was arrested for this case. He does have a number of cycles of driving history, including several convictions for speeding, and his license was suspended a number of times. The state is asking the court to deny the motion to recall the bench warrant and hold Mr. McGowan in no bond status. However, if the court is inclined to grant a bond, the state is asking for a bond of $125,000 with the conditions of the defendant being house arrest with an ankle monitor, report to pretrial services within 24 hours, that he not drive while on bond, that he have no contact with the alleged victims in the case. The state's concerns in this case are that the defendant it appears that he lacks ties to the community. He currently lives in Florida, and that concerns the state. The state is also concerned about the danger of the community and risk of reoffending, just given the driving history that is present. And I know that Mr. Roy Thomas, who's labeled as Steve Thomas, is here on Zoom. Mr. Thomas, did you want to address the court as far as bond is concerned?
Yes, I do. And both me and Douglas Coughlin, who apparently is not hearing you, were interested in testifying. We were both injured in the incredibly reckless driving he did. We were participants in this charity ride, standing on the curb, and we were all hurt. I sustained knee damage, which still affects my right knee and affects my ability to walk well. Doug, I believe, had more serious injuries than I did. And then the fellow you mentioned, there was a young guy who had very serious
Thomas,
injuries.
if you could pause.
Can you hear me?
I hear you well.
Okay, because I called your name several times. I was trying to stop you from proceeding because I have not sworn you in.
Sorry.
All right, raise your right hand. Do you testify? Do you solemnly swear or affirm that the testimony you're about to give to the court is the truth, the whole truth, and nothing but the truth, so help you God?
It is.
All right. And what you previously indicated to the court, is that all true and correct?
That is all true and correct.
You may proceed. You may proceed.
So thank you. I'm sorry. I go by my middle name. My name's Roy Thomas, but legal name, but Steve is my middle name. So, yeah, so I was there. Both I and Doug opposed this bond because what he did was incredibly reckless. He was standing on the seat of the motorcycle with his arms out in a cross, going as fast as this old motorcycle would go, probably 50 miles an hour, with hundreds of people lining the street on each side. And he says there was a mechanical problem. What we saw was he just basically lost his balance, fell off the bike. He tumbled down the street. The bike, so it's a big, heavy motorcycle, slid into the crowd. And it was like a chain reaction, domino effect, affected the young guy whose pelvis was broken, who was mentioned by Miss Caldwell. And then 4 or 5 of us in turn. I was the last one hit. My knee was damaged. And then, and it's not, it's permanent, but not something they're going to do surgery. And my bike was damaged, which was repaired by someone's insurance. So that's it. We just opposed the bond hearing because we knew he had a long history of crazy and reckless stunts. And doing this, he was shunned by the motorcycle community. I believe that's one reason he left and moved to Florida, because essentially everybody in the motorcycle community that I know shunned him for this action. So that's about all I have to say about it.
So, Mr. Thomas, you're saying that this event, you were involved, you were there with your motorcycle as well.
That's correct. I was on the curb, with my motorcycle parked sort of on the curb, between the curb and the sidewalk, and standing, as some people were driving, go up and down the street. It was like I say, a charity ride. So, yeah, I was on this curb. So was Mr. Coughlin. So was everybody that was injured. We were all standing in a row on the curb, and he hit the first person, and it was like a chain reaction. These motorcycles started tumbling over into everybody, and I was actually hit by a motorcycle that was parked beside mine.
Right.
They all just tumbled over, and that's how I was hit by that bike. It was just parked. So that's what happened.
Got it. All right. Thanks so much, Mr. Thomas.
Okay, thank you.
All right. Anything else, Ms. Caldwell?
Nothing else, Judge.
All right. Mr. Maloof, you didn't have any rebuttal?
Judge, the only thing I'd say is that some of what's been represented was speculation by the victim would be my opinion on that. Again, this case didn't get indicted for 3 years and 9 months. He was out on bond. There were no issues since that. There's been no issues for the 4 years after that. So I think it's reasonable to ask for a bond. He was out on bond. And again, he doesn't live in Florida. He lives in Texas, and he did provide notice of an address. I saw in the system that it went to his old address, but that could be incorrect.
Okay, Mr. Maloof, you're saying you think that the 2017 notice went to the old address, not the address that he had updated? Is that what you're telling me?
That is my position, Judge. But that being said, I don't send the notices. It's what is indicated in Odyssey. And to the DA's office credit, they had to rebuild this file because of the age. They had to get it out of archives. So I got the letter indicating the address change. The address that I saw on the, I can tell you right now, Judge, get it right here. The address that he provided as a new one was 880 Shadow Ridge Drive, Atlanta, Georgia. The previous address was 1641 Glenwood Avenue, Atlanta, Georgia. That was the address that I saw in Odyssey. And then again, in Odyssey, it indicated that the notice was returned. And it indicated the Glenwood Avenue address. So he posted bond, and, he provided, like he's supposed to, even the third jurisdiction that had it. So it was Atlanta, Fulton, DeKalb. And then, indicted 3 months or 4 months before the statute of limitations. There were civil lawsuits filed in this. He participated in one of the lawsuits. I know that, and was available.
What year was the lawsuit that he participated with?
It would have had to have been filed within 2 years, Judge. I don't know when it was settled. I don't think it was actually in DeKalb County. I represented that, but I think the registered agent, it was actually against the event itself, the Distinguished Gentleman Club or LLC. And I think they may be registered in Gwinnett. I tried to find that, but I couldn't locate it. That's my understanding, Judge. Is it would have been resolved that he indicated he remembered stuff in 2018 regarding that.
And so, Ms. Caldwell, you don't show any arrests after the 2015.
I do not show any arrests after that date, Judge. And I do just want to state for the record that I am looking at the notice right now that was sent for arraignment. And it was sent to the 880 Shadow Ridge Drive address, which is the address that Mr. McGowan had provided.
What I'm looking at doesn't show that. Okay, so if the one that I was looking at initially was the arraignment hearing notice for June 20th. Oh, wait a minute. We're looking at July. No, so the notice for June 20th. Okay, no, that one is the Shadow Ridge.
I believe there's two, Judge, and one was sent to the Shadow Ridge address.
Well, my apologies. I was looking at what I could see.
But there are two of them. Mr. Maloof, there are actually two. They sent it to both addresses. So the June 20th did go to his address. But the one on the Glenwood Avenue returned as it should, since he was no longer there. But the Shadow Ridge did not return, which means that the court has to accept that he received it. Or that there is sufficient evidence for the court to proceed as if he received it, which I often do on these cases, unless there's some reasons to the contrary. And then, let me see. All right, so now the next issue was, he updated on the 7th October, but he didn't get indicted until, what's the indictment date? Let's see. That looks like.
Which I believe that was June 18th, 2019.
2019, and about 18 months later, after he changed addresses. All right, and then after the indictment, we got an arraignment notice the following month. All right, and tell me one more time, Mr. Malou, when did your client leave Georgia? What month are we talking about, or year?
What I am going to represent, Judge, it's not exact. We're a time frame based on the amount of time that surpassed. I believe it was April of 2018, Judge, but that address at that time still would have gotten the notice and was still a valid address for him. So I don't know when he cut off contacts with that address. He got divorced, Judge, and that's one of the reasons he left the state and had a job opportunity in Austin.
Okay. And where is he currently living now?
He lives in Austin, Texas, Judge. I can give you the exact address. 1 second. I'm going through different files on this.
You don't have to give me an address, the actual address, but right now your position is he's in Austin, Texas. And what is he doing there?
He is a musician, Judge. He actually plays for there's several clients he has. They include elderly care places. There are plenty of, he's very successful musician. He's got plenty of gigs, and he's traveled throughout the country throughout this. You know, so he actually plays at the airport in Austin once a week prior to this incident.
And then the last thing you said that there were civil suits.
There was one that I'm aware of, Judge. he did testify at a deposition. And I believe that was for Mr. Owens, and he was a witness in that case. This is my understanding, Judge. I've tried to verify this. It's kind of all over the place. I believe that the entity that would have been responsible was this Distinguished Gentleman's Ride, or whatever entity owns that. I looked that up into CAB. I didn't find it as a registered or as an LLC. But I believe that it may be in Gwinnett. That's my guess. It's where most out-of-state corporations are incorporated. So I didn't see it in Gwinnett either, but he did testify, and that was in 2018. The statute of limitations for that would have run on September of 2017. So the suit had to be filed before then. His memory and what he indicated to me was in 2018 was when he was testifying for or called as a witness or defendant in that case.
All right, and then my final issue for matter is his connections to Georgia.
Judge, on that, there's two letters that I provided. One is one of his relatives, and one is a teacher. They both speak to him, when he lived here, saying he was big in the music community. The teacher, Mr. Krugman, he's a retired teacher. Mr. McGowan taught him for multiple years. Both of them indicate, his type of character, that he's the kind of guy that is reliable, would show up. And both of those people both still reside in Georgia. So he still has a footprint here in Georgia, even though he lives in Austin. And again, he's even filed something with the court saying, I've changed my address. Now, we can't prove that he didn't get it or did get it. And he had moved from that location. But that location, I think there were people there that he knew that should have forwarded him the notice. That I can't speak to what actually happened. All I can do is speculate on that.
Okay. All right, thank you. Oh, I had one more question. I'm sorry. One more question. When he was arrested in Florida, what was he there for?
Judge, he was actually returning into the country from a vacation. And when you come in through customs, I believe it was a Miami airport. And when you come in through customs, and usually when you leave, my cousin actually got arrested because his identity was stolen. Not but 3 weeks ago on something like this, where he was going to Scotland. So I know they run warrant checks often at those. So he was arrested in Miami, returning home from a vacation. I believe there was a layover in Miami, and he was going to Austin.
So he wasn't staying in Florida?
No, ma'am, he was not, Your Honor. He was traveling through Florida, and he has traveled, inside the country. I think this was his first time leaving the country since the incident.
All right. So what I'm going to do is I'll grant bond in the case. I'm going to make bond a little higher because he does not have significant ties to Georgia. And also he has been gone here for quite some time. Going to set it at 7, and also the seriousness of the charges based on the information that the court has received as well. I'm going to set it at 75,000. I'm also going to indicate that he is not to drive, and that he is to submit his license to the court. The court will keep it. So he's to submit his license to the court, and the court will retain the license so that he will not be permitted to drive. And
Understood.
receive another license, so he can't indicate that his license has been stolen. They're going to be remitted to the court.
Understood. I'll inform him of what the consequences would be if he even attempted, Judge.
Okay, that would be the position that the court will take.
Thank you, Your Honor. That's all I have today. May I be excused?
Yes.
And Ms. Laverick, you can log off. That's his fiance that was on the call.
Consideration, Ms. Caldwell, of the age of the case, you all probably want to start prepping this one up as quickly as possible, because you're going to lose a lot of course, information. That's actually for both of you, defense and the state, if we wait any longer, because usually around the 5th year mark, the evidence just starts, the value of it just dwindles significantly. And if you're looking at 8 years, that's going to be important for you to present and move as quickly as possible. Luckily for the state, you have Mr. Thomas and Mr. Coughlin who are participating and willing to assist, but we do need to go ahead and put that one on a calendar. I'm going to put it back on an arraignment calendar for next month. Ms. Davis.
It's already on, Judge.
It's already.
It's on July 3rd, I believe. Is that correct, Ms. Davis?
That's correct, Judge. As well, I just wanted to make sure his address was updated in the system. I was checking to see what address it went to.
Mr. Maloof, you need to file the address for your client.
I certainly will, Judge, and I'll send his current address right now to Ms. Davis in the private chat.
All right, thank you.
Thank you, Judge. That's all I have today. May I be excused?
So this is in the matter of the people of the state of Michigan versus Marcus Monroe, file number 22-20886 FC. I have Odetella appearing on behalf of Mr. Monroe. And this is Mr. Hartung's case. So Douglas Hartung appearing on behalf of the people. This is the date and time set for pretrial. Mr. Odetella, how would you like to proceed today?
Your Honor, we have reached an agreement with the prosecution, and we have would like to plea in this matter.
Would someone like to place the plea agreement on the record?
Mr. Hartime, if you would like to set that out, we'd appreciate it, sir.
Sure, I can do that. This is my understanding, Your Honor. We'll move to add a count, I believe, a count 5 to the information, and the count 5 will be for felonious assault. Mr. Monroe will enter a guilty plea to that particular charge. The other counts would be dismissed as sentencing. He would have an obligation to testify truthfully in the upcoming trial against co-participants, Skysham Tyndall and William Dillard, if that becomes necessary. He will set up a time for an officer to come over and take a statement from him between now and the time of the trial. He's expected to give a full and honest and complete statement at that point in time. He will give a summary of that statement on the record today as a part of his plea. We've agreed that the sentencing in this matter will be within guidelines. He will get full credit for the time he's been in jail. He's been in jail for, I believe, the better part of a year. Is that correct, Mr. Odetella?
That's correct.
And the resolution of this case does not, at this point in time, act as a resolution in any way of his other pending case, which is set for trial at the end of July in this court. We're still working on trying to resolve that case, and this does not affect that at this point. I think that covers it.
All right, Mr. Odetella, is that a correct summary of the plea as you understand it?
Yes, Your Honor.
All right, so Mr. Monroe, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, sir, can you state your full name for the record?
Marcus DeAndre Monroe.
Okay, so Mr. Monroe, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 5, felonious assault, which carries a maximum penalty of up to 4 years in prison? But there is a Killebrew agreement that you would be sentenced within the guidelines. You would receive credit for all the time you've served, and you must testify against your code of minutes. So is it your intention to plead guilty to that charge?
Yes, ma'am.
All right. Are you satisfied with Mr. Odetella and the advice that he has given you?
Yes.
Okay. Neither, other than that agreement, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Hartung?
Yes, Your Honor.
Mr. Odetella?
Yes, Your Honor.
And Mr. Monroe, is that correct as far as you're aware?
Yeah.
If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Monroe?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or a denial of naturalization. Do you have any questions about the rights that I've given to you?
No.
All right, so Mr. Monroe, how do you wish to plead to the charge that on or about June 26th of 2021 in Madison Township in the county of Lenawee that you did commit the offense of felonious assault?
Guilty.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that, Mr. Monroe?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Hartung?
No, Your Honor.
Mr. Otatella?
No, Your Honor.
All right, Mr. Monroe, has your attorney promised you any particular sentence or estimated what your sentence will be other than the agreement that was placed on the record?
No.
Okay, is it your own choice to plead guilty?
Yeah.
All right, so I don't know, Mr. Otatella or Mr. Hartung, because of the nature of the plea, if either of you wish to voir dire or place factual basis on the record, or do you?
I'd be happy with having Mr. Otatella place that, ask those questions on the record, and I'll happily help him at any point if he needs help.
Okay.
All right, Mr. Monroe, on the date in question, did you have a, let's see how we want to proceed with it.
Well, let me, Mr. Monroe, let's start with this. On June 26th of 2021, were you in Madison Township in the county of Lenawee?
Yes.
Okay, then go ahead, Mr. Otatella.
Okay. Did you have a weapon in your possession on that date, Mr. Monroe?
Yes.
And did you point said weapon at the victim on that date?
Yes.
And did you place the victim in a fear on that date?
Yes.
Okay. Your Honor, I believe we've established the factual basis.
Mr. Hartung?
Okay, so let's amplify that a bit, Mr. Otatella. Mr. Monroe, I'll ask you a few questions. That's okay. Is that all right?
Yes, sir.
Okay. So what type of weapon did you have?
380 handgun.
And was that your weapon?
It was mine at the time, yeah.
Okay. Where did this event occur at?
Madison Township, on Cloverdale Street.
Whose house were you at? Were you at a party that night?
Yeah.
Whose house were you at?
Diamond Russell.
Okay.
What was
Mr.
the name
I'm
again? Mr. Hartung, we didn't catch that name.
Diamond Russell.
What's first name?
Diamond.
Diamond,
Spell that?
Diamond.
Diamond. Okay, got it. All right, never mind.
And about what time did this incident occur, Mr. Monroe, if you remember?
If I remember correctly, probably around midnight, going on midnight.
And tell us what happened.
Car came approaching down the street. Slow pace, windows down. I seen two masked men, two men with ski masks. As they got closer, I seen the driver wave a gun. I opened fire on him. They drove off. I turned around. I see my co-defendant, William Dillard, wrestling with a gun with another individual that I couldn't make out. Will Dillard had got the gun from him. The car went down the street, made a U-turn. At that point, I took cover again behind the car. When they came back, they opened fire on me. I returned fire again, as well as my co-defendant. And that's what happened.
You said you saw Mr. Dillard wrestling with a gun?
Yes.
What does that mean, wrestling with a gun?
Like he was trying to take the gun from another individual.
All right, did you see Mr. Dillard fire the weapon?
I didn't see him visually, but he was next to me and I heard the shot, so I assumed that it was him firing.
How close was he to you?
I say a couple feet, like side by side. I was kind of like in front of him though.
Was there anybody else next to him at that point in time that you were aware of?
No, there was a crowd more of it in the back, but they were just other friends I knew and they were basically taking cover from the shooting.
So who do you think he was wrestling with a gun with?
There was a couple individuals out of town that I don't, you know what I'm saying, that I didn't really know personally. I don't even think that he knew him personally. And he was just wrestling. It was like a light-skinned figure. He was just wrestling with the gun. He had finally got it from him.
So your statement was that you saw someone with the windows down and had a gun in his possession?
Yes.
You said he was wearing a mask?
Yeah.
He did not fire at you at that point?
He did not fire first.
You fired at him initially?
Yes.
Did he point the gun at you?
He just waved it in the air. So it was visible for me to see.
And you, how many shots did you fire at the vehicle at that point in time?
At that time, probably like 2 shots.
And how about the person who was right next to you, who you assumed to be William Dillard?
He didn't fire the first round when the car came the first time. He didn't fire.
When did he fire?
He fired when the car came back and returned fire on me.
Where was Skysh and Tyndall throughout this?
Skysh and Tyndall was in the house the whole time.
He never came out?
No.
Not even at the end?
No, I went in the house and seen him on the ground. Went in the house to check on my baby mother. My baby mother was at the residence at the time. When I went in the house, Skysh and Tyndall was on the ground.
When did William Dillard fire a weapon?
After the car came the second time.
Before or after that car shot?
After the car shot at me.
So you're saying that Mr. Dillard fired in self-defense?
Yeah.
But you're not saying that you fired in self-defense?
No, I mean, I was fearing my life when I seen 2 masked men coming down the street waving a gun at me, but.
Okay, so you are saying you fired in self-defense?
Yeah, I was in fear of my life.
Okay. Your Honor, we're going to reject the plea at this point in time. Thank you.
Yeah.
So, Mr. Odekele, we have a couple options. You can have a breakout room with your client and take whatever time you need, or not. If you want to try again.
Yes, if we can, Your Honor.
Okay, so Mr. Hartung, do you have a few minutes to stick around?
I do.
All right, so Mr. Rotella, I'm gonna put you in a breakout room with Mr. Monroe. So, Mr. Monroe, you may go automatically, or you may have to use the mouse to click on Zoom. There you go. All right. Back on the matter of the state of Michigan versus Marcus Monroe, 22-20886 FC. So, Mr. Odetella, how would you like to proceed now?
Your Honor, my client would like the plea. He's a bit nervous there. I think we went from factual basis into the testimony. So he wasn't sure what was going on, but he'd like to proceed with the plea if Mr. Hartung will still take that in this matter.
If he's going to testify as we discussed, that's fine, but I'll ask you, Mr. Odetella, why don't you ask him the questions for this purpose of the plea, including what his anticipated testimony would be at trial before we have an officer go in and interview him.
Yes. So, you want me to get the factual basis as well on this?
Yes, please.
Okay. So, Mr. Monroe, on the date and time that was placed on the record in Madison Heights,
Madison Township.
I'm sorry, in Madison, sorry, in Madison Township, did you have a weapon in your possession?
Yes,
What was that weapon?
.380 handgun.
And was it in your name?
No.
Okay. You had it in your possession though, right?
Yes.
Okay. Did you point it at the victim?
Yes.
Okay. And what did you do with that weapon?
I fired at the victim.
Okay. Was that victim placed in a state of fear?
Yes.
Okay. And let's see. Your Honor, what was the address on that? I'm sorry.
Well, it would be, all right, so Mr. Monroe, as you said, on June 26th, you were in Madison Township in the county of Lenawee, is that correct?
Yes, ma'am.
And you were at a Diamond's home, is that correct, her house?
Yes.
And you would agree that that house was in Madison Township?
Yes.
Okay, Mr. Hartung, anything else?
Yes, Mr. Odetella is going to need to solicit the anticipated testimony related to the co-defendants, Your Honor.
Okay. Mr. Monroe, who was with you on that day?
William Dillard.
Okay. And Mr. Monroe, why don't you tell us what happened with you and Mr. Dillard on that day?
We fired at the victims, alleged victims.
Okay. So when you said you fired at the alleged victims, when you said you fired at the alleged victims, who fired at the alleged victims? Was it you and Mr. Dillard?
Yes.
Okay. So earlier you said that there was a wrestling of the gun. Was there any wrestling of the gun?
No.
Okay. And when you said that there was a wrestling of the gun, did that come from a nervousness that we discussed because it's your first time giving any testimony?
Yes.
Okay. All right. I just wanted to make that clear, Your Honor. And you saw Mr. Dillard firing?
Yes.
Okay.
And he fired that weapon towards the vehicle?
Yes.
Okay.
And just to make clear on this, just because my client doesn't have any information, you said, where was Mr. Tyndall during this?
He was inside the home.
Okay.
Oh, that one? Yeah.
And that's your testimony at this time?
Yes.
Okay.
Mr. Hartung, any follow-up?
Couple quick questions, Mr. Monroe. Make sure I understand the sequence here. You're saying the time they drove by, the vehicle drove by, when you you indicated that you fired at the vehicle, saying that Mr. Dillard also fired at the vehicle at that time.
No, Mr. Dillard still didn't fire to the second time.
Okay. I guess I misunderstood what you said before. You said indicated that there was a firing that occurred to your side.
Yeah, but that was the second time the car came around, but I don't know if he fired first or if the car fired first at us. But I'm saying I fired at the vehicle first. When the car came back, I don't know if he fired first or if the vehicle fired first. It was you know what I'm saying? But he was side by side to me at that point in time.
Do you know who was in the vehicle?
I mean, I knew that just from text messages and talk before the shooting happened that it was Cruz Silva and Terrell Love, but Cruz Silva did have a mask on and I couldn't see Terrell Love in the passenger seat.
You knew they were coming over.
Right.
From previous Snapchat or other types of messaging to you or to the crowd or to the people at the party, right?
That's correct.
And where were you at when you received that information?
I was outside of the house.
Okay, how far away from the road were you when this shooting occurred?
Probably just a couple of feet. I wasn't far. There was a tree right next to the road, and I was right behind the tree when it first rolled down.
And where was Mr. Dillard?
Mr. Dillard was behind me at that point. Mr. Dillard was the one that notified me that the car was coming down the street.
Okay, all right. Prior to walking out by the roadside, did you have the gun with you?
Yeah, I had the gun on my person all night.
What kind of gun did Mr. Dillard have?
He had a .380 also.
Okay. Did Mr. Tyndall ever have a weapon in his hand that evening that you saw?
No.
Okay. Thank you, Your Honor.
All right, are you satisfied, Mr. Hartung?
Yes.
All right, has the court complied? Has the court complied with the MCR 6.302 B, C, and D? Mr. Hartung?
Yes, Your Honor.
Mr. Otatala?
Yes, Your Honor. Thank you.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Other than the Killebrew agreement that was placed on the record, this court has made no agreement regarding the possibility of a plea or possible sentence in this case. The prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for pre-sentence investigation. So, Mr. Otatala and Mr. Hartung, I'm going to give it my standard sentencing date. Obviously, if we need to move the sentencing date, that's fine, but it would make sure that the PSI is done in a timely manner. So I'm going to set this for sentencing on. Mr. Otatala, are you available August 3rd for sentencing? At 8:15, and it can be done via Zoom if your client has no objection.
8:15 is perfect, Your Honor.
All right, so I'm going to set this for August 3rd at 8:15 for sentencing. So, Mr. Monroe, someone from the Michigan Department of Corrections is going to meet with you, and they're going to give you a packet to fill out, and then they're going to give you sit down and meet with you, and they're going to ask questions. Be truthful with them about your background. Be truthful about the events that occurred. They'll prepare a report. We will send that to both Mr. Hartung and Mr. Otatala. Mr. Otatala will review that with you before sentencing, and then we will see back on that day. Now, Mr. Monroe, you do have a right to be present in person for sentencing, but you can do it via Zoom if you would like. Do you care whether, or do you object to doing it via Zoom, or do you wish to be in person?
I have no problem either or.
Okay, so we'll do it Zoom. All right, anything else, Mr. Hartung or Mr. Otatala?
Not at this time.
Nothing further, Your Honor. Thank you.
All right, thank you, Mr. Otatala, thank you, Mr. Hartung, and thank you, Mr. Monroe. You're all set.
It would make Penny very happy if you would like, subscribe, and leave us a comment.
Today is a day set for a pretrial conference. Is this matter properly before this court?
So, Your Honor, I had an opportunity to speak to Mr. Henderson. From my understanding of the conversation that we had, I believe that this would be more proper for the DV docket.
All right, Mr. Flanagan, can you call next door and ask the clerk what is their pleasure? Do they want me to send the individuals there now or just give another date? Probably another date, because
Is you gonna make me a cup of coffee, please?
can you stop talking to somebody while you on my record, please? And you still not sitting up straight for me like I asked you to before we got on court. I mean, before you went in the breakout room.
Right, Your Honor?
Yes.
Okay, they set a pretrial date of July 14th at 8:30 a.m.
All right, so the court is going to adjourn the pretrial conference. I apologize, what's that date again?
July 14th.
To July 14th at 8:30. I'm also transferring the case to the domestic violence docket by the Honorable Austin Garrett. The court will note that the complaining witness is present. And therefore, Mr. Henderson, while you may appear, you're not required to appear. We will note the file that you appeared today. And then Ms. Robinson, well, Miss Stevenson, is this the case? I know you all asked me on a case, I don't know if this is it, to reduce the bond or to take away the tether, and I didn't because it was a potential DV case. That's not this. Ms. Robinson is being held on something else other than this case.
So I'm actually, I probably need my partner, and if Mr. Murad talked to Ms. Robinson this morning, because I am puzzled as to why Ms. Robinson is incarcerated right now.
Okay, well, let me bring Mr. Murad in.
If I may, Your Honor.
You may.
So, Judge, on June 15th, we actually had a tether violation hearing for Ms. Robinson. I don't know if the court remembers, but this is the case where Ms. Robinson put the aluminum foil on her tether.
Oh, yeah. Okay, I knew it was something. Okay, and then I said I wasn't, but I didn't. Oh, and then so did I not give her? I didn't give her a personal bond either, did I?
I have bond condition amended to $1,000, 10% with GPS tether and house arrest.
All right. All right, Mr. Murad, we figured it out. That's why I brought you out, but.
My apologies, Your Honor.
That's okay. Okay, so Mr. Murad, did you want to put your appearance on the record then for this one, or?
If I may, Judge, yes, Ryan Murad, P3665 on behalf of Mr. Arlene Robinson.
All right, so I'm transferring the case to Judge Garrett. There's a pretrial conference for July 14th. Mr. Henderson, if you want to appear for that pretrial conference, like I said, you may, but why don't you unmute and tell me, how did you log into this court today? How did you log in? Did you use the Zoom ID number or did you click my name? Unmute and tell me.
ID number.
Okay, so if you log in to Judge Garrett on the 14th, his Zoom ID number is identical to mine, except instead of where you see an 8, you're gonna make it, I'm sorry, where you see a 9 in mine, you would make it an 8. So his is 338, mine is 339, those middle numbers. So you just change that 8, I'm sorry, I keep saying it backwards. You just change that 9 to an 8 to log in.
Yes, ma'am.
Okay, with respect to Ms. Robinson, I did say that if she didn't bond out, I would readdress her bond today. Mr. Murad.
Your Honor, with regard to that, unfortunately, Ms. Robinson has not been able to post the monetary bond. She has sat in the Wayne County Jail for well over a week because of this violation. Judge, I'd ask the court to consider amending her bond to personal. I know the court's not inclined to remove the tether today, but I would ask the court to consider it. If not, Judge, we are asking for at least the bond to be amended to personal bond. She spent I believe, over 10 days in the Wayne County Jail.
All right. So, any response from the people?
So Judge, I had an opportunity to speak with Mr. Henderson about this case. And from my understanding, Your Honor, Ms. Robinson is still reaching out to Mr. Henderson via phone. She's actually allegedly calling Mr. Henderson from the jail numerous of times. I know that prior to her being incarcerated for the tether violation, when she was out on the GPS tether, she was sending cabs to Mr. Henderson's home. She was also sending cabs to people he knows. She was reaching out to Mr. Henderson's children's mother and those type of effects, Your Honor. So I'm actually going to ask the court, based on that information, to keep the bond as is and keep the GPS tether with house arrest in this matter, due to the information received from the people, Judge.
Your Honor, may we be heard as to that as well?
Yeah, but who gonna talk? Because now you know y'all both can't keep talking on the record.
If we both could, that would be helpful, because Mr. Mraz spoke with Ms. Robinson today, Your Honor. But so I think that both of us should represent her today.
I don't know how Ms. Ritter gonna feel about that, but go ahead.
Okay, I just really want to speak to the contact. I was confused as to why Ms. Robinson was still in jail today, because I have received numerous text messages from Ms. Robinson where she has expressed concern for her personal safety because of the complaining witness directly and through third parties attempting to contact her, to the point where I responded to Ms. Robinson that if she was concerned for her personal safety because someone was harassing her, that she should contact the police. Again, I have messages that were sent to me via text message as well as email. So Ms. Robinson clearly understands that she should initiate no contact with this complaining witness, that she shouldn't have any contact with him through third parties, and she doesn't want him to contact her either, either directly or through third parties, Judge. I'm gonna join my brother counsel's motion for the removal of the GPS tether, Your Honor, at least to the reduction of the bond to personal with the GPS tether, because that actually would help to provide Ms. Robinson with a necessary defense if the complaining witness is alleging that she's coming over to where he is.
Well, here's the thing.
So she doesn't want to have contact with him. She's afraid of him
Yeah, they both,
and other people
let me tell you what
working
I
at his
surmise.
behest.
Let me tell you what I surmise. I surmise they both want to have contact with each other. That's what I surmise. Now, one thing is for sure. If Ms. Robinson has called Mr. Henderson from the Wayne County Jail, where all phone calls are recorded, on a recorded, I don't need any affirmation. I don't need any thumbs up, thumbs down. I don't need anything.
Mr. Henderson, just listen, please.
Yes, ma'am.
If that has occurred, it's so easy to get. It's so easy to get. Like, it's so completely easy to get. What I also know is that Ms. Robinson goes through a lot of stuff to get around stuff that she want to get around, because she put that aluminum foil on that tether. She left out that house when she wasn't supposed to. She's getting into it with a person who she is dependent on because she is tethered to their home. And like I said at the bond hearing, I wouldn't get in the argument with a person who I had to be tethered to their house. I wouldn't get in an argument with them. They could say whatever they want to say to me, and I would just try to sit there and try to take it, as long as they weren't hitting me or cursing at me, you know, belittling me. And then if I had to get away from them, I just go on the porch. I'm not gonna leave the house while I go in the backyard. So listen, I never understand these types of situations. I never do, but because if somebody don't want me, I don't want them. If they don't want me, I don't want them. And so I'm not running after you begging for you to do nothing. And then I'm not, yeah. So I never understand these type of situations. What I'm saying is, I don't know who's contacting who, but please don't be silly enough to think that it's not easy to find out who's contacting who. With the flick of a pen, we can get the record just with the signing of a warrant, with the signing of a subpoena. We can get the records. So stop acting like we can't tell who contacted who. Stop acting like if somebody, a third party contacting another person, we can't get the record and say, you called this person on this day, this person called her on this day. Stop acting like kids on here. Let's act like some adults. If the relationship is over, it's over. Move on. Move on to the next thing, to the next person, to the next whatever, to get on somebody else's nerves. Go get on somebody else's nerves. But I'm gonna tell you this. If either one of you violate this no contact provision between now and July 14th, I am going to lock you up. If either one of you violate this no contact provision before the matter reaches Judge Garrett, I am going to lock you up. If you put something on Facebook, I'm locking you up. If you send a message through Messenger, I'm locking you up. If you send a text message, if you make a phone call, if you send a taxi, if you send your friends, your homeboy, your homegirl, I'm locking you up. Miss Robinson, if you contact him, I'm revoking the bond, the whole bond. And you're just going to be remanded to the Wayne County Jail until the case is heard. Now, wouldn't that be a shame to be remanded on a case and spend more time in jail waiting on the case to come to trial than you would be once if you get convicted? Then you get convicted, they just gonna say credit for time served because you've been serving the time. And then God forbid you get acquitted and you've been sitting in jail.
Can I say something?
No, you cannot.
No.
So let me say this. I don't know who the culprit is, but you better stop it. You better stop it because you're being silly. You're being ridiculous. The case is in court now. Let it be in court. If you wanted to be together, you should have stayed together. Let it be in court. So nobody is contacting anybody. There is nothing going on in the world that needs to be discussed between Darlenia Robinson and Dietrich Henderson. If they announce we getting ready to go to war, you two can't discuss it. The court is going to reduce the bond to a personal bond, but I am going to, don't shake your head at me. If you want to do my job, go to law school, get a law degree, practice for 5 years, and then run for judge. Put your cup down because we're in court. and there's only 4 people on the screen that are permitted to drink anything because we're doing all the talking. So if you think you can do the job better than me, please apply for it. Because I could just let her go without a tether. That's what I could do. And if you keep talking, that's what I'm gonna do.
Mr. Henderson, please stop talking.
Well, let me say this, because his behavior right now, like that whole head back, lean back, whatever, is all disrespectful. And it's all inappropriate court behavior. All of it is. All of it is. All of it is. I am going to reduce the bond to a personal bond. I am not going to amend the tether. It will remain a tether. She will be tethered to somebody's house who's going to allow her to be tethered there. And then it will also still be a house arrest tether. And then I want Ms. Ritter to confirm from somebody the allegation that she has been calling from the Wayne County Jail. Because I want Judge Garrett to be aware if she has been calling from the Wayne County Jail, so that on July 14th, when there's another motion made for the adjustment of the tether condition, they can be aware as to whether she in fact was calling from the Wayne County Jail. Is there anything else with respect to Ms. Robinson from the lawyers?
Nothing on behalf of the people, Judge. I will inquire on getting the transfers for those jail calls.
Nothing further, Your Honor.
All right. Then Ms. Robinson, when they have a tether available, they will let you out of jail, but you are on house arrest. Now, let me say this, put some more aluminum foil on a tether. I double dog dare you.
I double dog dare you.
I double dog dare you to put some more aluminum foil on a tether. And I'm gonna remand you again. I'm gonna remand you. I'm gonna remand, if you tamper with that tether, I'm gonna remand you to the Wayne County Jail. Anything further?
No, thank you, Judge.
Nothing
All
further.
right, then we're all set. Everybody have a great day and stay safe.
Yes. Calling case number 231891 in the matter of the people of the state of Michigan versus Mr. Terrell Pitts. He is here for a deposition conference. Appearances for the record, please.
Good morning, Your Honor. John, KCP number 56162, staying in for my colleague, Bill Heafy, on behalf of the people.
Good morning, Honor, to you and your staff and attendants. DeRay Elder, on behalf of Mr. Pitts. Mr. Pitts, state your name, please.
Terrell Pitts.
Okay, well, where's your face? I'm talking to a wall or a ceiling or
It's right
something.
here. Hello?
Hello. Counsel, you wish to be heard.
Yes, Judge. Mr. Pitts has been accepted into diversion. We're asking the court to sign the order allowing him to be placed in diversion, Your Honor.
Mr. Pitts, do you understand if you successfully? Mr. Pitts.
Yeah.
Counsel, I'm gonna give you an opportunity to call your client.
Mr. Pitts, show your face at all times, please.
Oh, okay.
And I don't know where he thinks he gonna go off calling me. Yeah.
It's yes, Your Honor, no, Your Honor.
All right.
Are you awake, Mr. Pitts?
Yes, Your Honor.
You understand you're in court, Mr. Pitts?
Yes, Your Honor.
You understand I don't have to do anything the prosecutor and defense attorney agreed to, that the final decision rests with me, Mr. Pitts.
I mean, yes, Your Honor.
Mr. Pitts, you understand that under this program, if you successfully complete the program, the case will be dismissed, fingerprint and arrest cards will be destroyed. Do you understand that, sir?
Yes, Your Honor.
I got busy, Mr. Elder.
Judge,
And
I'm
I got, you know, and I got a whole mental health court docket after I do this one. You don't want to do this with me today. You really don't.
Mr. Pitts, it's yes, Your Honor, no, Your Honor.
No,
That's
it's if he want this diversion, he better come back on another day. Right, is what it is. I'm gonna take a break.
And while you're working that, a little more relaxed, and no one will be in. Okay.
Sounds good to me.
Yeah.
Put it on your face. Terrell, sit down. Sit right there. No, everybody
Miss
hears
Pitts,
you,
mute
Terrell. Sit down.
your device.
Okay, sit down. Put the camera on your face.
Okay. The whole court hears you right now.
All right, Madam Clerk. What are we gonna do? I see Mr. Elder is a brave man and he's still here. Now, we haven't called any other matters. Mr. Retha, did you wanna tell me why Mr. Elder, nobody gave him a return date? Is that the problem?
I'll figure it out.
Trying to figure out, you know, what was going on, because it just.
His client is on the verge of losing his deal because he doesn't know how to talk to a judge when he comes to court. And rather than me lose all patience with him, I'm gonna give Mr. Elder an opportunity to counsel his client so that his client can get the benefit of all the hard work Mr. Elder has done.
Got it.
Judge, and I thank you for that, Your Honor. Your Honor, just for course information, Mr. Pitts is on the spectrum. I did have a conversation with him along with his mother, Judge. So if the court can just give us one last try, Your Honor. Otherwise, we'd have to come back in physically.
Well, is his mother with him?
Judge, she's in the other room. Mr. Pitts does not want her in the room. I'm asking the court to. I think Mr. Pitts now the court definitely has his attention.
Okay, then let me see. You know, I have this bad habit of trying to help people out.
You do.
So then my next question, if he is on the spectrum, is whether or not his mother is aware he's entitled to services and I can tell her where to go get them.
Judge, I know he is receiving services, but if the court wants to give her additional information on that, that'd be great.
Give me a second. Let me see if I can find my cell phone so I can give you. Now, counsel, have you had an opportunity to talk to the young man to explain to him how he has to conduct himself?
Yes, Judge, I did.
Let me pull up the form. I'm gonna try this one last time today. And if that doesn't work out, then maybe you need to get with him and his mother all in the same location.
Mm-hmm.
Because some things are not about what he wants. Some things are about what he needs to do.
Great.
All right, we're back on the record. Young Mr. Pitts.
Yes, Your Honor. I apologize for coming off rude.
Well, thank you. I appreciate that. How old are you?
23.
Did you finish high school?
Mm-hmm.
Where?
Belleville High School.
You got a job?
Not right now.
You ever have a job?
Yeah.
What was that?
Yes, Your Honor.
Why aren't you working right now?
Right now I'm looking for a job, Your Honor.
I'm gonna give your lawyer some information for some people that will help you get a job.
Okay.
He's gonna give that information to your mother so she can make the phone calls to see if she can get you in the program. Understood?
Yes, Your Honor.
All right. I have a motion from the people to place this young man in the diversion program. Mr. Elder, the program that I want him to participate in during this 1-year period is called Art Detroit. Now it's my contact is with Art Detroit.
Okay.
The gentleman's name is Lauren Glover. His cell phone number is 313-478-0302.
Got it.
Now, this organization works with the cognitively impaired. This organization is over 50 years old. I'm active with the organization, not because I'm cognitively impaired, but because I like the work they do. I MC their one fundraiser a year, every year. Understood? You need to explain to his mother that the benefit of him being in the program is that they will provide him with assistance, both in terms of being with the right social group, employment opportunity, other needs for life. Oftentimes, parents are afraid they won't outlive the children, and who's gonna help them when they gone. So she needs to get in touch. They probably have a program downriver, but Mr. Glover can tell her all of that. So, and when she calls, let him know that Judge Deborah Thomas sent her. Drop names.
Got it.
Now, young man, do you play basketball at all?
No, ma'am.
Never played?
Uh-uh.
Got any interest in learning?
No, ma'am.
Okay. They'll find something for you to do. You have to return back to court on June 21 of next year.
Yes, sir.
So that
Yes,
we can
ma'am.
find out, did you satisfy the program?
Yes, Your Honor.
And counsel, I presume you're going to relay this information to his mother.
All of it, Your Honor.
June 21. We may be in the new building. I don't know where we're going to be. I don't know if we're still going to be on Zoom or not. But he has to reappear on June 21. And she has to call Mr. Heafy tomorrow to find out what this young man must do in order to successfully complete the program. And you emphasize to her that if community service is involved, Art Detroit can assist with that. And that she needs to get connected with them so that they can help him.
Absolutely.
All right, I'm through.
Judge, thank you for your patience.
Thank you, counsel.
Take care.
You're free to go, Mr. Pitts.
Oh, there we go.
Ms. Pope, you have to unmute.
Okay, can you hear me?
We can now. Ms.
Perfect.
Pope, you appear to be moving. I don't know if the phone's moving or if you're moving. I know you're in a vehicle. If you are driving, you need to stop and stuff. I don't want you getting in an accident.
Yeah, no, I was just putting my phone up. I'm in my vehicle at the courthouse though, so we're good.
Okay, okay, thank you. Mr. James, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days. If it's a second or subsequent offense, up to 90 days. You understand that, sir?
Yes, sir.
Okay. Court has appointed Mr. Sackrider to represent you. Had you have sufficient opportunity to speak to Mr. Sackrider in preparation for this proceeding?
I spoke to him earlier, Your Honor.
Okay. Mr. Sackrider, are you ready to proceed?
Yes, Your Honor.
Okay. Ms. Hester, I'll have you and Mr. James raise your right hands. We'll have you sworn in, then we'll proceed.
Okay. Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
I do.
I do.
In the 1998 case, his total monthly obligation is $53.50. That would be $50 on the arrears, $3.50 service and processing fees. The last payment that applied to this case was February 7th, 2023, in the amount of $1. There was 9 show causes, 3 bench warrants, 0 contempt findings. We monitored his compliance by the last 3 months at $53.50 a month. He should have paid $160.50. 0 has been paid. The total arrears on this case is $1,108.11, and there is no previous jail sentences. On the 2014 docket with Vicky versus Robert, his total monthly obligation is $419.50. His last payment was April 25th, 2023 for $25 that he had paid on his own. There's been 6 show causes, 3 bench warrants, 0 contempt findings. We monitored compliance by the last 3 months at $416. He should have paid $1,248. $25 was paid, so that's a shortfall of $1,223. The total arrears on this docket as of today is $4,649.51. On this case, we're also requesting a payment on his arrears, Your Honor. On the 2021 case with Michelle Pope versus Mr. James, the total monthly obligation is $1,328.50. He's had, I'm sorry, the last payment was made April 25th, 2023 for $75. He had paid that on his own. There's been 2 show causes, 3 bench warrants, 0 contempt findings. Compliance was the last 3 months at $1,325 a month. He had paid $75 of that, the shortfall $3,900. The total arrears on this case is $6,947.18. We're also looking for a payment on his arrears to be ordered on this one. And then just for the record, at the last show cause hearing, April 13th, 2023, before Referee Coteau, Mr. James did appear for his show cause hearing, which in a tractor at a farm. An income withholding was sent out to Wilson Farms, and Wilson Farms had said that they had never hired Mr. James, just for the record.
Okay. Mr. Sackrider, do you contest or dispute any of the statements made by Ms. Hester?
No, Your Honor.
Any questions of Ms. Hester?
Yes.
Go ahead.
Ms. Hester, have you offered Mr. James the ability to participate in the LEAP program?
You know what? I believe I have, but I don't have the information right in front of me. He would be able to answer that. You have, Jamie. I have, okay. And he was found ineligible because
Hold on, Ms. Huntley or Ms. Pope. You don't have a chance to speak now. I'm going to give you an opportunity to speak later, but not now, okay? Go
All
ahead.
right. No further questions, Your Honor.
Okay, any proofs, Mr. Sackrider?
Yes, I'd call Mr. James Jr.
Okay, go ahead.
All right, Mr. James, can you hear me?
Yes, sir.
All right, you heard the testimony of your caseworker, Ms. Hester. Is there anything that you disagreed with?
Well, I did make a payment yesterday, sir, that wasn't brought up.
I don't know if it hasn't been posted yet or what have you, but I did make a payment yesterday of $100. But other than that, no, sir.
Okay. And where are you currently working?
I am not working. Like I told you earlier, I've applied for over 100 jobs. And every time I get something going, this home invasion case jumps up that I have pending with Miss Pope, and the offer is usually rescinded. Yesterday I was called and offered a job at Thompson Construction in Coldwater, starting July 10th.
Okay. When was the last time you were working?
In October, sir.
October of last year?
Correct.
Where were you working?
At McClellan Apartments.
Okay. And were you making regular payments on your child support obligations?
There was an income withholding at the time, yes.
All right. And so that employment ended in October of 2022. What have you been doing to find employment since that time?
Like I said, I've applied for over 100 jobs. I've been to multiple interviews. I've had 2 job offers. Once the background check comes back with a pending home invasion case, they rescind their offer.
Okay. And is that pending in Calhoun County?
That's correct, sir.
What is the status of the case?
As of right now, there's no upcoming court date scheduled.
Okay. Is there a reason for that?
That I'm not sure. I talked to my attorney yesterday, and he was supposed to check the status and let me know. I haven't heard back from him. Don Hammond is his name.
Okay. And you said you were just offered employment at Thompson Construction?
That's correct.
All right. Have you accepted that employment offer?
I have, and I start, like I said, July 10th, sir.
All right. And do you know the pay there?
$19 an hour.
All right. And do you know how many hours per week?
It should be between 38 and 45, Monday through Friday.
Right. Are you willing to set up income withholding?
Yes, I've let the foreman know there that there will be an income withholding set out.
All right. How have you been supporting yourself since October of last year?
So basically, I just do odd jobs here and there. Occasionally, I work for my brother-in-law who has a dairy farm. I don't know if they sent out a Wilson income withholding to the proper Wilson Dairy, because there's several of them. But the Wilson is spelled with 2 L's. It's WILLSON Dairy, and that's in Marshall, Michigan.
Okay. And
but I only work roughly 20 to 30 hours a week.
Okay.
And that's not every week. It's just whenever he needs help.
All right. Are you getting help with paying your living expenses?
Right now, I live with my parents.
Okay. And you voluntarily made payments on your child support obligations during that time from October to now?
That's correct, when I could.
All right. Do you have an ability to pay any money today?
I could make a payment today.
Of how much?
Well, I mean, I could probably pay 100 or 150 on each case.
All right. All right. Anything else you would like to tell the court?
No, sir.
All right. Thank you. No further questions, Your Honor.
Thank you. Mr. James, in this matter, you stated that you'd work some odd jobs, and obviously, how much would you say you average per week working those odd jobs?
Maybe 200, sir.
Okay. And when you worked for your brother, let's say on average, you were saying you were working 20 to 30 hours a week. How much would you make working for him on average?
So he paid me $15 an hour cash, sir.
Okay. So at that, you were working anywhere from basically anywhere from 300 in that matter to, let's say, 450 per week then?
Well, not quite that much. Like I say, about 20 hours. So roughly 350, sir, on the top end.
Okay. Well, if you're working the odd jobs and you're making 200 and you're making 300 at that, why were you not paying any more money on your support obligations?
Well, to be honest with you, sir, I was trying to pay all my obligations. I paid over $1,000 in dance for my daughter's dance class so she could dance. Her mother was adamant about making sure I paid for that so my daughter could dance. I just trying to make every end meet that I could.
Okay.
It's not that I don't want to pay. It's just that I really don't have the means to pay. My truck's about to be repossessed. Like I say, I'm starting a new job July 10th, and everything should fall back into place after that.
Okay. Anything else you'd like me to be aware of, sir?
No, like I say, I can make a payment if necessary today or first thing in the morning.
Okay, you said 150 per case, so you've got 3 cases that work out to $450.
Yeah, I'll just borrow it from my mother. I've got good credit with her.
Okay. Anything else you'd like to tell me, sir?
No, sir.
Okay. Why don't we start, Ms. Pope? What would you like me to be aware of?
So, Robert, he's 100% being deceitful about the his job at Wilson Dairy. And I know this because I've been with him when he's cashed a check from Wilson Dairy that's on their, company. It's a company check. We dated for a long years before we separated. In fact, I have text messages on my phone and on my daughter's phone and recordings where he can't see his daughter because he's working. He also has a bank account that he cashes the checks at. So is there any way can he have to provide his bank statement so you can see the checks being deposited? Because he's working. He did this. The home invasion was in January 1st. He quit his job in October before the home invasion. Robert is a habitual. He goes through jobs frequently. That's what led to our separation. I always had to, fork the bill for everything. He's 100% being deceitful. Also, friend of the court had the correct address to Wilson Dairy because I provided it to them myself. And I know the address. His sister and brother-in-law, just like Robert, they're, and he said it before. Actually, at our last show calls, he hung up, he disconnected the Zoom call. And after it was brought to his attention that he was appearing while sitting in a tractor, and he said, and the referee said, I'm going to refer this to the judge to deal with this. And he, quote unquote, said, good luck, and hung up. He's a habitual scammer. He's scamming the system to get out of having to pay child support and responsibilities. That's exactly what this is. He works full time at the farm. He gets paid on company checks that's deposited into his bank account. He has vehicle. He has softball teams. He's a very active man. How do you support yourself? He said he does odd jobs here and there. That's employment. Whether you want to call it an odd job or you're employed with a big company, you're working. The income withholding thing, that's his sister and brother-in-law. I'm not surprised they're not going to do it because of that. Make him forget the income withholding then and make him have to pay it out of pocket every month. Then they will never respond to an income withholding. He works there full time. He's being deceitful. I know that. I dated him for 8 years. I helped him with Vicky, his other cases before we separated. So I know how he is. That's all. Thank you.
Okay, thank you. Ms. Huntley, anything you'd like to say?
Robert's been working for Wilson Dairy since I've known him, and I was with him from 2012 to 2014. So this is not a new thing. It's been the same thing over and over again.
Okay. Anything else, ma'am?
No, sir.
Okay. Anything else, Mr. Sackrider?
No, nothing further, Your Honor.
Okay. Well, in this particular matter, the court will note that, again, the Mr. James has testified in this matter that he last worked in October of 2022. There's been some statements made by both of the mothers in this particular case that he's working full-time, et cetera. There, we don't know that for a fact, but we'll take that for what it's worth. He testified that in this matter that he did work odd jobs where he was making $200 a week. Other times where he was working for Wilson Dairy, he was making $350 per week. Notwithstanding that, at those times he was not paying his support obligations. So the court will find that he did, in fact, fail or refuse to comply, and that he willfully failed to pay in this matter, and the court will find him in contempt of court in this particular case. With that, anything, Mr. Sackrider, that you'd like to say before we pronounce sentence?
Yes, Your Honor. We would ask that Mr. James be allowed to participate in the employment that he was offered beginning July 10th. And he did testify that he's willing to set up income withholding to begin making payments. If the court does impose a sentence, we would ask that it be suspended and that any purge amount be in the amount of $450. Thank you, Your Honor.
Okay. Well, what the court's going to do is, Mr. James, I could sentence you up to 45 days in jail. I'm not going to do that. What I am going to do is I am going to sentence you to 21 days in jail with credit for no time served. Court will, in this matter, what the court is going to do is the court will set a purge amount on each of the cases in the amount of $500. What I'm going to do is I'm going to suspend that sentence through August 16, 2023 at 8:45 a.m. You'll have to come back at that time. That will give you time to acquire the employment that you stated you have coming. Also, during that time, to pay the purge amount on each of the cases. If you pay the purge amount, then you don't have to go to jail. If you don't pay the purge amount on that August 16th date, you will be going to jail and serving your jail sentence. You understand that, sir?
Yes, sir, I do.
Okay. For Ms. Huntley and Ms. Pope, just so you know, in this case, what we're attempting to do is obviously the importance is to get money coming to you so that you have money to support your children in this case, and the court looks at that as paramount to any particular punishment, unless it gets so egregious that, again, that's just not going to be an option. But we're giving Mr. James an opportunity, but I will tell you, this is the last opportunity. If he doesn't comply, then he is going to go to jail. So the court would also, in the case with Ms. Huntley, in this matter, the court would set a arrearage repayment. Well, I'll do it on both cases, arrearage repayment in the amount of $50 per month on both cases. So that will be added to the amount that's owed in both of those particular matters. Anything else, Mr. Sackrider?
No, Your Honor.
Ms. Hester?
Yes, Your Honor. Two things on all of these. Are you ordering court costs?
I didn't hear you.
Are you ordering court costs on these three cases?
Court cost?
Mm-hmm.
No, well, no, I'm not ordering any court costs at this point.
Okay, and then the other thing is could we please set it 8:16 at 8 a.m. instead of 8:45?
Oh, yeah, we can set it. We'll do it at 8 a.m. then.
Okay, thank you.
And so, Mr. James, you'll have to be back on that August 16th date. We'll see what you're doing to comply. I will tell you, if you don't, if you pay the purge amount of $500 in each case, then again, that would take care of it. If not, you're going to basically have to appear and demonstrate why you haven't, and at that point, be prepared to go to jail. Okay?
Yes, sir.
Okay. Thank you.
You said August 16th, sir?
August 16th at 8:00 a.m. Correct.
Okay, thank you.
Court will end this matter at 12:18 a.m. You're free, or at 12:18 p.m. You're free to go. Have a good day.
Thank you.
Thank you.
Have a good day.
Let's go on to Mr. Kelly, and the other party is present here too.
Is that Miss? Understand the charges?
Yes, Your Honor.
Court will advise you in this matter that I've appointed Mr. Sackrider to represent you. Have you had sufficient opportunity to speak to Mr. Sackrider in preparation for this proceeding?
Yes, Your Honor.
Okay. And Mr. Sackrider, are you ready to proceed?
Yes, Your Honor.
Okay. Mr. Kelly, I'm going to have you raise your right hand, be sworn in. Ms. Hester has already previously been sworn.
Okay. Sir, do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes.
Okay. Ms. Hester, you can proceed.
Oh,
Thank you, Your Honor. This is docket number 2012 I'm sorry. This is
there was
docket.
a delay, sorry. We can hear you for a moment.
Okay, can you hear me now?
Yes.
Okay, this is docket number 2012-002815 involving Jade Haggerty versus Brandon Kelly. The total monthly obligation for this case is $1,423.50 a month. The last payment made was February 28th, 2023, in the amount of $429.60 that was paid on his own. There's been 3 show causes, 0 bench warrants, 0 contempt findings. We monitor compliance by the last 3 months at $1,423.50. That equals $4,270.50. He was ordered to make a $2,000 lump sum payment, which made the total due $6,270.50. Nothing was paid. The total arrears on this case as of today is $7,933.40. There's been no previous jail sentences. And just for the record, when I called Mr. Kelly this morning, his voicemail did say that I had reached Kelly Carpentry in Ann Arbor.
Okay. Mr. Sackrider, do you contest or dispute any statements made by Ms. Hester?
No, Your Honor.
You have any questions for Ms. Hester?
Yes.
Okay, go ahead.
All right. Have you offered Mr. Kelly the opportunity to participate in the LEAP program?
I don't believe he has done that, but I don't believe that we have. He's always had employment as far as I'm aware.
All right. I have no further questions.
Okay, any proofs, Mr. Sackrider?
Yeah, I call Mr. Kelly.
Okay, go ahead.
All right, Mr. Kelly, can you hear me?
Yes, sir.
All right. Did you hear the testimony of Ms. Hester?
Yes.
Is there anything that you disagreed with?
No.
All right. You were ordered to pay $1,423.50 per month. Were you aware of that obligation?
Yes.
Is that amount too high for your current income?
Currently, yes.
Okay. And are you willing to take steps to file a motion to have that amount changed if necessary?
Yes.
All right. You made a payment on February 28th, 2023 in the amount of $429.60. Is that correct?
Correct.
All right. And are you currently working?
I'm self-employed, but our revenue is at a point where I'm just covering costs.
All right. How long have you been self-employed?
10 years.
All right. What kind of work do you do?
Residential remodeling.
All right. And recently you've had a slowdown in work?
Yes. Last fall, we had a significant slowdown. I had to lay off several employees and liquidate company property in order to cover expenses, including child support. And we are now in the process of rebuilding our workforce and client base.
All right. Are you also going through a divorce?
Correct. It was final in February.
Okay. And are you waiting on a property settlement from that divorce?
I am.
And what does that involve?
Because of my ex-wife's cancer diagnosis, it was determined in mediation to allow her through this year into next year time to recover until the sale of the house, which then I am entitled to a portion of the equity at the sale.
Okay. Is there any amount that you could pay today on your obligation?
I could pay $500 today.
Okay. What is your plan for paying your child support obligation in the future?
I have several jobs close to a contract, which would, and a new employee as of the last 3 weeks roughly, which is allowing us to move at a faster pace and generate income sufficient to begin paying regularly on child support.
Okay. And are you working on any issues for sobriety?
I am. As of 8/5/2022, I voluntarily entered a program of sobriety, mainly involving Alcoholics Anonymous. My issues with that played a significant role in my most recent divorce and affected my ability to work efficiently. But as of today, I have been alcohol and mind-altering substance free for almost 11 months, which has made a great impact on my ability to perform consistently, and it is my intention to continue that.
Okay. Anything else you'd like to tell the court?
No, sir.
All right, thank you. No further questions.
Mr. Kelly, so you're self-employed for approximately 10 years. Obviously, you had some issues with sobriety that affected your work, but you're working now, is that correct? You have ongoing jobs?
Correct, Your Honor.
What would you say over the last year, what's been your average weekly income from your job or from your business?
It'd be hard to say. I mean, gross revenue, maybe $3,000. We have, I have a payroll and a rent on the business lease space, which I'd actually been living in for the past 10 months as well, unable to afford regular housing. So anything that is net profit has not been significant for the past several months.
Okay. Have you attempted to acquire full-time employment outside your self-employment?
I have not.
Okay. And what's the reason for that?
Historically, the business has been able to produce enough income for myself and to cover child support. I've been able to pay that more or less regularly over since the beginning of the case in 2012. It's been an unusual year. I'm also committed significantly in a lease space and overhead that, in my opinion, it is long-term more likely that I will return to that and be able to pay regularly again versus trying to close the business, so to speak, and work at a much lower rate of income. What I would qualify for in the field is much less than I would make working for myself.
Okay. And what do you figure you could make if you were employed elsewhere in the field but not self-employed? How much could you make doing that?
At an entry level, maybe $25 an hour.
Okay. And what's the extent of your educational background, sir?
High school and some college.
Okay. Anything else that you'd like me to be aware of?
No, Your Honor.
Okay, thank you. Ms. Haggerty, is there something you would like me to be aware of, or what would you like to see the court do in this matter?
Well, that's really hard to say. I mean, I have several things I'd like to weigh in on. Namely that, Brandon has not mentioned the children once, and he has not seen the children in a year and a half. When we were going through some custody things earlier in the year, I think his 2021 business earnings were totaling over $500,000, and that was a loss for him. So, he had the ability to learn, and his personal matters, we all have personal matters, and we are still raising the kids over here. And he has had 3 hearings previous to this with a referee, which he has, made make the promise of paying these different amounts, and he has yet to do so. And if we look back in the history of over 10 plus years of child support payment, even when his business was bringing in the most earnings, he was never consistent with child support. I don't think there's ever been a year where Mr. Kelly has paid child support monthly for the entire year, maybe one in the series of 10 years. So, I really am at a loss at this point. I mean, the kids still have to have a roof over their head. They still have to be fed. We provided medical. He's not seen or provided for them, not seen them in a year and a half. So, I mean, the list really goes on. Self-employment is a choice at this point. He's made some other choices with employees that, that's speculation on my part, so I won't go into that. But, at some point you have to say, I'm not providing anything for my kids, even financially. I think the minimum he could do would go be a job, and, not even $10, to provide for his children. Never a question of, are they provided for? Are they cared for? Which they are in our home. But, we have a son that's going to college. Mr. Kelly was not a part of any of his graduation, anything. We just really are at a loss, these hearings, and, continue. I just feel he's been continually able to get a pass on these things, and it's ongoing. Even in his history of payments, he would go a month and pay, go a couple months and not pay. Mr. Kelly, has the ability to provide a life for himself. He's just moved into a new residence. He's gone on trips and vacations and things in the last year and a half and not provided for his kids consistently. So, I just really would like to make it clear that I don't believe any promise to pay at this point is just an extenuation of, what he's exhibited in the past, which is that he will not pay consistently for the kids. It's not a priority for him. And, I sure wish it was.
Okay, thank you.
Mm-hmm.
Mr. Sackright, or anything else?
No, nothing further, Your Honor.
Well, the court's heard the testimony in this case. It does appear Mr. Kelly has had a high school education, some college. He's been self-employed for approximately 10 years. As he stated, historically, he's been able to meet his expenses, pay his child support in the past. However, he does have a substantial support arrearage of almost $8,000 in this particular matter. He states that he believes that he could maintain his business and be self-employed, that he would make more than if he was out trying to work for someone else, where he stated he could make anywhere from $20 to $25 per hour. So clearly he has income sufficient to pay the support obligation. That the court will find that based upon his own testimony, that he's failed or refused to comply, notwithstanding his ability to do so, and therefore the court will find him in contempt of court. Anything else before sentencing, Mr. Sacrader?
Your Honor, my client is currently working. We would ask that the court not impose any jail sentence, and if the court were to impose a suspended sentence, and set a purge amount in the amount of $500. Thank you, Your Honor.
Okay, thank you. Well, what the court is going to do, the court is going to sentence Mr. Kelly to 21 days in jail with 0 time served. As far as credit, the court will allow him to purge himself of contempt by paying the sum of $500. He'll need to have that paid in this matter by this Friday, the June 16th, 2023 at 4:00 p.m. or otherwise report to the Calhoun County Jail to serve his time. The court would further in this matter would direct the front of the court to again, the court would grant in this matter a lien in this matter going to receive on the divorce case. He said that will be paid, he believes sometime later this year or next year, that the court would grant a lien against those particular proceeds to satisfy the support obligation in this matter. And further, what I'm going to do is I'm going to reset this matter to August 16, 2023 at 8:00 a.m. Mr. Kelly, you'll have to be back at that time. We're going to see what you do between now and then, and that will determine whether, again, whether you go to jail at that time or whether you're going to stay out. So it's up to you. If you paid nothing during this interim period of time, notwithstanding paying the purge amount to stay out of jail this time, you should be prepared to go to jail then. You understand?
Yes, Your Honor.
Okay. We'll see you back on August 16, 2023 at 8:00 a.m. We will now conclude at 12:36 p.m. You're free to go. Have a good day.
Cheryl Luckoff on behalf of the plaintiff.
I'm here.
Okay, Ms. Mathis. This is a termination of tenancy case. Is this a lease expiration? Or?
Same month-to-month tenancy not being renewed. Yes.
All right.
Yeah. Hello.
Go ahead, Ms. Mathis.
Your Honor, I wanted to renew. I went to the office plenty of times, but I did want to just not get terminated. I did want to come voluntarily to sign the paper to leave, to move out no later than August. But I wanted to renew. But however, I've been running off space heaters in my oven since December, since the winter time. So why would I renew when I've been constantly going? I haven't had water. I didn't have water for a whole month one time, and the lady knows it because I went down there with videos after being ignored by maintenance for over a month. So I wanted to renew, but however, I was going through. I had my niece. I was taking care of my nieces at the time, and I couldn't have babies in an apartment with no water, no heat, or no air. And they kept coming over and said, "It was nothing to do. We waiting on the park since December." Even when the state came into my house to do the statement checks, she came in bright early in the morning, and I had an oven running. And she was like, "That's unsafe," which is I know, which I have maintenance issues I'm not complaining about, but I don't want to get evicted just because I didn't renew my lease. I wanted to renew, but I was going through maintenance issues. I didn't have working heat and stuff like that, which I'm not tripping about. I will leave. But I've been living there since 2012 and I was waiting to move out or whatever, but I was signing a paper to leave out no later than August. I just don't want to be evicted. I don't mind. I came there yesterday and paid my rent, my balance, not my balance, but my, what I did, something that I owe.
Okay, Mr. Mathis. So you're willing to leave?
Yeah, I'm willing to leave in August. I was signing a paper to 30-day, but that's the thing. You have to give a 30-day notice, which I don't mind. But when I was going to renew back in January, but I didn't have any heat. I didn't have any air for months, sir. Months.
So Ms. Mathis, you say you're wanting to leave. So what do you want the court to do? You're muted. I can't hear you, Miss Mathis. You're muted.
Oh, I'm sorry. Hello. I didn't want to get evicted based on me not renewing my lease, but how do they want me to renew my lease in place that I had no running heat or no air, sir? I didn't even have water for over a month. I kept coming down
So
there.
do you want to vacate the premises?
Yeah, but not right now. Like I wanted to sign and
Okay.
leave an offer.
All right.
I voluntarily vacated.
Okay, listen, just when are you
Yeah,
when are
sorry.
you proposing to move?
I didn't know that I was a problem that I had to move. I wanted to renew. I just wanted them to get the maintenance issue down first. But since that's not the issue that they willing to do, I see they just trying to push me out instead of fix the issue. I will move. But at least let me get 30 days. Let me find an apartment. I wanted to renew where I stayed since 2012, sir. So I will move. They want me to leave, but let it not be right now off eviction because I've been a tenant there since 2012, literally. So I will move voluntarily, signing a 30-day paper in August if they want me to, if that's an option.
Okay, ma'am. I heard everything that you said, and you said it to me now 3 times.
Sorry.
So if what you would do is answer my question, I would appreciate it.
I will sign a paper, the 30-day paper, to leave like August if that's the option.
Okay, so you are willing to
September is the
vacate
latest.
August?
Yes.
Okay.
I'm sorry. I'll say nothing else. I'm sorry. August, September at the latest. That's it.
Okay, well, it's either August or September. I don't know what the plaintiff's position on this is.
Your Honor, plaintiffs do not want to wait. We have not been able to accept rent, obviously, because of the notice. So, at this point,
They just accepted a $1,400 check from me yesterday. I was just in the office yesterday. I'm confused.
Well, they will be returning that if you handed that in because they wouldn't be accepting that. And so, Your Honor, we're asking just for this is the first hearing. I think you're doing 2 hearings on terminations. If you are, we just have it set for a second hearing. Otherwise, we'd ask for judgment today. I mean,
Your Honor, can I say something, please, sir? Please, sir.
I haven't been able to
tenant-
stop you yet,
I'm
so
sorry.
go ahead.
I've been a tenant there since 2012. For the
I
last
know.
year, listen, so they can't work with me from a tenant from 2012, no problems. I'm saying, can I get at least a month? Can I have at least August and I volunteered? I don't want to, can I have the option? Because I don't have the option to move.
Ma'am,
Yes.
please. Here's what I'm going to do. And
yes,
did you take down the walk-in hours I had for legal services?
No.
All right, let me give those to you again.
I'm just.
Okay?
Yes.
They're located at 15 South Washington. Their walk-in hours are on Tuesdays from 10 to 11:30.
I'm sorry.
And on Thursdays from 2 to 3:30.
Tuesdays and Thursdays. Let me start. Can you repeat that for me again, sir? My pen wasn't
Yes,
working.
Tuesdays from 10 to 11:30.
Okay.
And then on Thursdays from 2 to 3:30.
You said Tuesdays from 10 to 11:30 and Thursdays?
From 2 o'clock to 3:30.
Okay.
Okay.
But,
Here's what
I'm not, go ahead, sir. I'm sorry.
Here's what I'm going to suggest you do. You go talk to them about what the issues that you have are. The landlord has not accepted rent because they'll be returning it, but according to them, but they apparently don't want to give you until that time. So you'll have an opportunity to speak with legal counsel by going to this walk-in to see what your options are, okay?
That's fine, but I have videos telling me she can't either they send her give me an extra month, no eviction. Like that's ridiculous since 2012.
Ma'am.
Yes.
What do you want me to do?
I want to voluntarily leave. I don't want eviction on my record. That stops me from getting somewhere else.
But you're not agreeing on the terms.
The terms is to leave now. That's the terms. It's the middle of the, like,
I mean, Your Honor, this notice was sent on April 1st, so we've had almost 3 months now.
sir, I didn't get this notice till I contacted by a thing. I didn't get this notice till till literally the beginning of June. So I don't know what April they're talking about. Yeah, and I've been to the issues of
but Your Honor.
I don't know anything. I don't know anything. But I'm saying the lady knows my face, Your Honor. I just want her or her attorney to at least give me a month. I don't want an eviction on my record, nor do I want the option to move somewhere else. I don't have to have September. August can be the month that I leave. Or they need when I want to move out, they
Miss
want
Mathis. Miss Mathis. Miss
Yes, sir.
Mathis. Miss
Yes.
Mathis. Stop.
Yes. Okay.
If you can work something out with the office, then feel free to do that. If you don't think that you can, and you're looking for 30 days, I don't know if that's an option. That's why I said you can go and talk to legal services and see if they can assist you in that regard.
Okay.
You're continuing to try to talk and overtalk me isn't going to work. It's not going to get you to where you want to be. I'll adjourn this matter to June 30th, 2023 at 11 a.m. Thank you.
Magistrate up there, Ms. Johnson. You're here on a criminal matter. Case number is 230-575-2901. What's your full name, including your middle name, ma'am?
Ashley Mayo Jackson.
Thank you, ma'am. You have an attorney. Go ahead, counsel.
Rita White on behalf of Anjali Laniel Johnson. For arraignment purposes, she will waive formal reading. Samuel.
Thank you, counsel. I'm gonna enter plea of not guilty. I'm gonna repeat the case number is 230-575-2901. I'm gonna enter plea of not guilty for July 3rd, 2023. Probable cause conference, followed by examination, July 10th, 2023. Both matters are in front of Judge Jefferson. Ms. Johnson, you have some bond conditions. One is you're not to possess any flammable liquids while this case is pending. Do you understand that?
Yes, ma'am. Yes,
Also,
ma'am.
you're not to possess any firearms or any other dangerous weapons. You understand that?
Yes, ma'am.
You go to the location 3610 East McNichols City, Detroit.
Moving back to the U.S. here, where police in Detroit arrest a man for allegedly setting fire to a gas station. The footage you're looking at right here, posted to Facebook by the Detroit Police Department, shows the suspect dumping a trash can into the store. He proceeds to taunt the gas station employee. You see him there. And then look what he does. He lights that garbage on fire that he just placed on the ground, and just wild video. The employee did receive injuries after running through the flames and was treated for first-degree burns.
which I believe it is a Valero gas station. Do you understand that?
Yes, ma'am.
That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Do you understand that, ma'am?
Yes, ma'am.
Okay. Counsel, in this particular matter, no case history, no criminal history. I see that she has local ties. Go ahead, Esteban, please.
Ms. Johnson is 41 years old. She is currently not employed. Your Honor, she has 3 children. She's a lifelong resident of the city of Detroit. Your Honor, given the fact that she has no KPS history and no assaultive criminal history, we are requesting that you allow her to be released on bond, given the fact that she confirmed in a very affirmative fashion that she will have no contact with weapons, the complainant, nor the incident of the location where the incident allegedly occurred. So we are requesting a personal bond.
Thank you. Also, counsel, from what I hear is that she may have been drinking during this at the time of the incident. So, Ms. Johnson, while this case is pending, there is no drinking of any alcoholic beverages. Do you understand that?
Yes, ma'am.
It appears reading the investigator's report that your client made an admission that she was off her medication. She had been drinking. She made an admission that she knew what she knows that she was wrong, that she had been told not to go back to the gas station, that she had been there at that location previously. Allegedly, she was caught trying to steal some items. She couldn't come back to the location. Ms. Johnson, I'm going to take a chance on you. If you violate any of the bond conditions, if you go to the location, don't show up to court, commit other illegal activities, it doesn't matter. It can be such as a minor matter. You're going to be looking at a high monetary bond. Do you understand that?
Yes, ma'am.
And counsel, to ensure that she follows the bond conditions and that she doesn't go to the location after she's been told not to go back there, she's going to have a GPS tether, house arrest. Bond in this case is going to be $100,000 personal bond. Counsel, do you want to add anything else for the record?
No, thank you, Your Honor.
Your Honor, was that 5,000?
Step aside.
Your Honor, was that 5,000?
$100,000 personal bond.
100,000, okay. Okay, come on, come on.
Like, look, all right. Ms. Tracy, can you hear me?
Yes, I can.
This is Judge Middleton. We're a little bit early, which is good because I've got a bunch of small claims matters that start here in just a few minutes. But this is a carryover landlord-tenant matter. It's entitled Gary Reifenberg versus Pamela Moberly or all other tenants at 123 West Armitage Street. Mr. Reifenberg is here with his technical advisors. Your mother, Pam, is here. She was here last time. She indicated she moved out of this address and you were a holdover tenant. You weren't here last week. But we continued the matter until today because you had not been served. The property was served by attachment. You're also actually being evicted from 2 places at the same time. I had another case last Friday, I think, where there's a land contract or a mortgage foreclosure and you're listed on that property as well. But presently you're in jail. Miss Moberly, you're out. You don't have any possessions in the property?
Correct, sir. I've
Ms.
actually
Tracy?
been out
I've actually been out since April 17th.
Miss Tracy, do you have property left in there?
Yes, I do. I at this point, I don't know. I guess I just don't have to. I guess I'm just not going to get it.
Well, you have 10 days to move or you're subject to being evicted. I don't believe you ever paid any rent. Your mom left and you just held over there April, May, June. The Reifenbergs want their property back. If you can get somebody to go get it, you have 10 days to do that.
Mom, would you go get my stuff for me, Mom?
I will try to make those arrangements. My situation is difficult. You know that.
Pam, as soon
Yes,
as you get anything out of there, turn over the keys to the Reifenbergs. Anything you can do before July would be one less month. They can have the property back.
Okay. I, at this point, do not have the keys. I thought Leandra had them. I do not have keys to the apartment. I left them when I left on April 17th.
All right, Mr. Reifenberg, would you unmute your microphone? Judy, could you unmute that?
You hear him now?
Yes, I got it. Thank you for your help.
Thank you.
All right, Mr. and Mrs. Reifenberg, you heard it, but I couldn't hear you. Leandra's in jail and she's gonna be there for a while, it appears. Her stuff is in there. She's asking her mother to come get it, but she doesn't have a key. So you're gonna need to work with her to get the stuff out of there. 10 days from today is July 6th.
Yeah. The police broke in there the other night to arrest her, and the door is no more a door. So you can just go in.
Great. All right. I had left a message. In your defense, Miss Tracy, you got arrested, you bonded out, and like 2 days later, they issued another warrant for your arrest.
Yeah.
So if we'd known about the other warrant when you were here on the other case, we would have dealt with it at that time. I told your friend to tell you to turn yourself in. In the meantime, the police came and kicked in your door.
Yeah. I wasn't even aware of the other warrant. I had no idea. And then how the police came.
I believe you. I believe you. It didn't come. You were here on like June 11th, and the warrant issued for your arrest in the new case on like June 13th.
Yeah.
So, but I told your friend there was a warrant and you should come and see me. Well, in the meantime, you got arrested. All right. You have until July 6th to vacate. No money judgment is entered at this time. Miss Moberly, if you do get her property out of there, let the Reifenbergs know so they can repair the locks and take possession of this property back.
Yes,
July
sir.
6th is 10
Yes,
days
sir.
from today.
Okay.
All right. There's no money damages ordered here. If we're going to have a hearing about money, it will be at a subsequent hearing. This is simply about possession. The
There have
Reifenbergs
been
want their
damages.
property back. It's gotten trashed. The doors kicked in. No one's paying the rent. Not a good situation, but you have 10 days from today to get everything out. Pamela, if you're able to get things, let them know and they can change the locks and take possession of the property.
Okay.
Does anybody
Judy,
have any
Gary?
questions?
Yes, I do. My communication with Judy and Gary had broken down, and I just want to make sure that when I do contact them, that they will acknowledge that I have and return a call, or at least let me know that they've got my message about that.
All right, fair enough.
I have a question.
But according to them, you can go in right now. So that's not a good situation. All right, they agree to do that. All right, you're all good to go.
What do we do about other people that are still in there?
They're subject to being evicted on or after the 6th of July. There's other people in there?
Yeah,
I don't believe,
Leandra, who's in there?
I don't know of anybody that is in there now that I'm not. And if anybody is in there, it's only because the door is easily open and accessible. It's big vagrant people that I don't want to be in there that have come in and probably taken everything that I own that's worth value. So I can't imagine that there's anything left there that is worth anything, because I've been told that people have just ransacked what was left.
Well, not a good situation. Well, Pam, go assess it. If anybody's in there, they're squatters, but this order is Pam Moberly and all others. She left there, left Leandra there. Things went south from there. Leandra's not on the lease. She didn't pay any rent. The place got trashed. Not good at all, but they're included as the occupants.
I had another question. You said something last time about paying $15 at the time of
Yes.
eviction or something.
Yes, if you want a writ of eviction, you have to come to the courthouse and pay $15, and the sheriff will come forcibly put everybody out. That's on or after the 6th of July.
Okay, so I could go ahead of time and get this writ.
Well, you have to wait till the 10 days have passed.
Okay, so I have to go on the 6th.
Yes,
Okay,
unless everything is out of there, then you can just lock it up.
okay.
All right. Thank you.
Jerry and Gary, I will do the ultimate best that I can to make that happen before the 6th and let you know. I'm very sorry that all this turned out like this. You have been wonderful people to me in my life, giving me a place to stay when I was completely flooded out and homeless. I love you both very, very much, and I'm very sorry things have turned out like this.
We
And
are
I will
too.
do my
We are
best.
too, Pam. We are.
Thank
too.
you, Pam.
Thank you,
Very
Pam.
good. Okay.
I'm so sorry. I'm so sorry.
Yes, there's a lot of that going around.
I had nowhere else to go. I literally had nowhere else to go. So I stayed there
All right.
and I shouldn't have. And then I am so sorry to you too as well.
Okay, good luck to you. All right, enough to make you not ever want to be in the landlord-tenant business. Amber, could you unmute your microphone?
Okay, be quiet.
Are you Garth Large?
Yes, Your Honor.
And you're Linda Large?
Yes.
And you're Amber Fox?
Correct.
And is Pedro Pena with you as well?
Yes.
It's Pablo.
Pablo, all right. Will everyone please raise their right hand? You all swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
I do.
Yeah.
All right, this is a claim again for the statutory limit of small claims, $6,500. Mr. and Mrs. Large were your landlords. We had a previous possession hearing. This is about damages. Looking for that breakdown sheet. The largest claim. First, let's see if we can figure out their figures, and then we'll address your counterclaim figures. So, Ms. Large, you contend that rent is November through February at $850 per month, $3,400. Is that correct?
Yes, Your Honor.
Ms. Fox, what do you say to that?
I say that I don't.
Go ahead.
I said I don't agree with it because every month that I lived there until we got a court date, I texted her every month and asked her if she wanted me to deposit the rent money in the bank because I was still there. And she told me no, that she had told the bank not to accept my payments.
Well, once they start a landlord-tenant termination action, they can't accept your money. So do you acknowledge that you didn't pay November, December, January, or February's rent?
Yeah.
All right. Then, Mr. Large, you had to get a dumpster, $650.
That's correct, Your Honor.
How much stuff was in there?
We
30 yard,
Only one person can talk at a time.
there's a 30-yard dumpster. It was completely full. And we have pictures of it.
So why don't you let me see those pictures? So did you hire someone or you went in and emptied this all out?
I did it myself and a friend of mine.
This is Bruce's statement of what will look like. The little pictures are before they moved in, and the big pictures is
Well,
how
the
they
problem
left
is
it.
you're here live and they're not, so it's gonna be very difficult for them to see these.
They're all dated.
Oh my. Yeesh.
We've
All
never-
right,
we've never
so,
had
all right, we have
this much of them.
650 for a dumpster. Roach infested, 8578, what is that? Did you get a treatment or something?
He bought treatment stuff and did it himself. It was full of roaches.
Bathroom cabinet atop, 110. Odor eliminator, 60. Door locks, $35. Broken windows, $318. Wall repair, holes in walls, $41.42. Dog, $25 per month. Does the lease say that?
Yes, Your Honor.
So that's, how long is that? A
I
year.
think, I don't know how long they had it. I assumed a year. They never let us know. They were supposed to get prior permission.
Did you have a dog there?
Yeah, but Garth knew about it when our main water line broke because my twin showed him the dog.
We'll put a question mark regarding that. Doors and knobs, $287.66. Bathroom cabinet, $18. Labor, Bobby Wright. That's the person that helped you under the dumpster.
Yes, Your Honor.
All right, so that adds up to $7,300. Minus the $800 deposit is $6,500. We'll put a question mark regarding the dogs. Do you agree that the deposit was $800?
Are you talking?
Ms. Fox? Yes.
Yes.
All right, so that is applied to any damages. How did the place get so wrecked up?
I don't see how it was wrecked up because I had been going through, there was already holes in the wall that we had repaired a whole bunch. I've been painting it, we've been fixing the cupboards. There was a few kitchen cupboards that was broken that we hadn't fixed. The whole bathroom upstairs never worked. Every time the bathtub or the shower or whatever was turned on, it flooded in my bedroom downstairs. Garth told me that he went through and he fixed all that. So I had to wait an extra week to move in when we first moved in. But in all reality, what happened is he went up there and he put black leaf bags in the ceiling. So Thanksgiving Day, the bag must have got too much water because it fell through and it ruined the whole bedroom ceiling. Like all the tiles fell out on my bed. It ruined my twins' brand new toddler bed. It ruined my laptop.
Well, let's talk about that. This is your counterclaim. You've got water and sewer, 1,186. What's that about?
Well, when I was there, I paid the last bill, but when I got this, I called the city and the lady told me that this November and December was actually for like September and October, and the January and February was for November and December because they bill ahead. Like, I don't know. I didn't understand that either. So I agree to that because if it's my bill, it's my bill.
All right. So dumpster, $650. All right, these are his. You got plaintiff owes me, I believe. Terminex for roaches and termites that was told about when I moved in, $2,034.96. What's that?
I texted Linda and I told her that I had been seeing little bugs all around the house. She told me that she would have Garth come over there and look at it, which never happened. I woke up, I want to say maybe about 2 weeks later, and the front room that we used for the twins' bedroom, I don't remember which one it was. Their bed was by the window. And when I woke up to go out there to check on them, they had termites all over them.
Well, did you hire Terminex?
Yep, because they wouldn't take care of nothing there. Linda kept telling me
All
that.
right, so you spent $2,034.96 of your money?
I did, yep. And I actually have the contract in my email, which I didn't know how to get it to you guys because I called them to get this for you.
All right. We'll come back to that. Upstairs bathroom,
Your Honor,
$650.
could I comment on that?
Oh, I said we'll come back to it. I'll let you respond when it's your turn to respond. Now, this is their contention. This is hard to see, but I'll hold these up of what the property looked like when you rented it.
I can't see none of those.
Yeah, well, I'm doing the best I can. Here's the room when they rented it to you. And here's what it looked like when you left.
Can't see. I can't see none of those.
You can't see that view?
No, I can see like me, but
All right,
No.
well, the place is trashed. There's
Okay,
junk
well, I don't-
all over the place. The pictures from when you rented it looked very clean and neat. You can't see them, but every room is freshly painted, clean floors.
Okay, well, they didn't paint nothing, so that's incorrect because I told Garth and Linda that I would paint to be able to move in fast. So there was nothing, no freshly painted when I moved in. That's a lie.
When did you move in? These pictures are dated 10/31 of 2020.
I signed a lease on 11/1 of 20, but I can guarantee you that there was no freshly painted nothing because I agreed to do it. You can, I mean, we're under oath, so ask Linda, did I not volunteer to paint her whole house just so we could be able to move in?
Oh my gosh. The toilet is deplorable.
Oh, the upstairs toilet that never worked. They would do nothing about it. We tried fixing. They said if you don't. I tried fixing the bathroom. We put new pipe. Yeah, hold on a minute. We put all brand new pipes underneath the bathtub because every time the bathtub was used upstairs, it would flood downstairs in my bedroom and ruin everything. That bathroom never worked.
The whole 3 years we were there.
We put in the new wall right there by the bathtub. We fixed all of that.
All right. Well, let's see what we can figure out. Mrs. Large.
Yes.
These pictures are dated October 31st of 2020. Are these pictures that you took that day?
Yes.
And are they
They're
fair and
from
accurate
my
pictures of
camera.
what it looked like just before the day before they moved in?
Right,
Did the upstairs bathroom work?
yes. I have a signed Johnsons are the ones who moved out on the 31st. Actually, Amber approached her because they were being evicted. We felt sorry for them. And we told them they were in a hurry. They could move in the kindness of our heart, but they'd have to accept it as is. But as you can see from the pictures, it was in very good shape. I mean, it was clean. I have
Well, did she paint it?
She did paint it, but she painted the colors she wanted to paint, all dark gray and black.
Those reds and blues that are there, that was the way it looked the day before they moved in.
Right, yes,
Right, and then
absolutely.
she painted it other colors.
Yeah.
Not the bedroom.
All right, now there's junk everywhere. When they moved out, doors are broken, there's trash everywhere, there's a clogged toilet, which I don't feel compelled to share that picture. It's in deplorable shape. So from November of 20, and they moved out in February of 22.
Watch this.
So they were there about 14 months. All right, now she claims that the ceiling broke loose and some of her property was flooded. What can you tell me about that?
I have a signed statement and it's dated from Johnson's that moved on the 31st of October. It's from Penny. She says, when I moved, the ceiling in the bedroom was not leaking. Also, we did not have any cockroaches and never saw any termites.
Would you hand that to the bailiff?
The bailiff.
Oh, there we go.
When I moved in, the ceiling in the bathroom was not leaking. Also, we did not have any cockroaches and never saw any termites. Termites are a little slipperier, but the way this property looked, I could see why it had cockroaches. So did they tell you that the bathroom this is the downstairs ceiling?
Yes, downstairs bedroom, the bathroom right above it. And I went in there and I checked it out and looked at it, thought I had it fixed. Okay. And I guess it kept on leaking. And then I asked
What
him,
was the source of the leak?
the drain. So,
The drain in the tub?
yes.
I changed that.
It,
I also
Say
called
that
you.
again. Just a minute. Go ahead.
We changed all of that. We took the wall down.
That's not something a tenant does. That's something the landlord does.
But every time I would call Linda and tell her that there was a problem, Linda would tell me I could either fix it or they would condemn the house.
And we'll kick you out.
Every time they came to the house, if there was an issue about the house being so dirty or so wrecked or whatever, why didn't they say nothing? My house was always clean. I'm not saying that I didn't put trash on the back porch, but I can guarantee you that the house was not dirty. So when I left, there was trash on the back that I texted Linda and asked her if I could come in, if I could have until tomorrow to get dump passes in a trailer to get all the bags of trash and everything off the back porch.
No, we want you.
Linda told me no, that she would not know that there was a writ. Okay, that's fine. What am I supposed to do with it? If I don't have a way to move it because one of my cars was down, I had my friends helping me get the stuff out that I needed to get out of there. They even took my furniture and cut it and put it on the front of the road that wasn't even mine. It was Rent-A-Center's.
We cut it in pieces.
So now not only do I owe them, as they're saying that I owe them, I owe Rent-A-Center for furniture that I had just got that is no good to me because somebody cut it up and put it outside to the front yard. So when Rent-A-Center pulled up to get it, they called me and had me come over there because somebody cut it all up and threw it outside.
well, that's, Your Honor.
Stop. I don't know how to show you these pictures.
Okay, so then can we adjourn it and get an in-court date? Because I'd love to bring in my receipt and contract from Terminex. I'd love to bring in my receipt for when me and my sister both fell through the deck and she wouldn't replace no boards and made me pay for the boards to be fixed. Like
People for the bathroom.
Yeah.
Penny asked for Penny Yeah, okay, there might have not have been a leak when Penny lived there, but Garth himself knows that there was a leak because he tried telling me that it was the guts of the toilet. So he was trying to figure it out before I moved in. Linda knows herself that I called her Thanksgiving morning. I apologized for calling her on a holiday, but I told her, I don't know what Garth put up in the ceiling, but a big black leaf bag just fell through all over my bed and ruined everything. She even got upset with Garth and told Garth, why would you put a leaf bag in the ceiling? Garth tried saying that I had to have did it. All the ceiling tiles was already up before I moved in. So there's no way that I could have been able to put a leaf bag in the ceiling. And to my knowledge, Garth got the problem fixed. So there would be no reason for me to put a leaf bag in the ceiling.
All right. Slow down. You claim that you hired Terminex, but you do have a receipt that you paid them that amount of money?
Yep, I got it in my email.
What do you know about that?
Nothing. They never approached us. They never said anything to us. We feel that would have been our responsibility and they accepted the place as is. It's right on the front of the contract.
Well, as is, there has to be a minimum covenant of habitability. Did the city inspect this property? When was it last inspected?
I think it was like a year ago, and it looked good then. It did. When we went in, we thought it looked good.
I'm ashamed of looking at these pictures. They're, in fact, all the toilets are just, I can't even stand to look at them. Why someone would leave a house like that? And there is a full dumpster and there's junk everywhere, inside and out. And so we've got to determine that. What I'm trying to determine, there's also the garage seems to be just full of garbage.
That's it.
And there's needles. There's a picture of needles.
There were spoons when we moved in the garage. That was all there. Needle.
All right. Yes, you're going to have to be here live to see these pictures, and we're going to have to.
But in the meantime, no, hold on. But in the meantime, Penny told me that 2 days after I moved out, Garth had to chase a whole bunch of people out of the house and off the property and all that. So, that's what I'm trying to figure out. Like,
all right, slow down. Were there ever squatters in there after they left?
Nobody was there. The day after Garth was working in the house, we had a lady come and she says, that grocery cart that's in your yard has some of my stuff in it. Can I get it? We had 2 days after they moved out, the mailbox disappeared, but there was mail in those 2 days from people. Terry Wilson was getting mail there. Mike and Peggy Herring was getting mail there. They had her sister-in-law Hannah and Brandon living there. And evidently that lady that had stuff in the shopping cart, she was living there, but nobody's been in the house at all since they moved. We've been there. My husband has been there almost every single day since February working on that house.
All right, Miss Fox.
Yep.
Did these other people also live there?
I don't know who the lady with the shopping cart is.
But did Terry Wilson live there?
She did not. I don't even know why
Mike and Penny Herring live there?
Penny was past residents.
Yeah, them was past residents. There was mail for Bradley Huey coming there, Mike Johnson. When I went to the post office, there's about 27 people's mail going there. That's just not since I've lived there.
All right. Who else lived there during the time you were there?
Me, Pablo, and the kids. She swears up and down that Brandon and Hannah lived there. Brandon and Hannah did not live there. I can have people over at my house without her controlling my household. She tried telling me who could and couldn't be at my house. who could stay the nights there, who couldn't stay the nights there. I do what I want to do when I'm paying her my rent faithfully every month.
All right. Well, you're using the belligerent technique. You trash these people's house and you're not slightly even remorseful about any of it. You're all
Okay,
indignant
but the
about
house
the
was
indignant.
not.
Stop. And so it might work with somebody, but it doesn't work with me. So these pictures are embarrassingly bad. You also owe several months of rent, which is not in dispute. So this claim is going to be substantial. What I'm trying to determine is whether there's a set off for your damages. They've supported their claim for $6,500. I'm trying to determine whether there should be some set off from your claim. Normally, if these pictures were scanned in, we could screen share and you could see them, but this is small claims court and people aren't technically savvy, but we're going to have to be here. Now, their claim is that your claim is you hired Terminex regarding termites. Why you would do that, I don't know. That's the kind of thing you would take to the landlord, but
I did. I did.
She did
And
not.
all right,
She told me-
all right, we'll determine that. So we're going to continue this
okay.
for
She even-
live
Down to
proceedings.
termites.
Okay. The irony is you'll get a judgment. You're going to have a very difficult time getting any money collected on it.
Right.
Right.
We're going to continue this to Monday, July 10th at 3 o'clock. Does that work for you guys? Live. The before and after pictures are telling. Mr. and Mrs. Large, it would also be helpful if you can get from the city of Three Rivers your last date of inspection, rental inspection.
You do that.
I'd like you to bring in any other documentation you have, Ms. Fox, including your Terminex bill.
Okay.
If it's for termites, it's one thing. If it's for roaches, I'm not surprised that there are roaches if the place looked like this. But we'll see what we can figure out. As I indicated, I believe they have established their side of the case. I'm trying to determine the set off for your counterclaim. So we'll continue this to live July 10th at 3 p.m. All right, we'll address it. I've got a couple other cases, but we should have a good hour and a half or so to devote to this. All right, Ms. Fox, I'll see you then.
Thanks.
Thank you. Mr. and Mrs. Large, why don't you come up? Return to the matter of Garth and Linda Large versus Pablo Pena and Amber Fox. We were here by Zoom on June 26th. We took quite a bit of testimony and I reviewed a large packet of photographs which supported. Just a minute. I thought I was done with this guy. Which supported Mr. and Mrs. Large's claim for at least $6,500 worth of damage. The photographs showed the property was in deplorable condition. Mr. Lafferty, you came back. Did we forget something?
No, I didn't know what happened, so I didn't know if I should log back in and just.
Yeah, no, I excuse you. You're good to go.
Oh, okay.
All right. They had filed a counterclaim for alleged property that it was kind of hard to discern. It was all scribbled on here. They claimed that property was damaged when they had water damage from the roof giving way. So I continued the matter for live testimony, and we could actually see the photographs, and they aren't here. She also contended that she had a large Terminex bill, which I was somewhat leery about, that the tenant would pay a very large amount to Terminex. And I wanted to see it. Well, they aren't here. The bill's not here. No pictures are here, and they're not here to have anything to support their counterclaim. Mr. and Mrs. Large, let me put you under oath once again. You swear or affirm any testimony you give again here today will be true to the best of your knowledge and belief?
Yes.
Anything further? Since we were here 2 weeks ago, you did send some additional pictures, which also showed a lot of damage. I'm looking for Amber Fox or Pablo Pena. Anything since we were last here?
Yes, Your Honor. After we left court, I called Terminix and I talked to the branch manager, Mr. Kevin DeVos, and they did indeed sign a year contract for the amount that they stated, but they canceled it. They canceled it in July. And he explained to him they would still owe that money, and she got really irate with him, and they never paid it, and it was turned over to collections, so they never did pay that money.
All right. You were also going to get the last Three Rivers City inspection date.
Yes.
Do you have the date of that?
I do. That was September 15th of 2021.
All right, so they were quite animated, but they aren't here to back any of it up. Very good. Your property was approved by Safe Built, Mr. Joe Klein. In Three Rivers and Sturgis, we have the benefit of having the property regularly inspected. Sometimes out in the townships or other villages like the Wild West, people are renting things that really are not up to code. City of Three Rivers does a good job at it, and so does Sturgis, but they're not here, live or otherwise. I find for the plaintiff $0 for counterclaim. The amount of $6,500 plus costs of $97.9501 for a total of $6,692.01. I expected they were going to be here. We were going to have a big go round. Maybe somewhat moot because trying to collect on this will be something else.
Right.
Right.
Whenever I see pictures like this, I think, I'm sure glad I'm not a landlord. And the before and after pictures are quite telling. The property was quite neat and tidy, and then it was something else altogether. And you're doing it yourself. So what you testified last week is since they moved out, you've been back in it it's hard to make any profit when you spend $10,000 with a loss.
Right.
But if you go out to the counter, the clerk will give you a copy of that judgment. They do have 21 days before you can take any collection action, but you're free to go.
Yeah, thank you, John.
Thank you.
It would make Penny very happy if you would like, subscribe, and leave us a comment.
Ice in my veins, I've been driving this train. Years in this lane, there's no stopping this flame. Cause I came to the game and I changed.
Ms. Vollmer, would you please raise your right hand? Mr. Wenzel, would you please raise your right hand? This is file 23612SC, Christina Vollmer versus Tyler Wenzel. Do you both swear or affirm that any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes.
Yes, sir. This is a claim for $6,500. Ms. Vollmer contends that there was a fire and the defendant's house burned, and she was reimbursed by her insurance company, but she claims that she had $9,000 cash that was burned up, and she's suing for $6,500. Mr. Wenzel answered, "I'm not liable for the fire. The cause of the fire is undetermined. She hasn't proved damages. There's no proof that she had $9,000. And if her insurance company wouldn't pay it, and my insurance company wouldn't pay it, why should I have to pay it, essentially?" So, Ms. Vollmer, why do you believe he owes you $6,500?
That was money that was basically saved. That was first time after my divorce that I was actually able to save some money. I wasn't home at the time of the fire. I carry responsibilities pretty far out when I'm grilling or doing anything as far as messing with flames when I have neighbors. The only thing he can say is that, well, I got a new house out of it. If I wanted a new house, I would have went and bought one. I worked really hard into saving that money. I basically had another job under the table, just, paying my bills, wrapping cars, helping out Morris Motorsports out in White Pigeon. And that was money that I was able to save. And I was very proud of myself to finally be able to save some money after getting rid of my ex-husband who spent it all.
Well, how do you intend to prove that you had $9,000 cash in there?
I sent pictures of a video that I took of it. The ladies at the court just told me to take screenshots as best as I can.
Well, I see the pictures of where you say it was.
Yes, it was in my mother's cabinet, along with
Yes,
all my.
but there is no picture of $9,000. There's a picture of a cabinet. There's a picture of you holding wads of cash.
Yes,
and
sir.
you claim you got a $600,000 settlement.
No, that was a joke. At the bottom of it, it said "see more" where you pushed it, and I sent you that too, that text as well.
I didn't understand that, but there's I guess not a very funny joke. I got paid off $4,000 in debt, got my $678,000, credit score 760. My finances are flourishing. I'm buying a new house. So you say you had $9,000, but there's no proof of it other than you say you had it. You filed a claim with your insurance, is that correct?
Yes, sir.
And what did they say about your $9,000?
That I would have to take them to court because the only way they don't cover cash. They gave me $250
out of the 9 grand. That's what they did cover. But as far as the rest of it, I would have to take them to court, to small claims court.
Take them or take Mr.
Take
Wenzel?
Mr. Wenzel. And that's what I'm doing. I don't know nothing about the legal system. I try to stay away from you guys. So when they told me that, excuse me,
that's probably a good idea.
Yeah.
All right, so that's not a wise idea to leave $9,000 worth of cash, but I don't have any way of knowing whether you actually had $9,000 worth of cash. Your insurance company wouldn't pay for it. Apparently his insurance company wouldn't pay for it.
Well, I got it from and I sent you my bank statements of the unemployment, putting it into my bank. And that's when I took it out, is because of COVID. I think everybody pretty much took out their money from the bank because we had no clue of what was going to happen next.
Not true.
All right, Mr. Wenzel, what do you say about this?
Thanks, Your Honor. Basically, I've already spelled out my reasoning from the court papers that I have to file. As you already stated, I'm not liable there. She hasn't proved the damages, and she hasn't proved beyond perpetuous of evidence. The money amounts that she has in the pictures, if you go through and add them up, they don't even equate to the amount of money she's trying to sue me for one. And then for two, her bank statements don't align up to $6,500.
They line up to $9 grand.
So many inconsistencies. There's so many inconsistencies that I can tell you what my real thought is on the situation, but I'm all facts and data. It's her duty to prove, it's not mine. And so she can't prove the money. Another one too is, COVID money is relief money. That should be used in proper ways. So you need to be buying food, you need to be paying for housing, you need to be doing that. So for her to bring money out of the bank, it's not smarter. She should be using it for actual things that she needs. But there's just so many inconsistencies going on here.
All right,
yeah.
Mr. Wenzel, are you still at 521?
Yes, that's where I get my mail, sir.
But your house is not there. Is that
No,
correct?
sir.
The house burned.
Correct. House burned.
Was the cause of the fire ever determined?
Not that I know of.
I talked to the firefighter after this, after you get there.
Yes. Was the cause of the fire ever determined?
It was not. Ever since, this matter happened like 2.5 years ago. Once I got the letters in the mail, I was pretty shocked myself. But I called the fire department up. I went and talked to Bloomington, and Bloomington's not the fire chief anymore. So then I figured out who was, and I got the paperwork I submitted. But no, there's no cause that they whatever.
All right. Ms. Vollmer,
Yes, sir.
did they build your house on that lot?
Yes.
So you're
They
at
they didn't rebuild it. They just gutted it and then put some sprayed some smoke damage stuff in it, and then rebuilt what was gutted out.
All right. Well, he makes a couple of points.
Mhm.
One, you have the burden of proving the case beyond a preponderance of the evidence. Also, there has to be some liability. So let's assume there was a power surge and his house burned up.
Okay.
In the meantime, it caught your house on fire. Well, that's not his fault. He had home insurance, you had home insurance. The home
Correct.
insurance you had apparently did not cover cash. So because he had now if he started the fire himself negligently or intentionally, perhaps he's got some causation, but we don't know what started the fire. He lost his house. You were foolish enough to have $9,000 worth of cash sitting in your house. Also foolish enough to flash pictures on YouTube saying, please come over and rob me. I have $2,000 worth of $100 bills and 120.
I didn't post anything on YouTube, sir.
Oh, on Facebook.
I didn't flash nothing on Facebook either, sir.
Okay, good. That
was a personal video that I took myself.
So A, there's no causation proven.
I heard it was a grill, that he didn't put the lid on the grill, and a piece of
Well, nobody's
coal or
able
whatever
to
went into the
establish
garage.
that.
That's what the fire
And-
department told me.
Well, there's no evidence to that effect. You had insurance, he had insurance.
Yes,
So
sir.
that's the other. Then there's no proof that you had $9,000 except your testimony under oath. His testimony is, I don't know. You've got some bank accounts which may or may not substantiate it, but your insurance company wouldn't pay it. A, they didn't have proof that you had that much money, and B,
They didn't ask for proof.
well, they wouldn't cover it anyway, so they sick you on small claims court. I find that the defendant has not, or is right, the plaintiff has the burden of proof, and the plaintiff has not established cause or preponderance of evidence to establish the amount was lost. So I find for the defendant, and the damages are zero. I guess lesson learned, don't keep large amounts of cash in your house or make sure it's covered by your insurance. But you can't recover in this forum. I'm sorry, I thought you really had recovered $678,000.
No, sir. It was all a joke. Somebody posted it and I shared it. I thought it was funny.
Well, I didn't get it. I thought you really got it, but you're not gonna get this either, so I'm sorry.
That's fine.
All right, I find for the defendant, I find the plaintiff had not met the sufficient burden of proof. All right, Mr. Wenzel, you go back to digging a hole.
Thanks, buddy.
All right, Ms. Fulmer, best of luck.